कोर्ट ऑफिसर, कोर्ट ऑफिसर, आई कॉल यू बैक, वेट वन सेकंड। हाँ हाँ।
National Commission. For what? So what? So what? If it's without jurisdiction, it is entertainable. Yes. Anything else? Next.
My lord, subsequent
see.
482.
I have granted an interim order. Who has granted an interim order? Give it.
My lord,
Even then, yes.
my lord, subsequent 482 petition, my lords, on the previous date of
Who
submission.
asked you to mention now?
Pardon, my lords.
Yes. Monday. ಹಿಂದೆ ಇರೋರು ಬರಬೇಡಿ, ಫಸ್ಟ್ ರೋ ಮಾತ್ರ. ಎಸ್. ಪೆಂಡಿಂಗ್ ಅದು ಮ್ಯಾಂಡಮಸ್ ಬರುತ್ತೆ. ಡೇಟ್ ಮಂಡೇ ಇಲ್ಲ. ಮಂಡೇ. ವೆನ್? ಟುಮಾರೋ. ಎಸ್. ಹಿಂದೆ ಇರೋರು ಮಾಡಬೇಡಿ. ಐ ಹ್ಯಾವ್ ಟೋಲ್ಡ್ ಯು ಟು ಮೇಕ್ 3 rows. ವೆಯ್ಟ್. ಈ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ವೆಕೇಟಿಂಗ್ ಸ್ಟೇನಾ? ಮತ್ತೇನು? ಪೊಸಿಷನ್ ಕೊಟ್ಟಿಲ್ವಾ? ಬ್ಯಾಂಕ್ ಕೊಟ್ಟಿಲ್ವಾ? ಮಂಡೇಗೆ ಹಾಕಿ. ಮಂಡೇ ಸರ್. FR ಇದ್ರೆ ಕೊಡ್ಬೇಡಿ. ಎಸ್. ಮಂಡೇಗೆ ಬರುತ್ತೆ ಕೊಡಿ. ಅಲ್ಲಿ ಕಂಪ್ಲೈ ಮಾತ್ರ ಮಂಡೇ ಬರೋದು, ಇಲ್ಲದ್ರೆ ಬರಲ್ಲ. ಎಸ್. ತಗೊಳ್ಳಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮಂಡೇಗೆ ತಗೊಳ್ಳಿ. 2:30 ತಗೊಳ್ಳಿ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ? ನಾಳೆಗೆ ಹಾಕಿ. ನಾಳೆಗೆ.
My lord, subsequent.
All right.
My lord, subsequent 482 matter, my lords, last
Tomorrow, give it.
submission.
Friday, give it tomorrow.
2:30 matters ಸ್ವಾಮಿ. ಪೊಲೀಸ್ನವ್ರು ತುಂಬಾ ಹರಾಸ್ಮೆಂಟ್ ಮಾಡ್ತಾರೆ.
ಅದು 2:30 ಅಲ್ಲ, ಮಂಡೇ. ಎಸ್. ವೆಕೇಟಿಂಗ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಒಂದು ಡೇಟ್ ಕೊಡ್ತೀನಿ, ಕೊಡಿ. ಸಾರಿ, ಪೆಂಡಿಂಗ್ ಫ್ರೆಶಾ? ಕೊಡಿ ಮೆಮೊ, ಕೊಡಿ ಮೆಮೊ. ಅದೊಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್, ಬಿಕಾಸ್ ಕ್ಲೈಮೆಂಟ್ಸ್ ಪೆರೋಲ್ ಪೆಂಡಿಂಗ್ ಮಂಡೇ. ಅದು ಕೊಡಿ ಮೇಡಮ್. 2:30 ತಗೊಳ್ಳಿ ಮೇಡಮ್. 2:30. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ? ಮಂಡೇ. ಎಸ್. ಹಾಂ.
84 days are passed since the FIR has been registered. Absolutely no progress. Credible evidence shows that there is interference from a Rajasthan IPS officer.
Now, you serve it on Rahul. Allah, copy on the AGA who is here. 2:30 ತಗೊಳ್ಳಿ. Yes. ಪಾಟಾಡ ಯಾವುದದು? ಯಾವ್ದು ತಗೊಳ್ಳಿ. ಪಾಟಾಡೆಲ್ಲ ಒಂದಿನ ಹಾಕ್ತೀವಿ. 7 ಏನ? ಅದೊಂದು ಡೇಟ್. ಪಿಟಿಷನರ್ ಇಸ್ ಸೀರಿಯಸ್ಲಿ ಇಲ್ಲ. 7 ಆದ್ಮೇಲೆ ಸೀರಿಯಸ್ಲಿ ಇಲ್ಲ, ಏನ್ ಮಾಡಕ್ಕಾಗ? ಒಫೆನ್ಸೇ ಹಂಗಿದೆ. ಎಸ್, ನೋಡ್ ಹಾಕ್ತೀನಿ ಬಿಡಿ. ಎಸ್. ಮಂಡೇ. ಏನು ಮೋಟರ್ ವೆಹಿಕಲ್ ಆಕ್ಸಿಡೆಂಟಾ? ಆಯ್ತು, ಕೊಡಿ. ಗಿವ್ ಇಟ್ ಸರ್. ಗಿವ್ ಇಟ್. ನೋ, we'll see. Yes. Thank you, sir. Yes. Wait. Yes, second row, man. Pending matters kodi, memo kodi. Monday only fresh matters, sir. No pending matters. When do you want it? All right, tomorrow. Settlement tomorrow on thaki. Wait. Third row lidira. Wait. Yes. Wait, sir. ಟುಮಾರೋ ಆಗುತ್ತಾ? ಅದು FR ನಂಬರಲ್ಲಿ ಇರುತ್ತೆ. 2:30 ಸಾರಿ, ನಾಳೆ ಬರಲಿ. ಕಂಪ್ಲೈ ಮಾಡಿ. ಟೈರ್ ವೇಟ್. ಎಸ್. ಫುಡ್ ಗ್ರೈನ್ಸ್ 2:30 ಪೆಂಡಿಂಗ್ 2:30 ಬರಲ್ಲ, ಫ್ರೆಶ್ ಮಾತ್ರ. ಹಾಗಾದ್ರೆ ಫ್ರೆಶ್ ಮಂಡೇಗೆ ಬರಲ್ಲ? ಆಯ್ತು, ಮಂಡೇಗೆ ಬರಲ್ಲ ತಗೊಳ್ಳಿ. ಆಲ್ ರೈಟ್, ಮಂಡೇಗೆ ಹಾಕ್ತೀನಿ. ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್ ಸರ್. ಮಂಡೇ sir. You want it on Monday? Take it. Monday. Yes. 2:30.
One matter for withdrawal.
2:30. Yes.
Diagnosis center, my lord, there has been an interim order provided in this. Since then, it has been not posted. Kindly, there's an urgency because I'm not doing any business, my lord.
Give it next week. Third row ಬಂದಿಲ್ಲ ಇರಿ. Yes.
Any application, inviting application for the.
Fresh or pending, madam? Stay ಆಗಿದೆಯಾ? ಮಂಡೇಗೆ ಹಾಕಿ ಅದು. Yes.
2:30,
ಅದು
madam.
ಮಂಡೇಗೆ ಹಾಕಿ madam.
Tomorrow is the auction.
2:30.
2:30.
My lords, the petitioner is a senior citizen, my lords, possession case not a magistrate allide. My lords, and complaints after Hakiru, there's precipitation. If it may be taken up at 2:30, my lords, there's grave urgency.
Pending matter.
Please, my lords.
Pending
But
matter
state
2:30
it.
ಗಾಲ. 2:30 ಆಗಲ್ಲ pending matter. Tomorrow.
2:30.
Tomorrow give it.
This is an election-related issue with regards to the Boxing Federation of India. Representations from Karnataka are going there. We are challenging the persons who are going there.
Why are you challenging persons who are going?
Matlab, we are the persons who are actual people who are the.
You had to go, is it?
They are not giving us the people, some people who are posing as.
Tomorrow.
Election is 22nd or 2:30.
Malad surface.
Tomorrow is 21st, right? Tomorrow.
Malad surface act. Malad possession is taken.
Who is making a mention surface act? Nimda.
Yes.
Ah.
Possession is taken. Malad tomorrow they are likely to issue public notice. It's a resort. Malad all bookings.
2:30.
2:30.
The interim order has been granted. Report advocate has been, I've already filed the deferred.
ಅವ್ರ ಹೆಸರು ಬಂದಿದೆಯಾ? ಕೊಡಿ. Being spoken to ನಾಳೆ ಹಾಕಿ.
Monday, auctions to be held on Monday. lords.
Wait, third row, don't jump. Yes. No problem, ಕೊಡಿ. Stay order ಇದ್ರೆ lookout circle ಇರಬಾರ್ದು ಅಂತ ಏನಿಲ್ಲ, ಕೊಡಿ. Come tomorrow, yes. Which one, sir? Monday, sir. Sugar factory ಗೆ urgency ಇರಲ್ಲ, ಕೊಡಿ Monday. 2:30. Give it. Next week, ಹಾಕಿ. Monday. Next Monday, April 1st. Yes. Next. You move it 100 times, sir. Not bothered. What fresh up pending ಹೇಳಿ. Pending matter ನೀವು ಎಷ್ಟು ಸರಿ ಮೂವ್ ಮಾಡಿದ್ರು ಅಷ್ಟೇನೆ. ಕೊಡಿ, ಏನು ಅರ್ಜೆನ್ಸಿ ಏನು? ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಗ ಏನ್ ಆಯ್ತು ನೋಡಿ ಕೊಡಿ. ಎಸ್ ಕೊಡಿ ಅದು. ಮಂಡೇ ವಿಲ್ ಸಿ. ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಗಿವ್ ಇಟ್. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಗಿವ್ ಸರ್. ಎಲ್ಲರಿಗೂ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಡೇಟ್ ಕೊಟ್ರೆ ನಾನು ಕೂತ್ಕೊಳ್ಳೋಕೆ ಆಗಲ್ಲ ಇಲ್ಲಿ.
Surface, lords.
ಎಸ್ ಗಿವ್ ಇಟ್. ಎಸ್
Surface.
fresh matters ಎಲ್ಲ ಕೊಡಿ. Here, whoever is waiting for fresh matters, all for Monday, please give it. All for Monday, please give it.
Lordship, surface.
Tomorrow I am not taking, except surface. All matters for Monday.
Surface.
All matters for Monday, first give. Surface I'll take, wait. Monday, ಎಲ್ಲ fresh matters ಕೊಡಿ. Wait. Mondayಗೆಲ್ಲ ಕೊಟ್ಟಾಯ್ತಾ? ನಿಮ್ದೇನು? Withdrawal. Give it at 2:30, yes. Monday. Last day ಗೆ ಯಾಕೆ ಬರ್ತೀರಾ ನೀವು? I'll stop entertaining your petitions like this. Correct? UN compliance ಗೆ. Don't DRT order ಕೇಳ್ಕೊಳ್ಳಿ. Extension in DRT you ask. No. ಹಾಕಿದ್ದೀರಾ? ಅದು ಪರವಾಗಿಲ್ಲ, ನಾನು ಮಾಡಲ್ಲ. I'll stop doing it in henceforth. Yes. Next ಕೊಡಿ. ಏನದು? ಕೊಡಿ. ಎಸ್. ಮಂಡೇಗೆ ಹಾಕಿದ್ದು BWS ಡಿಮಾಂಡ್ ನೋಟಿಸ್. ಎಸ್. Monday, yes. Next week, yes. Parole Monday.
My lord,
Parole Monday. Death. Who? ನಾಳೆಗೆ ಹಾಕಿ ಮೇಡಮ್.
my lord,
ಮಂಡೇ 2:30 ಮಂಡೇ ಎಸ್. ಮಂಡೇ ಕೊಡಿ ಸರ್. ಎಲ್ಲಿ ಹೋಗ್ಬೇಕು ನೀವು? ಇರ್ಲಿ ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಮಂಡೇ ಎಸ್.
pending matter, my lords, will
ಮಂಡೇ ಆನ್ ಸೀನಿಯಾರಿಟಿ ಆಫ್ ಕೋರ್ಸ್. ಹಳೆ ಮೆಮೋಸ್ ಫಸ್ಟ್ ಬರುತ್ತೆ. ಎಸ್.
the subsequent auction purchaser, my lords, will pay the entire sale consideration.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್, ಗಿವ್ ಇಟ್.
My lords, there's a stay order, my lords, the petitioner.
ಗಿವ್ ಇಟ್ ಮೇಡಮ್. ಗಿವ್ ಇಟ್ ಎಸ್. ಯಾವತ್ತಿದೆ? 2:30. ಪರೋಲ್ ಮಂಡೇ ಕೊಡಿ.
My lords, for
ಮಂಡೇ ಕೊಡಿ ಪರೋಲ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಮಂಡೇ ಹಾಕಿ.
my lords, for modification of interim order, my lords.
Give it. Past 1 year is not my problem, madam. I have not granted it unconditional interim order. Give it. Yes, no, don't pour on me all things that you have not been able to get it set aside elsewhere. Pending matters ella kodi memo. Maybe sir, pending matters kodi memo. Kodi sir. No date sir. If one date I give in any pending matter, I have to give dates in all matters. Please give pending matters. Yes.
My lords,
Give it sir. Please give all the pending memos.
my lords,
Unless there is grave urgency in the matter, give it.
my lords, for modification of interim order, my lords.
Modification, take that. Yes. ಈಗ ಕೊಟ್ರಲ್ಲ, ಎರಡಿದ್ಯಾ, ಇನ್ನೊಂದು ಮಂಡೆಗೆ ಕೊಡಿ. ಈಗೇನ್ ಕೊಟ್ರಿ? ಮತ್ತೆ ಒಂದೇ ಯಾಕೆ ಕೊಟ್ರಿ ಫಸ್ಟ್? ಹಾ ಸರಿ, ಎಸ್. ಎಲ್ಲ ಮೆಮೋಸ್ ಕೊಡಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮಂಡೇ, ನೋ 2:30. ವೈ? ವಾಟ್ಸ್ ದಿ ಅರ್ಜೆನ್ಸಿ ಫಾರ್ 2:30? ಮಂಡೇ ಕೊಡಿ, ಬೇಕಾದ್ರೆ ಮಂಡೇ, ಇಲ್ಲ ಅದು ಇಲ್ಲ. ಅದು ಕೊಡಿ ನೋಡಿ. ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು ಹಾಕಿ ಮೇಡಮ್. ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು ಹಾಕಿ ನಾಳೆ. ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು ಫ್ರೆಶ್ ಅಲ್ಲ, ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು ನಾಳೆ ಹಾಕ್ತೀನಿ. ಇಲ್ಸಿ ವೇರ್? ಎಲ್ಲಿ? ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ? ಕೊಡಿ ಸರ್. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ? ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ? ದೆನ್ ಮಾಡಿಫಿಕೇಶನ್ ಅದೇ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬೇಕು. 7-2 ಯಾರು ಆರ್ಡರ್ ಮಾಡಿದಾರೆ ಅವರಿಗೆ ಅಲ್ಲೇ ಹೋಗಿ. ಗಿವ್ ಇಟ್. ಎಸ್. Tuesday or Wednesday, give it. Yes. On vacating stay, yes. Give it, yes. Kodi memo kodi. Modification second respondent kodi. Fresh idre Monday ಬರುತ್ತೆ ಕೊಡಿ. On seniority. Monday. ಆಯ್ತು, ಅದು ನೋಡಿ. ಅದು ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು ಹಾಕಿ ಮೇಡಮ್. ಎಸ್. ಮಂಡೇ ನೋ 2:30. ವೈ? ನೋ ಪ್ರಾಬ್ಲಮ್. ಮಂಡೇ ಎಸ್. ಮಂಡೇ ಮೇಡಮ್. ನೋ ಮಂಡೇ ಎಸ್. ಆಲ್ ಅದರ್ಸ್ ಮಂಡೇ ಗಿವ್ ಇಟ್. 2:30 ಯಾವುದೂ ಇಲ್ಲ ಮಂಡೇ. ವೆಕೇಟಿಂಗ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಮಂಡೇ ಆಗಲ್ಲ. 2:30 ಕೊಡಿ. ಟ್ಯೂಸ್ಡೇ ಆರ್ ವೆಡ್ನೆಸ್ಡೇ ಹಾಕ್ತೀನಿ ಕೊಡಿ ವೆಕೇಟಿಂಗ್ಸ್. ಫ್ರೆಶ್ ಇದ್ರೆ ಮಂಡೇ. ಕ್ಲಿಫ್ಟ್ ಅಂಡ್ ವೆಯ್ಟ್. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಇದೆಲ್ಲ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಮೇಡಮ್, ಒಂದು ಹಾಕಿ. ಗೊತ್ತಾಯ್ತು ಕೊಡಿ. 2:30 KV ಲೋಕೇಶ್ ಇವತ್ತು ಕರ್ಕೊಂಬನ್ನಿ. ಎಸ್. ವೆಯ್ಟ್. ಎಸ್. DRT ಮೂವ್ ಮಾಡಿ ನೀವು. ರಿಜೆಕ್ಟ್ ಮಾಡಿರೋ ಆರ್ಡರ್ ತಗೊಂಬನ್ನಿ ಇಲ್ಲಿ. 2:30. ಎಸ್.
This order with the part of the state government is just supposed to identify the land. They give this order to put orders are. That's the matter stands the order. Sponsors are coming up again.
ಕೊಡಿ. ವೈ ಟುಮಾರೋ? ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಅಲ್ವಾ? ಟ್ಯೂಸ್ಡೇ.
Monday.
Because ಪೌರ ಕಾರ್ಮಿಕ ಅಂತ ಹೇಳಿದ್ರಿ ಅಂತ ಅಷ್ಟೇ. Wednesday. Monday is fresh matter day.
There is a, in another matter, there is already a entry model not taken. But my lord, in files of that order, they have taken. It's maybe listed on Monday.
Monday give it, yes. All right. Monday.
In which
SC/ST order. What do you mean SC/ST order?
no, it's classified as DMREA.
What do you mean SC/ST order? Commissions order ಅಂತ ಹೇಳಿ. Yes.
Connected matter where a sale has taken place by the same, the court.
Monday, Monday. ಡಿಸ್ಮಿಸಲ್ ಟೈಪೋಗ್ರಾಫಿಕಲ್ ಎರರ್ ಇದೆಯಾ? ಕೊಡಿ. ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು ಹಾಕಿ ಮೇಡಮ್ ಎಲ್ಲ. ವಾಟ್ ಎವರ್ ಇಟ್ ವಿಲ್ ಕಮ್ ಗಿವ್ ಇಟ್. ಎಸ್. ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ, ಟ್ಯೂಸ್ಡೇಗೆ ಏನಿಲ್ಲ, ವಿಲ್ ಸಿ. ಎಸ್ ಆಯ್ತು, ಟ್ಯೂಸ್ಡೇ ಹಾಕಿ ಮೇಡಮ್. ಎಸ್. ಮಂಡೇ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್. ವಿಲ್ ಕಮ್ ಆನ್ Tuesday or Wednesday, we don't know. Yes, next. Call the cases.
My lords, with the permission, my lords. My lords, Dharwad list, my lords.
Dharwad list ಇದೆಯಾ?
Please, my lords.
ಯಾವ್ದು
My
ಮೇಡಮ್?
lords, that MRP notification matter, my lords. Wherein
Objections
pleading-
ಹಾಕಿದ್ರಾ?
My lords, no, my lords, not yet, my lords. Seeks another
What
2
is
weeks time,
Girish?
my
What
lords.
is this Girish? ಇಷ್ಟು
My
ದಿನ
lords,
ಯಾಕೆ?
My lords, because the notification is being challenged, my lords, as such, the Paravas comments has to be obtained from the GST True Council, my lords.
All right, ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
My lords, another 2 to 3 weeks, my lords, without fail, I will comply. I will file the statement of objection, my lords.
Learned Counsel Girish Holdmani seeks 2 more weeks' time to file statement of objections. Objections be positively filed on or before the 21st of April 2025, failing which it shall be construed that there are no objections to the petition. Interim order
Please,
subsisting will continue till the next date of hearing.
Much
4 ವಾರ
obliged.
ಕೊಟ್ಟಿದ್ದೀನಿ.
Please, my lords, please.
Yes.
By that
call
time,
the
I
case.
will file, my lords.
Yes.
Much obliged.
Fresh matter still number 1.
That
My
I
lord.
bring for the petitioner in this matter, my lord. So your lordship may kindly see page number 44, my lord. That I have borrowed the loan from the Raghavendra Sahakar Bank, my lord. 50 lakh, my lord. Out of which, my lord, already I have 27 lakh of 23.7 lakh paid, my lord. Only due is 27 lakh, my lord. Your lordship may kindly see page 44 ಅಲ್ಲಿ annexure H. That bank was already seized by the ED, my
ಈಗ
lord.
ಏನ್ ಬೇಕು ನಿಮ್ಗೆ?
Your lordship may kindly that they have issued possession notice, my lord.
Who has issued possession notice?
That bank, my lord. Respondent,
Yes, sir. Mike ತಗೊಳ್ಳಿ.
that respond number 1, my lord.
Wait.
Due is to the tune of 2,89 lakhs.
Anything else, sir?
Now that the bank
I
is
would
not
like to,
sanctioned.
I would like to place.
Anything else, sir? 27 ಲಕ್ಷ ಅಲ್ಲಿ 2 ಕೋಟಿ 2.5 ಕೋಟಿ ಅಂತ ಇದೆ.
Since from 2022, bank is not functioning at all, my lord.
ಅದಕ್ಕೆ ಇಂಟ್ರೆಸ್ಟ್ ಗ್ರೋ ಆಗ್ತಾನೆ ಇರುತ್ತೆ. ಬ್ಯಾಂಕ್ ಫಂಕ್ಷನ್ ಆಗ್ಲಿ ಬಿಡ್ಲಿ, ಡೋಂಟ್ ವರಿ ಅಬೌಟ್ ದಟ್.
ಅವರೇ ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನನಗೆ ಡಿಸೆಂಬರ್ ಅಲ್ಲಿ
ಏನು ಇಂಟ್ರೆಸ್ಟ್ ಇರಲ್ಲ ಅಂತನಾ?
27 lakh ಅಷ್ಟೇ ನೀವು ಕಟ್ಟಬೇಕಾಗಿದ್ದು ಅಂತ ಹೇಳಿ.
ಆಯ್ತು,
My
ಅಬ್ಜೆಕ್ಷನ್.
lords,
I will file.
RBI is impleaded.
Yes, my lords, we have not yet received any instructions. The bank is currently under all-inclusive directives.
Correct, I know that, yes.
So,
We'll post it, list the matter after 3 weeks, interim illala. List the matter after 3 weeks of, no, sir. List the matter after 3 weeks to enable the respondents to file statement of objections. Any proceeding taken up by the respondents during the pendency of the subject petition would remain subject to the result of the petition. Next. Great.
In the meanwhile, possession notice has been issued, my lord.
50 ಲಕ್ಷ ಕಟ್ತೀರಾ?
OTS ಗೆ provision ಕೊಟ್ರೆ ನಾನು kindly.
ಬ್ಯಾಂಕ್ ಫಂಕ್ಷನ್ ಆಗ್ತಾ ಇಲ್ಲ, OTS ಯಾರು ಕೊಡ್ತಾರೆ ನಿಮ್ಗೆ? ಎಸ್. ನೆಕ್ಸ್ಟ್.
20 lakh.
ಯಾರಕ್ಕೆ ಯಾವ ಬ್ಯಾಂಕ್ ಕಟ್ತೀರಾ?
ಅದೇ ಈಗ ಅಲ್ಲಿ function
ಎಲ್ಲಿದೆ?
ಬಟ್ ಅವ್ರ possession notice issue
ಮತ್ತೆ?
ಮಾಡಿದ್ದಾರೆ. Not to precipitate that matter. ಅಂತಂದ್ರೆ ಸಾಕು.
ವೈ ಸರ್? ಪೊಸಿಷನ್ ನೋಟಿಸ್ ಯಾಕೆ ಇಶ್ಯೂ ಮಾಡಿದ್ರಿ?
Notice have been issued.
Bank is
ಸುಮ್ನೆ
functioning.
ಇದ್ರೆ.
Administrator is appointed. Bank is functioning.
Administrators issued the notice now, is
Yes,
it?
my lord. Bank is functioning.
Then let them pay
Let them pay. Let them deposit the.
25 lakhs. ಒಂದ್ ಕೆಲಸ ಮಾಡಿ. The respondent shall not precipitate the matter subject to the condition that the petitioners would deposit 25 lakhs to the bank in the next 4 weeks. In the next 3 weeks.
4 weeks.
3 weeks, list the matter after 3 weeks. Next, yes.
Number 2.
ನಾನು ಅದು ಕೊಡ್ತಾ ಇದ್ದೆ, ನೀವು ಸುಮ್ಮನೆ 77 ಲಕ್ಷ ಅಂತ ಹೇಳಿದ್ರಿ, 2.5 ಕೋಟಿ ಇರೋ ಕಡೆ ಅದಕ್ಕೆ. ಎಸ್, ನೆಕ್ಸ್ಟ್.
They made an application, my lord, seeking interconnection. My lord, if he makes an application, my lord, it will be considered on its merits. He has to make an application before the executive engineer. As far as synchronization is concerned. He is not yet to make an application. Let him make.
Shall we?
Let that be recorded.
Yes,
I'll close it on recording.
yes.
ಅಯ್ಯೇ ಮಾತ್ರ.
ಹಾ.
ಏನ್ ಅಯ್ಯೇ ಹಾಕಿದ್ದೀರಾ?
It's about getting my lord for a unit.
What is the IA for direction? Order on IA for direction.
Yes.
The petitioner has preferred an application seeking a direction to the respondent to consider the case of case of the petitioners for synchronization, is it?
Yes, please.
Synchronize, what, how do you,
Lord, synchronization, my lord.
just synchronization? For synchronization, the learned senior counsel, Shri S. Sriranga, representing the respondent, to submit that if an application is made in the appropriate format, the respondents would consider the same and pass necessary orders in accordance with law. The learned counsel for the petitioner thus submits that if a direction of the nature of the kind is issued, it would suffice for the present. Therefore, the application comes, therefore I deem it appropriate to dispose the application, directing the respondent to consider the application if filed by the petitioner in accordance with law and pass necessary orders and communicate the same to the petitioner.
Letting all the contention open about the writ petition, my lord.
Which
because-
writ petition, ಅದು open ಇದೆ.
Please, my lord.
Order on IA ಮಾತ್ರ ಇದೆ. Yes.
Let that be acceptably said, my lord, because, my lords, we are
All
asking.
contentions would remain open. Yes,
Please,
of both the parties.
as an interim arrangement, my lords,
Post the matter in B group. Next.
my lords, if I make an application within, my lords, 2 weeks, let them consider, my lords.
I'll work on it. In the event the petitioner would make an application in the next 1 week, the respondent shall
From the date
consider
of
and pass necessary orders within 3 weeks thereafter.
weeks, my lord, because, my lords,
Either 2 weeks thereafter, yes.
oblige.
ಅದು ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ post in B group.
Number 3.
Classification, your lordships have ordered to auction the petroleum product.
ಲೀಕೇಜ್ ಏನಾಯ್ತು ಕೊನೆಗೆ?
ಅವ್ರಿಗೆ ಆಕ್ಷನ್ ಮಾಡಿದ್ರು.
ಮಾಡಿದೀರಾ?
Fuel ಮಾಡ್ಬಿಟ್ಟು auction.
Huh?
Last time my learned friend submitted.
ಆಪ್ಷನ್ ಮಾಡಿದೀರಾ?
ಇಲ್ಲ auction ಆಗಿಲ್ಲ because
ಯಾಕೆ?
last time they said that crude oil ತರ ಸೇಲ್ ಮಾಡೋದ್ ಬೇಡ ಅಂತ.
ಹಾ.
For the quality of the it has been sent to the lab. Once the quality report,
Quality report will come 2026.
Right.
What do you do?
2 days, another 2 days it will come. We only need another 8 to 9 days to.
List the
defuel
matter
the matter.
on the 2nd of April in the fresh matters list.
Can I seek for 7th or 8th?
ನೀವು ಕೇಳಿದ್ದೆ 8 days ಅಷ್ಟೇ.
ಹೌದು, but one day this.
You will be responsible for any mishap.
Please, Manoj,
Yes.
please. No, we will defuel.
Defueled.
Defuel ಆಗಿದೆ.
List the matter on, list the matter on 8th on Beda. List the matter on 15th April.
Please.
At the request of the learned counsel appearing for the respondent, who is said to have sent the crude oil sample for the laboratory for its testing with regard to its quality. And it is only then a sale of the said crude oil can take place. Therefore, list this matter on 15th.
Another aspect is with regard to the lorry. Lorry is also similar to getting junked. It is 2022, it has been confiscated.
ತೊಂದ್ರೆ ಇಲ್ಲ.
Meanwhile,
15ರೊಳಗೆ ಏನಾಗಲ್ಲ. 2 ವರ್ಷದಿಂದ ಇದೆಯಲ್ಲ. All weather proof ಆಗಿರುತ್ತೆ. Yes. Next.
season ಆಗ್ಬಿಡು.
ಅದಕ್ಕೆ all weather proof ಆಗಿದೆ.
After the respondent bank, my lord, I was directed to file a affidavit for proof of service of the sale notice. We have provided that, served that on there.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರಾ?
Is out of station, my lord. Kindly press
ಕಾಪಿ
1 week
ಬಂದಿದ್ಯಾ?
time. Copy bandida, my lord. We have to file a
Copy was
Rejoin
served
rent
in
ಅಂತಂದ್ರೆ.
from the court only.
Is there an interim order here? We'll vacate the interim order.
Already sale has
There is an
taken
interim order.
There is no interim order.
place.
There is an interim order.
order.
This is the interim order.
11/3/2024. Amount pay ಮಾಡಿಲ್ಲಲ್ಲ?
Amount pay ಮಾಡಿದ್ದಾರೆ.
20% amount pay ಮಾಡಿದಾರಾ?
Yes, ma'am. But this is covered under the Bafna Bankruptcy case, madam. The sale is taken.
Pay ಮಾಡಿದಾರಾ?
Yes, ma'am.
ಯಾಕೆ ತಗೊಂಡ್ರಿ?
Not fully, my lord.
ಅಲ್ಲ, whatever, then return that money.
Non-compliance, we have filed this thing that.
ಅಲ್ಲ, return that money. Whatever you have taken in
We'll
terms of
return
the
that.
interim order,
We'll return it.
you return that money. You can't keep his money and this money also. Bank ಅಂದ ತಕ್ಷಣ ಏನ್ ಬರುತ್ತೆ ಅದು
We'll return,
ತಗೊಂಡ್ಬಿಡೋದು.
we'll return.
Return the money. We'll see. Yeah, when do you want money?
On 27.
list the matter on 26th in the fresh matters list.
No, my lord, 26th, 27th.
The 27th in the fresh matters list. Next. It is made clear no further adjournment would be granted. In the event no submissions are made, interim order would stand vacated automatically. Next.
Guarantor is before my lords.
Who is before my lords?
The guarantor is the petitioner
Guarantee.
before my.
Yaradre Nanth.
Yes, my lord.
Yes.
My lord, what happened, my lord? Original application was filed before the debt recovery tribunal, my lord,
Hmm.
against the borrower as well as the guarantor, my lord.
Hmm.
Then, my lord, the guarantor immediately approached the jurisdictional police and lodged the complaint regarding the collusion between the bank as well as the borrower, my lord.
Hmm.
Charge sheet came to be filed.
Hmm.
Blue collar notice has been issued against the borrower
Hmm.
because he has defrauded many people, my lord.
Hmm.
Then, my lord, I filed a suit, my lord, to
Hmm.
declare that, my lord, I am discharged from all the liability in the teeth of Madia Chemicals as well as section 133 and 134 of the Indian Contract Act, my lord.
Hmm.
Then the suit came to be rejected, my lord, at the instance of the banker, my lord.
Hmm.
Then I preferred an appeal before this honorable court. This
Hmm.
honorable court came to a conclusion that there is a prima facie case regarding the fraud, my lord.
What
Then
happened? Remand admale enayitu?
Remand admit suit is continuing, my lord. Then I filed an application before the debt recovery tribunal.
Hmm.
Hold the proceedings till the disposal of the suit.
Hmm.
Then that application came to be dismissed.
Hmm.
Then I preferred an appeal before the DRAT.
Hmm.
That appeal also came to be dismissed.
Hmm.
Then I filed a writ petition before this honorable court.
Hmm.
This honorable court observed that both the proceedings shall continue. In the event if the DRT come to a conclusion that there is a liability to be fastened on the guarantor, then the proceeding has to be stalled insofar as the defendant number 9, that is the guarantor, my lord.
Hmm.
At that point of time, when there is a stay, when those proceedings were at that particular stage, my lord,
Hmm.
I filed an application
Hmm.
seeking for the cross-examination of the banker, my lord. That application came to be rejected. Then I filed this writ petition, my lord.
Ah.
My submission is that, my lord, on 2 occasions, this honorable court has come to a conclusion that, my lord, the fraud is the prima facie case of fraud has been made out and collusion between the banker as well as the
Bank yavdu?
sorry, my lord.
Reliance Asset
My
Reconstruction.
lord, that has been assigned from time to time, my lord. When earlier it was Lakshmi Vilas Bank, my lord. That bank was closed. That was took over by the DBS. DBS has assigned the entire their right in favor of the Reliance.
In my assignment, my lord, Lakshmi Vilas Bank, my lord, assigned it in my favor. Yes, my lord.
Now, who do you want to examine?
I want to examine the banker, my lord. I have to cross-examine him.
Lakshmi
That is
Vilas Bank.
Yes, my lord.
Ah.
AW1. I request my lord to
Where,
kindly take
who is that?
the banker, that particular name, my lord.
Hmm.
AW1, my lord. I will just.
AW1 is the name.
No, that is the.
Hmm.
As a witness, he has been. I
So
request my lord.
who objects to that?
Sorry, my lord.
Who is objecting to that?
The bank, the bank is objecting for that.
Which
And they
bank?
have made the
Reliance, yes.
respondent before my lords. And on 2 occasions before this honorable court, my lord,
Hmm.
the banker has made a statement that I have every opportunity, every right to cross-examine and conduct the trial before the DRT proceeding.
No, it is
And
not
then
correct.
this particular, they have opposed before the debt recovery.
My lord, I may permit you to file a
Where
case.
is that?
Yes,
Finding?
Yes, my lord. I will take
Where
my
is
lords
that?
through that particular page number 130, my lord. Page number 130, para 33, my lord. I will just read, my lord,
Hmm.
para 33. She so and so, learned counsel appearing for the defendant number 2, submitted that appeal was not tenable either on law or on facts. It was submitted that OA number so and so was filed against the plaintiff and other defendants on so and so date. Plaintiff arrayed as defendant number 9. Therein had entered appearance was contesting the same. In the said application, evidence of the applicant was recorded on so and so, and as many as 145 documents were marked as exhibits. Instead of seeking permission to cross-examine AW1 and for leading his evidence, plaintiff herein has filed OS number so and so, seeking for certain declaratory relief, which was not maintainable in view of bar under section 34 of the Act. Now, my lord, they filed objection to my application.
My lord,
Having
may I
made
make
that
one submission?
statement.
34 is also connected
and
matter.
after
One
that,
minute. Who instituted OS 688 of 2019?
I have instituted.
OA, my lord, myself.
1 minute.
Suit I have instituted.
Oh, yes.
OS 688 of 2019, you have instituted.
Yes, ma'am.
All right. This, instead of seeking permission to cross-examine AW1
Yes, ma'am.
for leading evidence,
Yes, ma'am.
on whom is this remark?
This remark is on me, my lord.
Ashtata, not on them.
Not on us.
Sorry, yes.
That is the contention. That is their contention. And
That is the
having made,
contention, all right, of the bank.
having taken that contention,
Who is the second respondent is
the banker, my lord.
Reliance Asset.
Yes,
Ah.
my lord. Not only here, my lord. One more proceedings. That is with respect of stay of the proceedings which I sought for.
Yeah, that's all right. Yes, Vignesh, what's
My lord,
wrong?
my lord,
Why are you fighting shy to get cross-examined?
But it's contrary to.
Tell me, why are you fighting shy to get cross-examined?
Contrary to order made by this honorable court division bench, I'll just
ಅದ್
point.
ಕೊಡಿ. Cross-examine ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳಿದಾರೆ.
ಮಾಡ್ಬಾರ್ದು ಅಂತ ಇದೆ.
ಕೊಡಿ.
I'll just point.
ಕೊಡಿ.
But it is not the.
ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳಿದ sentence ಗೆ ಹೋಗಿ straight away.
No, my lord.
Don't beat around the bush. Straight away that sentence.
Give me, my lord.
Straight away that
Give me
sentence.
But I'll just point out, my lord, the sequences in this matter.
Huh?
2010, the my lord borrower availed a loan. My lord, the first my lord kindly see.
You
And
must
2011,
You must be aware that charge sheet was filed against.
Charge sheet not filed against me, my lord. I made a very specific submission before the division bench. I am not aware. That submission, my lord, I made before the division bench also. I was not aware. Maybe charge sheet against my lord, the principal borrower, which I was not aware. My lord, kindly come to my lord, tableau number 5. Petition executed.
You are the assignor now, assignee rather.
Oh,
Yes.
My lord, petition executed, my lord, set of documents in my favor.
Where is the division bench that you should not be cross-examined?
That is, my lord. at
You are
page number
Reliance Asset, right?
36. Munche, I'll just show there, my lord, which is their admitted debt before the DRT. They filed a written statement.
You said division bench has said you should not be cross-examined.
My lord,
Where is
my lord,
that?
I'll just point out, my lord, before the my lord,
No
kindly
history.
come,
Straight away to
kindly
that
come.
sentence first.
Kindly
Amal, I'll let
page
you
number
argue.
49, order passed by the division bench.
I'm at page 37,
Sorry, sir, copy quoted.
36. Tell me.
39, 36 is the my lord.
All right,
40, my lord,
39,
I made
where
a
is it?
submission before the division. What had happened, my lord, I'll just point out. I filed, my lord, original application before the DRT. My lord, DRT, they appeared before the DRT, they filed the written statement and they admitted, my lord, initial loan of rupees 7.5 crore because it is a registered mortgage executed in favor of my lord Lakshmi Vilas Bank. And there, in fact, in respect of 7.5 crore, it is admitted debt. Subsequently, there is announcement wherein, my lord, guarantee, my lord, executed and, my lord, there are set of documents also executed. It is not registered document. Their case is, my lord, subsequent, my lord, there are announcement taken place. I am not the, my lord, a part of it. That is their case. Then, my lord, I parallelly, my lord, I initiated the action. My lord, I'll just point out, my lord, the mortgage deed before this honorable court at, my lord, page number 18. Page number 18 of my set of documents which I filed before honorable court today. My lord, kindly come to, my lord, first para. We mortgage, the very same petitioner executed document, or it is a registered document, my lord, 20th/7/2011 at so and so. And my lord, kindly come to the next page, my lord, the schedule of the property. Very same, my lord, property. Subsequently, what had happened, my lord, in the year of subsequently that account became NP and I filed a suit before the DRT, where, my lord, they filed a written statement. And, my lord, along with, my lord, OA, I initiated action under Surface Act. Surface Act, my lord, they filed a suit before the civil court. Initially, civil court granted an interim order. We appeared, we filed an application under Order 7, Rule 11, read with Section 34. Civil court rejected the petition. Subsequently, they appeared before, they filed an appeal before this honorable court in RFA. RFA said that in view of the Madia, my lord, kindly appreciate the word Madia. Madia is, my lord, only at the context of Surface, not because of, my lord, added fact. In view of Madia, if any allegation on fraud, then civil court has to decide. Then, my lord, matter remanded to civil court. My lord, later, we choose that we will not initiate the Surface Act. We will proceed the matter before the DRT only because the suit is pending from 2015. Suit filed subsequent to that 2019 or 2020. My lord, we pursued the action before the recovery officer, presiding officer. Before the presiding officer, they filed an application for, my lord, stay the proceedings. That, my lord, that honorable civil DRT said, my suit is 2015. Their suit is in the year of 2019. Therefore, suit has to continue. OA has to continue. That, my lord, they assailed before the DRAT. That is at, my lord, page number 28. I'll just read, my lord, from page number 30. Advocate for the appellant submitted as per the plea of fraud and forgery cannot be decided in OA. Appellant filed a suit before the city civil court in respect of documents on the basis of which OA claim is made. He submitted that until the suit is decided, OA cannot be proceeded and for the reason application is filed to stay the OA proceedings, but the tribunal below dismisses that application accepting the objection of the respondent herein that application is not material. He submitted in Supreme Court, in the Honorable Supreme Court in Allahabad Bank versus so and so, report in so and so. Next para. Advocate for the respondent contained that the jurisdiction of the civil court to try the suit filed by borrower against a bank for a financial institution is not ousted virtue of the scheme of RDB Act 1993 and proceeding under RDB Act 1993 will not impeded in any manner by filing a separate suit before the civil court by borrower. To support of his argument, he pleaded reliance of the judgment of the Honorable Supreme Court in the Bank of Rajasthan versus VCK shares so and so. I have perused the material papers on the application IA number so and so. Appellant herein invoked section 22(2)(h) of RDB Act 1993 and section 150 on CPC of claiming relief in the application. It is not dispute that Section 150 on CPC will only apply when there is no specific provisions of CPC for the relief claimed. Here, the condition of the appellant is as already civil suit is filed respect of the same subject matter. OA has been stated. Section 10 of CPC deals with such situation. Even if the judgment relied on the applicant is to be considered at the best. Section 10 of CPC has to be examined to decide whether the relief claimed can be entertained or not. Without accepting the section 10 of the CPC is applicable for argument's sake, and said provision is examined to see whether the same can be applied or not. Section 10, my lord, they reproduced it. And my lord, para 8. Before that, from a plain reading above section, it is clear that where the matter is issue between the same parties, the latest suit has been stayed. Here, admittedly, OA is filed in the year 2015 and the appellant filed a suit in the year of 2019. Therefore, even section 10 of CPC is applied. The later proceedings, which is a suit filed by the appellant, has to be stayed, but not the OA, which is much earlier in point of time. So, as rightly contended by the advocate for the respondent, there is no impediment for the proceeding under RDB in view of the suit filed appellant. On a consideration of a material papers and the judgments relied on both the parties, I am of the considered view that tribunal below rightly dismissed the application is cannot be stay the OA even by invoking section 10. My lord, this order assailed before this honorable court before the division bench, that is at my lord, page number 36. This, my lord, considered by this division bench, my lord, we have argued both the party, we have argued at length. In fact, my lord, whole day we have argued before the division bench.
So what?
My lord, the honorable division bench, my lord, kindly come to page number 39 for a moment. 49. In fact, my lord, the honorable division bench accepted that cross-examination, there is no power under section 22. It's all.
You take me to that sentence I'm asking you. Without that, you're beating everywhere.
Lord, kindly come to my lord.
Take me to that sentence where cross-examination is denied.
May make one submission for that is a.
Don't beg
No,
the question.
not
I'm
a-
asking you,
that is
where
not-
is that sentence?
My lord, the very same word, my lord, we mentioned before the division bench. My lord, it is not recorded. However, my lord, the very same we made a submission. Court said it is not possible. Section 22 is not provides. My lord, I'll just point out, my lord, page number 49 for a moment. In both the circumstances and the above observation, this writ petition is disposed of. Page number 49, my lord, last para. Both the civil court in respect of surface and debt recovery tribunal are requested to try and dispose of the subject cases within an outer limit of 1 year. All the contention of the papers are kept open. This court places on record appreciation of performance of learned counsel for the petition, Mr. So-and-so, and also learned counsel for Mr. Ignition. My lord, honorable division bench said that, my lord, you go before the DRT as well as civil court. And my lord, as far as possible, my lord, the matter has to be dealt. My lord, I'll just point out two things. When this order passed by the division bench, this present writ petition, my lord, today we are arguing pending before this honorable court. The learned counsel would have pointed before the very same aspect before the division bench also. My lord, this petition, he kept it as, my lord, backup. In fact, my lord, he never, my lord, made a submissions in respect of this writ petition.
You should have made.
No, my lord, that I'll
You should have made.
my lord, my lord, in fact, I'll just, my lord,
Our backup father name makeup.
my lord, in
Madbekagitte
fact,
ನೀವು.
when initially the matter came up before this honorable court, it's not the first time, my lord, matter coming before this honorable court.
You should have told the division bench, sir.
My lord, when they are not seeking their relief because
Arre, you said they deliberately did not tell about the pendency of this petition. What were you doing there?
my lord, when they are not interested,
You
their
were not
relief-
aware of
when
this
they are
petition?
not interested, their relief, my lord. In fact,
You should, that should have been your submission.
my lord,
That deliberately they are not mentioning about this.
that is one.
Ah.
My lord, in respect, my lord, now I'm just pointing out two
Mm.
aspects. One, in respect of cross-examination, my lord, kindly point, I'll just point out the order passed by the DRT for a moment. My lord, if my lord permits, my lord, serial number 34 also, my lord, one more petition filed by the very same petition in very same.
Having spent this much time, I will not adjourn it. Tell me.
No, I'm not seeking an adjournment. I'm
Pass over also ಇಲ್ಲ, ಹೇಳಿ.
34, serial number 34.
ಪರವಾಗಿಲ್ಲ, ಅದ್ ನೋಡೋಣ ಆಮೇಲೆ.
Allah, my lord, what had happened in this matter? No, my lord, before the DRT, the matter is posted for argument in the year of 2024. It is not in dispute. My lord, I'll just show the, my lord, DRT order sheet for a moment. There are 10 adjournment taken.
So what?
My lord, kindly see, my lord. I'll just give you. My lord, kindly put in one order sheet. My lord, kindly come page 3.
Yes, sir.
From 13/8/2021, 1, 2.
Hmm.
Thereafter, my lord, total 10 up to 2024 for leading their defend evidence. In this junction, my lord, after matter posted for argument, no, they can't come and say that, my lord, I have to, my lord, do a cross-examination. And my lord, I have to, my lord, take a defense. In respect of, my lord, debt, it is their own admission before the DRT. The Honorable DRT said, my lord, I'll just point out one document before, my lord, I'm concluding argument. My lord, kindly come to page number. DRT order. DRT order. Page number 51. The DRT reasoned it. Why, my lord? Kindly come to page 51 for a moment. The document produced in IA number 418 of 2025 are accepted on record. My lord, what document, my lord, they wanted to, my lord, placed on record, it is taken on record. Subject of proof and relevance, which would be decided at the time of passing a final order OA 173 of 2015 on the document produced along with IA number so and so, certified copy of the forensic report so and so, along with the annexure issued by the Measures Truth Lab Forensic Service Bangalore. A perusal of the same shows that the said documents obtained by the petition as per the request dated so and so from the aforesaid institution, that tribunal has not called an explanation with reference to the same. So far as therefore the relief prayed in IA number so and so premature, hence rejected. My lord, next para. Para number 7, page number 55. Why, my lord, they rejected, my lord, top of the order. So that, my lord, I'll just. Page number 54, my lord, para 5. The question as to when the cross-examination can be permitted before the tribunal came up for consideration before the Honorable Supreme Court in the case of Union of India and others versus Delhi High Court of Bar Association and others. The Honorable Supreme Court, after considering the effect of Sub-Rule 6 and Rule 12, the Debt Recovery Tribunal Procedure Rules 1993, for short, the rules as it stood then held as follows. At the outset, we find out that
That
Rule
is
12,
Apex Court's judgment.
Apex Court judgment. That Honorable Supreme Court says that, my lord,
I've read it, sir.
my lord, it says that all are record. Bank, my lord, nothing oral. My lord, everything will be record. We placed all the records in the year of 2015 before the DRT. It is not in dispute, my lord, they availed a loan. It is not in their own admission, my lord, they executed a mortgage and given the documents in favor of the bank. It is all, my lord, we have placed before the DRT and they filed their defense. And their complete return statement has been taken on record. And now, after taking 10 adjournment for leading their evidence, now, and that matter, my lord, before the Honorable Division Bench, it said that within outer limit of 1 year, that has to be decided. Now they are filing the multiple application. Kindly see how many applications before the DRT now. The intention of the, my lord, the petition is to only drag. From now, it is 10 years. 10 years from the suit, which I filed in the year of 2015. It is said not, my lord, kindly see, there are 10 adjournments. It is not, my lord, OA, my lord, under section
10
19.
years, 10 adjournments.
Allah, my lord, there must be some, my lord,
I'll reason it out.
there are,
No
my lord, this case, my lord, is one of the classic case.
Classic case, that's
My
why
lord,
I'll reason
This
it
is
out.
one of the classic case where, my lord, they are availing the loan and subsequently, my lord, one after one.
Why are you fighting shy of cross-examination? That's all is the question.
My lord,
Why are you fighting shy of Rule 22 or Sub-Rule
law not permits.
Sub-Rule 6 of
When-
Rule 12? That is not an unambiguous embargo. It is discretion.
My lord, it is-
I'll quote the Supreme Court itself,
My lord,
sir.
I'll just continue, my lord, kindly permit me one
Supreme
more.
Court, proviso, go to the proviso of Rule 22.
Kindly come to page 55, para 23 of the judgment.
No, now, I'll answer that.
You ask everybody, no, my lord, after, my lord, deciding the matter by division bench, they would have pointed out to disrespect before the division bench. Now, my lord, after, my lord, division bench pass an order in my favor, now they can't go and file an application after. There are 6 applications pending for the DRT now. The only intention, even though they found, my lord, that would have been the case. They would have challenged that order before my lord, the Honorable Apex Court. They are accepted that order. Now, my lord, filing one after an application before the DRT saying that I have to send the document for forensic lab. That truth report, that report given by somebody, my lord, it has to be summoned. It is not permissible in law. One aspect. Now, my lord, I'll come to the point. There are 90 crore, my lord, as on today outstanding.
I am not on outstanding. I'll tell you one thing. What is being sought is cross-examination. Your submission is that the rules does not permit, Supreme Court says so. It is only on the basis of documents and affidavits filed.
Please.
All right. Now, here is a case where he has alleged fraud. Charge sheet is filed by the police. 1 minute.
Sheet filed against whom?
Lakshmi Vilas Bank is not the accused.
Borrower, I will make myself.
Borrower with whom?
Against the borrower. And the allegation is that collusion with the employees of the Lakshmi Vilas Bank. And they are further investigating into the matter.
All right. So that is pending. It is not in every case this is permissible. We will carve out an exception to be a classic case where cross-examination
That
is
being the case, my
necessary.
lord, kindly take along with serial number 34, one more matter in the very same matter.
Other application.
My lord, what
Other application.
what I did, my lord, I filed an application to produce the expert opinion of the Truth Lab, where there is a fabrication of the document, fabrication of my signature. Truth Lab gave a report saying that, my lord, there is a fabrication of my signature, and that particular report, I placed it on record. And I filed 2 applications to receive that particular report on record, then summon that particular Truth Lab report author who has given this particular report as a witness, and to mark this particular document. This document is taken on record. And then the court has said that it will be considered at the final stage. Now, my lord, under section 45 of the Indian Evidence Act, I have to mark this document, then only it will be exhibited. That particular application came to be rejected, summoning of that particular author. If I have not exhibited, my lord, this particular document will not be considered. And for that reason, my lord, I have filed that particular writ petition. And even that application came to be
ಸರಿ
rejected.
ಅದರದ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗೋಯ್ತು.
My lord, kindly come to page number 60 of their writ petition before this honorable court. Their written statement. I'll just point out.
Sir,
Because
this court, 1 minute.
they
This court for one will not leave anything unturned in the sense examination, cross-examination and all opportunity to whoever it is must be either in criminal law or here. Here the case, ಈಗ truth labs ಇಂದ you have taken that 1 minute.
ನಾನ್ ತಗೊಂಡಿದ್ದಲ್ಲ.
ಅಲ್ಲ ಆಯ್ತು
There is-
ನೀವಲ್ಲ whatever instance he will have to prove his defense.
It is
That
already
is
before the-
forgery has happened. Should he not prove?
It's already before the DRT, my lord.
It is already before the DRT. How can the DRT dismiss that application?
No, my lord. No, DRT
How can
said-
DRT do
No,
that?
my lord, kindly see that DRT said, I'll consider that truth lab report
ಯಾವಾಗ? After everything is over?
at the time of final argument.
Why final argument?
There are, my lord,
1 minute, sir. At the time of final argument, DRT is going to consider this report, oh, this is not forgery. Should not the man who has given that opinion be examined?
my lord, that being the case, my lord, they would have taken up this issue before the division bench when the matter was pending. My lord, kindly see the date of filing this writ petition,
Idu-
not now.
Yes. What is the date of application you filed before the DRT and Truth Labs report date? ಏನು?
Yes, my lord. Truth Lab report date, my lord. 12th February 2025. my lord.
What is the date of the division bench order?
Division bench order, my lord. The 27th January 2025, my lord.
ಅವ್ರಿಗೆ ಕನಸು ಬಂದಿತ್ತಾ?
Lab report ಅಲ್ಲ, my lord. If
ಮತ್ತೆ
this-
ಇನ್ನೇನು?
when this writ petition has been filed before this one.
ಹಾ.
This writ
This
petition
writ
filed-
petition is
this
pending.
writ petition
No
is filed.
problem. All right.
This
You
writ
should have told the division bench, sir.
Lord, my lord,
ಅಲ್ಲಿ absolute silence, ಇಲ್ಲಿ violence.
ನಾನಲ್ಲ, ಅವ್ರು violent, my lord,
ಹಾ.
silent. I was not,
Yes.
my lord, the matter was heard whole day, that
Hmm.
we have pointed out all the
Hey,
aspects.
whole day ಏನ್ ಮಾಡಿದ್ರಿ ಇದೇನಾ?
We have pointed out all the aspects.
You should have
On the-
pointed out this aspect.
My lord, against the division bench order, my lord, SLP has been filed. And they say that they are not aggrieved and that order is in their favor.
SLP in respect of, my lord, the civil, my lord, in respect of that RFA, not, my lord,
Hmm.
we are, in fact, we sought this very same relief from the division bench, which is granted. Why I'll go for SLP against that order? My lord, it's not so. My lord, I'll just point out. This writ
Indian
petition-
point out. Boy pointed out everything.
My lord, the
Yes.
risk petition filed on, my lord, 20th/5/2024.
So what?
This relief
You
would have-
should have told the division bench, sir.
Lord, I'll-
You were aware of this writ petition. What stopped you from telling?
my lord, in
Why
fact,
were you tongue tied
one case,
before the division bench?
one case, which was.
Why?
My lord,
Why?
that issue was something.
You are pointing at him that they did not bring it to the notice. Why did you keep quiet? ನೀವಲ್ವಾ ಅಪೇರ್ ಆಗಿದ್ದು?
ನಾನೇ appear.
ಮತ್ತೆ ಯಾಕೆ ನೀವು ಅಪೇರ್ ಆದ್ರೂ ಹೇಳಿಲ್ಲ ಅಂದ್ಮೇಲೆ ಅದೇನು ಇಲ್ಲ ಅಂತ ಅರ್ಥ.
No, my lord, in fact.
ಯಾಕೆ ಹೇಳಿಲ್ಲ?
In fact, I'll just.
Why?
I'll just point out two things.
Yes, sir.
It will become a kiosk. The reason is this.
Why you did not tell?
My lord, in fact, my lord, they would have pointed out, they're not able to get a relief in before this one.
Leave it, sir. ನೀವು ಹೇಳ್ಬೇಕಾಗಿತ್ತು ಇದೇ ತರ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ರೆ ಇದ್ರ ಬಗ್ಗೆನೂ ಬರ್ಸ್ಬಿಡ್ಬೇಕಾಗಿತ್ತು ಅಲ್ಲೇನೆ.
That being the case, my lord, that writ petition, my lord, against that order passed by the DRT, they gone to DRAT. DRAT, they.
ಎಲ್ಲ ಆಯ್ತು. ಐ ಆಮ್ ಆಸ್ಕಿಂಗ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಮುಂದೆ ವೈ ವರ್ ಯು ಸೈಲೆಂಟ್? ಅದಕ್ಕೆ ಉತ್ತರ ಇಲ್ಲ.
Ella, it's not that, my lord. In fact,
ಏನು?
division bench considered all the aspects.
Sorry, why you did not bring this writ petition pending aspects?
Their writ petition, my lord, they're not interested, my lord, relief.
Hey, why are you bothered about them, sir? You should have bought it.
In this juncture, my lord, they can't ask this relief.
See, that's
My lord, kindly
why,
take-
that's why when you have a difficult case, these things happen.
No.
That's all right.
My lord,
No problem. We'll pass orders.
34 ಜೊತೆ ತಗೊಳ್ಳಿ, ನನ್ನ lord, I have made. some more
34
submission.
ಜೊತೆಗೇನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಲ್ಲ. ಆ 34
But,
ಡಿಕ್ಟೇಟ್
my lord, I have to make some more submissions still on 34.
some more.
My lord,
No time, sir.
My only difficulty is 26th is the date. my
I'm
lord.
going to stay everything there. Yes. I'll stay at 34. Yes.
wait,
ಅಷ್ಟ್ರಲ್ಲಿ ಡಿವಿಷನ್ ಬೆಂಚ್ ಹೋಗಿ ಬರಂಗಿದ್ರೆ ಬನ್ನಿ.
the division bench
Yes,
order they
next.
accepted. Division bench said matter has to decide within a period of 1 year.
Yes, sir.
My lord, they're accepted and coming and filing one more writ petition. It is, my lord, nothing but abusing the process of law. My respect to
Which
submission
writ
before-
petition? 34.
ಅಲ್ಲ, ಹೌದು, ಅಲ್ಲ.
ಡಿವಿಷನ್ ಬೆಂಚ್ ಆದ್ಮೇಲೆ ಒನ್ ಮೋರ್ ರಿಟ್ ಪಿಟಿಷನ್ ಯಾವ್ದು ಹಾಕಿರೋದು?
That 34.
ಯಾಕೆ ಹಾಕಿರೋದು?
ಯಾಕೆ ಹಾಕಿರೋದು?
ಹಾಕ್ಲೇಬಾರ್ದಾ?
It's not so, my lord.
DRT ಏನ್ ಮಾಡಿದ್ರು ಸುಮ್ನೆ ಇರ್ಬೇಕಾ?
Subsequent to that, the honorable division bench said,
No, no.
you have to decide the matter within a period of 1 year.
ಹೌದಾ? ಕರೆಕ್ಟ್.
They-
ನೋ
thereafter
ಪ್ರಾಬ್ಲಮ್.
they filed-
ನೋ ಪ್ರಾಬ್ಲಮ್. ಡಿವಿಷನ್ ಬೆಂಚ್ ಆದ್ಮೇಲೆ ಟ್ರೂತ್ ಲ್ಯಾಬ್ಸ್ ರಿಪೋರ್ಟ್ ಬಂದಿರೋದು. That's why I asked when was the truth labs report?
My lord, I to understand. If the
If you
borrower
understand,
does
then you
not
should not
execute
argue
a
that.
document, borrower said that no point of time I am given a mortgage. Borrower said, my lord, I have not given this original documents to the bank. Everything they are admitting. 2010, my lord, when they rebelled, registered mortgage, otherwise, my lord, that also they would have denied.
See, if you had said, yes, cross-examination ಮಾಡ್ಲಿ ಪರವಾಗಿಲ್ಲ ಅಂದ್ರೆ dispose ಮಾಡಿ time limit fix ಮಾಡಿ ಎಲ್ಲ
My
ಮುಗಿಸ್ಕೊಡ್ತಾರೆ.
lord, they would have
That's the
2022, when the matter gone for defend evidence.
When
that
you,
court would have
when you
filed an
argue on points that are absolutely weak,
My lord,
this is what will happen.
2022, when they
Now I
filed the
can't
defendant
help-
evidence, the
yes.
matter is posted. That time they
Problem,
would have
sir.
filed an application for cross-examination. I
Sir,
don't
if the
understand.
division bench has directed disposal within 1 year, it is not disposal it is disposal in accordance with law, not driving him without any opportunity. That can't be the scene at all. ನೀವು ಅಲ್ಲಿ DRT ಇದೇ ತರ ಗಲಾಟೆ ಮಾಡಿದ್ದೀರಾ, ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
I am not permitted to lead my evidence also. my lord. That
That's
application
not-
is also-
That I pointed out 10 adjournment given by the DRT, my lord, on the record
All
they produced
corona, my lord,
10
because
adjournment.
during Corona, my lord.
24 ಯಾವತ್ corona, sir?
ನಾನು ತೋರಿಸ್ತೀನಿ ಅದನ್ನ. And the court on 2 occasions, my lord, has kept the matter reserved for 2 years. And date is not given, my lord. On one particular date, that particular order was pronounced. Then, my lord, later we have come to know, then we have appeared. I can file the affidavit to that effect also.
You want the affidavit to come?
It's all procedure.
Proceed.
My lord, first and foremost, my lord,
Yes, it's all procedure.
earlier proceedings, my lord, they
Uh,
gone
it
before
is
the
all
DRT, it
procedure.
came
I
to
am
the
also telling the DRT should follow procedure.
My lord,
Truth Labs, see, there is a report of a laboratory that says his signature is forged. All right? That forged signature, opinion of the handwriting expert, whoever has taken should not he be examined?
Lord, the
And
summary
DRT
proceedings-
says final hearing noಡ್ಕೊಳ್ಳೋಣ.
Respect of my lord, National Company Law, DRT, my lord, it's all summary proceedings, where my lord, DRT taken on record, even though.
Exactly. Generally, it is summary proceeding. But exceptionally, when such fraud is alleged, it can't be on the grounded summary proceeding, we can't brush away everything.
Out, my lord, we are assisting. And my lord, account become NPA, all the guarantor will have a same song. My lord-
ಬಿಡಿ. See, same song, whatever it, you're borrowing my words.
I'm
All
so sorry,
right,
I'm so
leave
sorry.
it.
I'm-
No, that's okay. So it may be same song, different song because of the cross-examination being denied. 34 ತಗೊಂತೀನಿ, dictate ಮಾಡ್ತೀನಿ.
Then virtually, my lord, that division bench order will become, my lord,
Division bench, I will write, sir. Division bench said disposal is in a particular period, but not contrary to law in accordance with law. Cross-examination ಬಿಡದೆ ಹೋದ್ರೆ ಇವ್ರಿಗೆ ಹೆಂಗೆ?
that being the case, my lord, I'll just point out, my lord, few dates, which, my lord, they are taken
34.
adjournment before the DRT, my lord,
34.
at this, 30, wait.
Yes.
And one authority from the Supreme Court. in
10
respect-
authorities you give,
Wait.
sir, no problem. Unit, report. ಎಷ್ಟು ದೂರ ಇದೆ?
That it's at 218 meters, my lords. And as per the
ನೀವ್ ಹೇಳ್ತಿರೋದೇನ್
MSW
50
rules-
meters ಅಂತಾರ?
Even adjacent, the lordship can.
Adjacent ಅಂದ್ರೆ ಎಷ್ಟು sir?
Yeah, there are couple of things, my lords, which I just want to bring, my lord.
Lordship again.
ಕೊಡಿ. Give it.
Photos, you know.
There are,
He is giving you the report, waits.
Yes.
one nimsham. That's the MSW rules, my lord, says that it should be of minimum of 200 meters, my lords. And it is at 218 meters on, if you've given a map, my lords. And we're able to show it, and even in the report, we have shown that it's 218 meters.
Look into this.
Now,
Your lordship again, see these photos.
ಅದು
Lord.
ಕೊಡಿ. ಅದು ಅವರು ಕೊಡಿ, ಕಾಪಿ
the
ಕೊಡಿ.
aspect to it, they had to leave buffer zone.
Okay.
In my documents, my lords, if my lords may turn to document number 5 at page number 35. In 2000, I'm sorry, page number 37, document number 6. It's a letter, my lords, dated Feb 2014. You've said that you have to leave buffer zone. And my lords, this particular locality comes in zone 2. Because it's 21 acres, they have to leave buffer zone between 50 to 100 meters, which my lords would get at page number 38. Adu bitilla. Now, my lords, there is some issue with regard to, they are saying that, my lords, this MSW site was not operative. It is their government in their writ petition that MSW site was sanctioned back in the year 2011 and it was continuing. In between, they didn't take permissions and it stopped. So, my lords, going by the circular, they had to take permission in terms of even leaving buffer zone, which they have not left.
Yes,
If
sir.
you had the buffer zone, it would be beyond.
Now, there are new things coming up.
Then I will go through the report.
ಅದಕ್ಕೆ you should go through it.
Please.
Yes. List the matter on Wednesday, Tuesday in preliminary hearing. Next.
Please.
The learned counsel, A. Mahesh Chaudhary files his report in terms of the direction of this court. The same is taken into the file. Next.
7. Appearing for petitioner, my lord. My lord, senior not available, my kindly have it on Monday or Tuesday, my lord.
In counsel for architecture.
Like, their allotment has been cancelled, my lord.
7 ಇದು.
7.
Oh, 7.
Allotment has been
Cancel ಆಗಿದೆಯಾ?
cancel ಆಗಿದೆ.
Interim order ಇಲ್ಲಲ್ಲ.
Interim order ಇದೆ ಅಂತ.
Interim arrangement subject to further orders, respondents directed not to allot to anybody else.
10 years, my lord, they have not paid the balance consideration. Kamalale, relying on Kamalale.
Yes.
Same case.
Yes, madam.
Sir, may I have it on Monday or Tuesday? my
List the
lord?
matter on Tuesday in the fresh matters list as a last chance. Yes.
Pleasure, my lord.
Grateful.
My
Next.
request for Wednesday, my lord.
ಆಯ್ತು witness. Next.
Oblige, my lord.
8. Preparing for the first one.
For the petitioner.
Instructed to file my statement of objections, my lord. I seek a week's accommodation.
ಅದು ರೆಡಿ ಇದೆ ಅಂತ. ರೆಡಿ ಇದೆಯಾ ಇಲ್ವಾ?
Ready, ಕಳ್ಸಿದೀವಿ ಸ್ವಾಮೀಜಿ.
My lords, already this matter was heard by my
Just
lord
weeks ago.
earlier and passed an order to take action about 12 weeks. They don't take any action for next 12 months. That is when the petitioner writes an email saying that I will be forced to initiate contempt proceedings. Aವಾಗ urgent ಓಡ್ ಹೋಗಿ ಒಂದು decision ತಗೊಂಡು they reject it on the same grounds. But the registrar of the Switzerland University agrees and says they both are doctrine of technical science and doctrine of science are both same.
Doctrine.
Sorry,
Doctrine.
doctorate,
Yes.
doctorate of technical sciences, doctorate of science are both are same. Now as
ಆಯ್ತು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕ್ಲಿ ಬಿಡಿ ಬೈ ಹಾಕ್ಬಾರ್ದ?
A week's
10
accommodation.
ವರ್ಷ ಆಗೋಯ್ತು the student is suffering my lord for no mistake of his.
What to do? This is 2024.
21 also he had filed a
Learned CGC Reshma KT seeks Reshma Tamaya seeks a week's time finally to file statement of objections. List the matter on Friday, the next in the fresh matters list. In the event no objections would come about, it shall be construed that the respondent has no objections to the petition. Yes. Next.
My lordship is in this matter. saying
Pass over. Yes.
says
Yeah, Lord.
personal
No
inconvenience.
adjournment, only pass over. Ilder I'll vacate the interim order now. Kodil.
Yesterday in this
I'll
matter,
vacate the interim order now.
my lordship, senior is the personal inconvenience. That
Yaar
is the
senior?
Vikram Muligod.
ಈಗಿದ್ರಲ್ಲ ಇಲ್ಲಿ?
ಇಲ್ಲ, personal inconvenience. Tomorrow.
Tomorrow, fresh
Okay.
matters list.
Oblige.
Tomorrow, my lord, I am not in station, my lord. Monday.
Tuesday in fresh matters. list.
Interim order extend, my lord.
Yes, next.
10.
Your lordship,
If
cross
you
the
have for the
three such
petitioner, my lords, we have filed our statement of objections.
To the vacating stay application.
Yes, my lords. My lords, senior counsel is held up in the Honorable Supreme Court. He's arguing Court Hall 7 right now.
Court Hall
My lord,
7.
yes.
How am I concerned about it? Wherever is
My lords may kindly pass over.
Don't tell me all this.
Your lordship.
Pass over, yes.
11.
For the petition, my lordship,
Yes, grant to
since 2014,
Weeks time, my lord.
2 weeks, have I?
my lordship, already copy has been served in
So what, sir?
5, 2020.
2017, you're also silent. Wait. Court ಬಂದ ತಕ್ಷಣ don't project urgency. I'll dismiss it on the ground of delay. 2017 grant you're seeking in 2024. So ಬರೋವರೆಗೂ wait ಮಾಡಿ.
It to be.
The learned counsel Shanti Bhushan seeks 10 days time to secure instructions and make his submissions with regard to the 50,000 grant. Yes. List the matter on 4th April. Yes, next.
Petitioner by me, my lord.
Request for a
Lord.
pass over, my lord.
Bank and the government, my lord, first lien is by the petitioner bank. Subsequently, my lord, under Butts Act, my lord, notification has been issued and auction notice has been.
The competent authority or party.
But Zactal competent authority, yaru.
APID no ಇದೆ, section 9.
Then make them a party and Viresh Budihal to take notice.
Please.
Learned counsel of the petitioner seeks leave of this court to implead the competent authority as a party respondent to these proceedings. The permission so sought is granted. The same shall be impleaded as respondent number 5. Viresh Budihal is directed to accept notice for the 5th respondent Petitioner to serve set of papers upon the aforesaid council next Thursday.
Interim order.
Interim order sub next Thursday and preliminary hearing. Interim order subsisting will continue to the next date of hearing. Next.
Producing the photographs and the
For what, sir?
ಅದು CCTV ತೆಗ್ದಿದ್ದು ಬುಕ್ ಎಲ್ಲ ತಗೊಂಡೋಗಿದ್ಕೆ
Your lordship,
furnished
ಕೊಡಿ,
the
ಕೊಡಿ
copies
ಅದು.
of the
ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ. Your lordship, this contempt proceedings which they have initiated, there the officer has filed an affidavit stating that what occurred. On an information, he has gone near the premises to find out if there was illegal activities. If there were any, to check if there were any illegal activities. So subsequently, the station dairy also he has made an entry and he has come back after that. So no case being filed, nothing. So there is no sort
That's
of.
all right. What is this seizure of CCTV?
There's no seizure in the contempt petition itself. The same allegation was made and an
What happened to the contempt?
Contempt is still pending.
ಕೊಡಿ ಏನದು?
ಅವರೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ, affidavit ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ತಗೊಳ್ಳಿ.
Lordship, come to the photographs where they are.
Your lordship, page number 16, contempt proceedings where complaints affidavit has also been filed by the officer and clearly.
Sir, who is
mentioned-
the officer here? Is the man, is it?
Yeah, Mohan. And
ಫೋಟೋದಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 39 ಮೇಲೆ CCTV ಎತ್ತು ತೆಗಿತಾ ಇರೋದು.
ಯಾರು ತೆಗಿತಾ ಇರೋದು ಇದು?
ಅದು CCTV ಮೇಲ್ಗಡೆ ಹಾರ್ಡ್ ಡಿಸ್ಕ್ ತೆಗಿತಾ
hard disk check ಮಾಡಿ ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಲ್ಲಿ.
ಇಲ್ಲ, ಇಲ್ಲ.
That we have mentioned in the affidavit. And we'll file an undertaking that no interference will be done. If there's any illegal activities, because the order says unlawful activities, action can be taken.
ಈಗ ತಗೊಂಡಿದ್ದೆಲ್ಲ ಎಲ್ಲಿದೆ?
CCTV ಏನ್ ತಗೊಂಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಏನೇನ್ ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ?
CCTV, ಲೆಡ್ಜರ್ ಬುಕ್, ಮೆಂಬರ್ಶಿಪ್ ಬುಕ್ ಎಲ್ಲಾನು ತಗೊಂಡೋಗ್ತಾ ಇರೋದು ಫೋಟೋ ಪೇಜ್
ಇಲ್ಲ, membership.
ಎಲ್ಲಿದೆ ಎಲ್ಲ?
ಮೆಂಬರ್ಶಿಪ್ ಬುಕ್ ಏನಿಲ್ಲ ಸರ್.
ವಾಪಸ್ ಕೊಡ್ತೀರಾ ಇಲ್ವಾ ಅದನ್ನ?
It's not ಸೀಸ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. It's not been seized.
What illegal activity was going on here?
No, there was an information, credible information that they were playing game of chance. And
Andar bar skill
the
ಅಂತ
order was
ಬರ್ದಾಗಿದೆಯಲ್ಲ.
clear, Swami. The coordinate bench order was also very clear. Adna, it was very clear that game of chance ಆಡಂಗಿಲ್ಲ.
ಎಲ್ಲಿ ಹೌದಾ? ಜಸ್ಟಿಸ್ ಕೃಷ್ಣ ಕುಮಾರ್ ಅವರು.
ಹೌದು.
ಬನ್ನಿ ಅದಕ್ಕೆ ಪೇಜ್ 35.
ಹೌದು.
ಆಡಬಾರ್ದು ಅಂತ ಬರ್ದಿದಾರಾ?
ಹೇಳಿದ್ದಾರೆ.
ಎಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ?
Your lordship, the petitioner shall not permit any activity by any of its member by including in acts of amusement falling within definition of so and so, and shall not permit any games of chance as explanation. So
That is common order which we pass in recreation matters.
no, but
Undertaking ಹಾಕಿ ಈಗ.
undertaking act is.
And ಏನ್ ತಗೊಂಡಿದ್ದಾರೆ
No, your
ವಾಪಸ್
lordship,
ಕೊಡಿ.
ಅಲ್ಲಿ ಏನ್ ಸೀಸ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. It's just an allegation. It's just an allegation.
ಈಗ ಏನೇನ್ ತಗೊಂಡಿದ್ದೀರಾ ಇದ್ರೆ ಅದು ವಾಪಸ್ ಕೊಟ್ಟು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಡಿ that you will not interfere unless
ಆಯ್ತು.
warranted. Yes.
Let them open the premises.
Your lordship, we have not sealed it, Swami. Let
Let
the court commissioner be itself.
ಓಪನ್
Your lordship, ಅವರೇ ಕ್ಲೋಸ್ ಮಾಡಿದ್ದಾರೆ.
1 minute, sir.
ಓಪನ್ ಮಾಡೋರು ರೌಡಿ ಶೀಟ್ ಓಪನ್ ಮಾಡ್ತೀನಿ ಅಂತಾರೆ, ಅದಕ್ಕೆ ಎದುರು ಅವ್ರು ತೆಗಿಯಕ್ಕೆ
You open up and continue your activities.
Please,
They will not
They
interfere.
are not interested.
And they will file an undertaking that they will not interfere.
Please.
ನೀವು ಬೇರೆ ಏನಾರು ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ
ಬೇರೆ ಏನಿಲ್ಲ, ಒಂದು 6-7 ಜನ, ಅದು ಹಳ್ಳಿ, ಅದು ದೊಡ್ಡ ಊರು ಅಲ್ಲ, ಅದು
ಹಳ್ಳಿನ
ಗೂಳೂರ್ ಹತ್ರ ಒಂದು.
ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
ಗೂಳೂರ್ ಹತ್ರ
ಬೆಂಗಳೂರು ಅಲ್ವಾ?
ಅಲ್ಲ, ಗೂಳೂರು.
ಅದು ಎಲ್ಲಿದೆ?
ಗೂಳೂರ್ ಹತ್ರ ಒಂದು ಮೇನ್ ರೋಡ್ ಅಲ್ಲಿ ಇದ್ ಮಾಡಿದ್ವಿ.
ಗೂಳೂರು ಎಲ್ಲಿ ಮೇಡಮ್? ತುಮಕೂರು.
ತುಮಕೂರು ರೂರಲ್.
ಯಾವಾಗಲೂ ಒಂದು 7-8 ಜನ
file an affidavit, betting activities ಮಾಡಲ್ಲ.
18 ಜನ ಬಂದವ್ರೆ.
ಈಗ ಅವ್ರು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಡ್ತಾರೆ, ನೀವು ಒಂದು ಅಫಿಡವಿಟ್ ಹಾಕಿ,
Please.
ಎರಡು ರೆಕಾರ್ಡ್ ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡಿ,
ಆಯ್ತು.
ಇನ್ನೊಂದ್ಸರ್ತಿ ಅವರು ನಿಮ್ ತಂಟೆಗೆ ಬರಲ್ಲ, ನೀವು ಚಾನ್ಸ್ ಎಲ್ಲ ತಗೋಬೇಡಿ.
ಅಲ್ಲ, ಚಾನ್ಸ್ ಎಲ್ಲ ವಿದ್ಯೆ, ಒಂದು 6-7 ಜನ ಕುಂತ್ಕೊಂಡು ಏನೋ ಆಡ್ತಿರ್ತಾರೆ. ಎಲ್ಲ ವಯಸ್ಸಾದವರು, ಎಲ್ಲ 65 ವರ್ಷ 70 ವರ್ಷ, ಅವರು
ಆದ್ರೆ ಏನ್ ಬೇಕಾದ್ರೆ
ಎಲ್ಲ ಏನೋ ಬಂದ್
ಟೈಮ್
ಪಾಸಿಗೆ ಬಂದಿರ್ತಾರೆ, ಅವ್ರನ್ನ ಎದುರಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅವರು ಎಲ್ಲ ಕೈ ನಿಂತಿದ್ದಾರೆ ನೋಡಿ.
Photographs
ಫೋಟೋದಲ್ಲಿ.
Not interfere, your lordship. If any
ಫೈಲ್
legal
an undertaking.
ಆಯ್ತು.
ನೀವು ಹಾಕಿ, ಅವರು ಹಾಕಿ. ಮತ್ತೆ ಈ ಇಶ್ಯೂಗೆ ಕೋರ್ಟ್ಗೆ ಬರಬಾರದು. That you file it.
ಏನಕ್ಕೆ ಅಂದ್ರೆ ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಇವ್ರು ಇದು
That
ಮಾಡಿದ್ರು
you
ಅದನ್ನ
file it, that will close the contempt.
ಆಯ್ತು.
also. File it.
Please.
Your lordship may have this on Wednesdays.
ಆಯ್ತು, Wednesday in the fresh matters list. By then, both of you file.
ಆಯ್ತು.
That will result in closure of the contempt also.
Much obliged.
14 part in person.
13%.
Yes, my lord, I am party in person, Pramod Kumar Thakur.
ಯಾರಿದು ಇಂಡಿಯನ್ ಓವರ್ಸೀಸ್ ಬ್ಯಾಂಕ್ ಯಾರು ನೋಡಿ ಮೇಡಮ್?
My lord, this is challenging one regulation number.
Oh, this is pension regulations.
Yes, my lord.
Yes, sir.
But my lord, I have seen so many cases, but there is no similar case on similar ground.
I will give you, sir. No worry. Yes, anything else? Regulation 22 is, where is Divya?
My lord, there is no
IOB appear ಆಗ್ತೀರಾ ಮೇಡಮ್? ಇಲ್ವಾ? ಯಾರು? ನೋಡಿ, ಇದು ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಇದು. It's not ಸರ್ಫೇಸ್ ಅಲ್ಲ. Regulation 22. Anything else, sir?
My lord, please post this case so that I can present my.
Present now, sir.
Now. Yes, my lord. Actually, they have claimed that this is made under some power taken from.
You
banking.
are an employee of the bank?
I was now dismissed.
Dismissed employee. You are dismissed, is it?
Yes, my lord, now
So,
dismissed.
that's why Regulation 22 challenge.
Yes, my lord, I was not aware of this. Now they are
When were you dismissed, sir?
dismissed 23, 2 years back.
2 years back. You are not aware of the pension regulations.
Yeah, but I sought the pension regulation in Chennai High Court because I was dismissed at Pondicherry. But after going through all these things, there is one regulation 22 which is denying pension to
Correct.
dismissed employee. So then
Regulation 22 did not spring yesterday, sir. Regulation 22 was pursuant to a settlement on 29/9/1993. That's a settlement. Afterwards, the regulation,
Yes,
which
ma'am.
comes about on 29/9/1995. After that, there are at least 10 high courts which have considered the purport of this, including the 2 judgments of the Supreme Court, which considers this whether the forfeiture of past service is correct or wrong. Dismissal, removal, resignation. All 3 categories, past
Yes.
service goes away.
Yes, my lord, that is there, but I am challenging this
You can't, sir. Nothing.
on the ground of constitutional provision, Article 20.
300A.
300A, 19, 20, 21, 14, and some other thing also. They have taken the power from Banking Acquisition and Transfer of Undertaking Act. There
Correct,
is
sir.
no such power.
No. It is, regulations are framed under section 19 of the Banking Companies Acquisition and Transfer of Undertakings Act 1969. Power is there to frame the regulations. No power to frame it. It comes about pursuant to a settlement.
Yes, my lord.
Statutory settlement. When did you join the bank?
But
When did you join the bank?
92, my lord.
Settlement was just then coming about. You were still a novice there.
But my lord, that power is not given by that Acquisition and Transfer of Undertaking
No
Act.
problem,
It is
sir.
clearly
Yes.
written
Anything
there.
else? Anything else, sir?
It is clearly written there, my lord, that
Yes.
they can manage the funds. They cannot take away the pension. They cannot
Anything-
forfeit the service. There is no such power given by that act.
We'll answer that. Anything else?
My lord, there are 16 grounds I have mentioned.
We'll consider all that. Heard, dismissed. Next.
My lord, can I withdraw in that case?
Withdraw. Withdraw you want. File a memo.
Because I don't know what is the.
File a memo. Yes.
Thank you, my lord.
Yes.
My lord,
Next.
eligibility, my lord, the respondent number 5 does not have eligibility to be passed in a technical bid, my lord. Even as per another clause also is ineligible, my lord.
60 lakhs.
Yes, my lord. Not only that, my lord, he has produced the documents from private firms. The condition stipulates that, my lord, it should
Stay
have-
ಕೊಟ್ಟಿಲ್ವಾ?
Stay ಕೊಟ್ಟಿದೆ. Stay there.
ಇದೆ.
Stay there.
ಅಲ್ಲ ಇದರಲ್ಲಿ
ಅಲ್ಲ, and one more-
the documents which I have uploaded. ಅದು ಏನಿದೆ ಅವರು ಕೊಟ್ಟಿದ್ದಾರೆ, for easy reference I am producing it.
It is.
What are the two grounds, Vinod Kumar, you said?
ಎರಡೇ ಗ್ರೌಂಡ್ ಇರೋದು ಸ್ವಾಮಿ.
ಅದೇ ಇರದೇ ಅದು ಹೇಳಿ ಅವ್ರು.
Yes. My lord, why the conditions are stipulated to see that the person who bids the document should have capacity. He has excellent.
ಗ್ರೌಂಡ್ ಯಾವುದು ಹೇಳಿ
Yes.
ಅಷ್ಟೇ.
My lord, he doesn't have 60 lakhs annual income. So my lord.
That is the stipulation in the tender.
Yes, my lord.
All right,
Lordship may
next.
kindly see page number 23, my lord. Experience.
Next ground.
My lord. And your lordship may kindly see page number 125. 124, 125.
Ground ಹೇಳಿ next, sir.
Yes, my lord. Yeah, the documents produced by him. And
Next
next round is for the very same person has submitted his bid in Bangalore.
That is
South.
rejected on annual income,
Yes, my lord, it's less than.
60 lakhs.
Yes, my lord. And even my lord, the documents produced by him, my lord, is pertaining to private firms, my lord.
Private
He
firm.
should have 5 crores annual turnover. He has not produced any documents.
Where is that condition in the tender?
That is in page number 23, my lord.
20?
23, my lord. 23 nadi 6 Roman 6. Experience. That transporter should, may I read my lord? That
Annual turnover of 5 crores and above registered on the Companies Act Society. You have that?
yes, I have, my lord. I may be permitted to produce the documents, additional documents, whatever I have produced. I have.
One minute. That is one ground.
Yes.
Bidder's annual turnover must be 60 lakhs and above from the transportation activity itself.
Yes, my.
All right. Amala.
And what is transportation activity is mentioned in page number 120, my lord. That says it should be food, my lord. 120, your lordship, corner, my lord.
I'll
The
work on it.
bidders. It should be,
Clarification.
yes, my lord. Food. And
ಈಗ-
what is food has been defined by.
What is
Honorable
food?
Supreme Court. Yes, food ಏನು ಅಂತ ಹೇಳಿದ್ರು.
All right.
Animal feed is not food ಅಂತ ಇದೆ, my lord. May I submit, my lord? The judgment of.
Food is not food.
ಅಲ್ಲ, animal feed.
Animal
Transportation-
feed is not food.
Not food ಅಂತ ಇದೆ. And my lord, what he has supplied, my lord, agricultural equipments and fertilizers. My lord, what happens, my lord? A person who transports fertilizers in the same vehicle, if he transports food, what will happen? There will be.
You have
it will cause-
transported only food
Yes,
grains.
yes, food. I have produced, I may be permitted to produce the documents, additional documents, which was, I have only supplied a PDF articles, my lord.
Well, I have also, I have produced, just now I have produced documents, my lord. Kindly see my documents, I have produced only the food grade.
What I have extracted
One
from
minute.
their
See-
bid itself, sorry.
minutes.
ಅಲ್ಲ, bid
Even-
ಇಂದಲೇ ತಗೊಂಡೆ.
ಈಗ 3 things. 5 ಕೋಟಿ ಇದೆಯಾ ಟರ್ನ್ ಓವರ್?
ಕೋಟಿ ಇದೆ. ಅವ್ರು ವೆರಿಫೈ
ಒಂದ್ ನಿಮಿಷ.
ಮಾಡಿ
60 ಲಕ್ಷ ಇದೆಯಾ ಆನ್ಯುವಲಿ? ಇಲ್ಲ ಅಂತ ಹೆಂಗ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
ಅವ್ರು ವೆರಿಫೈ ಮಾಡಿದ್ದಾರೆ. ಟೆಂಡರಿಂಗ್ ಅಥಾರಿಟಿ ಅವ್ರು ವೆರಿಫೈ ಮಾಡಿ
ಬ್ಯಾಂಗ್ಳೂರ್ಲಿ ಯಾಕೆ ರಿಜೆಕ್ಟ್ ಆಯ್ತು?
ಬೆಂಗಳೂರಿಗೆ ಅದನ್ನೇ ಅವ್ರೇನು ಒಂದ್ ದಿವಸಕ್ಕೆ ಅವ್ರು ವೆರಿಫಿಕೇಶನ್ ಕಳಿಸಿದ್ರು. ಅವ್ರು ಒಂದ್ ದಿವಸಕ್ಕೆ ಅವ್ರು ಕೊಡಕ್ ಆಗ್ಲಿಲ್ಲ. ಅದಕ್ಕೆ ಅದನ್ನೇ ನಾನು ರಿಟ್ ಹಾಕಿದೀನಿ, ಸ್ಟೇ ಇದೆ ಅದು. ಅಂಡ್ ಆಸ್
Which is that writ ಕೊಡಿ? Government is generating food grains litigation. ಏನು ಸರಿಯಾಗಿ ನೋಡಲ್ಲ.
ಕೊಡ್ತೀನಿ ಸರ್.
ನಂಬರ್ ಕೊಡಿ.
ಹೀಗೆ ಕೊಡು.
My lord, and. what
ಲಾಸ್ಟ್
is
ಟರ್ಮ್
trans-
ಇದ್ದಾಗ ಫಿಶಿಂಗ್ ಪ್ರಾಬ್ಲಮ್ ಇತ್ತು. ಈ ಫಿಶಿಂಗ್ 5 years ಆಗೋಗ್ಬಿಟ್ಟಿದೆಯಲ್ಲ, ಸುಮ್ಮನೆ ಇದಾರೆ ಎಲ್ಲಾರು.
Lord, 125 your lordship.
ಈಗ ಇದು ಫುಡ್ ಗ್ರೈನ್ಸ್ ಪ್ರಾಬ್ಲಮ್.
ಅದು ಫುಡ್ ಅಲ್ಲ, ರಾಸಾಯನಿಕ ಗೊಬ್ಬರಗಳು ಮತ್ತು.
ಅಲ್ಲ, ರಾಸಾಯನಿಕ ಗೊಬ್ಬರ
ಕೃಷಿ
ಅದ್ರ ಮೇಲೆ
ಪರಿಕರಗಳು.
ರಿಲೇ ಆಗ್ತಾ ಇಲ್ಲ.
2 ನಿಮಿಷ ಸರ್. ನಂಬರ್ ಕೊಡಿ.
That I'll furnish.
Give the number. Tag this petition along with so and so. ಇದೇನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದ್ದಾರೆ ನೋಡಿ, ಎಕ್ಸ್ಚೇಂಜ್ ದಿಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
ಅಲ್ಲ,
Please,
ಅದು ಕೊಟ್ಟಿದ್ದೀನಿ.
I have given.
Samanth, just go through it.
In fact, my lord, there are 50 matters totally from this arising out of this tender.
Food grains.
50 ಟೆಂಡರ್ ಮೇಲೆ ಸ್ವಾಮಿ.
50 out of this
ಎಷ್ಟು?
exact document.
ನಿಮ್ದು ಇದೆಯಮ್ಮ?
15.1, 2 and 3.
There is addendum, madam.
What addendum?
Addendum, they said that, you know, ಇಲ್ಲಿ ಫಸ್ಟ್ ನೋಟಿಫಿಕೇಶನ್ ಎನಿ ಟ್ರಾನ್ಸ್ಪೋರ್ಟೇಷನ್ ಅಂತಿತ್ತು. ಅಡೆಂಡಮ್ ಬಂದು ಬರೀ ಫುಡ್ ಅಂತ ಇನ್ಸರ್ಟ್ ಮಾಡಿದ್ರು. ಅಂಡ್ ಅಡೆಂಡಮ್ ಇಶ್ಯೂ.
Addendum was issued prior to, before the last date of receipt of tenders.
after the last date. Kindly see,
No, what was the last date, sir?
last date was 9,
Initially the 6/9 is the last day.
Last date ಏನು? ಎಲ್ಲ ನೋಟ್ ಮಾಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು. ಎಲ್ಲಾ ಪೇಜ್ ಇಲ್ಲಿ ತಿರುಗಿಸ್ತಾ ಇದ್ದೀರಾ.
Initially last date is 9/9.
Originative is my lord 10/9/2024.
9 is.
We'll stop granting interim orders if you have not looked into the papers and come.
9/9 is the last date for the initially. 9/9 is the.
Last date ಏನು ಟೆಂಡರ್ ಸಬ್?
Thereafter they
9/9.
have issued the corrigendum and thereafter last date is the 19/9.
ಅಲ್ಲ ಕಾರಿಜೆಂಡಮ್ 9/9 ಮುಂಚೆ ಕೊಡ್ಬೇಕಿತ್ತು ಅವ್ರು ಕೊಟ್ಟಿದ್ದೆ 10/9 ದಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ರಾಂಗ್.
ಒಂದ್ ನಿಮಿಷ. ಟೆಂಡರ್ ಡೇಟ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದ್ರು ಇಲ್ಲ ಕಾರಿಜೆಂಡಮ್ ಆದ್ಮೇಲೆ?
ಅಲ್ಲ ಕಾರಿಜೆಂಡಮ್ ಆದ್ಮೇಲೆ
ಕಾರಿಜೆಂಡಮ್ ಆದ್ಮೇಲೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದ್ರು ಇಲ್ವೋ?
10 days ಮಾಡ್ತಾರೆ,
ಸೊ
15 days ಮಾಡ್ಬೇಕು.
ಸೊ ವಾಟ್? ಕಾರಿಜೆಂಡಮ್ 15 days ಬೇಕಾ? ಸರ್ ನೀವು ಮಾಡಿದ್ರೆ ಒಂದ್ ದಿವಸದಲ್ಲಿ ತಂದು ಕೊಡ್ತೀರಾ, 15 ದಿನ ಬೇಕಾಗಿಲ್ಲ. If you are really eligible in a tender, pursuant to a tender, it's not that you should wait for 10 days.
Anyhow, in
1 ನಿಮಿಷ, 60 lakhs turnover, it is on record. ಅದನ್ನ ಅವತ್ತು ತಯಾರು ಮಾಡ್ಬೇಕಾಗಿಲ್ಲ, ಅದನ್ನ ಕೊಡ್ಬೇಕು. 5 crores
ಅದು ಇದೆ,
ಅದು ಕೊಡೋದು ಅಷ್ಟೇ, ದಟ್ಸ್ ಆಲ್.
ಕೊಟ್ಟಿದ್ದೇನೆ.
ಅದು 10 days ಏನಾದ್ರೂ one day ಆದ್ರೇನು?
I have given everything. In this matter, I am not relying upon that also. I have supplied only food grains, more than 5 crores I have supplied. I have produced every documents.
ಈಗ ಎಲ್ಲಾದ್ರಲ್ಲೂ ಸ್ಟೇ ಇದೆಯಾ ಅಲ್ಲಿ?
Work order also issued and they are working also, madam.
Give all the food grains matters you have.
I'll
Just
place
make
it-
a
I'll
list of
place it.
all of them and we'll post everything on one day.
Yes.
Yes.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಾಗ್ತದೆ, 3 ತಿಂಗಳಾಯ್ತು ಸ್ವಾಮಿ. In
not
spite of I am L1, he is the earlier bidder. He is
List ma-
continue to work.
I'm not the
I am
earlier bidder.
suffering.
No, my lord, false submission. I'm not the earlier bidder. I'm not.
Yes. We'll post it on Wednesday.
Yes, ma'am.
ಅಷ್ಟಲ್ಲಿ ಸಿಗುತ್ತಾ?
ಸಿಕ್ಕತ್ತೆ.
On Wednesday. Objections ಯಾವುದು ಒಂದರಲ್ಲಿ, if the grounds you know, there are similar grounds. You get ready with the grounds and come, I will pass, will consider them.
Please, ma'am.
Yes. Then we'll list them all on Thursday.
Thursday. ma'am.
Yes.
Interim order.
List this matter on Thursday along with all connected cases concerning the tender for transportation of food grains. Yes, next.
My lord,
Interim order subsisting will continue till the next date of hearing.
order, my lord, there is, ಇದ್ರಲ್ಲಿ ಆನ್ಲೈನ್
ಅಲ್ಲ ಅಲ್ಲಿ ವರ್ಕ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಿದಾರೆ ಸ್ವಾಮಿ.
ವರ್ಕ್ ಆರ್ಡರ್.
If something goes wrong, work order cancel ಆಗುತ್ತೆ ಅಷ್ಟೇ. Until then let him work.
ಅಲ್ಲ
List on Thursday is next.
interim order.
Interim order ಇದೆ ಅಲ್ವಾ? ಮತ್ತೆ
Work order shall be-
ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ಕರೆಕ್ಟ್ ಮಾಡಿದ್ನಲ್ಲ ಅದನ್ನ
ಒಂದೇನೇ ಇತ್ತು.
ಕೊಡಿ ಅದು. Shall issue, shall not ಆಗಿದೆ, not ಹೋಗಿದೆ.
Not marks.
ಲಿಸ್ಟ್ ಕೊಡ್ಲಿ Thursday. ಅದಕ್ಕೆ ಮುಂಚೆ ಅವ್ರಲ್ಲಿ post it on Friday, ಅದಕ್ಕೆ ಮುಂಚೆ ಕೊಡ್ತೀರಾ?
Give it today, Manoj.
Yes,
Today or
we'll give
tomorrow?
it. Don't worry.
Today or
Yes. No, these things should be set right. This food grains, your food and civil supplies
That
department
one
should be.
condition is causing a lot of issues.
Which one?
That 60 lakhs, my lord, out of only food grains. That is what is causing a lot of issues. Most of the matters relate to that itself. And the
No,
content.
that's a condition in tender that looks valid. Because if somebody is transporting manure and the man has only experience of transporting manure, he will transport food grains also like he transports manure.
What's happened there is, my lord, this court is eventually, my lord, relaxed that condition. We've gone ahead, my lord, and issued work orders also in quite a few matters.
Anyway, we'll see. Yes.
Much.
Because these food grains matters being stayed
Yes,
will
Lord.
create a huge problem to the hostels.
Tenders only for a period of 2 years. 3 months is already elapsed.
We'll see about that. Yes.
Please.
Correct ಮಾಡ್ಲಾ ನಾನೇ?
ನಾನು ತಂದ್ಕೊಡ್ತೀನಿ, xerox.
ಮಾಡ್ಲಾ? ಮಾಡಿ. Get that.
My lord, I'm for the petitioners, my lord. My lord,
ಏನಿದೆ ಹನುಮಂತಪ್ಪರೇ?
my lord, this is only amendment of cost settle. Already you filed the eminent petition you want already, only cost settle.
ಏನ್ ಆಗ್ಬೇಕು ಹೇಳಿದ್ರೆ?
My lord, I'm seeking a so the interim direction to the first respondent shall not give effect to the so the annexure E, my lord, page number 33. The second respondent, page number 33, my lord. My lord, the second respondent, in absence of the petitioners number 1 and 2, have conducted a general body meeting without voting for, without giving permission to the vote in the general body meeting. Now, the second respondent passed resolution, my lord, that to petitioner seeks only not to give effect to the resolution made by the second respondent.
Which is the majority union?
Hello?
You are a minority union?
Please, my lord, on the all India.
Are you a minority union or a majority union?
Majority, my lord, majority union.
How can they not do it?
My lord, because.
You are a minority
No,
union.
no, no, I'm in the working person, my lord. Working
Yes,
person.
wait.
This has become infructuous.
Why?
Meeting has already over and 24.
Resolution don't give effect ಅಂತ ಹೇಳ್ತಿರೋದು ಅವರು.
ಅಲ್ಲಲ್ಲ,
Just a second.
ಅದು
ಅಲ್ಲ,
previous
meeting
order ಗೆ
ಮುಗ್ದೋಯ್ತು
show.
ಅದ್ರಲ್ಲಿ.
Please, sorry.
ಹೇಳಿ.
ಅದರಲ್ಲಿ that prayer is issue the writ of nature of certiorari quashing the notice general body meeting of on dated 31/2/25 scheduled to be held on 25/2/25.
Second prayer also, second prayer.
Second is that meeting is already over. My second issue a writ in the nature of mandam as directing the first respondent shall not give any effect to the general body meeting and held on 24/2/25.
ಅದು ಎರಡು ಆಗಿದೆ.
ಎರಡು ಆಗೋಗಿದೆಯಲ್ಲ.
ನಾಟ್ ಟು ಗಿವ್ ಎಫೆಕ್ಟ್ ಅಂತ ಹೇಳ್ತಾ ಇರೋದು.
ಅದು
That-
previous
that
order ಗೆ
survives.
show ಅದರಲ್ಲಿ.
That survives.
ಅಲ್ಲ ನಾಟ್ ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ನಾನು just because he claims that he is the majority union and all.
Whether is majority or minority
Just
ಅಂತ
I
ಹೇಳಿ.
filed. Today only I have.
Because they need not sit and negotiate with the minority.
Already after the government guidelines is very clear, my.
Yes, no, the law is also clear on that.
So.
List
I'll-
on,
I'll produce
list
that.
on Monday in the fresh matters list. Yes.
8 minutes.
Yes, Punit.
Not complied, please, my lord, entry mark.
Complied, my lord, sale.
Sale ಆಗಿದೆಯಾ?
No, my lord, the sale was stayed
13 to.
pursuant. Yes, my lord. 4 weeks were given for 9 lakhs. Lord.
9
the-
lakhs. ಏ ಮನೆನಾ?
Nene,
My lord, in
ಅವಕಾಶ
fact, my-
ಕೊಟ್ರೆ ಕಟ್ತೀರಾ?
but,
My lord,
love none.
my lord, we
I-
kindly
What
observe the
lakhs?
previous order.
Sorry, yeah. Small borrower, yes.
Lord, ನಾನು phone ಮಾಡಿದ್ರೆ they are not responding me. That's why I'm making this.
ಫೋನ್ ಪೇ ಮಾಡಕ್ ಹೋಗ್ತಾ
ಅಲ್ಲ,
ಇದ್ದೀರಾ?
phone ಮಾಡಿದ್ರೆ client is not responding.
My lord.
Client is not responding. ಹಾಗಾದ್ರೆ dispose ಮಾಡಿ.
In fact, he's a BBMP employee, my lord, and they have taken repossession
ಹಂಗಾರೆ ಅವರು
twice.
ದುಡ್ಡು ಕೊಟ್ಟು ರೂಢಿ ಇಲ್ಲ ಬಿಡಿ. The petitioner is before this court seeking quashment of an e-auction notice dated 8/1/2025. This court, the coordinate bench of this court protects the interests of the petitioner, directing deposit of 9 lakhs as against the outstanding of 45 lakhs. The order is passed on 13/2/2025. It reads as follows. Not 4, but 8 weeks have passed by. The 6 weeks have passed by and the petitioner has not deposited, not even a rupee has been deposited by the petitioner. The learned counsel of the petitioner submits that the petitioner is not getting in touch with the counsel. In the light of the fact that there is breach of interim order, which had made clear that the petition would be dismissed on account of the breach of conditions, the petition stands disposed, reserving liberty to the petitioner to avail of any remedy as is available in law. Interim order, any subsisting, if any, would stand dissolved. Next.
Like,
18.
With the petitioner. That the petitioners have availed loan from the third respondent bank and they were regular in payment of EMIs, not even a single default or delay in.
ಈಗ ಎಷ್ಟಿದೆ ಸರ್?
Well, there is no due, my lord.
No, ಮತ್ತೆ why are you here?
My lord, they have declared it as NPA and I am not able to pay the EMIs, nor they have not issued. any-
Vignesh, Canara Bank. Counsel Shri Vignesh Shetty is directed to accept notice for the respondents. Petitioner to serve set of papers upon requisite set of papers upon the said counsel. List on Wednesday. Wednesday next in the fresh matters list next.
Till that time, I'll
ಏನು
not-
ಮಾಡ್ತಾ ಇಲ್ವಲ್ಲ ನೋಡ್.
year end ಅಂತ ಹೇಳಿ pressure ಹಾಕ್ತಿದ್ದಾರೆ some, that is all.
ಮತ್ತೆ
Not any coercive steps.
Wednesday we'll see. Yes, next.
19.
I'm challenging the interim order in view of the fact that I have not been served with the.
What interim order?
Sorry, my lords, the impugned order, my. lords.
Impugned order is all
Sorry,
right.
sorry. In view of the fact that I have not been.
Impugned
served-
fact or order?
In view of the fact,
All right, yes.
I have not been served with the notice. My lords, the petitioner is a trust which was established in the way, in the year 1981, my lords.
But was established then, trust was in 1981.
What was established in 1880, my 1850, my lords.
1850.
Yes.
Who are you, madam?
I am the honorary secretary, my lords. My lord,
Now government has taken over, is it?
yes, government has taken over, administrator was appointed. I had given a letter in view of the fact that Shantavira Swamiji expired on 30th/4/2022, my lords. So thereafter, we had a rectification deed was executed on 30th/7/2022. And after the expiry of Shantavira
Yes.
Swamiji,
Look into it. File your objections if you want, yes. The
My
order
lords,
is
I am
8/1/2025 is the order, madam.
yes, my lords, 8/1.
Yes.
And now they have also given a letter to me, my lords, calling upon the family members to issue the documents on 7/2/2025, my lords. I'm using this.
What document?
Documents pertaining to the MUT, my lords. So this is also being.
Yes, first time ಬರ್ತಾ ಇರೋದಲ್ವಾ?
Administrator,
Learned AGA is directed to accept notice for the respondent. Good to go through the papers.
All four.
To the respondents to go through the papers and make his submissions. List the matter on 4th April in preliminary hearing.
For the petitioners in this case.
The amendments in the representation itself shows it's a civil litigation. Decades of litigation between the parties.
File a private complaint.
Private complaint ಆಗ್ಲಿ ಇಲ್ಲಾಂದ್ರೆ your lordship.
Your lordship, my
seek,
kindly.
documents, revocation of GPA and then sale deeds.
Your lordship, my
Okay,
kindly.
Complaint is 6/10/2024, right?
Out, sir.
Your lordship, on 9/10/2024, FIR is registered against my uncle, your lordship, with regards to same subject matter.
Where is that?
When-
Where is the complaint there?
Please, your lordship.
Kodiyadu, FIR code.
This complaint is registered for non-performing the agreement, your lord, non-performance of agreement. That is the pure civil nature. Your lord.
406, 420, 316, 318.
Please, your lord.
Yes, of VNS.
When we go to give a
Wait, sir.
complaint,
Yes.
No, I'll look into this.
ಈಗ ನಾಳೆ ಒಳಗೆ register ಮಾಡ್ತೀರಾ? I'll ask that man to come here.
No, I'll find out what.
If you have registered a complaint against, a crime against this man and not registering the same, one ನಿಮಿಷ ಏನಿದೆ ಹೇಳ್ತಾಳೆ?
ಇದರಲ್ಲಿ agreement perform ಮಾಡಿಲ್ಲ ಅಂತ.
Specific performance suit ಹಾಕೋ ಬದಲು ಇಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. ಇವ್ರು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರೆ ಸಿವಿಲ್.
No, your lordship, I'll.
List the matter day after tomorrow, sorry, on Monday in the fresh matters list. The learned AGA to secure instructions as to how a crime comes to be registered against these petitioners on the same cause of action, while the complaint against the complainants in 277 of 2024 is rendered a non-cognizable report.
Here, station is different. That's why I couldn't.
ಏನಾರ
get it.
ಆಗ್ಲಿ, whatever.
I'll find out.
So and so, rendered a non-cognizable report. Yes,
Your
list the
lordship.
matter on Monday in the fresh matters.
It's registered against my uncle, your lord, and his family members.
That's all right. don't-
And
against the
another
complaint.
submission, your lordship, small submission. After registering this FIR, your lordship, without giving me a notice, they take my family to the police station, your lordship. And the whole day they make them sit there.
ಅದ್ ಹೇಳಿದ್ದೀರಾ? ಇದ್ರಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ?
Idral ಹೇಳಿಲ್ಲ. In quashing petition, we have said that.
ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ.
It is been said.
ಅಲ್ಲಿದ್ ಇಲ್ಲಿದ್ ಮಿಕ್ಸ್ ಮಾಡಬೇಡಿ.
Much obliged.
Yes.
21.
For the petitioner, please. Matter relates to number 2, not enrolling the petitioner.
Please, my lord.
70 ಇದ್ರು ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಏನ್ ಮಾಡ್ತೀವಿ?
My lord, the matter may be taken up on 3rd April, my lord. On 28th, we will get the enrollment.
20th?
28th, coming Friday.
May I please, my lord?
Yes, Brijesh.
My lords, I'm only requesting, lord, that.
No. The submission of the council was, there are 70 applications of the kind, so we will decide about all that. When do you decide it?
Just those list, we have not get the instruction, my lord. It is.
We allowed a petition, my lord, of a South Korean, to practice in India, my lord.
But insofar as the petitioner is concerned, my lord, we will get the enrollment on Friday.
That they will not enroll any person, and with the concerns that there are fake degrees, my lords. And my lords, my verification has come back way back in the month of December, please, my lords. And
Yes.
till date, they're not even accepting my
When do
application.
you do this?
28th, my lord.
list the matter on,
3rd of April.
no, wait, the next date rather than, list the matter on 2nd April in the fresh matters list. The learned counsel for the petitioner, respondent, bar counsel submits that action would be taken in the, on the application of the petitioner by then.
Please.
Yes, next.
Wait for.
If I may submit, at least let them accept my application. That is not being accepted.
They'll do
Then they
everything
can
by the
take
next
action.
date, sir.
They can
Yes.
take action after
See,
accepting.
it's
my
not difficult to pass an order on merits.
Absolutely. Absolutely.
Adar ಮೇಲೆ appeal, you will be nowhere.
No, no,
Okay, let them do that, wait.
Let them
Yes.
take my application as my only subject.
They will do everything by then, ಹೇಳ್ತಾ ಅಲ್ವಾ?
Great.
Yes. Hmm.
It's a paper petition.
I appear for the, I was directed to seek instructions because charge sheet has been filed, my lord. Let the lien may be marked on the disputed amount.
ಎಷ್ಟಿದೆ disputed amount?
Tax 15 lakhs.
62,066 rupees.
The petitioner is before this court calling in question an action of the respondent investigating officer directing freezement of the account of the petitioners held at various banks.
But as per as our instruction, it is only the bank person they are holding minutes.
Investigating officer ಇಲ್ವಾ?
ಮಾಡಿಲ್ಲ, that is the reason.
No, ಅದಿಲ್ಲದೆ ಆಗದೇ ಇಲ್ಲ ಸುಮ್ಮನೆ. Yes,
Not
not.
as an accused.
Yes. ಇದೆಯಲ್ಲ first respondent, station house officer Chelkere. The petitioner gets embroiled in a crime in crime number 75 of 2019 for offences punishable under section 420 read with 34 of the IPC.
Two crimes.
And the other crime in crime number 76 of 2019. The learned counsel Saravanan appearing for the petitioner, taking this court through the complaint and the summary of the charge sheet, would seek to contend that the total amount in dispute in against the petitioner is about 15 lakhs. But accounts of the petitioner in all the banks are frozen pursuant to the direction of the first respondent on account of registration of the crime. The learned AGA on instructions and verification of the records would submit the charge sheet is filed against the petitioner and others, and the total amount involved in the transaction is 15 lakhs. In that light, I deem it appropriate to direct the bank to which bank?
No, sir, respond number 4 and 5 minutes.
Respond number 4 and 5 banks to mark a lien on amount of 15 lakhs.
There is one FD, my lords, first one in the prayer.
Mark a lien on 15 lakhs in total and permit the operate the account as he was operating prior to the order of freezement. The learned counsel for the petitioner submits that there is a fixed deposit of
15 lakhs.
15 lakhs. ಅದರಲ್ಲಿ lien mark ಮಾಡ್ಬೇಕಾ?
ಬೇಕಾದ್ರೆ ಇಟ್ಕೊಳ್ಳಿ, ಇನ್ನು ಬೇರೆ
Fixed deposit of 15 lakhs. And the bank shall take a decision on marking a lien on that or even on the account, on the amount in the savings bank account. With the aforesaid observations, petition stands disposed with a direction to the bank to defreeze the accounts bearing in mind the observations made in the course of the order without broking any further delay. Yes, next.
15 lakhs 62,000.
15 lakhs 62,000 ಮಾಡಿ ಎಲ್ಲ ಕಡೆ. Yes, next.
Appear for the rare disease matter.
Rare diseases.
Please.
ನಿಮ್ದೇನಿಲ್ವಲ್ಲ ಇವರು 7th.
ನಾವ್ ಹೇಳುದು subject to
What happens is, my lord, one aspect, my lord, I have filed an amendment application.
Amendment
Only
application.
they're challenging the
that
guideline
50
itself.
lakhs, my lord, is the upper limit, my lord, that has been prescribed.
ಎಷ್ಟು?
50 lakhs, my lord, is the upper limit that they
Correct.
have prescribed.
Hmm.
Now they give it, my lord, in their own website, that the cost of, my lord, I have produced an IA, filed an IA, my lord, for production of
Eಲ್ಲಿದೆ
additional
IA?
document. I just request that.
ನೋ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರಾ?
ಕೊಟ್ಟಿದ್ದೇನೆ. IA for production of additional document ನ kindly be seen.
ರೆಡ್ ಪೆಟಿಷನ್ ಗೆ ಜಾಸ್ತಿ ಇದೆ ಇಲ್ಲಿ.
ಇಲ್ಲ, ಅದು ಡಾಕ್ಯುಮೆಂಟ್ ಯಾಕೆಂದ್ರೆ ಪಾಲಿಸಿ ಹಾಕಿದ್ದೇನೆ. Page number 56, my lord, is what I request, my lord, to kindly take. 56, my lord. There, my lord, what is the approximate cost of therapy? This is what they have web hosted in their own website. Now, one-time measure, my lord, it's 16 crore. And RISD plum, my lord, which I am now seeking. My lord, they say that per year it is 2 crore. Now, the policy says that it is only up to 50 lakhs, my lord, the upper limit is. That doesn't, my lord.
But are you not covered by under any insurance? Your
Absolutely
government,
no insurance,
government
my lord.
servant, right? What?
Yes, I am a
Both are
government
government
servant.
servant, husband and wife.
One is a teacher, my lord, in a government school.
All right.
And my lord, the father, my lord, is working as a deputy range forest officer, my lord.
You're not covered under any.
No, absolutely no schemes, my lord, which would cover this rare disease.
Yes, sir.
Whether they're covered or not, the head of the department has to file a undertaking. That's the scheme. Subject to that scheme.
Head of the department of
the
the petitioner. ಮಾಡಿ ಅದ್ನ.
employee.
That they'll do. There is no difficulty. Now they are saying all these things. Otherwise, I would have done that at that time itself.
No, no, the seventh,
now the challenge
the
is-
amount is in the custody of seventh respondent
Yes.
after the government gives it to them.
Yes.
Now seventh respondent has to release it in your favor. There are some conditions that are to be done.
Please.
You do that immediately.
Lord, I'll do that, but my lord, as far as this upper limit is concerned, my lord, let this challenge be entertained by my lordship.
With
Let them,
50
my
lakhs
lord,
upper limit.
Upper limit.
That is government policy, my
So
lord.
that is where I'm challenging it.
Now it comes
That
to you. Yes.
policy was made after, the Delhi High Court gave a detailed judgment on that the policy has to be framed like this. So pursuant to the order of the Delhi High Court, the 50 lakh caps was fixed.
No, the 50
Delhi High Court directs 50 lakhs.
No, what the
Section 50
government,
lakhs anta illa. But otherwise, this policy has to be drafted on certain idu anta helide. Lines anta, the court had ordered.
So that is what you have now
It
done.
is not under challenge now. Policy is not.
the
under
Honorable
challenge.
Delhi High Court said, don't fix on the 50 lakhs upper limit. Be flexible and decide it on a case-to-case basis. Page number 119 of the writ petition, my lord. The Delhi High Court judgment, the Honorable Delhi High Court judgment, page 119. My lord,
That's what, B5.
B5, please. The upper
Yes.
limit of rupees 50 lakhs under NRDP.
No, by then you
2020.
had already fixed 50 lakhs, madam. And the upper limit and rare disease shall be flexible in case of rare diseases in group 3. What is it, group 3?
Group 3, my lord, along with the notification, my lord, it is produced. My lord,
No, the Delhi High Court says should be flexible only in group 3.
Yes.
Ah.
Now, I am suffering from spinal muscular atrophy, which is a group 3
Where,
disease.
where do I get that?
My lord, along with that additional document application, my lord, page number 44. That is part of the policy, my lord, that have been placed on that. Page number 44.
Group 3 diseases.
My lord,
What is
three,
that you are suffering from?
spinal muscular atrophy. My lord, at the bottom, my lord, 3B admele, cystic fibrosis followed by,
3B, spinal muscular atrophy.
yes.
The Delhi High Court judgment is stayed now because it was difficult to
True,
implement.
but
certain-
diseases can't be stayed. What to do?
But we have anyway, for this annual, we have.
No, on a
allocated the
case-to-case
funds to the
basis.
Center of Excellence.
Then I left, because Delhi High Court is
No,
stayed.
even the Honorable Apex Court, my lord, has directed while granting the interim stay,
But-
that on a case-to-case basis, the decision should be.
Kodi madam.
That I placed on record last occasion.
Then
There, my lord, the
Sub-
notification was earlier notification, my
the
lord.
meanwhile shall comply with the terms and conditions so and so. Rare disease cell.
That's
We
that
have the operating
notification is
judgment
what
complete.
fixes the cap to 50.
That is
lakhs.
what, that is 19/5/2022.
Yes, that is what fixes at 50 lakhs.
ಎಲ್ಲಿದೆ case to case, flexibility case to case basis ಅಂತಿಲ್ಲ.
It has to be decided on a case to. In the very same order, man. The last paragraph, while granting the stay.
There
the
will be
Honorable
stay
Apex-
complying with the aforesaid notice, also
Notification.
payment on case to case basis,
Case-to-case
whenever it
basis.
is required. Yes, madam.
Case to case basis depends on Millards.
Depends on this case now.
It's confining to the cap of 50 lakhs Millards, because in the earlier paragraph, the Honorable Court has said that that guidelines dated 19/5/22 has to be followed.
Correct,
And that, as per
19/5/22.
that guidelines, 50 lakhs is a cap.
No, the Delhi High Court noticing that only has made it flexible. While staying it, Supreme Court says payment should be flexible on a case to case basis. How do you interpret it? So we have to interpret in favor of the person who is wanting medicine.
Because the situation is getting precarious, my lord. I need an urgent
Millards,
treatment.
It is difficult, Millards, because funds are not so much available
Let
because
them
a
start availing
thousands of
the-
children who are suffering
Let
from
them
this
start availing
disorder.
the treatment. This may be kept open, my lordship may hear this.
No, that 50 lakhs cap, I will keep it open.
Yes.
But,
That may be kept open, my lords.
but treatment,
More than
you start,
Only thing is subject to.
the head of the department, you
Yes.
get a letter
Yes.
and start the treatment. We'll
He
decide
should give an
about,
undertaking, that's what this.
whatever is there,
Whatever is
condition.
prescribed, my lord, will comply it within a day or a two.
50 ಲಕ್ಷದ ಆಮೇಲೆ ನೋಡೋಣ.
ಆಯ್ತು.
ಈಗ ಶುರು ಮಾಡ್ಲಿ ಅವ್ರು.
ಈಗ 50 ಲಕ್ಷನಾದ್ರೂ ಕೊಡ್ಬೋದು ಅವ್ರಿಗೆ, ಅದಕ್ಕೇನ್
ಅಲ್ಲ, ಅದಕ್ಕೇನೆ ಟ್ರೀಟ್ಮೆಂಟ್ will start with 50 lakhs.
Subject to he producing that he has
No, that they will take care.
not covered under any health.
No, that they will take care. That the seventh respondent will take care. Insofar as you are concerned, it is with regard to the cap of 50 lakhs that he is asking.
Yes.
We'll see, we'll answer that.
That 50 lakhs cap only we give it to Center of
ಈಗ
Excellence.
ಕೊಟ್ಟು ಆಗೋಗಿದೆ ಮೇಡಮ್ ಅವ್ರಿಗೆ. ಅವ್ರು 50 lakhs ನ ಅವ್ರು ಕೊಡ್ತಾರೆ. Now he is saying that he wants relaxation, flexibility in that 50 lakhs. Whether that's permissible or not, I will answer later, but let the treatment commence now.
50 lakhs per patient ಕೊಡ್ತಾರ ಅವ್ರು.
ಈಗ ಅದು ನಿಮ್ಗೆ ಕೇಸ್ ಟು ಕೇಸ್ ಬೇಸಿಸ್ ಮೇಲೆ ಕೊಡ್ತೀರಾ ಅಥವಾ ಜನರಲ್ 50 lakhs per
ಇಲ್ಲ, ಅದು staggered
ಎಷ್ಟು
payment.
patient ಗೆ ಅಂತ ಕೊಡ್ತೀರಾ?
ಅದು stagger.
No,
Only
per
when they give a
patient
list,
ಅಂತ.
right?
Per patient anta, there's a procedure, he has to apply for it and it has to go
The
through.
learned counsel appearing for the petitioner places on record certain documents seeking to demonstrate that he is entitled to be considered over and above the cap of 50 lakhs that is imposed pursuant to the direction of the High Court of Delhi. The Government of India issues a circular on 19/5/2022 depicting certain amount to be paid to the patients who are suffering from rare diseases. The rare diseases are also indicated in the circular. The petitioner falls within group 3. The Delhi High Court, in its direction at clause B5, observes that that the respondent should be flexible and the cap of 50 lakhs should not be imposed upon a person who suffers a disease under group 3. Therefore, the learned counsel for the petitioner submits that I would be entitled to a treatment beyond 50 lakhs to be paid by the seventh respondent or by the seventh respondent. Learned counsel Srimati Sadhna Desai, representing the Union of India, would refute the said submission that it's a policy of the government pursuant to the direction of the Delhi High Court that cap of 50 lakhs is imposed upon a particular treatment to those rare diseases. The other modes of payment should be availed of by the petitioner. Since the petitioner is a deputy range forest officer and the wife is also a government servant. The learned counsel for the seventh respondent submits that if the undertaking as necessary in terms of the circular is furnished by the petitioners, the treatment would commence and the issue with regard to cap of 50 lakhs could be decided at a later date. The list this matter on 4th April. The petitioner shall, in terms of the circular, render those undertakings that are needed, pursuant to which the seventh respondent shall administer the ಅಲ್ಲೇ ಸಿಗುತ್ತೆ ಮೆಡಿಸಿನ್ ಅದು ನೀವು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್
ಪ್ರೊಕ್ಯೂರ್ ಮಾಡ್ಬೇಕು.
shall procure the medicine
ಟೆಂಡರ್
and
ಹಾಕಿ ಪ್ರೊಕ್ಯೂರ್ ಮಾಡ್ಬೇಕು.
procure the medicine and administer it to the petitioner. Place the matter on 4th.
Subject to lordship may say that.
ಏನ್ ಸಬ್ಜೆಕ್ಟ್
But
ಹೇಳಿದ್ನಲ್ಲ ಅಂಡರ್ಟೇಕಿಂಗ್ ಅಂತ ಕೊಟ್ರೆ
That
ಮಾತ್ರ.
I'll do it. Time frame I'll do it, my lord, within 3 or 4
ನೀವು
days.
ನಾಳೆ ಮಾಡಿದ್ರೆ ಅವ್ರು ನಾಳೆ ಕಳಿಸ್ತಾರೆ.
ಮಾಡ್ಬಿಟ್ಟು
Like ಮತ್ತೆ ಟೆಂಡರ್ ಅಂತ ಹೇಳಿದ್ರೆ
ಅಲ್ಲ,
only
suppose
medicine ಅಂತ
ಮೆಡಿಸಿನ್ ಇಲ್ದಿದ್ರೆ ಟೆಂಡರ್ ಕರಿಬೇಕು. But this is an imported medicine. No, we have to.
Correct. We can't violate the laws.
We can't
We'll see.
violate the law. This is
But
not-
rare disease, this should be flexible, is not correct.
difficulty is, my lord, we have exhausted the medicine that is there.
We'll see.
The treatment is required.
List the matter on 4th. By then you start. ಇದರಿಂದ ಏನು ತೊಂದರೆ ಆಗಲ್ಲ. Direction will 50 lakhs will see.
Yes.
Next.
Petitioner's project model came to be approved by the District Single Window Clearance Committee by Annexure B.
ಈಗೇನ್ ಕೇಳಿದಿರಾ ಇಲ್ಲಿ?
And was to consider representation for allotment of site. Consider in accordance with law. This
Leave
project
hearing.
has been approved and plot
Leave
of
hearing.
site.
Corner number 3.
Udyog Mitra.
ಸುಕೃತ.
My lord, I have by mistake included number 3 also in my wakalat, my lord. My name may be struck off.
The petitioner is before this court seeking the following prayer, heard so and so. The petitioner files an application before the third respondent seeking allotment of land for establishment of an industry in the industrial area. It transpires that on 1/3/2019, the application is approved by the single window clearance committee for allotment of a land. After 1/3/2019, it is the case of the petitioner that the petitioner has submitted several representations seeking allotment of land. Those having not been considered has driven the petitioner to this court in the subject petition. The learned counsel appearing for the respondent KIDB submits that if reasonable time is granted, the representation of the petitioner would be considered for the purpose for which it is granted, which it is submitted, and appropriate orders would be passed in accordance with law. Then objection.
My lord, annexary, there was a plot identified.
So and so. The ಹೇಳಿದೆಯಲ್ಲ representation.
Yes.
So and so. The learned counsel for the petitioner submits that in the interregnum between 1/3/2019 and today, a plot was also identified. It would be helpful if the said plot is allotted to the petitioner. It is for the KIDB to consider the representation and pass necessary orders in accordance with law, bearing in mind the said fact as well. In that light, therefore, I deem it appropriate to dispose the petition, directing the respondent KIDB to consider the representation and pass necessary orders in accordance with law within 8 weeks.
Please, ma'am.
Within 8 weeks from the date of receipt of the copy of this order, if not earlier, ordered
Lord,
accordingly.
in 24.1, my lord. Two matters. I've already filed wakalat, my lord. My name has not been shown in the list. I'm sorry, my lord, I have not.
Separate again, registry to print the name of B. Vachan as appearing for respondent number 2 and Sukrita Gaudana, Babu, Sukrita R, and Sukrita R as appearing for the third respondent.
Lord, in the first
Separate order sheet already, same order.
As far as the second matter is concerned, my lord, I may be have permitted some time to revert back on the matter. I'm awaiting instructions in the matter.
ಹಾಗಾದ್ರೆ 24.1 dealing ಮಾಡಿ 24 dispose madam. 24.1
24 I filed a memo, my lord. That memo may kindly be taken on record where my wakalat, my lord, is shown for
all
R3
right.
also.
Yes, so and so. ಅಲ್ಲಿ ತೋರಿಸ್ಬೇಕಾದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿ ತೋರಿಸ್ ನೋಡ್ಬೇಡಿ. 24
R3 no by miss 24.1
Wednesday.
By mistake ನಾನು R3 no ಬರ್ದ್ಬಿಟ್ಟಿದ್ದೀನಿ ವಕಾಲತ್ ಅಲ್ಲ ಅದಕ್ಕಾಗಿ.
ಆಯ್ತು, ಎಸ್.
ಫಾರ್ಮಲ್ ಆಗಿ
24 ಪಾಯಿಂಟ್ ಅವ್ರು ತುಂಬಾ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದಾರೆ, ನಿಮ್ಮ ನಮ್ಮ ಹೆಸರು ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ ಅವ್ರೇನ್ ಹೇಳಿಲ್ಲ, ನಾನೇ ನೋಟ್ ಮಾಡಿ.
ಆಯ್ತು, ಎಸ್. ಆರ್ಡರ್ ಬರೀಬೇಕಾದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಬರೀ.
R1 I accept notice in the 24.1.
24.1 1 AGA 2 Vachan 3 Sukrita R. List on Wednesday in the fresh matters. 24 disposed.
Copy of petition may be.
Copy of the petitions code. Yes.
25.
For the petitioner.
It's 25, I'm appearing on behalf of the petitions council, my lords.
File an affidavit.
Hong Kong.
Lords, they are seeking to sell 2 properties at 15 crores. That is all what they want to recover. Lords, I have given a proposal for one-time settlement, which is more or less the same amount, Lords, as has been decreed by the Hong Kong court. I had given an offer of 33 crores. If they say that there is anything more to be paid, I will pay that amount also. Lords, I have given the schedule. I will file an affidavit of undertaking.
My lord, in fact, my lord,
You're not acceptable to this?
my lord, 33 crore, my lord, in fact, sale taken place.
No, let them say what is the total decretal amount I'll pay it.
Sale has taken place. ಎಷ್ಟಕ್ಕೆ ಮಾರಿದ್ದೀರಾ?
Put together, my lord, 27 crore.
33 crores ಕೊಡ್ತಿದ್ದಾರೆ.
Difficulty, my lord, they're having other assets which I can attach, Lord, for recovery of other dues. In fact, remaining dues.
No, so what is the total due?
Decretal amount they will have to tell. I've made a calculation.
Decretal, my lord,
What?
46
ಈಗ ಡಿಕ್ರಿ ಎಷ್ಟಕ್ಕಾಗಿದೆ ನಿಮಗೆ?
That is correct, my lord. In respect of
ಡಿಕ್ರಿ is 33 crores. ಸರಿ, ಅದ್ ಬಿಟ್ಟು
ಈಗ 46 crore ಆಗಿದೆ, including interest.
Lord's decree is along with the interest. If your lords were to see where the decree is, Lord's decree, Lords, is at page number 67.
ಈಗ ಅದು ಬೇಕಾ ಬೇಡವಾ?
Sale, my lord, taken place. In fact, my lord,
Well, sir.
33 crore, my lord, we
Sale
will
certificate also
issue
issued?
ಮಾಡಿಲ್ಲ. In view of my lord of order, my lord directed my lord not to issue a sale certificate, I am not issued it. My difficulty is this, my lord. I have to recover, my lord, 46 crore. My lord, which they are offering, my lord, one-time settlement offer, my lord, which earlier also, my lord, in fact, my lord, no point.
No, this decree of the Hong Kong court, ಅಲ್ಲಿ ನೀವೇ ಹಾಕಿದ್ದಾ?
My lords, yes, it is filed by Canara Bank. What they can recover is already plugged. My lords,
ಈಗ where do I get that figure 33 crores?
asking in excess of what the decree stipulates. You have arrived at page
INR
67.
30, yes,
Lords,
sir.
if you're- yes.
My lord, the decree is passed, my lord, not now. It is already, my lord, you know, now.
No, I made the calculation till date.
Till date
Calculation
ಎಷ್ಟಾಗಿದೆ?
will always be made till date. My lords,
Till
according to my calculation, it will be about 39 crores, my lords.
You are prepared to pay that?
39 crores, 73 lakhs, 66,190. That is the calculation.
You
My lord,
don't?
In fact,
Alla, you don't want that?
in fact, my lord, this up to June, in fact, my lord, I came in able to recover, my lord, in this sale by 31st of March. My lord, it's not the case, my lord, recent become NPA. My lord, we have given sufficient opportunity, wherein, my lord, we have given all the.
ಈಗ ಆಯ್ತಲ್ಲ ಡಿಗ್ರಿ ಇದೆಯಲ್ಲ.
Not decrease one aspect, my lord. Now I sold a property under Surface Act at the mortgage rate in India. In fact, my lord, this is not the first case, my lord, before this honorable court. Earlier, my lord, they filed the petition before this honorable
You
court.
don't go, ಯಾವಾಗ್ಲೂ don't go to history. If you want to solve this problem, we'll solve it. Otherwise, stay there, I'll post it in big group.
My lord, according to bank, my lord, if the interest is calculated from the decree, it's coming around 46 crore, which now they are offering.
That you sit with them and talk.
Lords, let them file a memo of calculation as to how they have arriving at 56. I will also file a memo of calculation. Lords, I made a memo of calculation. Lords, it comes to 39 lakhs 73,000.
My officers are there.
You discuss with them. If they want money, take it. Otherwise, I'll stay it and keep it.
My lord, if they're going to pay, my lord, not June and all, my lord, I need money from this 31st of March. Because my auction purchase is ready here. with the money.
Lords, we have paid 6.5 crore rupees, my lords, even before we submitted this proposal for one-time settlement. The total money which they are seeking to recover under this sale notice, as per their valuation, was 15 lakhs. Now they say they are bidded at 27 crore rupees.
Anyway,
I have already paid, my lords, 1/3 the amount. Lords, if you the lords can have this matter on Saturday, my lords, in the fresh matters list itself. In the meantime, we will also file the memo of calculations, just
let it come on
justifying as to how it is 39 crores.
Monday.
Saturday. The difficulty is this, my lord. I have sale certificate I have to issue.
No, don't issue, sir. Monday in the fresh matters list, yes. ಅಷ್ಟೊಂದು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ ಎಲ್ಲ ಬನ್ನಿ, yes.
We shall do that.
26. My lord, serial number 26, I appear on behalf of the petitioner, my lords. I'll file my objections to the in-pleading application. A week's time may be granted, my lords.
This is the matter where, my lord, the joint survey of the forest land was conducted. So that the petitioner is in encroachment of about 62 acres of land.
Encroachment.
Encroachment of forest land.
ನೀವು ಯಾರಿಗೆ?
I'm impleading applicant.
Who are you?
I'm the person who has filed a writ petition seeking a directions to survey the land. Now it is surveyed.
Let him come on record.
My lords, I'll file my objection. Senior has some inconvenience. It may
Last time
kindly-
also the same submission was made that you will file objections on 10/3.
We're trying to obtain some
finally-
documents, my lords.
Finally, time is granted up to 27th to file statement of objections to the impleading application as it is being sought for the second time. In the event no objections would come about, the impleading application would be allowed. The learned counsel for the learned AGA on instructions and verification of the records would submit that the petitioners are in encroachment of how many acres?
62 acres.
62 acres of land. Ellididu?
ಇದು ಶ್ರೀನಿವಾಸಪುರ.
62 acres of land. Therefore, the petitioner.
State range forest. I will also file my objection.
62 acres of land. Objections, avatrolak hakira? List on 27th, objections, if any, by the respondent state as well by the said date. Next.
My lords, interim order may kindly be extended.
Interim order subsisting will continue till the next date of hearing.
Obliged.
This is regarding that security, there is
one aspect I did not bring to the Lordship's notice, my lord, in 2022, that he was conferred the status of a minister and continued 2023. and,
Minister,
Yes, yes, he is conferred the status.
ಈ ಸಾಹಿತ್ಯ ಪರಿಷತ್ ಅಲ್ವಾ?
ಹೌದು, ಹೌದು, ಹೌದು.
ಹಾ, yes sir. Threat to life.
Yes. And there is already an earlier order, my lord, page 22 may kindly be seen. This honorable court, my lord, order.
Page?
Page 22, my lord. It commences at 22.
2000.
Yes, my lord.
ಅವಾಗಿಂದನೂ ಥ್ರೆಟ್ ಇದೆಯಾ?
ಅವಾಗ ಬೇರೆ ಇತ್ತು. He filed cases against CBI and all that. There is a liberty given to the petitioner that, my lord, last 4 lines. Further, if there is any threat to the life of the petitioner or the members of the family in response to threat against the petitioner or members of his family, the same may brought to the notice of the concerned police in that circumstance. They are to take necessary action in order to protect.
ಈಗ ಏನು?
Pardon?
Now what is the problem?
Now what has happened, brother? He is the person who is elected to the Kannada Sahitya Parishad, and there was a Sahitya Parishad meeting in Mandya, which saw violent altercations between the members and all that. Now thereafter, my lord, he is receiving series of, my lord, audio and video messages that I pointed out, my lord, page 44, 53 and 54. 44.
No, if let them prepare a threat analysis report.
Gunman committee, my lord, there are already recommendations and all that. I think.
Correct.
that is pending before-
I will direct them to prepare a threat analysis report.
Yes.
And if threat is in real time, give you security, personal, ಇವಾಗ gunman ಬೇಕಾ?
ಅಷ್ಟೇ.
But without threat analysis report, it can't be done.
So certainly.
The threat perception report will take,
When?
my lords, 10 days.
ಅಷ್ಟ್ರಲ್ಲಿ ತೊಂದರೆ ಆದ್ರೆ?
No, he has to travel. The reason is this. December, there will be annual Kannada Sahitya Parishad Sammelana.
December?
December.
December.
Normally, it will take minimum 10 months to prepare it's all India, throughout Karnataka.
ಆಯ್ತು, let them, I'll give them,
The border
7
area.
days.
My immediate concern is.
I'll give them a week's time
Yes, ma'am.
to place the threat analysis report here. And after that, I will pass out.
Immediate concern is, suppose if we visit border area like Belgaum, let them allot.
ಅಲ್ಲಿ police protection ಕೊಡ್ಲಿ.
The threat what is mentioned and that's completely different, my lords. They are having, the claim in the writ petition is they are having threat in Mandya. We'll
Like-
take
But
the
it is
report
not
and we'll
some
place it
property
on
dispute.
record.
ಅಲ್ಲ, it's all right. See,
We will take the
see,
threat perception.
ಅದಕ್ಕೆ threat analysis report ಬರ್ಲಿ.
Please,
And if the threat
entitled to
see, it's not that ಮಂಡ್ಯಾಗ ಹೋದಾಗ ಆಗತ್ತೆ, ಅಲ್ಲಿ ಹೋದಾಗ ಆಗತ್ತೆ ಅಲ್ಲ. Wherever he travels, if threat travels with him, then protection will have to be given.
place the report, my lords.
I'll take it next Friday.
Great.
Next Friday, in the heard the learned senior counsel, S. Basavaraj appearing for the petitioner and the learned additional advocate general Srimati Pratima Honnappa. The learned counsel for the petitioner takes this court through an order dated 28/3/2023. 23 alert. 2003. That's 28/3/2003 to contend that the court then had observed as follows. Page 22, early mark 22-23. The learned senior counsel submits that the threat persists even today as he's being threatened by messages and videos that are transmitted to his cell phone. Therefore seeks police protection or a protection of personal security to him. The learned the learned AAG submits that without a threat perception report or threat analysis report as is necessary in law, a personal security or a gunman cannot be provided. Therefore, the state shall drop a report of threat analysis of the petitioner or perception of threat as the case would be, and place the report before this court on the next date. List the matter on Friday in the fresh matters list.
Grateful.
Next Friday. ಮೇಡಮ್, ಬೆಳಗ್ಗೆ ಎಲ್ಲೋ ಮೆರಮಮ್ಮ ಮಾಡೋದಿಲ್ಲ, ಹಂಗೆ ಹೋಗ್ಬಿಟ್ರಿ ಕೊಡಿಯೋದು.
Please.
ಎಸ್, DRT ಏನಾದ್ರು ಕೊಡಲ್ಲ, ಕೊಡಿ. ಇದ್ರಲ್ಲೇನು GST?
Paid, my lord. Just, no, it was rejected, my lord, please.
What
the
was rejected?
OTS as rejected.
OTS ಎಲ್ಲ ನಾವೀಗ OTS ಮೇಲೆಲ್ಲ
ಅಲ್ಲ, regularize
ರೆಗ್ಯುಲರೈಸೇಷನ್
reject ಆಗಿದೆ.
ಈಗ ಚರಂಡಿ ಮೇಲೆ ಇದೆ, ಪ್ರಾಪರ್ಟಿ ಸೇಲ್ ಆಗುದಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು. ಈಗ ನಮ್ಗೆ ಪ್ರಾಪರ್ಟಿ ಅದು
That is
ಉಳಿಸ್ಬೇಕು
in-
ಅಂತ ಕೊಂಡು ನಮ್ಗೆ ಇರೋದ್ರಿಂದ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಕೊಂಡು 19 ಲಕ್ಷ ಕಟ್ಟಿದೆ ಸ್ವಾಮಿ. 14 ಕಟ್ಬೇಕಿತ್ತಂತೆ, 19 ಕಟ್ಟಿದ್ದೇನೆ. ಸೊ ಈಗ ವಾಟ್ ಎವರ್ ದ ಲಾಸ್ಟ್ ಟೈಮ್ ಇಟ್ ವಾಸ್ ಸಬ್ಮಿಷನ್ ವಾಸ್ GST is not paid. ಅದನ್ನು ಪೇ ಮಾಡಿದೆ ಸ್ವಾಮಿ.
If GST is paid, you would be considered ಅಂತ
Last
ಹೇಳಿದೆ.
week, they have rejected, regularized the account, my lord, and
Why?
they have filed OA also for recovery of the suit. They
ಯಾವ್ದದು?
suit.
ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಅವ್ರು ಹಾಕಿದ್ದಾರೆ.
ಅದೇ ಅವ್ರು ಹಾಕಿರೋದು ನಿಮ್ಗೆ ನೋಟಿಸ್ ಬಂದಿಲ್ವಾ? This-
I got the information from the bank saying that they are rejected of regularized the.
This is not fair. Absolutely not fair.
I'll-
19.5 lakhs ಇತ್ತು 10 days ಅಲ್ಲಿ ಕಟ್ಟಬೇಕು ಅಂತ ಕಟ್ಟಿದ್ದಾರೆ. Then you said bank will consider if GST is not paid along with that. GST also
ಈಗ
a
pay ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಹಾ.
Oh, I had to
Bank
inform. No, no,
inform
I had to
ಮಾಡಿ. It's not,
inform. I kindly,
not fair.
it may be listed on Monday.
I'll
my
list
lord,
it on Monday.
Please.
List the matter on Monday in the fresh matters list. The interim order subsisting will continue to the next data.
Great.
Madam, the previous matter. Order sheet. Next.
My lord, now the
This matter, my
intimation
lord,
notice has been issued by the second respondent.
Direction was issued to me as to check the status.
Hmm.
So this is regarding the Anekal Karaga, my lord. Now, my lord, what has happened is there are 3 claimants who have filed representation. Last time also there was a hearing that was conducted and the matter was sorted out because so that on that day won't be any disputes, my lord. One notice was issued yesterday to all the 3 stakeholders to appear before the Tehsildar on the 28th. And the matter will be sorted out, whoever is the right.
ಯಾವತ್ ಕರಗ ಯಾವತ್ತಿಂದ?
4th is the start.
4th April.
28th you should sort out everything and place it before the court.
Yes.
27th ಮಾಡಿ, 28th you place it before the court.
28th ಅಂತ ನಾವು notice issue ಮಾಡ್ಬೇಕು.
Issue ಮಾಡಿದ್ದೀರಾ?
Issue ಮಾಡಿದ್ವಿ.
ಆಯ್ತು, we'll post it on 1st April.
Please first.
But anyway, it's before 4th.
Yes.
The learned AGA on instructions should submit that there are 3 claimants to perform karga.
I will also place this before the court trial.
Well, 3 claimants to perform karga in the subject temple. The learned AGA submits that the Tahsildara Esina.
Tahsildar.
That the Tahsildar has summoned all the 3 stakeholders, 3 claimants, and is to on 28th for resolution of the dispute. List the matter on 1st in the fresh matters list.
Place this along with the.
Record ಮಾಡಿದೆ. You ತಗೋಬೇಕು ಅಂತ ತಗೊಂತ.
Just place it in the file. Not in proper form, I apologize.
Yes, ಅದು ಫೈಲ್ ಅಲ್ಲಿ ರೆಡಿ ಮಾಡಿ. Next.
Was appearing for petitioner. My lord, loan amount was of 5,40,000, my lord, 2017. I was regularly.
ಈಗ
paying-
ಎಷ್ಟಾಗಿದೆ ಹೇಳಿ ಸರ್?
My lord, that is a fact, my lordship. There is they state that 3 lakh rupees is outstanding and.
ಎಲ್ಲಿದೆ?
The amount is this one.
ಈಗ ವಾಟ್ ಆರ್ ಯು ಚಾಲೆಂಜಿಂಗ್?
My lord, possession, ಇದು, see of 14, section 14 ಆರ್ಡರ್, my lord.
ಅದಕ್ಕೆ ಆ ಆರ್ಡರ್ ಎಷ್ಟಿದೆ?
3 lakh 63,000.
Where do I get that? 3,62,000 as on 15/7/24. Yes, emergent notice, interim order is spread for. Next.
Hand over the possession, my lordship.
ಅಂದ್ರೆ ಸ್ವಲ್ಪ ಕೊಡಿ. 3,62,000 ಅಲ್ಲಿ 1 lakh.
Swami, one submission, they 138 matter ಆಗ್ತಾರ 2023 ಅಲ್ಲಿ. ಆವಾಗ್ಲೇ ಅವ್ರು ಅಡ್ಮಿಟ್ ಮಾಡ್ತಾರ, ನಾನು ಎಂಟೈರ್ ರೆಗ್ಯುಲರ್ಲಿ ಪೇಡ್ 2 lakh rupees.
ಈಗ you deposit 50,000.
Please, ma'am.
There shall, in the event the petitioner would deposit 50,000 as against the total liability of 3,62,000 as projected in the order impugned, the bank shall consider restoration of possession to the hands of the petitioner. Next.
Lord, permitted to take hand delivery, my lord.
You will get it, yes. Divide.
For next year, my lord, action say.
Yes, Lokesh.
Lords, sale has taken place.
3 crore
But
70,000.
This court has 3 times given them opportunity. This is the 4th
My lord,
time.
one
4th time.
submission, my lord.
Have
Previously,
also
my
they
lord,
dismissed ಮಾಡಿದ್ರು, incomplete.
previously, my lord, one submission, my lord.
And he has also
There is a
waived
3
off-
crore is there. I am ready to deposit the 30%, my lord, within 10 days, my lord.
I go to the honorable.
10 days, my lord. Previously, your lordship granted the interim stay, my lord, to deposit the 50. At that time, I can't deposit it. Now, my lord, a commercial suit is decreed in my favor against my tenants. I got this some money, my lord. Now I am ready to deposit 30% of the amount, my lord, that is in respect of the e-action sale notice. My respectful submission, the property worth more than 4 crores 50 lakhs, my lord.
This
They
order, my
only
lord,
the sale,
Honorable Justice
reserve
Hemant
price
Chandra
is
Gaur.
the reserve price is to 2.23, my lord.
ಎಷ್ಟನೇ ಮೂರನೇ ಸೇಲ್ಗೆ ಅದೇ ಆಗತ್ತೆ.
ಸ್ವಾಮಿ ಎರಡು ಸಲ ಅವರೇ ವಿಡ್ರಾ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. ಎರಡು ಸಲ ಅವರು ವಿಡ್ರಾ ಮಾಡಿದ್ರು. ನೋ ಐ ಆಮ್ ರೆಡಿ ಟು ಡೆಪಾಸಿಟ್ ದಿ 30% within 10 days, my lord.
ಈಗ ಆಪ್ಷನ್ ಪರ್ಚೇಸರ್ ಸೇಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದೀರಾ? ಇಲ್ಲ
Only 25% has been paid. Anyhow, we
That's
will
what
not pay.
my lord-
Is imposed also.
ನಿಮಿಷ.
Sorry.
25% payment ಮಾಡಿ 56 lakhs payment ಮಾಡಿದ್ದಾರೆ.
Purchaser also, if he wants to save his property, let him.
10 days ಅಲ್ಲಿ let him do.
10 days, 10
ಇಲ್ಲ
days.
ಅಂದ್ರೆ we'll proceed further ಅಂತ order.
That condition I will.
Aye, sir.
The petitioner is.
One submission, ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ OTS ಗೆ ಹಿಂದೆನೆ
ಅದು
WP
ನೋಡಿ,
ನಲ್ಲಿ
ಈ ಇಂಟೆಲಿಜೆನ್ಸ್ ತೋರಿಸ್ತಾ ಇದೀನಿ ಅಂತ ಎಕ್ಸ್ಟ್ರಾ ಕೇಳಬಾರ್ದು.
ಅಲ್ಲ ಅರ್ಜಿ ಕೊಟ್ಟಿದ್ದೆ ಸ್ವಾಮಿ. OTS ಗೆ ಅದೊಂದು ಕನ್ಸಿಡರ್ ಆಗ್ಲಿ.
ಪರವಾಗಿಲ್ಲ. ಎಸ್, ಫಸ್ಟ್ ಇದು ಆಮೇಲೆ.
ಆಯ್ತು sir, ಆಯ್ತು.
Yes. The petitioner is before this court calling in question a notice of auction which was slated to be held ನೆನ್ನೆ ಅಲ್ಲ?
14th.
On 14/3/2025. The learned counsel KV Lokesh representing the respondent submits that the auction has already taken place and the auction purchaser has deposited 25% of the sale amount, which is
56 lakhs 10,000 rupees.
56 lakhs 10,000. The learned counsel for the petitioner submits that they are ready and willing to save the property by deposit of 30% of the entire dues within 28th of March 2025. In the event the 31st ಒಳಗೆ ಬೇಕು ಅವ್ರಿಗೆ. ಅದ್ರದ್ದು ಬಂದಿದೆಯಲ್ಲ 2ನೇ ತಾರೀಕು ಹಾಕ್ತೀನಿ. Second honor before the 2nd of April 2025. In the event the petitioner would not deposit 30% of the total amount in due, the bank shall proceed with issuance of the sale certificate in favor of the auction purchaser.
Let there not be any further extensions on the
Auction purchaser. In the event the petitioner would deposit the amount as undertaken, observation of which is made herein above, the bank shall not proceed further with the sale. Since the auction purchaser has also deposited 56, the petitioner, the subject petition is the third in line. The very petitioners had approached this court twice and on both the occasions have faltered in payment. Therefore, both the petitions had been dismissed. Since the petitioner has now undertaken for the third time that he would pay the amount as aforesaid, indulgence is shown. Therefore, no extension beyond 2nd April would even be considered as a submission from the hands of the learned counsel for the petitioner. In the event no payment comes about before 2nd of April, the petition is dismissed. Yes.
On 3, my lord.
List on 3rd. Yes. 3rd ರಜಾ ಇರ್ಬೇಕು ತಾನೆ? ಇಲ್ಲ, list on 3rd.
any first week, any date.
Watch out.
List on 4th in the. All right. But 2nd ಒಳಗೆ ಕಟ್ಟಬೇಕು.
ಇಲ್ಲ ಸ್ವಾಮಿ, ವ್ಯವಸ್ಥೆ ಆಗಿದೆ. ಕಮರ್ಷಿಯಲ್ ಸೂಟ್ ಅಲ್ಲಿ ನಮ್ಮ ಟೆನೆಂಟ್ಸ್ ಮೇಲೆ ಡಿಕ್ರಿ ಆಯ್ತು ಸ್ವಾಮಿ.
ಎಲ್ಲ ವ್ಯವಸ್ಥೆ ಆಗಿದೆ.
ಬಂದಿದೆ ಸ್ವಾಮಿ. ಅದನ್ನೇ ನಾನು ಹೇಳಿದ್ದೀನಿ ನಾನು.
ಆಯ್ತು.
ಮಚ್ಚು.
ನಿಮ್ ವ್ಯವಸ್ಥೆ ಕರೆಕ್ಟ್ ಆಗಿ ನೋಡ್ಕೊಳ್ಳಿ. ಅವತ್ತು ಅವಸ್ಥೆ ಅಂದ್ರೆ ಕೇಳಲ್ಲ. ಎಸ್.
It's a writ seeking defreezing of account for an amount of 25,000. HDFC Bank, my lords.
ಸೇಮ್ ಮಾಡಿರೋದ್ರಲ್ಲಿ ಎಲ್ಲಿ ಆರ್ಡರ್ಸ್ ಕೊಡಿ. HDFC ಬ್ಯಾಂಕ್ ಇದೆಯಲ್ಲ ನಿಮ್ದೇ ಕೊಡಿ. ಬಂದಿಲ್ವಾ?
ಮದ್ರಾಸ್ ಹೈಕೋರ್ಟ್
ನಿಮ್ಮ ಕೇಸಲ್ಲೇ 10 ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ. ದಿ ಪೆಟಿಷನರ್ ಇಸ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್. ಎಲ್ಲಿ ಇವರು ಲರ್ನಡ್ HDFC ಒಂದು ಸರ್ವ್ ಮಾಡ್ಬಿಡಿ ಬೆಟರ್. ಝೇವಿಯರ್ ಇರ್ಬೇಕು. To serve set of papers upon the aforesaid council Monday, fresh matters.
Great.
Yes, next. Orders ತಗೊಂಬನ್ನಿ. Yes.
Lord, I put for petitioner in this case. Lord, the KEB have disconnected the connection. Lord,
Why?
Pursuant to the direction of BBMP directions.
BBMP stay ಆಗಿದೆಯಾ?
ಅಲ್ಲ, ಅದು ಇಂಜಂಕ್ಷನ್ ಇದೆ. ಅವ್ರು ಕನ್ಫರ್ಮೇಶನ್ ಆರ್ಡರ್.
OS ಇಂಜಂಕ್ಷನ್ ಅಲ್ಲ, BBMP stay ಆಗಿದೆಯಾ?
ಅಲ್ಲ, ಕನ್ಫರ್ಮೇಶನ್ ಆರ್ಡರ್ ನಮ್ಗೆ ಇಶ್ಯೂನೇ ಮಾಡಿಲ್ಲ.
Civil court had no jurisdiction to entertain itself.
I do agree with that.
If you do agree, then we'll dismiss the petition.
My lord, provisional order, confirmation order issue ಮಾಡಿದ್ರೆ I would have approached. They have not issued. Straight away they have given direction
BBMP
to
ಕೌನ್ಸಿಲ್
KB.
ಇಲ್ವಾ ಇಲ್ಲಿ?
BBMP ಬಂದಿಲ್ಲ. I have been served for Besco Millet.
ಹಾ.
ಇಲ್ಲ ಇವ್ರು ಇನ್ನೂ ಅಪ್ರೋಚ್ ಕೂಡ ಮಾಡಿಲ್ಲ BBMP ನ. LB ಕೋರ್ಟ್ಗೂ ಹೋಗ್ಲಿಲ್ಲ. ಡೈರೆಕ್ಟ್ ಆಗಿ ಬರೀ
ಅಲ್ಲ,
ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಕನೆಕ್ಷನ್ ಮಾತ್ರ ಇದ್ದಾರೆ.
Definitely approach the
And they are not the
appellate authority. Confirmation ಆರ್ಡರ್ ಇಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ನಾನು
ಅದು BBMP ಕೇಳಿ.
They are not the occupants
Till
also.
then, my lord, let them.
No, no.
My lord,
Who are you?
my lord.
Who are you?
Owner.
I am the owner of the property.
Are you staying in that property?
No.
Lord?
Are you staying in that property?
No, my lord, I am not staying, my lord. I have let it out. It is, my tenants are residing there. Already residents are there, my lord. Now they have disconnected, my lord. ಅಲ್ಲ, ಕನ್ಫರ್ಮೇಶನ್ ಆರ್ಡರ್ ಕೊಟ್ರೆ ನಾನು ಹೋಗ್ತೀನಿ.
ಅದಕ್ಕೆ
ಕನ್ಫರ್ಮೇಶನ್
BBMP ಕೇಳಿ ಸರ್.
ಅಲ್ಲ, till then, my lord.
LB ಒಂದು ಮ್ಯಾಟ್ರ್ ಹಾಕಿ ಸರ್. ಹಾಕ್ಬಿಟ್ಟು ಅಲ್ಲಿ BBMP ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ. ಮಂಡೇ I'll take it on Monday in the fresh matters list. ಅಷ್ಟ್ರಲ್ಲಿ ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ಬೇಕು, ಪಕ್ಕದ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡ್ಕೊಂಡು
ಟೆನೆಂಟ್ಸ್ ಇದಾರೆ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ವಾಸ ಇದಾರೆ.
ನೀವು ಮಾಡಿ ಸರ್. ಎಸ್.
ಅಲ್ಲ, ಎಲೆಕ್ಟ್ರಿಸಿಟಿ 4
Right away I would have given, but there is something here. Yes. Monday. Fresh matters. Yes, next.
ಕನ್ಫರ್ಮೇಶನ್ ಆರ್ಡರ್ ಇಲ್ಲದೆ ನಾನೇ ಹೋಗಿ
ಅದಕ್ಕೆ ಅಲ್ಲ. That's why. That is why I said Monday.
ನಾನೇ
ಯಾಕೆಂದ್ರೆ ನೀವಾಗ ಈ ಕನ್ಫರ್ಮೇಶನ್ ಆರ್ಡರ್ ಕೊಡಿ ಅಂತ ಕೇಳಿದಾಗ ಇಲ್ಲಿಗ್ಯಾಲಿಟಿ ಆಚೆ ಬರುತ್ತೆ, ಅವಾಗ ಏನೂ ಆಗಲ್ಲ.
ಅಲ್ಲ, ಇವರು
ಅದಕ್ಕೆ will be put to further problem.
ಅಲ್ಲ, if there is a confirmation order, my lord, that
Why have you rejected BBMP communication?
ಇಲ್ಲ BBMP ನಾನು BBMP ಮೇಲೆ ಏನೋ ಆಕ್ಷನ್
ಜಾರಿ ಆಗಿರೋದು 12/3
Yes, sir. How's the suit maintained?
ಎಲ್ಲಾ ಬಿಲ್ಡಿಂಗಿಗೂ ಒಂದೇ ದಿನ ಕೊಟ್ಟಿದ್ದಾರೆ. ನಾನು ಇದು 2 ಕೇಸ್ your lordship have granted same order.
Monday. Yes.
Blood confirmation order, your lordship may consider.
I am not holding LB roster here. Yes.
I agree, my lord, but my lord, without authority, my lord,
Monday.
BBMP direction is also without authority.
Monday, sir. Yes. List on Monday in the fresh matters list.
But tenants current ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರ.
ಅಲ್ಲಿ tenants ಇಲ್ಲ. Yes.
Tenants ಇದಾರೆ ಇದರಲ್ಲಿ.
Yes, sir.
I'll
Next.
produce the rent agreement also,
Produce it.
lordship permits.
Registry to print the name of ನಿಮ್ಮ ಹೆಸರು? ಲೋಕೇಶ. So and so as appearing for a respondent Bescom. Tenants ಇದ್ದಾರೆ ಅಂತ ಕೊಡಿ first.
I'll furnish the rent agreement itself.
Furnish.
I'll furnish.
Yes.
34.
Yes, sir.
My lord, I'll file a wakalatnama today, my lord. There may be copy may be served upon me. I'll file my objections today itself or tomorrow. Have it on day of tomorrow. My lord, my objection may be taken on record. That's all my submission.
Correct. Our objection ಬಂದ್ಬಿಡ್ಲಿ ಬಿಡಿ. But
26 ಅಲ್ಲಿ ಏನು ಆಗಲ್ಲ ಸ್ವಾಮಿ.
Vignesh, ಯಾವತ್ತಿದೆ?
26,
my lord.
26th. Yes,
My lord, I will just explain, my lord. How many times?
Wait, sir. Yes. Monday ಒಳಗೆ objection ಹಾಕ್ತೀರಾ?
We'll file it.
All right. List the matter on Monday at 3:30 PM. ಅಲ್ಬೇಡ, ಅದು DSG ಗೆ ಯಾವತ್ತು ಕೊಟ್ರಿ? ಯಾವತ್ತು ಮೇಡಮ್? SV ರಾಜು ಅವ್ರಿಗೆ ಯಾವತ್ತು ಕೊಟ್ಟರು? ಎಷ್ಟೊತ್ತಿಗೆ ಅದು? That's at 4:50. Morning. All right. List the matter on Monday at 3:30 PM.
Grateful, madam. Copy of the petition.
Objections, the petition, learned counsel Vignesh Shetty is directed to accept notice for the respondent. He shall file a statement of objections by, learned counsel would submit that he would file a statement of objections by the next date, i.e. Monday. List, Monday ಹೇಳಿದಲ್ಲ, 3:30 PM.
Grateful, madam. Deeply.
Yes.
Office serve, my lord.
Sir ಮಾಡಿದ್ರ? 26th ಅಲ್ವಾ ಇರೋದು?
26.
ಅವತ್ತೇನಾಗಿಲ್ಲ ಅಂದ್ರೆ ಸ್ಟೇ ಕೊಡಿ.
Grateful.
Both 5 and 34 together.
35.
ಇದು ಅದೇನಾ?
ಇದು ಅದೇನೆ, ಬಟ್ ಇದರಲ್ಲಿ ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇದೆ. ಕನ್ಫರ್ಮೇಶನ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇದೆ.
ಒಂದು ನಿಮಿಷ. I'm sorry, madam.
ಹೇಳಿ ಲೋಕೇಶ್.
Lord, ಇದು ಅಪಾರ್ಟ್ಮೆಂಟ್ ಪ್ರಾಜೆಕ್ಟ್, ಹೊಸ ಕನ್ಸ್ಟ್ರಕ್ಷನ್. ಯಾರು ಇಲ್ಲ ಇದರಲ್ಲಿ.
File your objections. Yes.
ಅಲ್ಲ.
ಏನು?
ಇದರಲ್ಲಿ
ಅದ್ರಲ್ಲಿ ಯಾಕೆ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಟೆನೆಂಟ್ಸ್ ಫೈಂಡಿಂಗ್ ಇರೋದೇ ಅದು.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇದೆ. ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಸ್ವಾಮಿ, ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇದೆ. ನಮ್ದು ಇನ್ನೂ ಒಂಚೂರು
ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಬಾಕಿ ಇದೆ.
ಇಂಟೀರಿಯರ್ಸ್
ಅಪೀಲ್
ಪೆಂಡಿಂಗ್ ಇದೆ. ನನಗೂ ಕಾಪಿ ಇಲ್ಲ. ನನಗೆ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಯ್ತಲ್ಲ ಅಂತ
ಕಟ್ತಾ ಇದ್ರೆ ನೀವು ಅನಾಥರೈಸ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ನ ನಡೀಲಿ, ಅಲ್ಲಿ ಅಪೀಲ್ ಸ್ಟೇ ತಗೊಂಡ್ಬನ್ನಿ, ಆಮೇಲೆ ಹೇಳಿ. ಎಸ್. ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್. ಒಂದು ವಾರ ಬೇಕಾ?
ಇದು ಮಂಡೇನೇ ಇರಲಿ ಸರ್.
ಮಂಡೇನೇ ಇರಲ್ಲ.
Appeal copy I'll produce. Appeal
Monday.
I'll be able
List
to
on-
only because the appeal is not at
List on Monday. List on Monday in the fresh matters list.
36.
Even public premises. ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ? ಕಾಪಿ ಇಲ್ವಾ ಜಾಫರ್?
ಫೈಲ್ ಕೊಟ್ಟಿಲ್ಲ.
You're already evicted?
ಅಲ್ಲ, ಲಾಕ್ ಮಾಡಿದಾರೆ ನಿನ್ನೆ. ಅದನ್ನೇ ಹೇಳಿದ್ನ.
What is the ground?
Flush my kindly see the annexure A. A notice
No
for-
enquiry is conducted?
No enquiry.
Learned,
Rule 5. Supreme Court
all
also
that
says.
is there, yes. Learned AGA is directed to accept notice for respondents 1 and 2. The counsel for the petitioner taking this court through the order passed would seek to demonstrate that there is blatant violation of Rule 5 of public premises
Public-
so-and-so rules. In as much as no enquiry as is mandated under the said rule is even conducted in the case at hand. In that light, there shall be an interim order as prayed for.
Lock me kindly.
ನೀವೇನ್ ಕೇಳಿದ್ದೀರಾ?
Fine.
As prayed for.
Since because of the
ಏನ್
latest.
ಕೇಳಿದ್ದೀರಾ
That's-
ಇಂಟ್ರಿ ಮಾಡ್ರಲ್ಲಿ? ಲಾಕ್ ಹಾಕಕ್ ಕೇಳಿದಿರಾ ತೆಗಿಯಕ್ ಕೇಳಿದಿರಾ?
ಇಲ್ಲ, ಅದರಲ್ಲಿ ಸ್ಟೇ ಕೇಳಿದೀನಿ, ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಈಗ ಅಲ್ಲಿ ಈಗ ನಿನ್ನೆ
ನೀವು
ಸಬ್ಸಿಕ್ವೆಂಟ್
ಕೇಳ್ಬೇಕಾದ್ರೆ ಅದು ಕರೆಕ್ಟ್ ಆಗಿ ಕೇಳ್ಬೇಕು.
ಸಬ್ಸಿಕ್ವೆಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್ ನಿನ್ನೆ ಆಗಿರೋದು, ಹಾಕಿದ ಮೇಲೆ ಅದು.
ನಿನ್ನೆ ಲಾಕ್ ಹಾಕಿದೆ.
ನಿನ್ನೆ ಲಾಕ್ ಮಾಡಿರೋದು. ನಿನ್ನೆ ಇಷ್ಟ
Learned counsel for the petitioner submits that the respondents have locked the premises yesterday, nene date haki, after filing of the petition. In the light of the interim order granted, the respondents shall open the lock and permit business of the petitioner which is subject to the result of the petition. Next. ಎಲ್ಲಿದು ಇದರಲ್ಲ?
DC ಕ್ಯಾಂಟೀನ್.
DC ಕ್ಯಾಂಟೀನ್. ಎನ್ಕ್ವೈರಿ ಯಾಕೆ ಮಾಡಿಲ್ಲ?
ಅವರು ನೋಟಿಸ್ ಕೊಟ್ರು, ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ಮೇಲೆ ಆರ್ಡರ್ಸ್.
ವೈ ಎನ್ಕ್ವೈರಿ ಮಾಡಿಲ್ಲ?
ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. They have not
ಬರೀ they have not appeared.
appeared
DC ಕ್ಯಾಂಟೀನ್ ಅಪಿಯರ್ ಆಗಿದೆ.
appear ಆಗಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ಮೇಲೆ posted for orders. No enquiries.
ಜನಕ್ಕೂ ತೊಂದರೆ ಆಗುತ್ತೆ ಅಲ್ಲಿ. ಕೊಡಿ. Yes.
But there are some fans of.
ಬೇರೆ ಏನ್ ಕಂಪ್ಲೇಂಟ್ ಇಲ್ವಾ?
There are some fans of DC canteen.
ಕರೆಕ್ಟ್. ಅಲ್ಲೇ ನೋಡಿ. Yes.
hand delivery order.
God, let's give it. Yes. Let the canteen run. ಸುಮ್ಮನೆ ಜನಗಳಿಗೆ ತೊಂದರೆ ಆಗತ್ತೆ ಅಲ್ಲಿಂದ, ಇಲ್ಲ ಅಂದ್ರೆ.
37.
Yes, Venkateswara. ಏನ್ KEB?
AERC, the temporary connection, my lord, is disconnected.
Temporary connection itself is disconnected.
7/2/2025, they may not sanction the power. And meanwhile, my lord, the BBMP writes to them.
ಇದು BBMP ಪ್ರಾಬ್ಲಮ್.
Alleging deviation. Nevertheless, my lord.
ಅಲ್ಲಿ BBMP ಅಪೀಲ್ ಹಾಕಿದ್ದೀರಾ ಅದ್ರ ಮೇಲೆ?
My lord, suit is filed, my lord, the suit, my lord.
ಹೆಂಗ್ ಬರುತ್ತೆ BBMP
My
action?
lord, what had happened? Notices were not issued to us. My lord, when there was a threat, my lord, we were before the, my lord, the civil court. Nevertheless, my lord, I have stated in the petition, my lord, we will approach, my lord, the competent authority because notices were not served.
Then I'll have to stay Srinivas's matter also.
My lord, in the instant case, my lord, BBMP itself, my lord, communicates with regard to the civil court's order and says that, my lord, the status quo be maintained. Please look at, my lord.
Where is,
page
you show me that? Yes.
Page 99 may kindly be seen. Annexure R, page 99.
ಮೇಡಮ್ ಶ್ರೀನಿವಾಸ್ ನಾಳೆ ಹಾಕಿ ಎರಡು.
ಸ್ವತ್ತುಗಳಿಗೆ ನೀಡಲಾಗುವ ತಾತ್ಕಾಲಿಕ ವಿದ್ಯುತ್ ಸಂಪರ್ಕವನ್ನು ಕಡಿಸಿಕೊಳ್ಳಲು ಹಿಂಪಡೆಯಲು ಪತ್ರ ಬರೆಯಲಾಗಿತ್ತು. ಸದರಿ ಸ್ವತ್ತಿನ ಮಾಲೀಕರು ಉಲ್ಲೇಖದ ರೀತ್ಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾವೆ
Lokesh so and so is directed to accept notice for the respondent. The learned counsel for all the respondents. ಅಲ್ಲ ಇವರು AGA 1. Remaining respondents Lokesh so and so. The learned counsel for the petitioner takes this court through an order of the civil court granting status quo and the BBMP themselves directing status quo to be maintained qua the property in terms of the connections as well. Therefore, there shall be an interim order of stay as prayed for. Srinivas ನಾಳೆಗೆ ಹಾಕಿ ಮೇಡಮ್.
My lord, by way of an interim order, I have sought, my lord, reconnection of the temporary supply, not the permanent one.
Temporary supply.
Please.
R5 BBMP ಇದೆ.
The BBMP ಇದಾರಾ?
I have made them.
R5 ಗೆ ಪವನ್ ಕುಮಾರ್ ಅಂತ ಕೊಡಿ. ಆಮೇಲೆ interim, there shall be interim order of as prayed for, which is restoration of temporary connection.
Great.
Yes. Next.
38.
Yes, Mutanar.
The petitioner availed the education loan.
Education loan.
11,90,000.
ಈಗ ಎಷ್ಟಿದೆ?
She has completed the MBBS course on 12/6.
ಎಷ್ಟು ಡ್ಯೂ ಇದೆ ಈಗ?
Due 30 lakhs.
30 ಲಕ್ಷದ?
ಯಾಕೆ ಕಟ್ಲೇ ಇಲ್ವಾ ತಗೊಂಡ್ಮೇಲೆ?
ಇಲ್ಲ, ಅವ್ರು ಏನಾಗಿದೆ ಈಗ afterwards she has taken PG. Yeah, she has complete PG as a entrance exam. She has completed exam and
ಈಗ
get this-
ಆಯ್ತು, ಈಗ ದುಡ್ಡೇ ಕಟ್ಟಿಲ್ವಾ ತಗೊಂಡ್ಮೇಲೆ?
ಇಲ್ಲ ಅವ್ರನ್ನ ದುಡ್ಡು
ದುಡ್ಡು
ಕಟ್ಟಿಲ್ಲ.
ಹೋಗಲಿ ಅಲ್ಲಿ
ದುಡ್ಡು ಕಟ್ಟಿಲ್ಲ.
during the after sanction loan that interest has to be debited, even interest also not debited and the account has become
ಏನ್
empty
ಎಜುಕೇಶನ್
and-
ಲೋನ್ ಫ್ರೀ ಅಂತ?
ಹೌದು
ಕೊಲಾಟ್ರಲ್ ಏನ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಅದು-
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹಾ,
That
ಅದನ್ನೇ
is
ಆಕ್ಷನ್ ಸೇಲ್.
auction sale.
ಎಸ್ ಸರ್.
That my
ಹೌ
lord,
ಮಚ್ ವಿಲ್ ಪೇ?
she has now my lord get the seat in PG.
ಅದೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ ಸರ್.
With 30 lakhs.
30 ಲಕ್ಷ ದುಡ್ಡು ತಗೊಂಡ್ಮೇಲೆ ಕೊಡೋದೇ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಹೆಂಗೆ?
ಕೊಡದೇ ಇಲ್ಲ ಅಂತ.
ಮತ್ತೆ ಕೊಟ್ಟೇ ಇಲ್ವಲ್ಲ?
ಅವ್ರು
ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ, ಪ್ರಿನ್ಸಿಪಲ್ ಇಲ್ಲ. ಎಜುಕೇಶನ್ ಲೋನ್ ಇಸ್ ಫ್ರೀ.
ಫ್ರೀ ಅಂತ ಅಲ್ಲ.
ಮತ್ತೆ
ಅವ್ರದ್ದು
MBBS.
ಅದೇ
ಎಸ್ ಸರ್.
ಇದರಲ್ಲಿ
ಸೇಲ್ ಸ್ಟೇ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಕೊಡ್ಲೇಬೇಕು.
ರೆಸಿಡೆನ್ಷಿಯಲ್ ಹೌಸ್ ಅಲ್ಲ.
ಮೇ ಬಿ ಏನಾದ್ರೂ ಇರ್ಲಿ.
Now she has joined the
ಮೇ ಬಿ ಡೋಂಟ್ ಟೆಲ್ ಆಲ್ ದಟ್. 5 ವರ್ಷದಿಂದ ತಗೊಂಡು ನಾಟ್ ಎ ರುಪಿ ಆಫ್ ಇಂಟ್ರೆಸ್ಟ್ ಯು ಪೇಡ್ ಬ್ಯಾಕ್ ಆಸ್ ಇಫ್ ಇಟ್ ಈಸ್ ಎ ಫ್ರೀ ಲೋನ್ ಗಿವನ್ ಟು ಯು.
ಹಾಗೇನಿಲ್ಲ.
ಹಾಗೆ ಇರೋದು, ಹಾಗೇನಿಲ್ಲ ಅಲ್ವೇ ಅಲ್ಲ.
21 ಮೊರಟೋರಿಯಂ ಪೀರಿಯಡ್ ಮುಗಿಯುತ್ತೆ. ಅವಾಗ ಇದು ಕೋವಿಡ್ ಇರೋದ್ರಿಂದ ಎಲ್ಲ ಪ್ರಾಬ್ಲಮ್.
ಕೋವಿಡ್ ಹೋಗಿ 4 ವರ್ಷ
ಇಲ್ಲ
ಆಯ್ತು. ಮತ್ತೆ ಕೋವಿಡ್
22 ಜೂನಿಗೆ ಮುಗಿಯುತ್ತೆ.
ಎಷ್ಟಿದೆ ಡ್ಯೂ ಈಗ? 30 lakhs.
30 lakhs.
37,000.
Pay 5 lakhs, I will stay it.
Please.
Sale will go on, don't issue the sale certificate, subject to
yes,
payment of 5 lakhs, because chronic default.
Yes, yes.
The petitioner, projecting herself to be a student, is at the doors of this court, calling in question an auction that is slated to be held tomorrow, auctioning the property.
24.
Or 24th, auctioning the property, the residential property of the petitioner.
Petition number 2.
For the second petitioner. The first petitioner avails a loan, an educational loan of rupees 11 lakhs,
11,90,000.
of rupees 11,90,000.
On
In the year?
2/7/2016.
On 2/7/2016. 8 years pass by. The first petitioner has availed the loan and forgotten the loan. Not a rupee is paid, even as interest or principal for the last 8
Tax
years.
have been paid, my lord. December.
For over 8 years. And for the first time remits 2 lakhs to the bank. The counsel for the respondent bank submits that the loan amount today is close to
30 lakhs 36,000.
30 lakhs 36,000.
772.
In the light of the fact that the petitioner, a student who has availed the education loan 8 years ago and not bothered to pay even a rupee of interest to the bank, no indulgence of stay of the auction would be granted without any condition. The sale shall go on. The bank shall not issue the sale certificate in favor of the auction purchaser, subject to the condition that the petitioner would pay 5 lakhs to the bank in the next 2 weeks. List the matter on 7th April. In the event the petitioner would not deposit the amount in the next 2 weeks from today, the bank is at liberty to issue the sale certificate and take the sale to its logical conclusion. Yes. 39 same order. 37 ಏನಾಯ್ತಲ್ಲ ಅದು same order. Next.
Just for hand delivery of the order.
ಎರಡು ಕೊಡ್ತೀವಿ. Next. 3-4 ಇದೆ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಮಾಡ್ಬೋದು.
40.
Yesterday's matter.
I had a word with the medical superintendent, my lord. He has no objection if your lordships were to pass an order.
What order?
My lord, directing them, my lord, to submit the report to the prison.
To confirm the medical condition.
That's the prayer that is sought.
8 of the HIV and AIDS Act says that
I
unless there
will
is a
not
court
dispose
order.
this. I will direct him to do it and then take it on the next day.
What has happened is, my lord, the report that I am not privy to it because they can't disclose what the
No, there
information
are,
is.
it's undisclosable.
It's undisclosable. What
ailments.
they say is, my lord, the procedure that has been adopted is suspect.
No, no, sir.
What they wanted
He
to
is
convey.
suffering from terrible
He'll-
disease.
my lord-
Procedure ಬಗ್ಗೆ ಹೋಗ್ತಾ ಇದೆ. The petitioner is before this court seeking a direction to the Medical Board Victoria Hospital to provide the medical report and medical certificate of the petitioner and transmit it to the Chief Medical Officer of the Central Prisons Hospital. The keeping the petition pending, I direct the respondent number 2, Victoria Hospital, to furnish all the medical reports of the petitioner to the Chief Medical Officer of Central Prisons forthwith. List the matter on Tuesday in the fresh matters list. Great. You communicate. Release ಮಾಡ್ತೀನಿ. Communicate. Yes, next.
41.
Abnormal increase in the license fee and
Your
renewal
Lordship,
fee.
This is the notification, this is 2023 notification which they are
It has been
challenging.
stayed by this honorable
No, no,
court,
that is
Madam.
regarding
Annexed.
property mark. That's the
No, no,
stay is
entire
regarding,
same notification, entire notification has been stayed.
no, no,
Section B
there's
make
no
it-
clarity. And
One
we have
minute,
not
page.
demanded,
Page.
Page 21, my lord.
that is regarding,
And the relevant.
dates are
portion is-
different,
One minute. 1 minute.
22 is the relevant portion.
1 moment.
property mark.
1/4/2024. Impugned communication. Notification ಅಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ.
ಅಲ್ಲ ನೋಟಿಫಿಕೇಶನ್
ಮತ್ತೆ ಈಗ ನೋಟಿಫಿಕೇಶನ್ ಸ್ಟೇ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರಿ?
8/4 ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದು.
You said notification is stayed in its entirety. Where is that stay? Tell me. What is stayed is one communication dated
It is regarding the increase-
1/4/2024.
Chiponier state.
It is regarding the increase in the renewal fee, my lord. Same thing.
Notification and stay ಆಗಿಲ್ಲ.
ಅಲ್ಲ, ಇದು ಕೊಡಿರಿ.
Notification stay.
I have the
All right. ಈಗ
I'll seek further instructions and.
again, what is the
Only on the controversy.
what is the urgency now?
25th is the last day
For what?
for applying for renewal, my lord.
Renewal of license for what?
Please, madam.
Controversy.
For all the controversies.
All controversy.
ಒಂದಕ್ಕೆ 40-50 ಸಾವಿರ ಜಾಸ್ತಿ ಕೊಡ್ಬೇಕು.
Monday.
List on Monday in the fresh matters list.
Hello, Swami, Tuesday.
25th last date ಅಂತ ಇದಾರೆ?
Monday.
Monday 24th. Yes, next.
42.
ಅಭಿವೃದ್ಧಿ ಸಂಸ್ಥೆ.
Your Lordship, since from 2015, I am of the tenant under that respondent, Your Lordship.
ಯಾವ ದೇವಸ್ಥಾನದಲ್ಲಿ ಸರ್?
Yeah, hospital.
Hospital.
Cycle stand for the cycle stand.
ಈಗ ಏನಾಗಿದೆ?
Now they call for the fresh tender, Your Lordship, without terminating my tenancy.
ಹಾ.
So in the Your Lordship, I
ಏನ್
have
ಸೈಕಲ್ ಸ್ಟ್ಯಾಂಡ್?
cycle stand. Now
Then
that
DGA is directed. ಯಾರಿದಾರಲ್ಲಿ? ಸ್ಟೇಟ್ ಅಲ್ವಾ?
Chitteri Hospital.
Lana DGA is directed to accept notice. Jafar, AG na HCGP na? AG is directed to accept notice for the respondent. The petitioner is said to be running a cycle stand on it being leased out to the petitioner since 2015. The learned counsel of the petitioner submits that a tender is called for the said place as a bolt from. How did you enter tender?
ಹೌದು.
ಮತ್ತೆ term ಮುಗ್ದೋಗಿದೆ.
term ಮುಗಿದೋಗಿದೆ,
ಮತ್ತೆ?
but repeatedly 2015 ಇಂದ they extend, but
We'll see.
termination.
Cycle stand ತಾನೆ. Sounds. 2 and tender call for maintenance of 2 and 4 wheeler. Maintenance ಅದು?
ಬಾಡಿಗೆ ಆಧಾರದ ಮೇಲೆ ನಿರ್ವಹಣೆ ಮಾಡಲು ಟೆಂಡರ್.
Just check this, Shamanth. Learned HCGP is directed to accept notice for the respondents. List the matter on next Thursday in the fresh matters list. Status quo, the tender be maintained till the next date of hearing. Copy ಈಗಲೇ ಕೊಡಿ. Petitioner to serve 2 sets of papers upon the council upon the HCGP forthwith. Next.
Orders 43.
My lords, although they have complied with the interim order, they have failed to discharge their own subsequently, my lords. It's been 3 years.
Oh. ಅದು EMI ಕೊಡಬಾರದು
The
ಅಂತಿದ್ಯಾ?
current outstanding amount is.
ಮತ್ತೆ yes, sir.
Currently, the only
ಇದು ಸ್ಟೇ
submission-
ಕೊಟ್ಟಿದ್ದು only for a particular purpose. That doesn't mean you should stop payment.
I highly obliged. with what the
No,
honorable
sir,
court
no
has done.
obligation here. ಕೊಡ್ತೀರಾ ಇಲ್ವಾ ಅಷ್ಟೇ?
ಇಲ್ಲ, my instruction as of now from my client is he's out of station and day after
Oh, that
tomorrow. he's
case
coming
also
here.
will send it out of station.
My lords, the current outstanding amount is 42 lakhs.
List on learned counsel for the petition.
2 weeks time is given. He would be
Respondent-
interested in
one
one
minute.
time settlement.
Respondent bank, so this ಒಂದು ಕೆಲಸ ಮಾಡಿ ಬೇಡ. This court on a coordinate bench of this court on 11/2/2022 had passed the following order. The interim order is complied, but the EMI is not paid for the last 3 years, as if this court has stayed the payment of EMI. Therefore, the amount today has grown to 42 lakhs is the submission of the counsel for the respondent. Therefore, if substantial payment is not paid by the next date, the petition would be dismissed. List the matter on 28th in the fresh matters list. Next.
Manoj, appearing for the petitioner.
What is this memo? So and so, I have for permission.
It's now, this is the land which is owned by the petitioners.
Interim order idea?
Interim order is there. That is not to evict any construction. Now, for the last 8 years, the respondent MESCOM has not been paying my rents.
Oh, MESCOM has to pay your rents.
Pay me rents. They are in occupation of the land. One. Second is they had.
Anyway, it's come up in orders. We'll post it in B group. List the matter.
B group.
B group.
If it could be taken up at fresh matters.
No.
There's a short point of
List the
consideration.
matter. List the matter in B group. It's a monetary claim. Yes. ಯಾರಿಗಾರ ತೊಂದರೆ ಆಗ್ತಾ ಇದ್ರೆ ನೋಡೋಣ.
The rent that they are
No problem.
occupying close to 1 acre.
We'll decide it, sir. We'll decide it. You're a landlord?
I am the landlord, Manoj. 1 acre, 34 guntas of land in Udupi, Manoj. But the problem is they're
List
only
them.
paying 275 rupees every year. They've not been paying.
What interim order is there?
Not to evict any construction, not to put up any construction.
Parole, yes. List the matter on 4th April in B group. Yes, next. Interim order subsisting will continue to the next.
Interim order is still further order.
And then leave it. Ashte haki.
Grateful.
45.
Post immediately after service of notice upon the second response R2 to R4. Interim order ideyala? Interim order subsisting will continue to the next date of hearing. Next.
My lordships, yesterday, the other 2 matters were listed. There are 4 connected matters.
Number kodi. Birth kodi. Tag the petition along with zones. 46 the same. Vacating stay.
Got a tenant's petition filed, Lord, for against the section 14 order. Lord, I want to show you, Lord, one document, Lord, which in my humble submission will make this
Sir,
fairly apparent.
petition.
ಅಲ್ಲ, ಆಯ್ತು.
ಏನು ಅವ್ರು ಪರವಾಗಿ ಮಾತಾಡ್ತಿದ್ದೀರಿ?
ಇಲ್ಲ ಇಲ್ಲ.
Yes.
I don't have that much of courage.
Yes.
SBI, my lord, we gave a.
You have loan is taken over by Kotak Mahindra Bank now?
Yes.
All
They
right.
are taken over. Kotak
Yes.
Mahindra Bank has taken over.
Hmm.
Please come to my lord page 101.
ಈಗೇನೋ ಕೊಟ್ರಲ್ಲ ಸರ್ ಏನು?
I'm sorry, list of dates.
ಕೊಟ್ರ ಈಗ? ಅಲ್ಲ ನನಗೇನೋ ಕೊಡಕ್ ಬಂದ್ರಲ್ಲ.
ಕೊಟ್ಟೆ, ಆಮೇಲೆ ಇವರೇನೋ ಅವರೇನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ ಶುರು ಮಾಡಿದ್ರೆ ನನ್ನ ಪರವಾಗಿ ಇಟ್ಕೊಂಡು ನಾನು.
ಎಸ್ ಸರ್. ನಿಮ್ಮ ಪರವಾಗಿ.
ಅಲ್ಲ, ಆಗ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತೀನಿ.
Yes, sir.
101, my lord, if your lords come to. They themselves, my lord, SBI, my lord, was the person. They gave a no objection, my lord, for leasing out.
This is vacating stay application. Yes. SBI gave?
Bell's house, my lord, at so-and-so. We have come to know that you are leasing out substantial portion of the above properties against rent and advances. Please be informed that we hold first charge in the above properties while the company's account with us remains highly irregular. Accordingly, any receipt from the property should be paid directly to the credit of your account with us. In this connection, please inform the details of any other properties, assets, lease let out by the company and the lease income deposits received from the company for the same. Principal borrower, my lord, is Bell's house at Carmack Street, Bell's factory. So, my lord, they say that, if you have leased it out, pay that directly. So, my lord, we have been sending, my lord, they leased out, my lord, under registered lease deeds. Please come to page 103, my lord, and 121. 103, my lord, is a registered lease deed. Then, my lord, 121, another lease deed. We have been, my lord, sending the amount, my lord. Our lease, my lord, is, we are sublessees under them, page 65.
Yes.
Ultimately, my lord, we have been remitting the amount, my lord.
To whom?
Fifth respondent, which is, my lord, the lessee, we have been paying it to them. They have to, my lord, remit it to the
bank. Who is the borrower?
Borrower, my lord, is Wells Control.
Borrower is the 4th respondent.
Yes.
So borrower has leased it out to the 5th respondent.
Correct.
Then the petitioners are sublessees from the hands of the fifth respondent.
Correct.
The amount in due is of the borrower.
Yes, ma'am.
That is the fourth respondent. So now the,
Property is
you,
mortgaged.
Huh?
This property is mortgaged.
this
to the
property
bank.
is mortgaged. Now the sublessee will have to pay it to the lessee or to the borrower. That is the question, is
Borrower
it?
has gone under liquidation.
Not
I
the
think.
question, my lord.
So
First,
fourth, the borrower has gone into liquidation.
borrower has gone, the issue is slightly different. This document is very clearly a fraudulent document, which
Which
your lordship saw
document?
at page 101.
Fraudulent document, why?
Yes, I'll tell you lordship why. They have produced, my lord, a document, the official liquidator has produced a document in the Calcutta High Court, which is the correct document, which my lord will come to page 577 of the statement of objections.
577 of statement of objection.
Yes, we produce all the pleadings, my lord, in the Calcutta High Court, where, my lord, these documents have been placed on record. The correct document, your lordship will say everything is similar, the last few pages, my lord, 577. Annexure R10. Please see this letter, my lord. This letter was only with respect to Bell's house at Kamak Street, that's in Calcutta, not with respect to the Mysore property at all.
So Metkalli is added.
It's been added. And then you please see, my lord, this is the document filed by the official liquidator before the High Court of Calcutta. This document is produced to say, no, that is the basis on which we have entered. Otherwise, my lord, it's a violation of 65A of the Transfer of Property Act. Therefore, to get over that, this document is produced.
All right, well, sir, I'll take it another day. Other day, we'll hear it completely and finish.
Please.
Yes. ಯಾವತ್ತು ಆಗ್ಬೋದು? Monday, Tuesday? Tuesday or Wednesday, ಯಾವತ್ತರ?
1 minute.
ವಚನ್ ನೀವು ಯಾರಿಗೆ? All right.
All same property, my lord, different portions.
You're okay with?
You've given me, not fine.
We have given.
That also is there.
Wednesday, no?
Wednesday ಆಗ್ಬೋದು, sir?
26. I'll be here.
Yes, then.
In fresh matter. Or same.
In the same stage,
Same,
let it be in
same.
same stage.
Yes, same.
Because it's interlocutor, it's as good as hearing the matter.
But it is hearing only.
Yes,
So
yes.
we'll not take, my lord, more than we'll that. List
No,
of
no
dates in
problem. Because it's vacating stay, I'm
I agree,
taking.
ma'am. Yes, entirely.
List on 26th in the same stage, heard so and so on Thakuta. Interim order subsisting will continue to the next date of hearing.
My lord, I am for the respondent bank, my lord. This is the OD account. As on today, there is a 78 lakhs due, your lordship. OD account, your lordship.
Order complaint. Regularize ಅವರು restructuring ಮಾಡ್ಲಿಕ್ಕೆ.
OD ಸ್ವಾಮಿ ಇದು restructure ಬರಲ್ಲ ಸ್ವಾಮಿ OD account.
OD account ಬರುತ್ತಾ? ಬರಲ್ಲ ತಾನೆ? ಮತ್ತೆ ಪೂರ್ತಿ ಪೇ ಮಾಡ್ಬೇಕು. OD account ಆದ್ರೆ ನೋ restructuring. It's overdraft over the account. ಯಾವಾಗ ಪೇ ಮಾಡ್ತೀರಾ?
78 lakhs ಇದೆ ಸ್ವಾಮಿ.
ಮೊನ್ನೆ ರೀಸೆಂಟ್ಲಿ ಕಟ್ಟಿರೋದಷ್ಟೇ.
ಆಯ್ತು, just ಟೈಮ್ ಕೊಡ್ತೀನಿ, ಕಟ್ಬಿಡಿ. ಈಗ 4 weeks ಬಿಟ್ಟು ತಗೊಂತೀನಿ. You pay another 20 lakhs. Place the matter on 15th April. 15th, on 17th April. Interim order stands, learned counsel for the petitioner submits that interim order has been complied with. Counsel for the respondent bank submits that it's an overdraft account and cannot be regularized until the entire payment is made. Therefore, the petitioner shall pay another 20 lakhs on or before the 17th of April. List the matter on 17th.
Much obliged.
Where there, Deepak?
There as a.
ಯಾವ್ದಕ್ಕೆ ದೀಪಕ್?
47 ಅಲ್ಲಿ. So.
47 ಅಡ್ಜನ್ ಆಯ್ತಲ್ಲ?
I'm sorry.
This is 48. 47 I posted it on 26th. You are for the official liquidator?
Yes.
Yes. Your document is now become everything. Yes.
I just had
Much
my objections.
On 26th. Yes.
Sorry, I was in the other courts.
No problem. Yes.
49.
For the petitioners, madam. The assistant commissioner ordered the application filed by the second respondent.
Office objections ಏನ್ ಹೇಳಿ?
Office objections ಅಲ್ಲಿ.
Gift deed ಆ?
Gift deed, madam.
ಎಷ್ಟು gift deed ಏನ್ condition ಇಲ್ವಾ?
Condition, there is no condition, madam.
Where have you driven the father now?
Father is not, property is mortgaged before the bank. So lordship has granted annexure G or interim order against the bank not to take course steps. Lordships kindly see the annexure H, annexure G.
Where is the father?
Father is taking the property.
Which property?
He is the subject matter of the property.
Gift ಏನ್ ಮತ್ತೆ?
ಅದೇ property ನೇ gift. After obtaining the property by gift by the.
ನೀವು ಅಲ್ಲೇ ಇದ್ದೀರಾ?
ಇಲ್ಲ, ನಾನು ಗಂಡನ ಮನೆಯಲ್ಲಿದ್ದೇನೆ. Husband, wife. The petitioners.
What are you paying as maintenance to the father?
He has not filed any application. Another 2 daughters are there. He received a pension.
ನೀವು ಸಣ್ಣ?
ಇಲ್ಲ, ನಾನು daughter, first daughter.
Daughter.
Only 3 daughters are there. Another 2 daughters are staying with him.
Anyway, but respondent here,
Dhanappa is appeared.
there is no representation behalf the respondent. Early hearing ಹಾಕಿರೋದು ಯಾರು?
ಇನ್ನೊಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಇದೆ.
Tag ಮಾಡಿ. Tag this petition along with
28,729 of 2023.
Less them both after 2 weeks. Interim order subsisting will continue till the next day.
Interim order ಇಲ್ಲ.
ಇಲ್ವಾ ಇದ್ರಲ್ಲಿ?
ಇವತ್ತು ಕೊಡು.
ಬರ್ಕೊಡಿ. ಅದು ನಂಬರ್ ಬರ್ಕೊಡಿ.
ಕೊಡ್ತೀನಿ.
ಹಿಂಗು ಅದರಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಾ?
ಅದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದೆ.
ಎಸ್ ನೆಕ್ಸ್ಟ್.
ಇಲ್ಲ, ಅದರಲ್ಲಿ ಸ್ಟೇ ಅಂದ್ರೆ ಬ್ಯಾಂಕ್ ಅಗೇನೆಸ್ಟ್ ಇದೆ.
ಇದರಲ್ಲಿ ಏನಿದೆ?
ಇದು ನಾನು AC ಆರ್ಡರ್ ಸ್ಟೇ ಕಾಡ್ತೇನೆ. ಅಲ್ಲಿ ಮಾರಾಟ ಮಾಡಕ್ಕೆ ಹೋಗ್ತಿದ್ದಾರೆ ಪ್ರಾಪರ್ಟಿನ. ಆಫ್ಟರ್
Status quo where the property be maintained till the next date of hearing. Next.
ಮತ್ತೆ petition interim order complied.
Bank, my lord.
The conditional order.
Early hearing ಯಾರು ಹಾಕಿರೋದು?
I had filed for her.
Why sir?
Lord, the sale, my lord, their challenge sale notice.
Sale did not take place?
Sale took place, my lord,
Ah.
and the successful bidder has deposited the entire amount also.
Entire amount?
ಮಾಡಿದ್ದಾರೆ. 1 crore 81 lakhs.
There was an order complied, my lord. 45 lakhs I paid. 45 lakhs.
When was the sale and when enters over? What is notice?
I paid the entire 25% of the amount I
ಆಯ್ತು,
paid.
1 crore 81 lakhs ಪೂರ್ತಿ ಯಾವಾಗ ಕಟ್ತೀರಾ ಹೇಳಿ?
No, my lord, because that is the sale amount. My liability is not that much.
ಎಷ್ಟಿದೆ?
My liability is 1 crore 40 lakhs.
ಅದು ಕಟ್ಟಿ.
That within 3 months I'll clear it.
Yes.
Lord,
What
NP
happens
of
to the auction purchaser who has paid the entire amount?
That
You know, Supreme Court
yes,
says. nothing
interest
can be
part
done.
will whatever that deposit.
Interest and solatium both. If you want, there is already order of the coordinate bench staying it.
Lord, but your lordship may kindly see as on 21/1/2025 itself, the entire sale consideration has been deposited.
No, correct. That
And
coordinate bench has recorded that also.
No, my lord, here in this case, there is no sale notice served to the
NPA
borrower.
My lord, NP of 2016, my lord. They did not fix
Bank
for
is-
9 long years.
My lord, the bank
What
is
were you
filing
doing
statement
for
of
9 long
objection.
years?
Sir,
What were you doing for 9 long years?
my lord, the entire process, my lord, they kept on challenging it and 13 to 13/4, in fact.
ಮತ್
other
ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಏನಂತ ಇದ್ದೀರಾ?
Here, that they have, sale notice, they are not served to the borrower. They are given the statement of objection. They are producing the 13 to notice proof of service, my lord.
Where is the sale notice?
My lord,
Furnished.
Kindly see there,
Notify ಮಾಡಿಲ್ವ ಸೇಲ್ ನ?
ಮಾಡಿದ್ವಿ.
ಇವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ದೆಲ್ಲಿದೆ?
page number 16, my lord, statement of objection.
Produce ಮಾಡಿ ಎಲ್ಲ.
I will produce.
List the matter on 9th April.
Please.
Interim order.
Interim order subsisting will continue till the next date of hearing. Comply ಮಾಡಿದಿರಾ ಇದನ್ನ? 25% payment.
25% is complete.
Because the coordinate bench captured everything. Yes, next.
Please. Okay.
Lord, I appeal for the respondent.
See, Jagdish, GM police. ಏನು?
Lord, they have questioned the
Yes.
notice issued by the CRE, sir.
Lord, in the last date of hearing, we are not, the petitioner has not stretched the
Who is that?
here, my lord.
Who is that? Which council? ಅವ್ರಿಗೆ ಬರಕ್ ಹೇಳಿ.
Lordship, after receipt of the notice from this honorable court of this petition, they have taken the order from the coordinate bench to expedite the proceedings within 2 months of the.
ಕೊಡಿ. Who has taken?
Lordship.
Who has taken?
Requesting respondent, my lord.
Respondent, 3 and 4.
Respondent number 4.
3 and 4.
Again, what is the matter?
Matter is concerning to, my lord, there is a, the petitioner, number 2 has filed in a 498 case against the respondent number 3 and 4. There is a matrimonial.
One minute. Petitioner?
Petitioner is a wife of the, petitioner number 2 is a wife of the respondent number 4, my lord.
All right.
Respondent number 3. My lord, she has filed a complaint before the Chandralaya police station
All
for
right.
498.
All right.
My lord, in order to harass the petitioners, they have filed a complaint before the DCRE alleging that we are in possession of some fake caste certificate.
Hmm.
Whereas, my lord, my grandfather has this document, school document is produced in page number 39, my lord.
Yen caste?
Lord Chennadasari they have
SC.
taken.
Hmm.
In fact, they belong
After
to
the-
Dasari community.
After due verification of by the Tahsildar,
Oh.
the certificate has been given.
Where is the Tahsildar's?
It is in page number 38, my lord. Annexure C, J, the Annexure K. Para number 2, my lord.
ವೆನ್ ಕೃಷ್ಣಪ್ಪ ಅವರು ಚೆನ್ನದಾಸರು SC ಜಾತಿಗೆ ಸೇರಿರುತ್ತಾರೆ ಎಂಬುದಾಗಿ ತಿಳಿಸಿ ಇದಕ್ಕೆ ಸಂಬಂಧ ಗ್ರಾಮಸ್ಥರ ಮಹಾಜರ್.
This is the report given by the Tahsildar, my lord, based on the report of the Deputy Tahsildar, who has conducted the Mahajar and report in the village.
This Krishnamurti is the husband, is it?
Krishnamurti is father-in-law.
What proceedings expedite ಮಾಡಕ್ಕೆ?
They have given a complaint before the DCRE in order to investigate the certificate of.
ಇಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಾ?
Yes, Swami. Last time only we have not stressed for the interim prayer. Now they have taken the order from the coordinate to expedite the proceedings. So the interim relief may be granted to avoid the further.
The petitioners.
Lord, all that will not, the records will be that they are.
One minute. Well, we'll get the records. 1 minute, sir. The petitioners are, the third petitioner is the daughter of, who is this second petitioner?
Second petitioner.
And who is third petitioner?
Third petition, my sister, my lord.
The second petitioner, so the petitioners 2 and 3 are the daughter of the first petitioner. The third respondent is the wife of, is the husband of the second petitioner. Their marriage is said to have floundered. On floundering of the marriage, it transpires that the third respondent approaches the district, DCRE,
Yes. My sister.
approaches the CRE cell, Mysore, alleging that the caste certificate of the petitioners 2 and 3 are fake. The learned counsel for the petitioner takes this court through an order, an endorsement of the Tahsildar, which depicts that the petitioner belongs to petitioners 2 and 3, or the petitioners belong to Channadasar, a scheduled caste. The communication in the endorsement reads as follows. It is by the Tahsildar, in which the Tahsildar observes that Mahajar is drawn from the revenue inspector of the taluk. The further development is that the husband approaches, the fourth respondent approaches the coordinate bench in writ petition 3114 of 2025 and seeks a direction of the investigation be expedited in the aforesaid case. Therefore, the petitioners have moved the matter on the ground that the respondent CRE cell is now wanting to investigate into the matter. In the light of the aforesaid, there shall be an interim order of stay of all further proceedings / investigation conducted by the CRE cell till the next date of hearing. The respondent shall place on record the entire original, the respondent shall place the original records of the complaint and all other investigation that is done by the next date. Yes. Next.
52.
Two weeks to do the need.
Yes, matter, my lord. I have a submission to make.
Yes, sir.
The emergent notice was issued on 30th January 2025, my lord. I'm challenging the order of the district commission in this matter.
So what?
Please, my lord, after the.
Go before
issuance
the
of
National Commission.
Emergent notice. my lord.
Go for the State Commission.
My lord, I'm seeking the indulgence of this honorable
Why,
court under
sir?
the order Article 227, my lord.
So seriously,
Order
sir?
is such that.
What is it? Tell me.
Please, my lord. The order, impugned order is that, my lord, order sheet, my lord, page numbers 15.
What is the order of the commission?
The order of, I filed an amendment application, my lord, under order 6 rule 17. And the application on the same day of filing, my lord, even the.
This
the
has to be
opposite-
gone before the, it's not a case without jurisdiction. no,
Emergence
sir.
notice was already issued, my
So
lord.
what?
My lord, 1 minute, my lord.
Hmm.
Kindly bear with me, my lord. The amendment application was rejected on the ground that the application was not filed under the proper provision. They had not given an opportunity to me, even to do hearing on the application, my lord. Even the opposite side was not on record at that point. My lord, the grievous part is, my lord, after the issuance of the emergent notice by this honorable court, I didn't press for a stay order, my lord, at that time because there was no impediment at that time. But subsequently, my lord, there has been a substantial development in the case, my lord. Even providing an opportunity for me to lead evidence, my lord, it's been posted for arguments.
When?
Very next day, my lord.
When?
Very next day.
When
May I
is
pass-
the, when is
may-
the next date?
May I pass on the
When
order
is,
sheet,
I'm asking you a date. When is the next date?
coming, my lord, April, my lord, April 5th.
List on Monday in the fresh matters list. Next. Next.
Three.
Post immediately after service of notice upon the respondent, interim order subsisting will continue to the next date of hearing. Next.
54.
Same order. Interim order there.
54.
54, there is an interim order?
There's no interim order, madam. It's only seeking for a mandamus onto the authority, the third respondent, to hold a forensic audit. Lord, with
Into
regard
what? Audit into?
of the
Ozone
fourth
Urbana's
respondent.
affairs. We'll see, yes. List the matter after, list the matter
No,
of
your
2
lordship,
weeks.
kindly
Yes.
appreciate only one thing.
Who is the fourth respondent?
Lord, fourth respondent is the ozone.
Let them
Lord,
come.
your lordship,
Post
kindly
post
appreciate
immediately after service of notice upon the fourth respondent. Yes.
But you may appreciate only one thing. Page number 157, your lordship.
Sir, without hearing Ozone Urbana, you want a forensic audit to be conducted against the company. Should they not be heard?
Lord, I am only seeking.
You may be seeking anything. Mandamus irbodu. Yes. Next.
Lord, you may have it on the 7th.
7th. Yes. ಯಾವ್ದ್ರಲ್ಲಿ ಕುಶಾಲಪ್ಪ ಅಂತ ಯಾರೋ ಹಾಕಿದಾರಲ್ಲ ಯಾರು?
Okay, we'll also take in.
I already appeared, my lord. Respond number 1.
He is there. Yes, yes.
Lord, serial number 55.
I will take notice in this month, the secure
Why
instruction.
is the land agency waiting?
Item 60.
Oh, let me see.
Lord, this
ಮಧ್ಯಾಹ್ನ ಆಗ್ಬೋದು. Yes.
serial number
Yes,
55.
Reshma madam.
The petitioner,
I'll take notice, my lord, I'll secure instruction. There's a charge sheet filed in this matter, my lord.
Short validity passport. ಅಷ್ಟೇ.
As in line with GSR.
my lord, that this, in this matter, my lord, stepmother has given the complaint and that was stayed before this.
ಏನಾರು ಆಗ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಇದೆಯಾ?
That's it. Against this petitioner.
ಚಾರ್ಜ್ ಶೀಟ್ ಇದೆಯಾ ಇಲ್ವಾ?
ಇದೆ, my lord, not against.
ಚಾರ್ಜ್ ಶೀಟ್ ಇದ್ಮೇಲೆ 62F will come into operation. You get only a short validity passport, no regular validity passport. FIR stage ಅಲ್ಲಿ ಇದ್ರೆ you will direct regular validity passport.
Also, I have produced, my lord, head of the charge sheet.
62F ನೋಡೇ ಇಲ್ವಾ? ನೋಡಿದೀರಾ?
Published.
ಇಲ್ಲ ಅಂದ್ರೆ ಜಡ್ಮೆಂಟ್ ನೋಡಿ.
Yeah.
It's completely covered on that ಅಷ್ಟೇ. 62F. You want to seek in secure
Line
instruction?
with GSR is what I was mentioning.
Correct, same. GSR 570.
70.
GSR 570 of 93, which I have considered in that Santosh.
Bijadi Srinivas.
Where is that? Yes, pass over. ಮಧ್ಯಾಹ್ನ ಮಾಡ್ತೀನಿ. Close matter will grant direct granting of a short validity passport. ಸಾಕು. ASG ಅವರೇ ಮಧ್ಯಾಹ್ನ ತಗೊಂತಾರೆ. 60 ಏನದು?
Serial number 56, my lord. Would your lordship grant me a 2 weeks time to secure records, my lord?
ಆಯ್ತು ಸರ್. ಯಾವುದು? ಯಾವುದು?
56, my lord.
Next matter.
ಆಯ್ತಾಯ್ತು.
Serial number 59.
ನಾರಾಯಣ್ ಭಟ್ ಇದ್ದಾರೆ.
I appear for the petitioner. The date may kindly fixed after 2
That's 7th April.
Please, my lord, serial number
Publish.
89. Interim order may kindly be
ಒಂದು
extended.
ಕೆಲಸ ಮಾಡಿ ಮೇಡಮ್. ಪೇಜ್ ವೈಸ್ ಕರೆದು ಬಿಡಿ.
56, interim order may kindly.
Satellite.
Sign, my lord, withdraw, memo for withdrawal, I'm telling.
Which one, sir?
Serial number 89, my lord.
ತಗೊಳ್ಳಿ ಮೇಡಮ್.
Page 10, 57 and 58 for adjournment. Page 11, 59 to 63. Page 12, 54.
60? Payment due with the?
Have say subjection 230.
Huh?
Little bit 230 will be, I'm ready.
ಆಯ್ತು. 230. Yes.
page 13, 68 to 74.
71, serial number 71.
Yes, sir.
Petitioner objection not maximum 2 weeks time.
Vacating stake objection.
Objection. Interim order is.
Finally, 2 weeks' time is granted to file objections to the application seeking vacating the interim order. List the matter on 6th April. In the, 8th April. In the event objections are not filed, the interim order would stand vacated. Yes, next.
My lord, serial number 77, my lord.
1 minute. 77 now.
Yes, my lord.
76 yen. 76, 77.
76, my lord. 76.
It was said by Lord Denning.
77.
Admel eno.
Kindly grant 2 weeks time.
Sorry, yes, next.
77, my lord.
77.
I pray for a 2 weeks' time, my lord, because I have to get some
Amale.
instructions from the department, my lord, from the corporation.
Number?
77, my lord.
Sir, nimuk kottaito. Wait. Yes.
8th of April, my lord.
2 weeks, yes.
Much obliged, my lord. Much obliged.
Stands as a testament to justice.
Serial number 80. All right, next. Interim order, the country mabdi. And midala GM KEB. Ella adjourn mabdi. Yes.
Serial number 94, my lord. 815, 82 to 86.
82, my lord.
Granted, sir. Yes.
In working conditions remain.
Serial number 94.
My lord.
94.
87 to 90.
94. Further hearing. Waits. No. ಏನಾದ್ರೂ ಇಲ್ಲ ಸಬ್ಮಿಷನ್ ಎಲ್ಲ ಆಮೇಲೆ ರೀಚ್ ಆದಾಗ ಎಸ್
My lord.
ಈಗ ಇದು 20ನೇ ಸರ್ತಿ ಟೈಮ್ ತಗೊಂತಾ ಇರೋದು ರೀಚ್ ಆದಾಗ ಮಾತ್ರ ಪರವಾಗಿಲ್ಲ.
My lord, one submission.
There is a survey to be conducted on Monday. I'm seeking for police protection because there's already a survey.
Tomorrow.
Wait.
My lord, one submission, my lord. This petition
If it
filed.
will be had at 2:30 minutes.
No, sir, tomorrow. Yes.
This criminal petition has been filed on 5/2/2024, my lord. And this matter has been sent to the Dharwad bench because of your, my lord, again, this matter has been come back to here, my lord.
5/2/24 part heard.
Alla, part heard. Before your lordship, because.
ನಾಳೆ ಬರುತ್ತೆ ಕೊಡಿ.
Kindly take it. Tomorrow, my lord.
ಸ್ಟೇ ಇಲ್ವಾ?
My lord.
ಇಂಟರ್ ಮಾಡರ್ ಇಲ್ವಾ?
ಇಲ್ಲ, first time ಬಂದಿದೆ, fresh matter.
ನಾಳೆ ಬರುತ್ತೆ.
Please,
yes.
Madam, 82. 82.
EMI ಕಟ್ಟೋದೇ ಇಲ್ಲ. ಇನ್ಮೇಲೆ ಎಂಟ್ರಿ ಮಾಡಲ್ ಅದು ಅಬ್ಸರ್ವ್ ಮಾಡಬೇಕು. This does not mean that EMI should not be skipped.
No, no, my lord.
ಅಲ್ಲ,
We have
henceforth
paid-
we'll do that.
Till 20 months pending is there.
In fact,
Ah,
after the
20
notice.
Madam, 20 months EMI ಯಾವಾಗ ಕಟ್ತೀರಾ ಹೇಳಿ?
My lord, within 50% of the amount we will pay within 2 months, my lord.
2 months, 20 months EMI ಇರೋದು. Next 4 weeks I'll grant you time, pay 10 EMIs. All right? The learned counsel for the respondent bank submits that after 2/3/20, after compliance with the order dated 2/3/2023, not a rupee is paid as equal monthly installment. The interim order is only giving a temporary reprieve to the petitioner qua the sale of the property. That would never mean that the equal monthly installment that is to be paid in future should be, is also stayed. Therefore, the petitioner shall deposit 10 months EMI to the respondent bank within next 4 weeks, within 17th April 2025. List the matter on 21st April. In the event the deposit is not made, the interim order would be vacated and the petition also would be dismissed. Yes.
For listener, respondent. So there is a wait service of notice for R3 and R4.
1 minute. 50?
58 months. ಅಲ್ಲ,
ಏನ್ ಮೇಡಮ್ ಇದು?
this is filed by the son and daughter-in-law. ಅಂದ್ರೆ mother of the son and daughter-in-law. That is respondent number 3 and 4. What they are saying is notice anta. They are none other than the children of the petitioner themselves. They have been.
No, it's my lord, sir. Senior citizen appellant tribunal's order has been challenged before this court.
Court below, page number 118.
ಈಗ 1 minute. Who went before the commissioner, assistant commissioner?
I am.
What is the order?
Lord, the assistant commissioner cancelled the gift deed as well as the sale deed.
Deputy commissioner reversed it.
Yes.
It's all right.
Now I am before this court challenging the deputy commissioner's order, my lord. Now there is a await of service of notice to respondent number 3 and 4 who are
That's
my
all.
son and.
That's all right. Now, why did the assistant commissioner cancel this gift deed?
Yes, my lord.
Why?
Lord, so it was obtained under fourthly
Fraud.
obtained.
Same cyclostyle order.
No.
Forcefully obtained, fraud played,
Yes,
all that.
My son has given even undertaking that he will return the gift deed.
Huh.
It is at annexure C, my lords. Annexure D, page 65.
Where are you residing now? Same
one.
property.
Yes.
All right. Maintenance ಏನ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ madam?
Nothing.
10,000 rupees maintenance.
I am not appealing for the children. I am
ನೀವ್
appealing
ಯಾರಿಗೆ
for the
madam?
That's what I am submitting, my lords. Children is not before the court. He is a subsequent purchaser.
Malade, she is a very rich landlady. She gifted 2 properties to 2 children.
No, that's all right.
Out of which, son, second son, sold the property. in
Now you are the subsequent purchaser, is it?
Yes, respondent number 5, subsequent.
4 and 5 ಗೆ ಸರ್ವ್ ಮಾಡಿ.
ಅದೇ await.
ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಕ್ಕೆ.
await.
ಇಲ್ಲ, ನಿಮಗ್ ಸಂಬಂಧ ಇಲ್ಲ ಅದು. ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ 10,000 ರೂಪಾಯಿ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡಕ್ಕೆ ಹೇಳ್ತೀನಿ.
ಅಲ್ಲ, ಅವ್ರು ಮಾಡೋದೇ ಇಲ್ಲ, 2 ವರ್ಷದಿಂದ ಮಾಡಿಲ್ಲ.
await service ಅಂತ ಬಂದಿದೆ.
ಈಗ ಮಾಡದವ್ರು ವೆಕೆಟ್ ಮಾಡ್ತೀನಿ, ಎಂಟ್ರಿ ಮಾಡಿ.
But they have been placed as expired.
That's all right. Now to pass an order. See, deputy commissioner's order is illegal. Division bench holds that appeal is not maintainable by you before the deputy commissioner. So I'll have to hold that order to be illegal.
Yes.
Then assistant commissioner's order will spring back. So wait. Yes.
I'll serve.
The petitioner shall serve respondents 4 and 5 by way of hand summons. The respondents 4 and 5 are the children of the petitioner. If no service is effected.
3 and 4. 3 and 4.
3 and 4.
Children and daughter-in-law.
Children, child. 3 and 4.
Please.
The son and daughter-in-law of the petitioner. In the event no service is effected or no service is effected by the next date, the interim order, is the interim order?
Absolute.
Interim order would, absolute will stand vacated.
Yes, I will
The
take that.
interim order that is absolute is restricted till the next date of hearing.
Within 2 weeks.
List the matter on 2nd April. Yes.
Preparer for petitioner, my lord. Vacating of application does not arise, my lord, in view of
Why?
this, in view of the subsequent development.
ಏನು?
Today I filed memo along with the government circular issued under clause 16 of the PDS control order, staying all further regarding consideration of authorization as well as consideration of application for granting of authorization, my lord. On the basis of this on court direction, government passed the order, my lord.
ಕೊಡಿ ಯಾವ್ದು? ಯಾವ್ದು ಗವರ್ಮೆಂಟ್ಗೆ ಗೊತ್ತಿಲ್ಲದೆ ಆರ್ಡರ್?
Itself is not maintainable, my lord.
Who is the petitioner?
Petitioner is an
Is an authorized fair price of running.
ನಿಮ್ಗಿಂತ ಜೋರಾಗಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಕೇಳಿಸ್ದೆ ಇಲ್ಲಿ. ಅದಕ್ಕೆ ಹೇಳಿ ಸರ್.
Lordship, kindly page number.
Who are you?
I am the authorized holder of license for running the fair price shop at Shivamogga town, my lord.
ಈಗ ನಿಮ್ಗೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಏನಾಗಿದೆ?
ನಮಗೇನಾಯ್ತು ಸ್ವಾಮಿ, without providing an opportunity of being heard, restricting only as per the procedure of minimum card ಇಟ್ಟು ಮಿಕ್ಕದ ಕಾರ್ಡ್ ನಂದ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡಾರ ಸ್ವಾಮಿ. ಆಮೇಲೆ ನಾವು
ಒಂದ್ ನಿಮಿಷ, ನಿಮ್ಗೆ ಕಂಟ್ರೋಲ್ ಆರ್ಡರ್ ಪ್ರಕಾರ ಎಷ್ಟು ಕಾರ್ಡ್ ಇರ್ಬೇಕು?
ನನಗೆ ಅಲಾಟ್ ಮಾಡಿ
ಅಲಾಟ್ ಮಾಡಿದ್ ಎಷ್ಟಾರು ಇರ್ಲಿ, ಎಷ್ಟು ಇರ್ಬೇಕು ನಿಮ್ಗೆ?
ಅಲ್ಲ, ಮಿನಿಮಮ್ 800 ಸ್ವಾಮಿ.
800 ಅಲ್ವಾ?
800.
ಎಷ್ಟು ಅಲಾಟ್ ಮಾಡಿದ್ರು?
At the time of granting the authorization 1471 ಅಲಾಟ್ ಮಾಡಿದ್ರು.
ಮಿಕ್ಕಿದ್ ಕೊಟ್ಬಿಡಿ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಈಗ ಅವರು ವಿತೌಟ್ ಫಾಲೋಯಿಂಗ್ ದ ಪ್ರೊಸೀಜರ್.
That will see.
ಅಲ್ಲ
You are asking the writ court to run the race of cards. I've been telling this. PDSL ಅಂತೂ it's become hot. ಎಲ್ಲಾದ್ರಲ್ಲಿ ಯಾವ್ದ್ರಲ್ಲಿ?
Trying to transfer it now. What has happened, your lordship, is not telling the correct facts, your lordship. A notification came to be issued. Admittedly, there are about 1,731 cars he is enjoying, my lord, since long decades. Therefore, my lord, the authority thought it fit to issue a notification. Notification has been issued. I have been granted with the authorization, and that order was not questioned.
ಈಗ 800 cards ಮೇಲೆ ನಿಮ್ಮ ಹತ್ರ ಇರೋಂಗಿಲ್ಲ. I will pass an order.
ಅಲ್ಲ
And maintain under the under the PDS control order, urban area ಎಷ್ಟು 1200, 800, rural area 500.
Class 11 prakar.
Equal distribution ಮಾಡಿ so that others also will get
That was the purpose of the notification. That was the purpose of the notification.
Correct. ಈಗೇನ್ ಸ್ಟೇ ಆಗಿದೆಯಾ ಅದು?
Stay ಆಗೋಗಿದೆ. ನಮಗೆ
ಯಾವ್ದ್ರಲ್ಲಿ?
ಮಾಡಿಲ್ಲ.
ಯಾವ್ದ್ರಲ್ಲಿ? ಇದ್ರಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ.
ಇದ್ರಲ್ಲಿ ಸ್ಟೇ.
Yes, sir.
ಅಲ್ಲ, one kind submission. ಅಲ್ಲ, one kind submission ಸ್ವಾಮಿ.
ಆಯ್ತು.
ಅಲ್ಲ, ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ತಾವು ಏನ್ ಸರ್ಕ್ಯುಲರ್ ಹಾಜರ್ ಮಾಡಿದ್ರಲ್ಲ ಸ್ವಾಮಿ, whether government is having a power under section 16 of the PDS control order, ನಾನು ಮೆಮೊ along with ಹಾಕಿದಲ್ಲ ಸ್ವಾಮಿ.
Regarding what, sir? Power? Regarding what are you questioning the power of the state?
At any stage, the government discretion power to.
I will write that now henceforth it should be done. This has become too much. ಒಂದರಿಗೆ 1200, ಒಬ್ಬರಿಗೆ 300.
ಆಗಲ್ಲ ಸ್ವಾಮಿ.
What is
moreover, without following the procedure of law.
That's all right. What
Subclause 3 of clause 11, they are not followed.
What is the ಇದು 800 and 500 ಅಲ್ಲ?
800 and 500.
Where is the control order ಕೊಡಿ?
11. Clause 11. Notification has been issued after noticing all these things.
1 minute, sir. 1 minute. ಎಲ್ಲ ಮೊನಾಪೊಲಿ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. Yes. ನಿಮ್ ಕ್ಲೈಂಟ್ಸ್ ಇದಾರೆ ಸುಮಾರು ಜನ, ಈ ಕಡೆ ಇದ್ದಾಗ ಅದೇ ಬರೋದು.
ಇಲ್ಲ, ನಮ್ದಿಲ್ಲ ಯಾರು.
Yes, ನೋಡಿ.
ಇದ್ರೆ ತಾವು ಹಾಕ್ಸ್ಬೋದು.
ಆಯ್ತು.
Assignment of ration card under clause 11.
The petitioner is before this court
ಅಲ್ಲ,
seeking the following prayer.
ಅಲ್ಲ, one kind submission.
The petitioner.
My pleadings are completed, my lord.
ಹೀಗೆ ಮಾಡ್ತಿರೋದು ಈಗ.
ಬಿ ಗ್ರೂಪ್ ನಾಗೆ ಮ್ಯಾಟರ್ ಪೋಸ್ಟ್ ಆಗಿದ್ದು, ಅದನ್ನ ಈಗ ಮತ್ ಪುನಃ ವೆಕೇಟಿಂಗ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇದು ಮಾಡಿದಾರೆ.
So what? ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇನ್ನೇನಿದೆ ಹೇಳಿ.
ಅಲ್ಲ, ಇದನ್ನೇ ನಾನು ಇನ್ ವ್ಯೂ ಆಫ್ ದಿ ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಸಬ್ಮಿಟೆಡ್ ಸರ್ಕ್ಯುಲರ್ ಅಲಾಂಗ್ ವಿತ್ ಮೆಮೊ ಹಾಕಿದಲ್ಲ ಸ್ವಾಮಿ, ತಾವು ನೋಡ್ಬೋದು.
ಏನ್ ಸರ್ಕ್ಯುಲರ್ ಅದು? ಏನ್ ಸರ್ಕ್ಯುಲರ್ ಸರ್?
ಪೇಜ್ 4 ಇದೆ ಸ್ವಾಮಿ. ಪೇಜ್ 4.
ವಾಟ್ ಸರ್ಕ್ಯುಲರ್ ಇಸ್ ಇಟ್? ಇವತ್ತು ಹಾಕಿದ್ದ?
ಹೌದು ಸ್ವಾಮಿ, ಇವತ್ತು ಹಾಕಿದ್ದೇನೆ ಸ್ವಾಮಿ. On 13/2/2024.
ಆಯ್ತು, ಏನ್ ಮಾಡಿದ್ದಾರೆ?
At page 5, my lord. It is denied Germany to notice that the writ.
ಜರ್ಮನಿನಾ? ಏನ್ ಜರ್ಮನಿ?
Germany to notice. Germany ಅಂತಂದ್ರೆ
ಜರ್ಮನ್. Yes.
To notice that the writ court if flooded with the cases concerning public distribution system.
ದೀಕ್ಷಿತ್ ಸಾಹೇಬ್ರದ ಆರ್ಡರ್ ಅದು ಗೊತ್ತು.
Allotment of fair price shops, of the allotment of cards to any particular fair price shop, indiscriminate allotment of fair price shops or discriminate distribution of cards has lead to this problem.
in every allotment, there would be a complaint and those complaints gather before this court by way of filing writ petitions.
ನಂದೇ ಇರ್ಬೇಕು.
It is this that has to be looked into by the competent authority,
Oh, it's my order.
either the first respondent or the second respondent.
It's
in
my order,
particular.
sir, to put its house in order and I have written it, yes.
Circular is dated 13/2/2024.
Under writ petition 2023, when the matter is pending before the court, the government issued this circular.
So what?
ಮಾನ್ಯ ಅಲ್ಲ ಸ್ವಾಮಿ ಮುಂದ್ ಸಾಹೇಬ್ರ ಅವರು ಹೇಳಿ ಇದರ ಗವರ್ಮೆಂಟ್ ನೋಟಿಫಿಕೇಶನ್ ಹೇಳಿದ್ದಾರೆ.
ಇದು ನಂದೇ ಆರ್ಡರ್ ಸರ್, ಕೋರ್ಟ್ ಮಾಡ್ರ ಆರ್ಡರ್ ನಂದು.
ಅಲ್ಲ ಅದು ಅಗ್ರೀಡ್ ಸ್ವಾಮಿ.
ಹ್ಮ್.
ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ಅಗತ್ಯ ವಸ್ತುಗಳ ಸಾರ್ವಜನಿಕ ವಿತರಣಾ ಪದ್ಧತಿ ಆದೇಶ 2016 ಕಲಂ 16(1) ದತ್ತಕವಾದ ಅಧಿಕಾರ ಈ ಕೆಳಗಿನ ಕ್ರಮ ವಹಿಸಲು ಸೂಚಿಸಿದೆ. ಈಗಾಗಲೇ ಹೊಸ ನ್ಯಾಯಬೆಲೆ ಅಂಗಡಿಯನ್ನು ಮಂಜೂರು ಮಾಡಲು ಹೊರಡಿಸಿರುವ ಅಧಿಸೂಚನೆಯನ್ನು ಆಗ ಎಲ್ಲಾ ಪ್ರಕ್ರಿಯೆಗಳನ್ನು ಕೂಡಲೇ ತಡೆ ಹಿಡಿಯುವುದು ಹಾಗೂ ಇನ್ನು ಮುಂದೆ ಯಾವುದೇ ಹೊಸ ನ್ಯಾಯಬೆಲೆ ಅಂಗಡಿ ಮಂಜೂರಾತಿಗಾಗಿ ಸಾರ್ವಜನಿಕ ಪ್ರಕಟಣೆ ಹೊರಡಿಸುವ ಮುನ್ನ ಹೊಸ ನ್ಯಾಯಬೆಲೆ ಅಂಗಡಿಯ ಅಗತ್ಯತೆ ಕುರಿತು ಸಕಾರಣಗಳನ್ನು ನಮೂದಿಸಿ ಸಮಗ್ರವಾಗಿ ಮಾಹಿತಿಯನ್ನು ಆಯುಕ್ತರು, ಆಹಾರ ನಾಗರಿಕ ಸರಬರಾಜು ಮತ್ತು ಗ್ರಾಹಕ ವ್ಯವಹಾರ ಇಲಾಖೆ ಇವರ ಮೂಲಕ ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಿ ಸರ್ಕಾರದ ಪೂರ್ವಾನುಮತಿಯನ್ನು ಕಡ್ಡಾಯವಾಗಿ ಪಡೆಯುವಂತೆ ಸೂಚಿಸಿದೆ.
No problem. The petitioner is before this court calling in question a notification dated 15/7/2023.
ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ನಾನು ಇನ್ನು 11(3) ಕೆಳಗೆ ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋಣ ಅನ್ಸ್ಮಿದ್ರಲ್ಲಿ ಏನಂದ್ರೆ 11(3) is very clear.
Correct. 11(3) is very clear.
11(3) is very clear. Shall I read the?
Please read, sir. Odi, sir.
The authorized authority may, if we consider it necessary, transfer ration cards from one pair shop to another on the request of the ration card holders as a result of recognition of the judicial area of the shop.
Jurisdictional area.
Area of the shop with permission of the commissioner as a part of well defined in the parameters. Admittedly, in this case, in the impugned annexure A, there is no demand either from the card holders or from the general public. Moreover, this area jurisdiction has been not obtained from the Commissioner of Food and Safety Supply. They are unilaterally published this. Moreover, without issuing any prior notice on the recommendation of the
MLA.
ಅಲ್ಲ MLA ಅದನ್ನು ಮಾಡಿದಾರೆ ಸಮಿತಿ, ರಿಪೋರ್ಟೆಡ್ ಜಜ್ಮೆಂಟ್ ಇದೆ ಅದನ್ನು ಹೇಳ್ತಾರೆ ಸಮಿತಿ. On the food inspector report as well as assistant director of food and civil supply, the authority second respondent reduced the petitioner cards from 1471 800 limit ಮಾಡಿದಾರೆ ಸಮಿತಿ. I produce my rejoinder annexure G, my lord.
Yes.
Without providing opportunity, my lord.
All right. Anything else?
Moreover, in one reported
moreover ಏನು ಯಾವ್ದು ರಿಪೋರ್ಟ್ ಜಡ್ಮೆಂಟ್ ಹೇಳಿ ಸರ್. ನಿಮಗೂ ಅನ್ವಯ ಆಗತ್ತೆ ಈ ಕಡೆ ಬಂದಾಗ.
Law is very clear on the point. Judgment.
This is, sir, when Shaman, when law declares that 800 should be given, why do you give 1400?
Lord, initially, what would have happened?
If, no, initially what would have happened? In that area, if there is create another.
That's what we've done here.
Alternative arrangement, ಯಾರು ಸತ್ತೋದಾಗ alternative arrangement.
ಅದಕ್ಕೆ ಅವರು ಪರ್ಮನೆಂಟ್ ಅರೇಂಜ್ಮೆಂಟ್ ಮಾಡಿ.
ಅಲ್ಲ ಇದ್ರಾಗ ಪರ್ಮನೆಂಟ್ ಏನಿಲ್ಲ ಸ್ವಾಮಿ. At the time of granting the authorization, there is no another abandonment of the fair price shop to ಅಥವಾ license.
ಪರವಾಗಿಲ್ಲ ಬಿಟ್ಟು. Yes.
This is clear case it was attached to.
The petitioner.
ಒಂದು ಸ್ವಾಮಿ ರಿಪೋರ್ಟೆಡ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
ಕೊಡಿ.
ಗುಲ್ಬರ್ಗ ಬೆಂಚ್ ಜಸ್ಟಿಸ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೈಕಲ್ ಪುನಃ
ಏನ್ ಬೇಕು ಸರ್ ಇದರಲ್ಲಿ?
ಹೆಡ್ ನೋಟ್ ಹಿ ಸ್ವಾಮಿ. ಪವರ್ ಆಫ್ ಹೈಕೋರ್ಟ್ ಟು ಇಶ್ಯೂ ಸರ್ಟನ್ ರಿಟ್ಸ್.
I don't, paragraph ಹೇಳಿ. Head note is not by the honorable judge.
Para 7 also.
I will quote that, don't worry. Yes. The petitioner is before this court calling in question a notification dated 15/7/2023 issued by the second respondent to regulate the distribution of cards to a particular fair price shop in terms of the PDS control order, hereinafter referred to as the order for short. The petitioner heard so and so. The petitioner on 22/2/2019 was issued an authorization / license by the second respondent to run a fair price shop. The license was on renewal as it was initially issued on 17/6/2017, which was to be in operation up to 16/6/2020. It is the case of the petitioner that the license has been renewed from time to time. At the time of grant of license, the cards that were allotted to the petitioner, the ration cards that were allotted to the petitioner was 1471. And it is the claim of the petitioner that it is wrongly shown as 1737. When things stood thus on 15/7/2023, the impugned notification comes to be issued where the petitioner's fair price shop where another fair price shop is sought to be where another fair price shop was granted an authorization in the same area, and the cards that were in possession in excess of the petitioner is taken away and is placed at the hands of the new allottee, the third respondent herein. It is this notification that comes to be challenged by the petitioner in the subject petition. The learned counsel for the petitioner submits that he was entitled to have 1471 cards, and before taking away the said cards, the procedure as stipulated under the order is not followed. It is a submission that subsection 3 of section 11 of the said order would clearly indicate that the cards should be varied only if there are recommendations to vary such or vary such or there is a request from the ration card holders or reorganization of the jurisdictional area. It is a submission that none of these things have happened, and the cards that were initially granted, i.e. 1471, should not have been taken away is the submission. The learned counsel appearing for this learned HCGP for the state would submit that the state wants to regulate the distribution of cards in terms of the order, and therefore the said fair price shop was granted license or authorization, and the cards that were in excess with the petitioner's kitty is taken away and handed over to the third respondent. He would submit that there was no fault found. There can be no fault found with the notification. The petitioner is wanting to set up a monopoly by keeping all the cards to himself. The learned counsel H.C. Shivram, representing the third respondent who has now been allotted the fair price shop authorization, submits that the control order clearly stipulates number of cards that are to be in one's fair price shop. He cannot have it in excess as it would become contrary to the statute. Procedure has been followed in the case at hand as the need for the next fair price shop came about in terms of plethora of orders passed by this court. Both of them would seek dismissal of the petition. I have given my anxious consideration. The aforenarrated facts are not in dispute. The petitioner, being an allottee of a fair price shop by way of authorization or license, is a matter of record. The authorization of the grant of authorization to the fair price shop and the ration cards to the particular shop is regulated by the essential commodity so-and-so control order. Clause 11 of the said control order becomes germane to be noticed in the case at hand. It reads as follows. Clause 11 deals with assignment of ration card. In an urban area, the ration card should not be less than 800, and in a rural area, 500 in a particular fair price shop. The power to relax for reasons recorded in writing is only up to 100 cards for a fair price shop in a rural area and nothing in an urban area. The state ought to have kept this in mind while granting authorization to the petitioner or to any other fair price shop. The cards, i.e. 1471 is granted to the petitioner while granting authorization. This has led to arbitrary exercise of power, as in one case, the state would grant 1,000, in one case 1,200 or 1,500 as the case would be. If a statute is in place, the state is bound to follow the rigor of the statute unless situation otherwise warrants for reasons to be recorded in writing. The cards that were issued to the petitioner 1471 was blatantly contrary to subclause 2 of subsection 2 of section 11, which mandates 800 cards at a fair price shop. The state shall therefore, as the state henceforth, while allotting cards to the fair price shops that are newly authorized, shall bear in mind the rigor of the statute and not deviate it themselves, so that it would not generate huge litigation before this court with regard to heartburn in the distribution of cards indiscriminately to the favorite fair price shops of the state. Therefore, the petition, the subject petition would not merit any consideration. However, it is made clear that the petitioner's cards should at no point in time come below 800 as is stipulated under the statute. The aforesaid.
It can come below 800 if someone.
No, cannot hangala.
Minimum
Minimum
maximum fix ಮಾಡಿಲ್ಲ
so the early maximum 3,000 ಕೊಡ್ಬೋದಾ?
ಆಗಲ್ಲ, ಅವರು ಅಥವಾ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ನಲ್ಲಿ ತೋರಿಸಬಹುದು ಸ್ವಾಮಿ, ಅವರು ಮಿನಿಮಮ್ ತೋರಿಸಿದ್ದಾರೆ, ಮ್ಯಾಕ್ಸಿಮಮ್ ತೋರಿಸಲೇ ಇಲ್ಲ.
ಅದು ಮ್ಯಾಕ್ಸಿಮಮ್ ನಾ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. So and so. The said direction has become imperative in the case at hand, so that the court exercising its jurisdiction under Article 226, extraordinary jurisdiction under Article 226 of the Constitution of India, should not participate in the race of cards with the fair price shop holders. The state shall bear this in mind and act accordingly in grant of fair authorization to fair price shops, including that of the petitioner. Yes, ordered according.
Reading application may be allowed.
Parole bidi. Yes.
R3 ಅಂತ ಹೇಳಿದ್ರೆ ನಾವು.
Madam, impleading application.
ಲಾಂಗ್ ಬ್ಯಾಕ್ ಹಲೋ ಆಗಿದೆ ಸ್ವಾಮಿ. ರೆಕಾರ್ಡ್
ಕಾಸ್ಟ್ ಟೈಟಲ್ ಹಾಕಿದ್ದಾರೆ ಬಿಡಿ. ಅಮೆಂಡ್ ಮಾಡಿದ್ದಾರೆ. Next.
Lords, filed an amendment application in February. There is an error, my lords, in the petition. What has happened, my lords, is that.
Then we'll dismiss the petition on that error.
My lords, I'll argue. I'm not that.
Really?
First of all, I bold ಮಾಡ್ಬಿಟ್ಟೆ ಸ್ವಾಮಿ.
Adjournment
ಇಲ್ಲ adjournment ಅಲ್ಲ ಸ್ವಾಮಿ. I had served a copy. They have no objection for the amendment application.
Because it vindicates my stand. That amendment vindicates my stand, which is why I don't
ಅದಕ್ಕೆ amendment.
ಸ್ವಾಮಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ 33B ಅಂತ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಮೆಂಡ್ಮೆಂಟ್ 2018 ಅಲ್ಲಿ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು. Before that there was a NCBC Act of 1993. ನಾನು petition draft ಮಾಡುವಾಗ ಸ್ವಾಮಿ I have quoted the sections of the NCBC Act. But NCBC Act has been now transposed into the Constitution.
Yes,
so therefore that
let him amend it. But he can amend it. No, there is no difficulty. But 2 minutes, my lord, if I explain what this matter is. There are two sets of facts. Number one, the National Commission for Backward Classes was earlier a statutory body.
Yes.
With very limited powers.
Constitutional body now.
In 2017, it was elevated to the status of a constitutional body with vast powers, including right to summon and the report prepared by it
Like
before both the houses.
Commission for SC/ST.
As the facts are concerned, the petitioner KPCL was allotted certain coal blocks and it acquired certain lands. And having acquired the lands, it had to pay compensation. It entered into certain rehabilitation agreement. And please have a look at that rehabilitation, but just 2 points.
Page?
Not page 39 is the first one, Annexure D. Page 39. It's called as between the KPCL, petitioner KPCL and Government of Maharashtra, rehabilitation of project affected persons of integrated Barang open cast project, Bhadravati, Chandrapur on 9/11/2025. In this, there were certain liabilities. For example, please have a look at page 46. Certain housing was to be provided for the project affected families. Item 6 is certain financial assistance was to be provided. And then item 13, page 48, there was a detailed scheme laid down for implementation. This agreement was revised in 2016, which your lordship will find at page 55. In page 55, in this agreement, a new condition for payment was laid down at 2.1 at page 62. Page 62. Page 62, 2.1. As referred to in the notification dated so and so by the divisional commissioner under section 13(3) of the Maharashtra Act, land has been acquired in relation to project 2 from villages in so and so. The land of these villages will be acquired, the villages will lose their source of income. Therefore, KPCL will provide civic amenities as per so and so provision. Then an annual provision of rupees 25 lakhs shall be provided for maintenance. And next page 2.5. Subject to applicable laws and the approved mining plan and approved mining closure plan, upon completion of all mining activities and upon receiving completion certificate from the relevant statutory authority, KPCL shall return 50% of the land acquired. Then 2.6 is the most critical one. In the event KPCL is unable to do so, does not return the said 50% of the land, the original landlords to the original landlords, then KPCL shall pay a one-time compensation of 4 lakhs per acre. No, my lord, this was not done. Therefore, my lord, in exercise, my lord, lot of complaints were there. Majority of the people who were to get this were backward classes. Therefore, my lord, the commission addressed a letter to the divisional commissioner asking, what have you done? He called for a meeting. And then, my lord, the commission called for a meeting and asked, what have you done about this? Why don't you pay? That is all that we have done. And before your lordship, my lord, a wrong submission was made that I am saying that they should pay enhanced compensation. I am only saying, what have you done?
What have you done?
And interim order was granted on the basis that I do not have power to summon. No, my lord, they admit that I have the power to summon.
I'm not saying.
No, where does the interim order, basis for the interim order to continue?
Lords may see the affidavit. What portion has been read, my lords? Kindly see page 63 for a minute, minutes. Kindly see page 63 for a minute. My lords, mine close ಆಗೋದು 25 ವರ್ಷ ಆದ್ಮೇಲೆ 25 ವರ್ಷ ಆದ್ಮೇಲೆ 4 ಲಕ್ಷ ಕೊಡಬೇಕು if I don't return the land. The affidavit which is compelled to be filed from me, my lords, I am summoned on the basis that there is OBC power, etc. Then, my lords, an application is, then the affidavit is filed. Kindly see the affidavit, my lords. They are saying pay me 4 lakhs right now.
Now, this is an agreement.
Agreement, yes, my lord.
You have signed this agreement.
Yes, my lords.
Then you are bound by it.
My lords, I'm bound by it. My lords, I'm bound by the agreement. There is no doubt about what they are saying is.
So, what is wrong in them asking?
My lords, just my lords, I'll make myself. My lords, only. I don't know how to say it. I'm sorry, my lords.
Amendment ಮಾಡ್ತೀರಾ?
My lords, learned AG is instructed in the matter, my lords. The matter was moved.
Advocate General.
Advocate General is, that is the reason. I don't want to make.
But I find nothing wrong. I find
But
the
I will
submission
make some.
correct.
My lords may fix the date, my lords. My amendment be allowed and.
Where is the impugned communication now?
Lord, annexure ABC. There is nothing in that. Annexure ABC.
ABC.
Lord, page 32. At the bottom, my lord, I simply say, shall have to start distributing the 4 lakhs. That is what I say. As per the agreement.
Check should be paid as per the agreement.
That 4 lakhs has to be paid.
Landlords ದುಡ್ಡು ತಾನೆ.
Swami, we've given them, not that we've not given the money. We've given the money. I'll do one thing, I'll file an affidavit on that.
It is not compensation as is projected. It is not enhanced compensation as it is projected. It is pure clause of an agreement sought to be executed by the center. Ashte. Since he is instructed, why do you want? I'll take list this 25th, Tuesday.
Just confirm that, my lord, I was not able to reach him. Please keep it on 20. I'll file the amendment. I'll make sure.
25th in the fresh matters list.
Yes, my lord, the amendment application has to.
Will allow the on order on IA. The learned counsel for the learned counsel of the petitioner submits the petition has preferred an application seeking amendment of the petition. The learned ASGI representing the National Commission has no objection to allow the impleading application in that light for the reasons indicated in the affidavit accompanying the application and being satisfied with the same. The application is allowed petitioner to file an amended petition in the next 2 days. Let's the matter on 25th or 26th in the fresh matters list. 25th, all right.
25th.
Can I just on the date?
Confirm,
just 2 minutes.
But inform.
I'll take sir into confidence only then fix.
For adjournment.
No, date ಗೆ ಸ್ವಾಮಿ, date ಗೆ.
Date ಗೆ ಅಷ್ಟೇ.
My lords, interim order may kindly be accepted.
Yes.
The fresh list.
Fresh matters. Because this farmer's money we will not keep. Yes. If it has to go to a farmer, it has to go to a farmer.
I appear for the petitioner in this matter, my lords. Petitioner is a class 1 contractor.
Early hearing ಯಾಕೆ sir?
My lords, he has a financial constraint, my lords. This is a writ of mandamus.
ಅದಕ್ಕೆ early hearing ಆಗ್ತಾರ. What is all this? Early hearing.
The project is complete, my lords. Defect liability period is also completed. I mean,
Kaveri
it is
Niravari
for-
Nigam, who appears? Petitioner to serve set of papers upon case Bhimaya appearing for the first respondent Kaveri Niravari Nigam with requisite set of papers. Both the respondents, set of papers, list the matter on 28th in the fresh matters list. Karkomani dispose ಮಾಡಿ. Early hearing application.
Much of it.
Yes, next.
I appear for the
Lord, in this
petitioner, my lord.
matter, the issue is about shifting the office. Lord, I have given some instructions to the regional director.
You're shifting the office?
No.
No, we don't want him to shift his office. We want him to be here. We want to shift our registered office, my lord.
Okay.
There is a,
Yes, Lord, I have issued some instructions. If your lordship to call this in the first week of April, Lord, probably by then. this
Issue will be
subject
resolved.
my friend is saying that, my lord.
If he's saying that, definitely it will be resolved. Yes.
I have issued instructions already.
Yes.
There's actually an order, interim order already granted by this court, directing, my lord, to consider our application.
Anyway, he's saying so.
First week of April.
The
Lord.
learned additional Solicitor General of India, Shri Arvind Kamath, submits that the grievance of the petitioner would probably be redressed by the next date. List the matter on 2nd April.
Yes, great.
Interim order subsisting will continue to the next date.
Great.
Yes, Kumar sir.
No change. 25th.
No change.
Interim order, my lord.
Interim order ಇಲ್ವಾ?
ಇತ್ತು. Three-
Apply ಆಗಿಲ್ವಾ?
three- ಅಲ್ಲ, 3 hearing dates ಗೆ
unconditional
extend-
interim order.
ex- unconditional ಅಂತ ಹೇಳಿದ್ರೆ I have complied, my lord. 1 ಕೋಟಿ
ಅನ್ಕಂಡೀಷನಲ್ ಏನ್ ಕಂಪ್ಲೈ ಮಾಡಕ್ಕಾಗತ್ತೆ? ಕಂಡೀಷನ್ ಇಲ್ಲ.
Before I have complied, 4 ಕೋಟಿಯಲ್ಲಿ 1 ಕೋಟಿ ಕಟ್ಟಿದ್ದೆ ಸುಮ್ನೆ.
ಈಗ 4/10/2024 there is some order.
That was unconditional interim order.
ಆಮೇಲೆ
The matter was pending before DRT.
ಅಲ್ಲ, it may
That
become,
petition notice was under challenge.
that
That case
order
got
may-
dismissed.
that order may kindly be read.
ಆಮೇಲೆ ಏನಾಗಿದೆ?
ಆದ್ಮೇಲೆ ಈಗ last date of hearing interim order was not extended, my lords. The bank attempted taking physical possession of the property, they did not take.
ಈಗ ಎಷ್ಟಿದೆ?
My lords,
ಅಲ್ಲ, 50 ಲಕ್ಷ ಕಟ್ಸಿದ್ರು.
before
Did not take ಅಂತ ನಾನು I moved the matter just because, my lord, in adjourned ಅಂತ ಇದ್ದಿದ್ದಕ್ಕೆ ಅಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು 50 ಜನರನ್ನ ಹೊರಗಡೆ ಹಾಕಿದ್ರು. ಹೊರಗಡೆ ಹಾಕಿದ ತಕ್ಷಣ ಒಂದೊಂದು ಮನೆಯಿಂದ
50 ಜನ ಇದ್ರ ಮನೆಯಲ್ಲಿ.
ಹೌದು.
not house.
It's a
I'm saying it's a hotel,
complex.
100-room hotel, my lords. Since last 4 years, my lords.
ಅದಕ್ಕೆ
not a
hotel
single
ಅಂತ
room is-
ಹೇಳ್ಬಿಟ್ಟು
Madam,
previously, my lord, 1
ನೀವು
ಕೋಟಿ ಕಟ್ಟಿದೆ.
ಇಲ್ಲ ಹೋಟೆಲ್ಗೂ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಅನ್ಬಿಟ್ರೆ
ಅಲ್ಲಲ್ಲ.
ಇರೋದ್ ಹೌದು ಬಟ್ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಆಗಲ್ಲ.
Each occupant, my lord, paid amount. Every time they have been doing that. March ಅಂತ ಬಂದಾಗ every time, my lord, they do that.
My one
Even in
submission-
spite of there being
ಈಗ
an
ಎಷ್ಟಿದೆ
interim order.
ಲೋಕೇಶ್?
my
50 ಲಕ್ಷ
submission-
ಕಟ್ಸಿದ್ರು.
ಒಂದು ನಿಮಿಷ ಮೇಡಮ್.
Since 2020, only by virtue of these court orders or by DRT, we are getting the money. Voluntarily, they are not paying any EMIs. Once interim order is taken, 4 lakhs EMIs per month. Once interim order is taken, the EMIs are forgotten. It's elixir of air for them.
ಅಲ್ಲ ಇನ್ಮೇಲೆ ದಟ್ ಕ್ಲಾಸ್ ವಿಲ್ ಬಿ ದೇರ್ ಇನ್ ದಿ
Because
ಆರ್ಡರ್ಸ್.
they forget by paying EMI, this is
Yes.
the building of the hotel, building. hotel.
ಆಯ್ತು, ಈಗ ಎಷ್ಟಿದೆ ಡ್ಯೂ?
Let them take time till May, my lords. 1.24 crore is required for regularization.
ರೆಗ್ಯುಲರೈಸೇಷನ್.
2 months ತಗೊಂಡು, let them close it.
ಅಫಿಡವಿಟ್. ಫೈಲ್ ಅನ್ ಅಫಿಡವಿಟ್.
May make,
ಫೈಲ್ ಅನ್ ಅಫಿಡವಿಟ್.
may make.
ಐ ವಿಲ್ ಡಿಸ್ಮಿಸ್ ಇಟ್ ಅದರ್ವೈಸ್.
Position notice challenge ಮಾಡಿದಕ್ಕೆ.
ತೊಂದರೆ ಇಲ್ಲ. ಈಗ ಅಫಿಡವಿಟ್ ಹಾಕಂಗಿದ್ರೆ ಹಾಕಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಡಿಆರ್ಟಿಗೆ ಹೋಗಿ.
Let them go before DRT.
Yes. No, madam, time has come to regulate it this way. Otherwise, these are all cases which are not even maintainable. I will send it before the DRT.
My side, my lord, I will also make some submission. Once this property was belonged to my father, my lord. Lord, initially when he came challenging the one of the action of the bank, my lord, 1 crore ಕಟ್ಟಿದ್ರು. Subsequent to that, my lord, once again,
ಈಗ 1 ಕೋಟಿ 40 ಲಕ್ಷ ಇದೆಯೋ?
4 ಕೋಟಿಗೆ 1 ಕೋಟಿ ಕಟ್ಕೊಂಡು ನಾವು, my lord, later on, my lord, before the DRT, my lord, we are challenged possession notice. 79 lakhs ಕಟ್ಬೇಕಿತ್ತು, ಅದು ಕಟ್ಟಿದ್ದೇವೆ ಸುಮ್ಮನೆ. ಸೆಕೆಂಡ್ ವಾಲಂಟರಿ ಕಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ, ವಾಲಂಟರಿ ಹೋಗಿ ಒಂದು 50-70 ಲಕ್ಷ
ತೊಂದ್ರೆ ಇಲ್ಲ
ಕಟ್ಟಿದ್ರು
ಬಿಡಿ,
ಸ್ವಾಮಿ.
ವಾಲಂಟರಿನೇ ಕಟ್ಟಿದ್ದೀರಾ,
50
ಪರವಾಗಿಲ್ಲ
ಲಕ್ಷ
ಹೇಳಿ.
ಕಟ್ಟಿದ್ರು. ಕಟ್ಟಿದ ನಂತರ DRT
ಈಗ ಎಷ್ಟಿದೆ ಹೇಳಿ? 1 ಕೋಟಿ
50 ಲಕ್ಷ ಮೊನ್ನೆ ಕಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಅದು
ಈಗ
ಬಿಟ್ಟ ಅದು ಸೇರಿನಾ?
ಮೊನ್ನೆ ಶನಿವಾರ 50 ಲಕ್ಷ
ಅದು
ಕಟ್ಟಿದ್ದೀನಿ.
ಅದು ಬಿಟ್ಟೆ 1 crore 24 millions per lakh loan is more than 4 crores. The per lakh per month EMI is 4 lakhs.
ಪ್ರತಿ ವರ್ಷ 70 ಲಕ್ಷ ಕಟ್ತೇನೆ. ಒಂದು
ಅದು ನಿಮ್ಮ EMI ಅಲ್ಲ ಅದು.
1 ಕೋಟಿ ಪ್ರತಿ ವರ್ಷ ಕಟ್ಟಿದ್ರೆ ಮಾರ್ಚ್ ಅಲ್ಲಿ ಅಲ್ಲಿ
No,
ಬಂದ್ಬಿಡ
you
ಸ್ವಾಮಿ.
are treating equal monthly installment to be equal yearly installment. ಅದಲ್ಲ ಅದು. ಒಂದ್ ನಿಮಿಷ.
Crore 24 lakhs 20,000 rupees within May 2025. I have calculated as per.
Will permit you till 31st May 2025 file an affidavit. ಅವಾಗ I'll entertain the petition. Otherwise no. ಇಲ್ಲರ ಏನು ಕಲೆಕ್ಟ್ ಆಗಲ್ಲ ಅದು. And all of you taking interim orders, you think interim order ಕೊಟ್ಮೇಲೆ EMI stop ಅಂತ.
My clients may not, they make us always,
you
always I tell them continue the
exception.
EMIs. My lord.
Exception.
My lord, one more submission.
Anyway,
One more submission. My lord, last May kindly ಈಗ ಒಂದು ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಏನ್
page,
ಏನ್
last-
ಹೇಳಿ? ಏನ್ ಹೇಳಿ?
Challenging the position notice, my lord. I am before my lord, death recovery appellate tribunal, my lord, DRAT.
ಆಯ್ತು.
ಅಲ್ಲಿ ಸ್ವಾಮಿ ನಂಗೆ ವೇವರ್ ಅಪ್ಲಿಕೇಶನ್ ಮೊನ್ನೆ ಎಲ್ಲ ಆಗುತ್ತೆ. ಅದೆಲ್ಲ ಆಗಿದ
ಏನ್
ತಕ್ಷಣ
ವೈವರ್ ಅಪ್ಲಿಕೇಶನ್? ಡೆಪಾಸಿಟ್ ವೈವರ್ ಅದು.
Deposit waiver.
ಆಲ್ ರೈಟ್.
ಅಲ್ಲಿ ಕಂಡೀಷನಲ್ ಆರ್ಡರ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ.
ಹ್ಮ್.
ಇಷ್ಟು ಅಮೌಂಟ್ ಕಟ್ಬೇಕು ಅಂತ.
ಹ್ಮ್.
ಅದ್ ಕಟ್ಲಿಕ್ಕೆ ಅಂತ ಆರ್ಡರ್ ಆಗಿದ್ ನೆಕ್ಸ್ಟ್ ಡೇನೆ ಬಂದ್ಬಿಟ್ಟು ಇವ್ರ ಫಿಸಿಕಲ್
ಈಗ
ಪೊಸಿಷನ್
ಎಷ್ಟು ಹೇಳಿದಾರೆ ಅಲ್ಲಿ?
ನೋಡ್ರಿ 68 lakhs 80,000.
ಹ್ಮ್.
Petitioner to deposit 25%. My lord, that is 68 lakh 80,000.
ಹ್ಮ್.
My lord, in 2 installments, 34 lakhs
ಟೈಮ್
40.
ಟೈಮ್.
My lord, before 27/3,
ಹ್ಮ್.
50 lakhs ಕಟ್ಟಿ ಆಯ್ತು.
ಆಯ್ತು.
ಇನ್ನೊಂದಕ್ಕೆ ನಂಗೆ ಈಗ 21/4/2025
ಆಲ್ ರೈಟ್. ಹ್ಮ್.
ಆನರ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಹ್ಮ್.
ಅಷ್ಟೊತ್ತ ತನಕ ಅವ್ರಿಗೆ ಬಿಡಿ
ಅದಕ್ಕೆ 31/5/2025 ಒಳಗೆ ಇನ್ ಮಿಕ್ಕಿದ್ ಕಟ್ಬಿಟ್ರೆ ರೆಗ್ಯುಲರೈಸ್ ಆಗುತ್ತೆ, ಅಷ್ಟು ಸಿಂಪಲ್.
They'll be out of NPA, they'll be out of the problem.
ಆಗ್ಬೋದಲ್ಲ? ಒಂದು ಅಫಿಡವಿಟ್ ಹಾಕ್ಬಿಡಿ ಅಷ್ಟೇ. DRAT ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕ್ಲೋಸ್ ಆಗ್ಬಿಡುತ್ತೆ. ಎಲ್ಲ ಎವ್ರಿಥಿಂಗ್ ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್ ಹಿಯರ್ ಓನ್ಲಿ. ಫೈಲ್ ಅನ್ ಅಫಿಡವಿಟ್
ಇದಕ್ಕೆ
ಹಾಕಿ. ಅಫಿಡವಿಟ್ ನಿಮಗೆ ಹೆಂಗ್ ಅಫಿಡವಿಟ್ ಅವ್ರ ಕಾಪಿ ಕೊಡಿ, ಕೊಟ್ಬಿಟ್ಟು ಆಮೇಲೆ ಹೇಳಿ. ವಿಲ್ ಸಿ. ಯಾವತ್ತು ಹಾಕ್ತೀರಾ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕ್ತೀರಾ? ಪೊಸಿಷನ್ ಕೊಟ್ಟಿಲ್ವ ವಾಪಸ್ಸು?
Position ಅವ್ರ ಹತ್ರನೇ ಇದೆ.
ಅವ್ರ ಹತ್ರನೇ ಇದೆ ಸರ್. ಎಸ್. 28th ತಗೊಳ್ಳ?
Please.
Placed on 28th in the fresh matters list.
ಎಂಟ್ರಿ ಮಾಡೋದು.
Interim order ಇಲ್ಲ.
No, ಅದು ಬೇಕೇ ಬೇಕು ಸ್ವಾಮಿ. ಎವ್ರಿ ಡೇ ಇಟ್ಸ್ ಹ್ಯಾಂಗಿಂಗ್ ಸ್ವರ್ಡ್.
Interim order have continued.
There be order that they'll.
Interim order stands continue, subsisting stands continued, subject to the condition that the petitioner would file an affidavit of undertaking before this court about the amount to be paid to the bank to get the account regularized. ಅಷ್ಟೇ.
Please.
I represent the state, my apologies. On the last occasion, I had undertaken that the objections are to be filed ready there. Officer is not there. But Monday, my lords.
What is all this?
Only.
Tell me, yeah, what is this, sir?
Still, objections are ready, my lords. Unfortunately, I couldn't get the signature. Monday, I will have it filed.
One moment, sir.
Please.
Sanction ಕೇಳಿದೀವಿ ಸ್ವಾಮಿ.
Sanction ನೀವು ಕೇಳಿದ್ರಾ?
ಹೌದು. ಯಾಕೆ ಅಂದ್ರೆ they my lord came without my lord warrant anything, my lord they came.
So this is my order, earlier order.
Yes, absolutely.
There are other things which I had to bring it to my lord's notice as to what was the reason why the FIR was filed, subsequent registration.
And
of
there
FIR,
are
what happened.
difference, my lord, law corrector first submits a report. And then, my lord, thereafter, my lord, when we apply into the RTI, it's a different thing altogether. There's a distinct, my lord, difference. And the law secretary has said, grant the sanction after, my lord, going through the whole, my lord, this thing. Nothing is brought to the notice of the authorities, the higher authorities, and, my lord, the sanction is rejected in one matter.
Sanction is rejected.
Rejected.
challenged
Against
this
that, my lord, I have come before your lordships.
Hmm.
In the other two, my lord, they said, ತಾವು ಕೊಟ್ರೆ ಕೋರ್ಟ್ನವ್ರು ಕೊಟ್ರೆ ನಾವು ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿ.
ಯಾವುದ್ರಲ್ಲಿ?
There are two, my lord.
There are 3 matters here.
Three matters. In the first one, they say, my lord, this. In the second two other matters, they say, court.
ಅಂದ್ರೆ different officers sanctioned.
Please.
There are about 6 or 7 officers here.
Yes. They went, my lord, before the media. They, my lord.
Media?
ಎಲ್ಲ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಡಿಫೆಮೇಶನ್ಗೆ ಹಾಕಿದೀವಿ ನಾವು. ಅದಕ್ಕೆ ಡಿಫೆಮೇಶನ್ ಅಂಡ್ ಇದು ಅಷ್ಟೇ.
Defamation go ಹಾಕಿದ್ದೀರಾ?
ಡಿಫೆಮೇಶನ್.
That's a
Defamation and
part.
malicious prosecution.
Sanction for that also.
Monday is my request, my lords. Last chance.
This is not
Ready it
correct.
is illa. Ready it is for some session and other things I couldn't get the officers to sign. Monday.
ಸೆಷನ್ ಎಲ್ಲಿ ಆಗ್ತದೆ? ಸುವರ್ಣಸೌಧ ಅಲ್ಲ? ಇಲ್ಲ.
But some
ಮತ್ತೆ?
reason, my lords, I could not.
What, sir?
Last Monday.
Heard the learned senior counsel, Sri Uday Hulla, appearing for the petitioner. These petitions are an offshoot of an order passed by this court in criminal petition 5232 of 2024, disposed on 5th July 2024. The issue therein was the concerned court taking cognizance of the offense, which included the offenses, taking cognizance of the offenses and registering CC without sanction being in place. Therefore, this court disposed the petition, allowed the petition, set aside the order of taking of cognizance, reserving liberty that if sanction would be accorded, the concerned court could proceed with the matter. Sanction is rejected after the order passed by this court. Therefore, the petitioner therein, the respondent complainant therein is now before this court, calling in question rejection of the order of sanction. The learned Additional Advocate General seeks 3 more days' time to file statement of objections. Statement of objections be filed by the next date of hearing. List the matter on Tuesday at 4 p.m. for further hearing.
Great.
Sir,
ಕೊಡ್ತೀನಿ.
Wednesday ತಗೊಳ್ಳ?
ಬೇಡ, ಮಂಗಳವಾರನೇ ಇರಲಿ, before that only I'll serve.
ರೆಡಿ ಇದೆ ಅಂತ ಕೊಟ್ಬಿಡ್ತಾರೆ.
ಬೇರೆ.
My lord, I'm being led by senior counsel.
Yes.
My lord, I appear on behalf of the petitioner, my lord.
There are 3
My lord,
petitions.
in WP number 32798, what is called in question, my lord, is a public notice at page 247. Kindly see, my lord, this public notice is such an extraordinary action that has been taken.
Ready, Idira Kumar?
I had to file objections. There are 3
My lord, I
matters.
have objection, my lord. This matter
No,
has
there
been
cannot
going
be
on
any
for-
objection because 2019, they have questioned in
My lord,
2024. Multiple proceedings have been initiated. It is a fraud, cheated to the thousands of public, and various agents have initiated proceedings and winding up petitions pending. And also that is not.
Behind direct selling private.
My lord, can I?
Yes, sir. 1 minute, tell me, sir. Yes.
Can I say something, my lord?
Yes,
My
sir,
learned
yes.
friend will permit. Your lordship permits me, my lord, by my learned friend doesn't. That is my difficulty.
Yes, yes, sir.
That is my lord, kindly turn to page 247 for a minute.
In which
I am
page? I am holding 30600.
No, my lord, you your lordship kindly take 32798. Please see, my lord, what has been done in this case. I am conscious of the fact that this is a public notice of 14th of August 2019. Now, my lord, I'll read this, my lord, for your lordship's consideration. The Registrar of Companies Karnataka has conducted an inspection under section 2065 of the Companies Act 2013 of the books of accounts of Vihan, having a register office at so and so. The inspectors appointed have reported various violations under the Companies Act and also have highlighted the fraudulent activities of the company with an intention to dupe the investors. The inspectors have also pointed out a number of violations under the Consumer Protection Act and various clauses of the Direct Selling Guidelines 2016. The inspection report is therefore uploaded on the website of the Department of Consumer Affairs for information of the general public with a view to aware them so as to prevent any possible fraud by the company under the garb of direct selling business multi-level marketing. The following investigation complaint cases against the above said company are also brought to the notice of the general public in order to create awareness among them. A prosecution has been launched against Vihan under section 276B and 279(2) of the Income Tax Act. There are several FIRs registered against the company in the state of Maharashtra, Telangana, Karnataka, West Bengal, and NCT, Delhi. WP criminal number so and so in the matter of Financial Fraud Victims Welfare Association with the Union of India. WP criminal number so and so in the matter of Vihan direct selling so and so in the matter of Vihan in respect to the company are sub judice before the Honorable Supreme Court of India. Now, my lord, this has been put on the website, and we have not. This has been done, my lord. Virtually now, what has happened is because of the public notice, my lord. What I do is, my lord, direct selling. I use, my lord, the services of the postal department for the purpose of supplying goods which are ordered by my various customers. Because it's a bulk selling activity, I enter into an agreement with the postal department. Now, my lord, I entered into this agreement with the postal department, and my lord, I was using their services. And the report in the postal department is that I have been very regular. There has been no default. Now, but because of this, the postal department now says, sorry, I am not going to renew your agreement. You can do your business as an ordinary person without permitting me to enter into a wholesale supply agreement with the postal department.
ಈಗ what is the grave urgency now?
My lord, the grave urgency is, my lord, just kindly now turn, my lord, to the my lord, page 70. Your lordship may kindly turn to page 71, my lord. If your lordships are kind enough to turn to page 71. I'm sorry, my lord. I'm sorry. Your lordship may...
Other petition, 30600.
I'm sorry, my lord. Your lordship may kindly...
30600.
30600. On the basis of this. If your lordship will kindly see, my lord, what has happened. Now from the department, I get a communication, my lord, at page 96. Kindly see what has happened. In connection with the above subject, renewal of agreement with the above said customers may be put on hold as ROC has intimated that several criminal cases are filed against the company in different courts and investigated by various agencies for fraudulent activities carried on by the company. But this is a serious issue. I have virtually been blacklisted now.
May I make one submission?
One minute. I'll answer.
I have been virtually blacklisted now.
Sir, this is a clear offshoot of what was in 2019 itself. It is only communicated to you. All the things, if you see the order.
Yes, madam.
If you see the notice.
Yes, madam. Public notice.
Public notice and travel throughout the notice. Everything is said in this.
No, my lord. I tell you, lordship, what has happened.
Let the objections come about.
This has been going on. Kindly see how many times it has been adjourned at the instance of my learned friend.
This will go on for the last time now.
May I make one submission? With regard to this postal departments, I have instruction to place a memo. They can make a representation within 8 weeks. They consider and take a decision. Two petitions, 30,600. Postal department is
petition.
Yes.
Bad, we'll close everything at once.
19 is concerned. I have instruction to file objections.
Your instruction should come fast, sir. File objections immediately. I'll grant you last occasion, last chance. Yes.
As well, these two petitions can be closed, matters.
I shot your lordships, my lord.
We'll see on that day. Yes. Idral barkoli, madam. WP 32798 of 2024. What is called in question is a public notice dated 14th August 2019. Even according to the petitioner, the following issues arise for consideration in the case at hand. All the issues are as follows. Page 6 and 7. All the issues that which according to the petitioner have fallen for consideration are all of the year 2019. The subsequent petition is the subsequent action is communication of an electronic mail to the petitioner by the respondent. This, in the considered view of this court, albeit prima facie, is an offshoot of the notice that is public notice that is challenged in the companion petitions. Therefore, objections in the case at hand would become imperative. The learned senior counsel KG Raghavan, representing the petitioner, submits that time is being sought for filing of statement of objections ad nauseum. Therefore, I deem it appropriate to direct the respondent to file statement of objections positively by the next date of hearing. Murvara last.
Well, no, my lord, your lordship may post it next week. My lord, there are urgency for us. My lord, my business is very bad.
Yes. I'm suffering loss every day.
My lord, my business is affected. Kindly take it up any date next week.
Business is affected since 2019.
No, my lord, no, my lord. It is only 2024.
We'll see.
My lord, one minute, my lord. My learned friend will kindly accommodate me.
List the matter 2 weeks. 2 weeks of objections haki. That is on, list the matter on 8th April. Yes.
8th. My lord, yeah, go.
15th or 16th.
No, no, earlier.
For
My lord, can it be little earlier, my lord? There's urgency for us, my lord. 4th or 5th.
Objections illa andre matte problem
My lord, let them file it. My lord, unless there is, unless they,
They
my
will
lord, if
file
they
it.
don't.
In the
My
event,
lord, there is an order passed by the Supreme
1
Court.
minute.
My-
In the event, Supreme Court?
Yes, my lord, I showed your lordship that. That's important. My lord, 1 minute, my lord.
All 31.
My lord, my
Where
lord,
is the order of the Supreme Court?
I will show your lordship the order of the Supreme Court, my lord. Please
is
be kind.
pertaining to them.
Yes, yes, my lord,
Nothing to do
kindly,
with us.
Wait,
let
sir.
my learned friend kindly have little bit patience, my lord.
Wait,
Kindly
Kumar
turn to,
sir.
kindly turn to page 139. In respect of these very type of complaints. Same thing that is referred to. In fact, in the notice, they say it is sub judice before Supreme Court. There is an interim order.
Vihan direct idu adene.
Please see page 140, my lord. This is what they say is sub judice before Supreme Court. We have heard the learned senior counsel appearing for the parties. Exemption allowed.
List the matter on 4th April. Objections, if any, by the respondent by then. In the event objections are not filed, it shall be construed that there are no objections to be filed. Next.
Grateful.
One indulgence, my lord.
Under fresh matters, my lords. My lords may have it under fresh matters.
No, preliminary hearing. Yes.
Wednesday because
Instead of Tuesday.
ತಾವೇ ವೆಡ್ನೆಸ್ಡೇ ಬೇಡ ಅಂದ್ರಲ್ಲ ಅದಕ್ಕೆ.
First one, I thought, my lord, there was one matter, my lord, where matter will go until about 5:30 ಕಾಣುತ್ತೆ. ಅದಕ್ಕೋಸ್ಕರ
ಇಲ್ಲಿ
ಅಲ್ಲ, ಇನ್ನೊಂದು court ಅಲ್ಲಿ.
ಸರಿ.
ಅದು Tuesday ಬರುತ್ತೆ. ನಾನು I thought it was on Wednesday.
ಆಯ್ತು ನಿಮ್ಗೆ ಯಾವತ್ತು ಬೇಕು ಅವತ್ತು ವೆಡ್ನೆಸ್ಡೇ ವೆಡ್ನೆಸ್ಡೇ.
Wait, sorry.
ನೋ ಪ್ರಾಬ್ಲಮ್ ನೋ ಪ್ರಾಬ್ಲಮ್. Yes, next.
Please, my lord.
Yes, Aditya, what is this?
Under challenge, lords will see page number 29, annexure A, is an auto-generated email order by the registry of the Karnataka Real Estate Regulatory Authority.
For
The
respond
complaint
number 1.
filed.
Okay, I'm for respond number 2, your lordship.
It's a pure question of law, my lord. I'll just point out what is there.
What is
Complaint.
No, he wants to produce your lordship. Maybe which are taken on record, and I am ready for the.
Objections, sir.
Not objection, only a list of documents, your lordship, which are not produced.
Who are you?
I am respondent number 2, your lordship.
Complainant there.
No, your lordship, the private respondent.
The private respondent.
Yes.
The issue, my lord, is a jurisdictional one. The question of pure question of law is, my lord, may just see the annexure A order that has come from the registry of the RERA.
All right.
I'll just read it. Dear sir, madam,
Yes.
complaint has been rejected for complaint number so and so. That is my complaint.
Oh, your complaint is rejected.
My complaint is rejected on this ground. Reason peruse the facts of the complaint and reliefs. Complaint has sought for permanent injunction restraining the respondent from constructing in violation of the original sanction plan and demolish the structure so and so. Declare the revised sanction plan is illegal in respect of the project. The relief sought in the complaint does not come under the jurisdiction of this authority. Hence, the complaint so and so is not registered as not maintainable. Two issues, my lord. First, of course, is that this is without a hearing. So I filed a complaint. I automatically get an email rejection saying that we will not hear the matter further. I file an IA saying I can convince the court on the jurisdiction because it comes from the statute itself.
Yes.
Because it's a question of section 14 of the RERA Act. I mentioned the matter for a hearing. I file an application for oral hearing. That is also declined. And finally, I am left remediless.
Yes,
Now, directly on the question.
Let it be heard.
My lord.
Not by me, by RERA. What's the problem? How can the administrative office of RERA send an email saying complaint is rejected? Does it have the stamp of the members?
My lords may see the signature. It says, note, this is a system generated email. Please do not reply.
Yes, sir.
To be
How
an-
can it happen? Whether his complaint is tenable or not, it needs an answer by the member sitting there, not a clerical mail or system generated mail.
Yes, my lord, kindly have this on 2 days, my lord. I'll just collect what is the detail and I'll just submit fairly to the.
Yes, Monday, fresh matters.
Obliged.
List the matter on Monday in the fresh matters list.
Obliged.
Prima facie, I am of the opinion
Yes,
that I'll
ma'am.
send it back to RERA to get
Yes,
it, to hear it on merits.
I'll inform, my lord. Obliged.
So deeply.
Next.
My lord, bail notice was under challenge. My lord, the petitioners have paid full loan amount. The principal amount was 6 lakh. My lord, 47 lakh is paid. On 31st of December, my lord, interim order was granted. subject
Who
to
appears
payment.
to respond?
I appear for the respondent bank.
What's the grievance, sir?
My lord,
My lords, they
now
have paid.
Now the auction purchaser has come on record, my lord. I have filed impleading application. He has filed.
You are the auction purchaser.
I am the borrower, my lord.
All right.
I am the borrower. I had obtained the interim order on 31/12/2024, my lord. I complied it on 3/1/2025 by making the full loan payment. I have filed the memo to that extent.
All right.
On 30, and the bank has endorsed the same by collecting 47 lakhs in total, along with 96,000 of court charges. My lord, now the problem has, my lord, the auction purchaser. The auction was conducted on 20/12/2024.
Oh, before the interim order.
Before the interim order. However, the sale certificate was not issued. My lord, now the bank has to return the documents by
Auction purchaser.
auction purchaser.
Auction purchaser, my lords.
You have to compensate the auction purchaser also. How much money have you deposited?
Lords, 2 crore 52 lakhs, my lords.
The
entire amount?
Please, my lords.
My lord, 16 acres is the land.
Coffee-
My lord,
coffee
on a
plantation.
coffee plantation.
Please.
For an average price, there runs amount 40 lakh. The neighboring sale deed I have,
ಎಲ್ಲಿದೆ ಅಲ್ಲಿ?
my lord, in Mudgere Taluk. My lord, the average
ಮೂಡಿಗೆರೆ
price
40 ಲಕ್ಷ ಇದೆ ಎಕರೆಗೆ.
40 lakhs ಇದೆ. I have the sale deed of the neighboring in the same village, Hasgal. However, even considering the very moderate price, it is 25 to 30 lakh. That
How
amounts
much is
to
it
40
sold
lakh,
for?
4 crores rupees. Now the
How much is it sold for?
now it is sold for 15 lakh per acre. Even the residential house is there inside. The residential house amounts to easily amounts to 70 to 80
ಅದಕ್ಕೆ
lakh.
you compensate the auction purchaser also.
I have paid 96,000 extra to
ಅಲ್ಲ
bank also, my lord.
ಇಂಟ್ರೆಸ್ಟ್ ಏನ್ ಬರುತ್ತೆ ಅವರು ಡೆಪಾಸಿಟ್ ಮಾಡಿರೋದಕ್ಕೆ ಆ ಇಂಟ್ರೆಸ್ಟ್ ಅಮೌಂಟ್ ಪೇ ಮಾಡಿ ವಾಪಸ್.
Nominal interest.
ನಾಮಿನಲ್ ಅಲ್ಲ, ಫೆನಾಮಿನಲ್.
It's a agricultural loan, my lord. Loan is on 2016. It was considered NPA in 2024, May ಅಲ್ಲಿ.
ಪರವಾಗಿಲ್ಲ.
ಅಲ್ಲಿಂದ ಇಲ್ಲಿಗೆ
ಆಲ್ ದೀಸ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕಾರಣ ನಿಮ್ ಡಿಫಾಲ್ಟ್.
Yes.
ಆಕ್ಷನ್ ಪರ್ಚೇಸರ್ ಎಂಟ್ರಿ ಆಲ್ಸೋ ನಿಮ್ ಡಿಫಾಲ್ಟ್. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕೊಟ್ಮೇಲೆ ಮಾಡಿದ್ರೆ ಬ್ಯಾಂಕ್ಸ್ ಪ್ರಾಬ್ಲಮ್. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕೊಡಕ್ ಮುಂಚೆ ಮಾಡಿದೆ. ಸೊ ಆಕ್ಷನ್ ಪರ್ಚೇಸರ್ ಹೂ ವಿಲ್ ಲೀವ್ 16 acres?
16 acres.
16 acres for 2 crores.
For 2 crores.
That's why he has deposited the entire thing. Yes, sir. Yes, sir. Our plantation ಉಳಿಸ್ಕೊಳ್ಳಿ ಬಿಡಿ. ನಿಮಗೆ ಇಂಟ್ರೆಸ್ಟ್ ವಿಲ್ ಡೈರೆಕ್ಟ್.
Please.
ಬ್ಯಾಂಕಿಗೆ ದುಡ್ಡು ಬಂದಿದೆಯಲ್ಲ ಪೂರ್ತಿ?
Yes, my lords, we have received the entire amount.
ಈಗ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ವಾಪಸ್ ಬೇಕಾ?
Documents.
ಫುಲ್ ಕ್ಲಿಯರ್ ಮಾಡಿದಿರ ಲೋನ್?
Clear ಮಾಡಿದೆ. 47 lakh clear, including penal interest, ಎಲ್ಲದೂ
ಆಯ್ತು.
ಸೇರಿ ಕೊಟ್ಟಿದೆ.
Interest on the deposit.
Interest on the deposit of auction purchaser.
ಅದ್ ಮಾಡಿ ವಿಲ್ ಕ್ಲೋಸ್ ಎವ್ರಿಥಿಂಗ್. ಎಷ್ಟು ದಿ ನಾಮಿನಲ್ ಇಂಟ್ರೆಸ್ಟ್ ವಾಟ್ ಎವರ್ ಇಟ್ ಇಸ್ ಅದೆಷ್ಟು ಅಂತ ಹೇಳಿ I'll post it on Tuesday, we'll close it on Tuesday.
Okay.
Yes, bank, you return all the documents.
Yes, my lords.
But plantation ಅವ್ರಿಗೆ ಇರ್ಲಿ ಬಿಡಿ sir.
We have no objection. We have received our money.
Yes, yes.
Grateful.
Grateful.
Yes.
We have a petitioner in this case, my lord.
Your lordship, there's a connected writ petition 7253 of 25 dismissed. There, the convict himself had sought for parole. Here, this is his wife.
Why it is dismissed?
No, it was dismissed because 1 year.
1 year ಆಗಿರ್ಲಿಲ್ಲ ಅಂತ.
No, 2 years ಆಗಿರ್ಲಿಲ್ಲ.
ಎಮರ್ಜೆನ್ಸಿ ಪರೋಲ್ ಕೇಳಿ ಅಂತ ಹೇಳ್ತಾನೆ ಇದೆ.
ಅದನ್ನೇ ಹೇಳಿದೀವಿ ತಾವು.
030 ಅಲ್ಲಿ.
I will not grant. Contrary to the law, I will not grant parole at all.
Earlier ಅಲ್ಲಿ ವೆರಿಫೈಯಿಂಗ್ ಅಫಿಡವಿಟ್ ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದು ಲಿಬರ್ಟಿ ತಗೊಂಡು.
ಅಲ್ಲ ಅದು ಏನಾರು ಇರ್ಲಿ ವೆರಿಫೈಯಿಂಗ್ ಅಫಿಡವಿಟ್ ಅಲ್ಲ.
ಮಾಡ್ಕೊಳ್ಳಿ.
ಈಗ 2 ವರ್ಷ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಆಗಿಲ್ಲ.
11 months ಆಗಿದೆ.
11 months ಪರೋಲ್ ಬರುತ್ತಾ? ಪೊಲೀಸ್ ಮ್ಯಾನ್ಯುಯಲ್ ಪ್ರಕಾರ 11 months ಪರೋಲ್ ಬರುತ್ತಾ? ಪೊಲೀಸ್ ಆಕ್ಟ್ ಪ್ರಕಾರ ಬರುತ್ತಾ? ಪ್ರಿಸನ್ಸ್ ಮ್ಯಾನ್ಯುಯಲ್ ಕರೆಕ್ಟ್. ಇಲ್ಲ ತಾನೆ? ಬರಲ್ಲ. ಎಮರ್ಜೆನ್ಸಿ ಪರೋಲ್ ಕೇಳಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಆಲ್ ಆಫ್ ಯು, ಐ ವಿಲ್ ಗ್ರಾಂಟ್ ಅಂತ. ಅದನ್ನ ಮಾತ್ರ ಮಾಡಲ್ಲ, ಜನರಲ್ ಪರೋಲೇ ಬೇಕು. ಜನರಲ್ ಪರೋಲ್ ರಿಜೆಕ್ಟೇ ಮಾಡ್ಬೇಕು, ಚಾಯ್ಸೇ ಇಲ್ಲ.
Aged about 72 years, my lord.
ಏನಾರು ಇರ್ಲಿ ಸರ್, ಏಜ್ ಈಸ್ ಏಜ್ಡ್ ಅಬೌಟ್ 72, so I will violate the statute and pass an order.
No, if there's any emergency.
Emergency parole definitely we will grant. See, if I grant this parole, then ಎಲ್ಲಿ ಅವರು he will come with 100 cases. ಯಾರ ಬಗ್ಗೆ ಹೇಳ್ತೀನಿ ಗೊತ್ತಲ್ಲ. ಅವ್ರಿಗೆ ಗೊತ್ತು. ಒಂದು ಕೇಸಲ್ಲಿ ನಾನು ಏನಾದ್ರು 2 ವರ್ಷದ ಕೆಳಗಡೆ ಒಂದು ಪರೋಲ್ ಕೊಟ್ಟಿದ್ರೆ ಬೈ ಮಿಸ್ಟೇಕ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ರು ಆಯ್ತು. ಫಿನಿಶ್. There will be 100 petitions here. Yes. File emergency parole, I will definitely grant, but file it immediately. Yes. Monday ಮಾಡ್ತೀರಾ?
Let them withdraw the petition.
ಈ withdraw ಮಾಡಿ Monday ಹಾಕಿ. Learned counsel for the petitioner, after arguing the matter, would seek leave of this court to withdraw the petition and file an appropriate petition seeking emergency parole. Liberty so sought is granted. Monday ne haki, I'll take it and grant. Emergency parole ತೊಂದ್ರೆ ಇಲ್ಲ.
That's for the petition.
How to my lord.
Complainant. Entry ಮಾಡ್ರ ಇಲ್ಲ?
ಇಲ್ಲ.
ಹಂಗಾರೆ ಇದು ಡಿಫಿಕಲ್ಟ್ ಕೇಸಾ?
Difficult case ಅಲ್ಲ, it was, we were unable to convince the court why we entry ಮಾಡ್ರ ಕೊಡ್ಬೇಕು.
ಹೇಳಿ.
My lords, the crux of the matter is, there was a suit in the year 2017 filed by the petitioner against several people seeking permanent injunction. That suit is at page, annexure D, page number 81, the judgment of that suit, my lords.
Date?
It is dated 8th day of December 2022. Permanent injunction was granted. The suit was for.
In your favor?
Yes, my lord.
All right.
The defendants in that suit were, defendant number 1 was the PDO.
PDO?
PDO,
All right.
Panchayat Development
ಗೊತ್ತಾಯ್ತು,
Officer,
ಗೊತ್ತಾಯ್ತು. ಹೇಳಿ.
Appanaganta, Gram Panchayat, Arsikare. And then other persons, Raju, Doddamma, Chandrasekhar,
ಆಯ್ತಾಯ್ತು.
and so on so.
ಹಾ.
Now, in this, it was with regard to the petitioner's suit schedule property, measuring 60 by 60, a permanent injunction was granted. And the facts of the case were that the father of the first petitioner has expired. He had to get a khata transferred into his name, which he was unable to, and the others were causing some trouble, so he filed a suit for injunction, and which was granted. Then after that, there were several representations made to the PDO for transfer of khata, which were unattended. Then subsequently, we filed a writ petition before this Honorable High Court. The writ petition came to be allowed, and the directions were given to the PDO to ascertain and to make necessary, if the documents are in place. The khata may be paid out anta.
ನೀವು ಹೇಳ್ತಾ ಹೋಗಿ.
The defendant, the complainant in this matter is my neighbor. No, not the complainant, sorry. CW6. CW6 is Chandrappa. Chandrappa is my immediate neighbor. There is a dispute with regard to the boundaries of the property between Chandrappa and myself. When I was pursuing for khata of my property, I have filed a writ petition. I have got a order from the Honorable High Court, and I was pursuing my writ petition. This complaint has come in place, my lords. The allegations are that the petitioner and his 2 children have assaulted and used some unparliamentary language on the complainant. And that, and if you also look at complaint at page number 15, my lords. There is an allegation in the complaint. The allegation is that Raghu annavaru nannannu baiduru anta. Raghu is accused number 2, but charge sheet has been filed against accused number 3. Accused number 3 is a young boy aspiring government a job, and this is all out of personal vendetta. This thing has arisen. These are the facts.
Yes.
There is a suit pending against.
ಅದು ಹೇಳಾಯ್ತಲ್ಲ ಮತ್ತೆ.
ಅದೊಂದು suit dispose ಆಗಿದೆ. I have filed another suit. 376 of 2024. I have an interim order in my favor directing the, that is CW6, not to interfere with my possession and so on. To avoid all this personal jagada idan itkondo, they have
there is the allegation or this complaint has been staged, my lords. That I have scolded that lady, unparliamentary language, unparliamentary words, all staged. And the real crux of the matter is the CW4/6 is my neighbor. There is a
ಅದನ್ನ ಮತ್ತೆ ಹೇಳಾಯ್ತಲ್ಲ.
ಅಷ್ಟೇ ಇರೋದು ಸ್ವಾಮಿ.
ಮತ್ ಬಿಡಿ ಸಾಕು.
Yes, ma'am.
Swami, dispute is Satya Swami. CW2 and CW6 and petitioner. Dispute is Swami. When CW6 also taken injunction order against the petitioner, my lord. Copy is here. ಅದು ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಇತ್ತು ಅಂತ ಅಂದ್ರೆ ಅವ್ರವ್ರು ಸರಿ ಮಾಡ್ಕೋಬೇಕು ಸ್ವಾಮಿ. ಇವ್ರ ಲೇಬರರ್ ಕಂಪ್ಲೇಂಟ್ ಇಸ್ ಲೇಬರರ್ ಹೂ ಆರ್ ವೆಂಟ್ ಟು
Whose laborer are you?
ಕಂಪ್ಲೇಂಟ್ ಮೈ ಲಾರ್ಡ್.
Chandrappa's laborer.
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
Correct. There lies the problem.
ಹಾ ಸ್ವಾಮಿ, ಅವ್ರು ಹೋಗಿದ್ದು ಬಿಲ್ಡಿಂಗ್.
Suit is between Chandrappa and him.
Yes, please.
There is an injunction operating against Chandrappa in their favor. All right?
Yes, please.
You are Chandrappa's employee. On the ground that something has happened, Chandrappa's laborers have been set up to give this complaint. And evidence, eyewitness evidence, yaro CW6 is Chandrappa, with whom he has a dispute.
There are independent eyewitness also, my lord.
That's all right. Now Atrocities Act straight away goes. Next. Now come to the wound certificates that are there. There are 3 wound certificates, 48, 49, 50.
Yes, my lords.
Those 3 wound certificates indicate there are wounds. Whether it is simple or grievous is not the thing.
Yes, ma'am.
And next, section 354 IPC is alleged, outraging the modesty. Now come to last 4 lines at page 28. ಆಕೆಗೆ ಕೆಳಗೆ ಹಾಕಿ ಹೊಡೆದು ಎಳೆದು ಎಲ್ಲ ಮಾಡಿದೆ.
Yes, ma'am. Then there was a direction.
See, there is that is a matter of evidence. ಅದು ಗೊತ್ತಿಲ್ಲ. Atrocities Act I will quash and you will face trial for 323, 504, 506 and 354.
I think this is a, yes, ma'am. And the charge sheet is.
ಇಲ್ಲ Atrocities Act quash ಮಾಡ್ತೀನಿ. ಆ ಬಾಯ್ ಯಾರೋ ಇದಾರಲ್ಲ ಅವ್ರು ತೆಗಿತೀನಿ.
Yes,
that I will take off. The others, yes. ಈಗ ಯಾರಿದು A3 ಒಬ್ರೇನಾ? ಶಾಂತಪ್ಪ ಯಾರು ನನಗೇನ್ ಗೊತ್ತು ಸರ್.
ಬ್ರಿಟಿಷ್ ನಂಬರ್ 3 1 2 3 3 ಜನ ಇದ್ದಾರೆ.
This Shantakumar we will quash in its entirety.
Yes, ma'am.
2 and 1 and 2, 323, 324,
We'll
why
face the
not?
trial.
That he will face.
Yes, ma'am. We'll face the trial with regard to.
Chandrappa has set up his employees to give a complaint of Atrocities Act.
Page 61 sir 164 that's 2 164 statement.
ನೋಡ್ದೆ ಎರಡು ನೋಡ್ದೆ 164 ಸ್ಟೇಟ್.
ಶಾಂತಕುಮಾರ್ ಮೇಲೆ ಇದೆ.
ಗೊತ್ತಾಯ್ತು. 164 ಯಾರ್ದು?
CW1 2, my lord.
CW1 and 2. CW6 is employees.
Yes, ma'am.
Backdrop ಹೇಳ್ಬೋದಲ್ಲ. ಯಾವ್ದು? ಅಲ್ಲ CCTV footage ಇರ್ಲಿ. Now this is all that can be.
You have CCTV but in fact I asked why they are not given. RTA they applies it. There is a letter written to them asking them to pay money.
No,
and
this
they are not taken.
in view of the impending dispute and that background, Atrocities Act will not get attracted at all. Yes. Other offenses, yes. The more matra, because there is offense saying that you have dragged the lady, pulled her saree. I will not quash that such things. Yes. The petitioners accused 1, 2 and 3 are at the doors of this court calling in question proceedings in special case 325 of 2024 registered for offenses punishable under section 323, 324, 354, 504, 506 of the IPC and sections 31R and S, 32VA of the Atrocities Act. Heard so and so. The petitioners and CW6-1 Chandrappa have an impending dispute with regard to the boundary of the property. It transpires that the petitioners 1 and 2 institute a suit in OS
326.
14 of 17 ಅಲ್ಲಿ ಸ್ಟೇ ಸಿಕ್ಕಿತ್ತು.
376 of 2024, in which the concerned court grants an injunction against Chandrappa CW6, restraining him from interfering with the possession of the petitioners. On 3/5/2024, the employees of Chandrappa, the complainant, the complainants, the complainant registers a complaint alleging that they have been assaulted and the lady has been, the complainant has been assaulted and also hurled abuses which would become an offense under the Atrocities Act. This becomes a crime in crime number 71 of 2024 for the aforequoted offenses. It transpires that the police, after investigation, have filed a charge sheet. Filing of the charge sheet is what has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner would vehemently contend that the complainant is set up by CW6 Chandrappa, who has an axe to grind against the petitioner since the civil dispute between the two regarding the boundary is pending consideration before the concerned civil court. He would submit that none of the incidents that have happened on the said date have occurred. It is only an imaginary allegation that is made by the complainant against the petitioners. The learned counsel appearing for the second respondent complainant would refute the submission in contending that the complainant was assaulted, gravely assaulted and hurled abuses, taking the name of the caste of the complainant. Therefore, the complainant and the police, after investigation, have filed a charge sheet. The matter is it is a matter of trial for the petitioners to come out clean. Therefore, would seek dismissal of the petition. The learned additional SPP, B.N. Jagdish, taking this court through the wound certificate and the evidence of eyewitnesses, would seek to demonstrate that in fact abuses have been hurled and the injury is caused to the complainant, and would seek dismissal of the petition, contending that it is a matter of trial. I have given my sounds. Therefore, narrated facts are not in dispute. The issue is the dispute between one Chandrappa, CW6, and the petitioners. The petitioners approached the civil court in 376 of OS 376 of 2024, in which they are granted an order of injunction. After which comes the impugned complaint on 3/5/2024. The complainant is the employee of CW6. Since the entire issue has triggered from the complaint, I deem it appropriate to notice the gist of the complaint as found in column number 10 of the FIR, page 13, madam. The police, after investigation, have filed a charge sheet. The summary of the charge sheet as obtaining in column number 17 reads as follows, page 28. A perusal at the complaint and the charge sheet would unmistakably indicate that the offences under the Atrocities Act are untenable, as the dispute between Chandrappa and the petitioners have led Chandrappa to have led the employee of Chandrappa to register a complaint against these petitioners. Hurling of abuses is vaguely quoted in the complaint and in the charge sheet. It is trite law that mere hurling of abuses would not amount to an offence under section 3(1) R and S of the Atrocities Act. There must be clear intention on the part of the accused to insult the complainant of the kind. Therefore, the offence under the Atrocities Act cannot be permitted to be continued. They are to be obliterated. What remains are the offences under the IPC. They are 324, 504, 506, and 323. The offences, those offences will have to be tried for the reason that the wound certificates are appended to the charge sheet. The three wound certificates would clearly indicate several injuries all over the body of the complainant and others. Though they are not grievous in nature, nonetheless, they are injuries. Pendency of a civil suit between the two is not a license to injure any person who are the defendants or the plaintiff in this suit. Therefore, the offences under 323, 324, 504, and 506 shall continue. shall continue. The remainder of the offense is section 354 of the IPC. To allege section 354, the last 5 lines of column number 17 is a vivid narration of what has happened on the said date. Therefore, the offense under 354 also will have to be tried. Not against the third accused number 3, but against accused number 1 and 2. Accused number 3 is said to be a student. Is said to be a student who is now aspiring a service in the state, and he was not present in the spot is the allegation. Even otherwise, except in the statement under 164, the complaint does not narrate any overt act upon the third upon accused number 3. Accused number 3 for the trial to be continued against him for the aforesaid reasons, the following order. The offense under the Atrocities Act, so and so, are obliterated in its entirety against all the accused. Offenses under 323, 324, 354, 504, 506 are sustained against accused number 1 and 2. The accused number 3, all proceedings in Special C 325 of 2024 stands obliterated qua accused number 3. Ordered accordingly. Yes. 230 ಬಂತಾ?
Hearing 70.
Petitioner madam.
Not appear for respondent.
For restitution madam.
Then restitution.
The property is sold and the list has been set at rest by all the courts that will be time barred it.
Time barred data.
Yes.
Well,
Ah.
but the property was sold not under the Surface Act, not under the SFC Act.
Who
Not-
sold it?
KSFC has sold it, by exercising power under the Surface Act against the secured property. It was possession was taken. That order was challenged before the DRT. It was possession was it was set aside and matter was remanded to the once again to the case of to issue a fresh notice. However, possession was not redelivered to him. Against that order, an appeal was filed before the DRAT. DRAT, I filed my objections. DRAT dismissed the appeal on the ground of delay. This honorable against that and a writ petition was filed before this honorable court, and writ petition was allowed subject to deposit of 50 lakhs rupees before the DRAT.
ಈಗ ಎಷ್ಟು ಏನ್ ಕೊಡ್ಬೇಕು ನಿಮ್ಗೆ ವಾಪಸ್?
ಅದು ಕೊಟ್ಟೇ ಇಲ್ಲ ಅವರು. ಆಮೇಲೆ
The house has to come back to me because the property was subject matter at page 39, my lord, before the district court, Chamarnagar. Item schedule A.
It has a checkered history. 2012 ಇಂದ ಏನೋ ಇದೆ.
ಹೌದು. This court in appeal.
File a synopsis.
I've already filed.
Synopsis. Petition ಇರೋ synopsis ಅಲ್ಲ. ಸಪರೇಟ್ ಆಗಿ ಹಾಕಿದೀರಾ?
ಇಲ್ಲ ಬೇರೆ.
I am for second. I am the purchaser.
ನೀವ್ ಯಾರು?
I am purchaser.
Auction purchaser. All right. The parties to the list to file a short synopsis of list of dates and events as the issue dates back to more than a decade. List the matter. In the event synopsis is filed by the parties, list the matter on 4th April. In preliminary hearing. Next.
71 and then 72.
Early hearing. Neneda.
Before my, last week, senior friend did start, I have secured the records. This is the case where just my document has been withheld since 2011.
ಅದೇ ಗೊತ್ತಾಯ್ತು. But what is stamp duty impose ಮಾಡಿರೋದು 2011 ಇದೆ ಅಲ್ಲ guidance.
11 ಇದೆ. In fact, they missed it. What had happened is
ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ ವಾಪಸ್ಸು?
document ಇನ್ನು ಕೊಟ್ಟಿಲ್ಲ.
ಈಗ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ?
ದುಡ್ಡು ಕಟ್ಟಿಲ್ಲ ಅವ್ರು.
ಏನ್ ದುಡ್ಡು ಕಟ್ಟಬೇಕು?
They have to pay the difference.
19 ಲಕ್ಷ.
19 ಲಕ್ಷ.
19 ಲಕ್ಷ ಡಿಫರೆನ್ಸ್ ಟುಡೇ ಆರ್ ದಟ್ ಡೇ?
On that day. My lord, I'll tell you what has happened. I have secured the entire.
No, that's all right. But even if ಈಗ ಕೇಳಿದ್ರಲ್ಲಿ ಏನ್ ತಪ್ಪಿದೆ?
Only see, before going to that, before that, we have challenged the validity of the assessment. But even before that, very recently, just to say the time of this honorable court. Very recently on 4th March 2025, this
I have passed a detailed order, I know.
they can't recover after 5 years.
ಅದೇ ಕೇಳ್ತಾರೆ, ಅದ್ ಕೊಡಿ ಇಲ್ಲಿ.
I am sorry, my lord, I am their lordship justice.
ಕೊಡಿ ಅಷ್ಟೇ. ಜಡ್ಜ್ಮೆಂಟ್ 4th March ಅಂತ ಹೇಳ್ತಾ ಇದ್ರಿ. Sorry.
I am sorry, my lord, I was not able to.
Hey, no
lay
problem,
hand
no.
on your lordship.
Yes, that's all right, yes. I'll close it.
My lord, in this matter, my lord, I.
Recover it from the pocket of the man who kept quiet for long years.
7 years. No, my lord, I will, this is where they are mistaking. I have the record here, my lord. I will come to the.
ಹೇಳಿ ಸರ್, ಎಸ್. 5 ವರ್ಷ ಅಂತೂ ಆಗಿದೆಯಾ?
5 ವರ್ಷ ಆಗಿದೆ ಬೇಡ. My lord, what has happened is, a notice was issued to them. They appear before the court. They file a.
When?
My lord.
They filed their written arguments in the year 2011.
Yes. Yes, my lord.
Correct.
Yes, my lord. Then subsequently, my lord, in this matter, in a 45-year matter, a spot inspection has to be conducted to ascertain the duty. A notice was issued to him to show the spot, my lord. He.
ಬರ್ಲೇ ಇಲ್ಲ.
ಬರ್ಲಿಲ್ಲ.
11 ವರ್ಷ ಕಾಯ್ತಾ ಇದ್ರಿ ಅವ್ರು ಬರ್ಲಿ ಅಂತ.
My lord, in fact, it is in his interest, if we have made a mistake, my lord, I will agree on that point. If they had passed.
If you have made a mistake, you should
If they had passed an order on that day.
pay the price of that mistake.
They'll have to pay with interest, my lord. Now subsequently, if your lordship could kindly see, they come back in the year 2024.
Why?
They come and say that.
Why they came back? Tell me. Because you passed an order in 24.
No, but it didn't. This is
In
before
fact,
the
we
order.
had to file a writ petition to dispose of the matter.
No, this is. No, my lord.
ಹೌದು. ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ಮೇಲೆ ಡಿಸ್ಪೋಸ್ ಮಾಡಿರೋದು ಅದನ್ನ.
They have given a letter to us on 19/3, my lord, then it is disposed of. Well, then.
Why did they give a letter?
Inspection was not conducted unless and until an inspection is conducted to ascertain the market value.
Why the property is in Texas, is it?
ಇಲ್ಲ, my lord, they have to identify because it says survey number 60.
ಅಲ್ಲ ಅವ್ರ ದೇಶದಿಂದ ಆಚೆ ಇದ್ರ?
ಅಲ್ಲ, it is.
ಅಲ್ಲ ಅವ್ರ ದೇಶದಿಂದ ಆಚೆ ಇದ್ರ?
ನೋಟಿಸ್ ಕೊಟ್ಟರೆ ಅವ್ರು ಬಂದು ತೋರಿಸಿಲ್ಲ ಜಾಗ.
ಯಾವಾಗ ಕೊಟ್ರಿ ನೋಟಿಸ್?
Way back in 2011 itself, my lord.
ಆಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರಿ? ಫಸ್ಟ್ ನೋಟಿಸ್ ಆಯ್ತು. ವೇರ್ ಇಸ್ ದಿ ಸೆಕೆಂಡ್ ನೋಟಿಸ್?
Subsequent notices also issued.
Where, sir? ಯಾವತ್ತು? ನೆಕ್ಸ್ಟ್. Where is the second notice?
11/7, my lord, 11/7/2011.
ಅದು 11.
16/7.
11 ಆದ್ಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರಿ?
That is that they have come before the court. They have given an application to us.
Yes, sir. Anything else? ಇದ್ಯಾವುದು ಕಾಂಟ್ರಾಕ್ಟ್ ಸರ್? ಅಲ್ಲ ಜಡ್ಮೆಂಟ್ ಏನು? Which paragraph?
Paragraph.
For recovery which are not levied or short levied could be initiated after 5 years. ಇದು ಇನಿಷಿಯೇಷನ್. ಇಲ್ಲಿ ಇನಿಷಿಯೇಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಮುಂಚೆ ಇನಿಷಿಯೇಟ್ ಮಾಡಿದ್ದಾರೆ. They have not taken it forward.
That was referred. Subsequently, they did not decide at all.
Correct. ಇಲ್ಲಿ ಏನಾಗಿದೆ? It was for the first time initiated.
Deficit idru, they will have to recover only within 5 years.
Correct. ಇಲ್ಲಿ whether proceeding under 46A for recovery of stamp duty, short levied or whatever it is.
Yes.
Can be initiated after 5 years. ಇಲ್ಲೇನಾಗಿದೆ? ಇನಿಷಿಯೇಟ್ ಮಾಡಿದ್ದೆ ಯಾವಾಗ?
In 2011 we submitted the document after for registration, it was registered. Subsequently, they did not take any action at all. Later, we had to file a writ petition before the honorable court.
ಅದು ಗೊತ್ತು.
They did not determine at all.
They have an alternate remedy also, my lord. They have to prefer an appeal.
Seriously?
Hello.
ನೀವು 10 ವರ್ಷ ಆರಾಮಾಗಿದ್ಬಿಟ್ಟು ಈಗ ಆಲ್ಟರ್ನೇಟಿವ್ ರೆಮಿಡಿನ? No, this 19 lakhs
Yes, sir.
will have to be recovered from those officers who have held that post for the last 9 years. No choice. Citizens' rights are taken for granted, and these orders are passed casually imposing stamp duty upon the person after 10 years, 11 years.
They have followed the guideline, my lord. as per the
Seriously, sir, correct. 11 ವರ್ಷ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? 11 ಅಲ್ಲ, 13 ವರ್ಷ ಏನ್?
13 ವರ್ಷ.
13 years. Do you have any responsibility that you are holding a post with which has to be accountable for some things? ನೀವು ಅಂದ್ರೆ ನಿಮ್ಮ ಯಾರಿದು ಸ್ಟ್ಯಾಂಪ್?
District registrar.
ಡಿಸ್ಟ್ರಿಕ್ಟ್ ರಿಜಿಸ್ಟರ್. ಅಷ್ಟೇ. ಇದರಲ್ಲಿ ಇನಿಶಿಯೇಟ್ ಮಾಡಿಲ್ದೇ ಇರೋದನ್ನ ಮಾಡಿದ್ರು ರಿಕವರ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತ ಎಲ್ಲಿದೆ? ಜಸ್ಟಿಸ್ ಸೂರಜ್ ಗೋವಿಂದರಾಜ್ ಅವರು.
ಅಂದ್ರೆ last minute, kindly see the question raised was at para 9. Whether proceeding under section 46A for recovery of stamp duty, whether that is determined, not levied or short levied, could be initiated after 5 years. This is a suo motu case.
ಇನಿಶಿಯೇಟ್ ಮಾಡಿಲ್ವಲ್ಲ?
Suo motu case. This is a case. This is 46A. This is ours is a 45A. where the
Suo motu
document-
proceedings.
ಹೌದು. So 46 is suo motu.
ಸುಮೋಟೋ ಸ್ಟಾಪ್ ಇಟ್.
ಅಲ್ಲ 45A. ನಮ್ದು
ಅದಕ್ಕೆ ಸುಮೋಟೋ ಸ್ಟಾಪ್ ಮಾಡಿದ್ದೀರಾ?
My learned friend, what
That
seems,
is
this judgment is
determination.
46A ನಲ್ಲಿ. ಹೌದು, not this.
ಸ್ಟಾಂಪ್ ಹಾಕಿ ಕೊಡಿ.
45A, ours is a reference from the sub-registrar. But his document was presented in terms of a decree.
ನೋ ಪ್ರಾಬ್ಲಮ್ ಸರ್.
Yes, madam.
ಈಗ ನೀವು ಯು ಕಾಂಟ್ ಎಸ್ಕೇಪ್ ಪೇಮೆಂಟ್. ಇವತ್ತಿನ ಗೈಡ್ ಲೈನ್ ಮೇಲೆ ಹಾಕಿರೋದು ಅವತ್ತಿಂದ ಹಾಕಿದ್ದಾರೆ.
ಅವತ್ತಿಂದ guideline ಹಾಕಿ.
ಫಾರ್ ಇಂಟ್ರೆಸ್ಟ್ ಏನು ಹಾಕಿದಾರಲ್ಲ ಈಗ
ಇಲ್ಲ, interest ಏನು ಹಾಕಿಲ್ಲ.
ಡಿಲೇಡ್ ಪೇಮೆಂಟ್ಗೆ
ಇಲ್ಲ, direct interest ಹಾಕಿಲ್ಲ.
ಇಂಟ್ರೆಸ್ಟ್ ಹಾಕಿದಾರ?
ಹಾಕಿಲ್ಲ.
5 years ಆದ್ಮೇಲೆ ಬರಲ್ಲ ಅಂತ 46A ಅಲ್ಲ ಅದು. 45 come to 45. 45A.
45A, determination, they will have to recover. If they want to recover, they must go under 46A only.
246?
46A,
46A ಅಲ್ಲಿ.
yes. Para 16 may kindly be seen of the order.
No, come to the statute.
Yes. 46 capital A, this is after amendment in 1918, blood. 46A, recovery of stamp duty not levied or short levied. Where any instrument chargeable with duty has not been duly stamped, the chief controlling revenue authority or any other officer authorized by the state government, hereinafter referred to as the authorized officer, may within 5 years from the date of commencement of the stamp duty, Stamp Amendment Act 1980, or the date on which the duty became payable, whichever is later, serve notice on the person by whom the duty was payable, requiring him to show cause why the proper duty or the amount required to make up the same should not be collected from him. By that time, blood, they will have to determine.
We'll see. No, that not easy as that way.
46A is a suo motu power of the authority.
45A.
45A is the reference. 45.
ಈಗ ಯಾವ್ದ್ರಲ್ಲಿ ಇನಿಶಿಯೇಟ್ ಮಾಡಿದ್ದೀರಾ ಈಗ?
45A.
ಅದನ್ನೇ ನಾನು ಹೇಳ್ತಿರೋದು.
Determination ಮಾಡಿರೋದು ಅದರಲ್ಲಿ. Recovery will have to be made if there is any true. 45A.
The division bench judgments, what is determination, what is recovery? Anyway, list on ನಾಳೆ tomorrow ಆಗಬೇಡ, but Tuesday ಹಾಕಿ ಸಾಯಂಕಾಲ 4 o'clock. We'll look into it and dictate. Yes, Tuesday 4 o'clock. Those two judgments will see whether they are applicable or not. But your officers be aware that exemplary costs will be imposed if I am holding it, that 19 lakhs have to be paid.
I will also.
Yes, definitely. Yes. No, no.
We are also on the other ground, as they saying that the assessment is also not correct.
We may send it back. That's a different thing.
Please.
But for having kept it for this long, yes.
Great.
The petitioner, my lords, writ of mandamus, my lords. Petitioner is the resident of Tubingire village, which is adjacent to National Highway 275, that is Bangalore and
Who appears for the respondent, madam?
My lords, for respondent number 2 and 3.
Aదే, that crack in the house, adena idu?
Howd.
Yes, government.
Yes, sir. So this
Use of
part-
explosives for the purpose of
This
National
is
Highway.
National Highways Authority has to answer.
ಅದು ಯಾರು ಬೇರೆ ಆಗಿದ್ದಾರೆ?
Actually, the only thing is we can assess the damage if all, because they have given a representation to us.
Then assess the damage and place it before the court. Then I will direct the National Highway Authority to do it. The petitioner is before this court seeking a direction for consideration of the representation for payment of damages or compensation for the act of the second respondent National Highway Authority of India in using explosives for the widening of the road, which resulted in a crack of the house of the wall of the petitioner, wall of the house of the petitioner. The state shall conduct an inspection and assess the damage that damage or slash compensation, but I will say it as damage. Assess the damages to be paid to the petitioner by way of a report. The report shall be placed before this court on the next date, placed on say 4th April. Yes.
24.
Date of hearing, there was a direction to deposit up to 1 lakh. Accordingly, I have
Petition can be disposed of. There's another 1,30,000 balance.
ಮಾಡಿದಾರ
1 lakh deposit ಮಾಡಿದ್ದಾರೆ. ಇನ್ನೊಂದು 1 ಲಕ್ಷ ಇದೆ. 1 or 2 months time may be granted.
ಲಕ್ಷ
There are
1,20,000.
there are two.
ಆಯ್ತು. ಈಗ ಎಷ್ಟು 1,20,000 ಬಾಕಿ ಇದೆಯಾ?
ಅಷ್ಟೇ, there was a crop loan ಅಷ್ಟೇ.
ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ಕೊಂಬಿಡಿ ಅಷ್ಟೇ.
ನನಗೆ breathing time
I'll give you time. ಎಲ್ಲಿವರೆಗೆ? 2 months? 3 months?
For the 6 months.
Eh?
If you lost me, there are 2 loans, one crop loan and housing loan.
Maybe. Yes.
One crop loan and housing loan.
Maybe.
Housing loan, there is no due. Crop loan ಅಷ್ಟೇ ಡ್ಯೂ ಇರೋದು. ಇವ್ರು ನನ್ನ ಟ್ಯಾಗ್ ಮಾಡ್ಬಿಟ್ಟು ನಾವು
Crop loan due ಇದೆಯಾ?
ಹೌದು.
The NPA in 2023, he wants to promptly pay.
ಕ್ರಾಪ್ ಲೋನ್ ಆಗಿರೋ
He is a
NPA ಆಗಿರೋದು
victim
crop
defaulter.
loan.
ಆಯ್ತು, ಈಗ will grant some time. Crop loan ಇತ್ತಾನೆ.
1 lakh ಇರೋದು.
You're a farmer.
ಹೌದು ಸರ್. Only one property there.
The petitioner is before this court seeking the following prayer. This court on 18/2/2025 had passed the following order. The learned counsel for the petitioner submits that the interim order has been complied. Counsel for the respondent submits if 1,20,000 is paid in the crop loan, the loan accounts would get regularized. The learned counsel for the petitioner submits he has 2 loans, one crop loan and one housing loan. In the housing loan, there is no due. It is only in the crop loan there was due, and therefore both the accounts are tagged. The therefore seeks reasonable time to get the account regularized. On more 4 ತಿಂಗಳು ಕೊಡೋಣ.
ಅಲ್ಲ 6 months. ಅಲ್ಲ ಅಷ್ಟೊಳಗಡೆ ಕಟ್ಬಿಡ್ತೀನಿ ನಾನು.
He should at least continue the
EMI, housing loan he will pay.
Housing loan, there is no due.
They are not.
And that will continue. You can't, ಅದೇ escape ಆಗದ್ ಬೇಡ.
Can't regularize that until he reports.
Kindly
So
see the
then I have to
statement.
pay. We are
Sir,
in-
Page number
ನಿಮಿಷ.
70.
They are not doing it on their own. RBI circular prakara, if one goes NPA, everything else would get attached to it. So they are doing it. That has become a problem everywhere. Now, you, I'll give you 4 months' time.
ಅಲ್ಲ 6 months. ನಾನು 2 ತಿಂಗಳಿಗೆ ಆದ್ರೆ 2 ತಿಂಗಳಿಗೆ ಕಟ್ಬಿಡ್ತೀನಿ.
He is paying.
4 ತಿಂಗಳು ತಗೊಳ್ಳಿ, ಪರವಾಗಿಲ್ಲ.
Promptly paying. He is not wanting
Yes.
to pay the.
Therefore, the petitioner is granted 4 months' time from today to get the account regularized by paying an amount of rupees 1,25,000. This would not, however, mean that the petitioner will stop paying equal monthly installments in the accounts that are with the bank. Till such time, no precipitative action nor coercive step shall be taken against the property of the petitioner. The aforesaid observation, petition stands disposed.
25.
In this case, the election was held, but there was no quorum, my lord. Your
No,
lordship
that
may
is not
secure
the-
the records and satisfy if there is a quorum.
My
dismiss
lord,
the
this petition was filed only with a thing saying that their apprehension was that the election was not conducted on the previous date of.
Election was not?
Conducted on the previous day when it was notified on a trivial issue. Then now-
Election will not be postponed ಅಂತ ಹೇಳ ಮಾಡಾಯ್ತು.
Not at the election.
Now the
Petition
election
becomes
has been
purchase.
held, but there was no quorum on that day.
That's all right. Separate cause of action. ಇನ್ನೊಂದು ಹಾಕ್ಬಿಡಿ.
But your lordship may look into the records and.
ಅಲ್ಲ, ಇನ್ನೊಂದು petition ಬಂದ್ರೆ ಒಳ್ಳೇದಲ್ಲ.
ಬೇಡ ಇದ್ರಲ್ಲೇ amendment
ಮಾಡಿ.
My lord, this was specific.
Tomorrow.
Petition, my lord.
I'm told the application is ready.
My lord,
But
this
your
is
lordship may
only to
secure
Sir,
the records and.
Prayer ಅಷ್ಟೇನೆ ಇದೆ.
conduct-
Yes.
Prayer ಅಷ್ಟೇ ಇದೆ. With
Even-
this prayer, I can't go any further. Prayer is the respondent authorities should conduct the election. Election should not be postponed. It is not postponed.
Conducted, election is conducted.
Now.
How it is conducted is a separate cause of action.
Total members are 11.
ಅಲ್ಲ ಈ
Five are-
prayer ಹೋಯ್ತು. ಇನ್ನೊಂದು petition I'll give you liberty. The petitioner is before this court seeking the following prayer. Heard the learned senior counsel V. Lakshmi Narayan appearing for the petitioner. This court, on the submission of the learned senior counsel, had passed the following order. The learned AGA had undertaken that the elections will not be postponed. The prayer also was that the election should not be postponed. The learned AGA now submits that the election has been held. The learned senior counsel submits it as the election has been held contrary to
But
law,
no quorum.
with no quorum. If that be so, it is a separate cause of action, reserving liberty to the petitioner to knock at the doors of the appropriate forum. On the said cause of action, the petition stands disposed. Officer. Lakshmikant.
Yes, sir. I'm appearing for respondent.
ಗೇಮ್ ಆಡ್ತಾ ಇದ್ದೀರಾ?
Hey, ಇಲ್ಲ sir, I was waiting for my number to be called.
ಮತ್ತೆ ಬೈಕ್ ಸೌಂಡ್ ಬರ್ತಾ ಇದೆ?
Yeah, sorry, your lordship, I am alone in the office.
All right.
More matters. Which matters still number 1?
ಬೆಸ್ಕಾಂ
Anand Veeran our.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಮೂವ್ ಮಾಡಿದ್ದೀರಾ?
Pending matters. It is first, fresh
Sir,
matter,
counsel is here.
first time it has come.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ ಅವ್ರಿಗೆ?
I inform my lords, and even the copies are also been furnished.
ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ?
Served my lords. Now, the petitioner obtained the.
ಏನ್ ಎಲೆಕ್ಟ್ರಿಸಿಟಿನ?
Please.
Cut ಮಾಡಿದಾರಾ?
Also, cut ಮಾಡಿದ್ದಾರೆ. ಒಂದು ವಾರ ಆಗಿದೆ almost.
ಯಾಕೆ?
My lords, it's only for a letter issued by the BBMP officials.
BBMP ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
Challenge ಮಾಡಿದ್ದೀವಿ ಸ್ವಾಮಿ.
ಅಪೀಲ್ ಮೆಮೊರಾಂಡಮ್ ಎಲ್ಲಿದೆ?
Appeal memorandum is at page number, my lords.
ಸ್ಟೇ ಇದೆಯಾ?
Status quo has been ordered, my lords.
ಎಸ್ ದೇವರಾಜ್, ನೀವು ಅಪೀಲ್ ಮುಗಿಯೋವರೆಗೂ ಸುಮ್ಮನೆ ಇರಕ್ಕೇನು?
ಗೊತ್ತಿರಲ್ಲ. BBMP issued a letter intimating to disconnected.
The petitioner is before this court calling in question a notice dated 4/1/2025. The notice is issued, ಯಾರಿಗೆ BBMP issue ಮಾಡಿರೋದು ಇವರ?
BBMP has issued an annexure.
The notice is issued by the first respondent, the second respondent, assistant executive engineer of the BBMP. Correct?
Please.
ಇಲ್ಲ notice issue ಮಾಡಿರೋದು ಯಾರು?
6/12.
Fourth respondent, sorry. Fourth respondent, the assistant executive engineer of BESCOM. The assistant executive engineer of BESCOM issues a notice on the communication of the second respondent, the AEE of the BBMP. The result is disconnection of the electricity connection. The communication from the officer of the BBMP to the respondent BESCOM is to cut the electricity on the score that the building is in violation of the building norms. The petitioners have produced documents to demonstrate that against the order of the BBMP, they have preferred an appeal before the Chief Commissioner, and the Chief Commissioner has granted an interim order of status quo. In the meantime, the electricity is disconnected to the place of the petitioner, which has resulted in grave jeopardy to the petitioner as he is said to be living in darkness. Therefore, henceforth, the BBMP shall wait for the appeal period, whether against the orders passed by them to be appealed before the Chief Commissioner, and then communicate to the BESCOM for disconnection of electricity, as this has not only generated huge litigation, but results in those persons living in the houses to live in darkness, while the action of the BBMP stays stayed before the Chief Commissioner. The order shall be circulated to the Commissioner BBMP by the registry. Yes. Interim order. There shall be an interim order as prayed for. ನೋಡೋಣ, ನಾಳೆ ಬೆಳಗ್ಗೆ ಕೊಡ್ತೀನಿ. Yes. Next.
I'm for the, but I'm running a resort in Tirthalli.
Resort in Tirthalli, na?
Yes, my lord.
Ah.
There is a due of EMI due of 80 lakhs.
80 lakhs.
Yes, my lord.
ಯಾಕೆ ರೆಸಾರ್ಟ್ ಜನ ಬರ್ತಾ ಇಲ್ವಾ?
They were constructing a flyover in front of the resort. There was some issues. my lord.
ಏನ್ ಪೊಸಿಷನ್ ನೋಟಿಸಾ?
Possession ತಗೊಂಡಿದ್ದಾರೆ, symbolic possession.
ಹಾ.
No
ಎಷ್ಟ್
auction.
ಎಷ್ಟು ಕಟ್ತೀರಾ? ಎಷ್ಟು ಡ್ಯೂ ಇದೆ ಈಗ?
80 lakhs due ಇದೆ towards EMI.
ಹ್ಮ್.
20% in 4 weeks I'll pay.
20% ಅಂದ್ರೆ 16 ಲಕ್ಷ.
Yes.
20 lakhs, 10 lakhs, 10 lakhs, 4 weeks, 4 weeks. The aforesaid, it is made clear that ಅದೆಲ್ಲ ಕಂಡೀಷನ್ ಆದ್ಮೇಲೆ one more ಹಾಕಿ ಇನ್ಮೇಲೆ. It is made clear that this order would not mean that the borrowers stop paying the EMI to the bank. Future EMIs shall continue to be paid, failing which the interim order now granted would get automatically vacated.
Much.
Yes. Handle.
Tomorrow there is a,
ಏನಿದೆ ನಾಳೆ?
they may issue this one, my lord, auction notice.
They may issue, don't, yes.
Much.
We'll get it tomorrow. Next.
3, PA Karun bhai.
ಎಷ್ಟಿದೆ?
4.3 crores.
4.3 crores ಜಾಸ್ತಿ ಆಯ್ತು. ಯಾವತ್ತಿದೆ ಸೇಲ ಏನಿದೆ?
Tomorrow is the auction, man.
Let the auction go on. They will not issue the sale certificate. How much you'll pay?
25% within 6 weeks.
Heard the Learned Council's rules. What is called in question is the auction of the subject property slated to be held tomorrow. The amount in due according to the petitioner, amount in due according to the documents is 4.3 crores. Yes, madam, 4.3 crores.
Yes, my lord, but here it states second respondent has issued notice calling upon the petitioner to pay 5 crores 17 lakhs within 60 days time.
Anyway, 4.3 crores or 5.7 crores as the case would be. The sale that is slated to be held shall continue. But however, the certificate of sale shall not be issued in favor of the auction purchaser, subject to the condition that the petitioner would deposit 25% of the amount in the next 6 weeks. List the matter on 17th April.
Great.
Yes. Next.
4, Kiran SF.
Bring for petitioner, my lord. Petitioner has applied for parole, my lord.
Parole. ಅದು ಯಾರು ಸತ್ತೋಗಿದ್ದಾರೆ?
Yes, my lord. His father-
90 days ಅಂತ ಕೇಳಿದ್ದಾರೆ ಜನರಲ್ he has not averred anything about the death, but generally what happens is
ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಆಮೇಲೆ ಬರೋದು. ಡೆತ್ ಯಾರ್ದು ಹೇಳಿದ್ದೀರಾ?
His father, my lord.
ಎಲ್ಲಿ
Yesterday-
ಹೇಳಿದ್ದೀರಾ?
No, my lord. On the grounds we have applied for, his mother is not feeling well. She is suffering from cancer, my lord. Unfortunately, yesterday, my lord, 3:30 PM.
Your lordship, what happens is if anyone dies in the family, immediately if they give a requisition, we would inquire and take them. But idralli
You forget about the death.
ಆಯ್ತು,
We
ಆಯ್ತು.
will, on the mother's cancer, will grant parole. ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ?
Since 2017, my lord.
ಎಷ್ಟನೇ
She-
ಅಲ್ಲ, 3
ಎಷ್ಟನೇ
years.
parole?
3 years, first parole.
First time.
3 years, 2 months, my lord.
ಅದು ಪೋಕ್ಸೋ ಕೇಸಲ್ಲಿ ಇದಾಗಿ
ಪೋಕ್ಸೋನ?
Section 6 of Poxo,
Section
my lord.
6.
And
And his
363.
appeal is pending. In view of his, in view of the appeal being pending.
Will
they
grant him
take-
15 days
ಆಯ್ತು,
parole.
ಆಯ್ತು.
Yes.
My lord, general-
Subject, ನಿಮ್ conduct ನೋಡಿ extension. Yes. 370 section POCSO.
Yes.
The petitioner is before this, who is the petitioner?
Petitioner,
Convict.
Convict.
Suraj.
The petitioner convict is before this court seeking his release on grant of parole. The petitioner gets embroiled in a crime which is tried in crime number 382 of 2021 for offenses punishable under so and so. Illi para 1 alli the brief facts alli. The concerned court of session convicts the petitioner in terms of the order dated 29/2/2024, sentencing him to life imprisonment,
20 years, my lord.
20 years and imprisonment for life, or life antide ಮತ್ತೆ ಇಲ್ಲಿ
In custody,
20 years imprisonment. Yes. The petitioner is appended a prison certificate which does not indicate any adverse entry against the petitioner. The petitioner is now completed 3 years and 2 months in prison. The reason for seeking parole is the mother of the petitioner suffering from cancer and wanting the son to be with her. The Learned Council would further submit that the father has expired yesterday. No document is produced to that effect, nor any pleading, be that as it may. In the light of the mother suffering, I deem it appropriate to grant the petitioner parole for a period of 15 days initially, subject to extension owing to the conduct of the petitioner to become operational from tomorrow morning. ನಾಳೆ ಬೆಳಗ್ಗೆ ಸಿಗಿ.
1 month, kindly 1 month.
ನಾಳೆ file extension. Because it's POCSO and rape. Yes. Next.
Yes, I appeal for the petitioner comes.
Sharp watch investigation.
Yes. In fact, I called in question the tender condition, my lord. May I request, my lord?
Tender condition.
Yes. Page 24 may be kindly be seen. Your lordship, covered by your lordship's order also. That is in there. In fact, the clause, my lord, I served the copy on the other side. Your lordship kindly appreciate tender condition as such.
ಈ 230 ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ದು?
The reason is today is the fine.
ಏನು today?
Last date for submitting the bid.
Last date.
For submission of the bid. Now, your lordship kindly appreciate the tender.
Wait, what were you doing all these days?
No, in fact, my lord,
when was the tender notified?
Tender was notified on, your lordship kindly on 4/3 on 2025, my lord.
Then what were you doing till now?
In fact, that is the 20th is the last date.
ಆಯ್ತು, ಇಲ್ಲಿವರೆಗೆ ಏನ್
And I
ಮಾಡ್ತಾ
do,
ಇದ್ದೀರಿ
in fact, I can understand. Now, in fact, what I try to pursue, my lord, is here, my lord, if your lordship, mean it, if your lordship kindly appreciate the tender condition.
Sir, conditions cannot suit your desires.
Idil tav nodಬಹುದು. Tenderer should have obtained a class 1 electrical from chief electrical inspectorate and class 1 KPW contractor license. The nature of your lordship kindly appreciate the nature, assuming for a moment your lordship, if I do agree, only it is a manpower agency, your lordship kindly, page 32 may be kindly be seen. Proposed manpower, your lordship, diploma engineer and data entry operator, electrical wireman, telephone operator, driver. For the nature of work, it does not. In fact, I do agree if the electrical installation is concerned, or a line of electrician, or nature of work is such that I do agree. The condition is that. But here, my lord, the possessing I mean, in fact, is a company, it is a partnership for a tenderer. It is what is the criteria is really. It is a uncalled for in such a for a manpower agency, for a driver, cook and security guard and attender, and particularly wallman and sanitary helper. What is the condition? Whether such a condition is required or not. So that's why kindly tenderer should have obtained a class 1 electrical from chief electrical inspectorate and class 1 KPW contractor license. Such a condition is uncalled for. And also there is a group insurance, that is another condition, that is so far that has been. In fact, I filed an objection. Well, that's why kindly, even I submitted the objection I brought to the notice on 14/3/2025. Well, that's why page 175, my lord. I brought to the notice, this condition is to be deleted or to be modified, and corrigendum has been issued and prevailing the condition. That's why I am before this court. And you are subjected to the order of this honorable court. Your lordship may kindly, whatever the bid, subject I may be permitted with your lordship's order.
ಬಿಟ್ಬಿಡಿ sir. ಎಲೆಕ್ಟ್ರಿಷಿಯನ್ಗೆ ಎಲೆಕ್ಟ್ರಿಕಲ್ ಇನ್ಸ್ಪೆಕ್ಟರೇಟ್ ಇಂದ ಲೈಸೆನ್ಸ್ ಇರೋದು ಇಲ್ಲದೆ ಇನ್ನೇನ್ ಮತ್ತೆ ಯಾರು
So far the installation of electrical line is concerned, I do agree. Mary, that's why I brought.
Then for what you don't agree?
Your lordship's judgment, your lordship has.
What you don't agree ಹೇಳಿ.
The question is here, my lord, the nature of work, helper ಗೆ, driver ಗೆ,
ಹೆಲ್ಪರ್ ಡ್ರೈವರ್ ಅಲ್ಲ ಇರೋದು ಎಲೆಕ್ಟ್ರಿಷಿಯನ್.
ಡಾಟಾ ಆಪರೇಟರ್ ಇದ್ದಾರೆ. ತಾವು ಇವಾಗ ಲಕ್ಷ್ಮಿ ಕೈಲಿ ಸೆಕ್ಯೂರಿಟಿ
ಹೆಲ್ಪರ್ ಡ್ರೈವರ್ಗೂ ಕುಕ್ ಎಲ್ಲ ನಿಮ್ಗೆ ಎಲೆಕ್ಟ್ರಿಕಲ್ ಇನ್ಸ್ಪೆಕ್ಟರೇಟ್ ಇಂದ ಯಾಕೆ ಬೇಕು?
ತಮ್ಮ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ರೆಫರಿಂಗ್ ಎ ಜಡ್ಜ್ಮೆಂಟ್ ಆಫ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ page 221. The aforesaid provision only deals with the electrical installation work only by the electrical contractors who have a license. The work of electrical installation is not assigned to the manpower agency, but it will be assigned only to the contractor. Under the regulations, the corporation has nominated.
ಈಗ ಇವರು ಬಿಡ್ ಅನ್ನು ತಗೊಂಡ್ಬಿಡಿ.
Yes. Let them consider.
ಅಲ್ಲ ಡ್ರೈವರ್ ಕ್ಲೀನರ್ ಇವ್ರಿಗೆ ಕುಕ್ ಇದಾರ?
ಹೌದು ಕುಕ್ಸ್ ಇದ್ದಾರೆ.
ಕುಕ್ಸ್ ಇದಾರ?
ಕುಕ್ ಇದೆ. ಡಾಟಾ ಆಪರೇಟರ್ಸ್ ಇದ್ದಾರೆ. Non just tender condition is that the tender should have obtained a class one electrical.
ವರ್ಕೌಟ್ ಇಶ್ಯೂ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ ಮತ್ತೆ ಟೆಂಡರ್ ಅಲ್ಲಿಗೆ ಯಾಕೆ ಹೋಗ್ಬೇಕು? ನೀವು ಎಲ್ಲದಕ್ಕೂ ಅಲ್ಲಿಗೆ ಕಳಿಸ್ಬೇಡಿ. ನೋ 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 ವರ್ಕ್ ಆರ್ಡರ್ 13 ನೀವೇನಾರು ಆಕ್ಷನ್ ಮಾಡಿದ್ರೆ ತಗೊಂಡಿದ್ರೆ ಮಾತ್ರ 16, ಎಲ್ಲದಕ್ಕೂ 16 ಕಳಿಸಲ್ಲ. ಹಿಂಗೆ ನೀವೆಲ್ಲ ಬರ್ಸ್ಬಿಡ್ತೀರಾ. ಯಾಕೆ ಸರ್ ಆಗೋಯ್ತಾ? ಇವರಿಗೆಲ್ಲ ಸೇಮ್ ಕ್ವಾಲಿಫಿಕೇಶನ್, ಸೇಮ್ ಲೈಸೆನ್ಸಾ? ಎಲ್ಲಿ ಓದಿರಿ ಜಗದೀಶ್ ಸರ್? ಆಯ್ತು. ವಿಚ್ ಕ್ಲಾಸ್ ಸರ್? 3.2. 3.2. ಅದು ಎಲೆಕ್ಟ್ರಿಷಿಯನ್ಸ್ ಬೇಕೇ ಬೇಕದು. ಬೇರೆ ಯಾರ್ದು ಎಲ್ಲಿದೆ? ಈಗ ಪ್ರಪೋಸ್ ಮ್ಯಾನ್ ಪವರ್ ಎಲ್ಲ ಇಲ್ಲಿದೆ. ಗ್ರಾಜುಯೇಟ್ ಇಂಜಿನಿಯರ್ ಕರೆಕ್ಟ್ ಆಗಿದೆಯಾ? ಇದ್ರಲ್ಲಿ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ನಿಮ್ಗೆ? ಈಗ ಏನಕ್ಕೆ ಟೆಂಡರ್ ಕರ್ದಿರೋದು ಈಗ? ಫಾರ್ ವಾಟ್ ಸರ್? ವೇಟ್ ಸರ್ ಒಂದು ನಿಮಿಷ. ಹ್ಮ್ 19. All right. Why do you need the license from electrical inspectorate for few of them? ಈಗ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ಗೆ ಅವರಿಂದ ಯಾಕೆ ಬೇಕು? No, that is the qualification. Here you are asking some certificate. No, ಹಂಗಂತ ಕುಕ್ಗೆ ನೀವು ಎಲೆಕ್ಟ್ರಿಷಿಯನ್ ಹತ್ರ ತಗೊಂಬನ್ನಿ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಅಲ್ಲ ಮತ್ತೆ that tenderer should have, manpower agency should have from the electrical inspectorate. ನಿಮ್ಮ ಹತ್ರ ಇದೆ ಅಲ್ವಾ? ಶಾರ್ಪ್ ವಾಚ್ ಅವ್ರು ಪ್ರತಿ ವರ್ಷ ಹಾಕ್ತಾರೆ, ಇದೆ ಅವ್ರಿಗೆ. Not these. See, for a cook, then for helper, for attender, ಇವ್ರಿಗೆ electrical inspectorate ಇಂದ ಏನಕ್ಕೆ ಬೇಕು? So you should at least qualify when you are calling ಇವ್ರಿಗೆ ಇದು ಅಂತ. ನಿಮಗಿದೆಯಾ ಲೈಸೆನ್ಸ್? ನಿಮಗ್ ಲೈಸೆನ್ಸ್ ಮ್ಯಾನ್ ಪವರ್ ಏಜೆನ್ಸಿ you take his tender, we'll see. Yes. Cook. That qualification is fine. Are you holding that he should have license for all this? We heard the learned senior counsel, D.L. Jagdish, appearing for the petitioner. The learned senior counsel takes this court through the tender document to demonstrate that even for cook, operator, security guard, telephone operator, the license is sought to be secured from the hands of the inspector, electrical inspectorate. The learned counsel for the respondent clarifies that what is sought is the license of the manpower agency and not individual. The matter may require consideration. The bid of the petitioner shall be accepted by the respondent, subject to the result of the petition. You should have clarity in what you say. Naale last day, one nimsha, naale last day anತಾರೆ. I'll take it tomorrow, no problem. But secure instructions and come, he will. Tomorrow is last day na ಏನು? Then list it ನಾಳೆ 2:30 ಹಾಕಿ. ಇಲ್ಲ ನಾಳೆ 2:30 ಹಾಕಿ. ಇವತ್ತು ಆಗೋಗಿದೆ. ಅದೇ by judicial order I can do it. Next. Yes. Loan borrower, ಎಷ್ಟು borrow ಮಾಡಿರಿ? ಎಷ್ಟು borrow ಮಾಡಿರಿ? You who is the victim? Borrower a victim. You are the president of the bank. One minute, sir. One moment. Sir. Either Vishwakarma Sahakara Bank, KV location. Learned Counsel KV location is directed to accept notice for the respondent. List the matter next Thursday in the fresh matter. There shall be an interim order of stay as spread for. Yes, next. ಎಷ್ಟಿದೆ? When is the sale, sir? Tomorrow sale ಮೆತ್ತಿಗೆ last moment ಅಲ್ಲಿ move ಮಾಡಿ ಎಲ್ಲ ಆರ್ಡರ್ಗಳು ತಗೊಂಡ್ಬಿಡ್ತೀರಾ.
Your Lordships, I appear on behalf of the KVT Bank, my lords. This is Sridhar Babu versus Canara Bank, if I'm not wrong.
ಯಾವುದು? ಬೆಳಿಗ್ಗೆ ಏನಾಗಿದೆ?
Your Lordships, the sale is tomorrow. I'll just take my lords to page number 25. The sale notice, the outstanding is 206 crores.
ಎಷ್ಟು?
206 crores. This is not the first petition, my lords. They don't comply with any of the orders. Now they say that the third party who submitted some amount, that writ petition is pending, therefore this has to be stayed.
You want refund or you want? Oh, seriously, yes, nothing. When is the sale?
Tomorrow.
List the matter next Friday. No, sir. I am not going to stay. That is a separate cause of action that we will see. Yes.
Obliged.
Next week. Yes. What directions? That is, I'm hearing that matter will direct all that to be done. Sir, you are asking return of the money, so you don't want the property. Now you are wanting the sale. Yes, sir. No problem. Yes. List next Friday. Next, yes.
Like
With Saturday, hakidiva.
the other matter is on the 22nd, my lords. The third.
Tag the petition along with sounds. Yes.
Obliged.
All right. Next.
Order seal number 8, Ramdish.
You are withdrawing? Francis, ನಿಮ್ದಲ್ಲ. ಇದು ಸ್ಟೇಟ್ ಆಫ್ ಜಾರ್ಖಂಡ್. Yesterday's matter. Yesterday state of Gujarat. ಈಗ ಏನ್ ಬೇಕು ಹೇಳಿ ಸರ್? What do you want now? Thank you. ಕೊಡಿ. Yes. 1 week. All right. Yes. Today you have time, is it? All right. Yesterday you were not having time. All right. No problem. Oh, 190?
197 annexure E2. This is the main base petition. This is contains 16 WPs are filed before Honorable Kerala High Court. This is the main petition where I gave before.
Yesterday you told me this, sir. Ilva? I have. All right. All right.
Based on this 60 WP, I filed page number 244. 244 annexure F1. This is the base of the going to be
Going to be admitted. Ayo, don't worry about this. This court Sako. You don't go on reading all the judges' names now. Yes. What do you want to tell? The state of Karnataka. Now you don't want state of Karnataka. Then we will issue. 1 minute. State of Jharkhand you serve, sir.
I made a party bank plus state of Gujarat. Straight away we have taken interim order. Convincing the 16 WPs before pending with the Honorable High Court of Kerala. And then before this Honorable Court, convincing these 2 WPs have taken.
Now what? Simple. You don't want state of Karnataka to be a party. Defreeze, I will not direct state of Gujarat or state of Jharkhand to defreeze anything. No, sir. No, sir. See, yesterday I told you, serving state of Gujarat or state of Jharkhand will take a long time. You make state of Karnataka a party, they will get to know what is the amount. That I will mark clean and allow all accounts to be defrozen. Already, not interim order, I will pass final order. Oh, thank you, sir.
Has been allowed the WP, but still bank is not given a remedy. Our lordship order is allowed. If I go and my remedy is not fulfilled. For that, I'm giving one example. I want to go to again for the contempt. For contempt, I have to make. That's the reason, my lord. My two concern is interim order.
Contempt against whom? Okay.
Then again, so many complications.
Oh.
Interim order and then bank is not going to give. It's only two concerns. I'm having the example petitions where they are
Example petition. Hey, Beda, what do you want to tell me, sir? Thank you, sir. Law, interim order ಬೇಕಾಗಿದ್ರೆ ಇನ್ನು ಎಷ್ಟು ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದೀರಿ ವಿಡ್ರಾಯಲ್ಗೆ ಇಷ್ಟೊಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಸರ್ಕಮ್ಸ್ಟಾನ್ಸಸ್ ಮ್ಯಾಟರ್ಸ್ ವಿಡ್ರಾಯಲ್ ಪಿಟಿಷನ್ಗೆ ಯಾಕೆ ಹೋಮ್ವರ್ಕ್ ಮಾಡ್ಕೊಂಬಂದ್ರೆ also should be withdrawn. Oh, it will. Why not came? Yes. Yes. Ashte alva. I'll make it simple, don't worry. Don't complicate it so much. You want the relief, you will get it. Contempt ಹಾಕ್ಬೇಕಾಗಿಲ್ಲ. Get the bank. ನಾಳೆ ಯಾವ್ಯಾವ ಕೇಸಲ್ಲಿ ಬ್ಯಾಂಕ್ ಇದ್ದಾರೆ ಕರ್ಕೊಂಡು ಎಲ್ಲ HDFC ನಾ? ಪೇರೆಂಟ್ ಬ್ಯಾಂಕ್. ವಿಚ್ ಬ್ಯಾಂಕ್ ಸರ್? ಪೇರೆಂಟ್ ಬ್ಯಾಂಕ್ ಅಂತ ಅದನ್ನೇ ಕೇಳ್ತಾ ಇರೋದು. ಮೈ ಪೇರೆಂಟ್ ಬ್ಯಾಂಕ್ ಅಂದ್ರೆ ಎಸ್ ಸರ್. ಆಲ್ ರೈಟ್. ಯು ಫ್ರಾನ್ಸಿಸ್ ಝೇವಿಯರ್ HDFC Bank Banili. He is the counsel who appears for HDFC Bank. You give a copy to him in all those cases. See, I will mark a lien on whatever the disputed amount is and permit defreezing immediately. If the bank is there, he will convey it. Adike, let the counsel be there. ಅವ್ರದ್ದು ಯಾವ್ಯಾವ ಕೇಸಲ್ಲಿದೆ HDFC ಅವ್ರಿಗೆ ಕೊಡಿ, ಅವ್ರು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಂಬಿಟ್ಟು ಮಾಡ್ತಾರೆ. ಎಸ್, ನಿಮ್ಮ ಮತ್ಲಬ್ ಎಲ್ಲ ಸರಿ ಹೋಗುತ್ತೆ ಅವಾಗ. Yes. Where do you practice? Inside the hand summons. ತುಂಬಾ ಮತ್ಲಬ್ ಆಗೋಯ್ತು ಬೇಡ. Yes. Tomorrow we'll do it. Yes, next. Next. ಇಷ್ಟೊತ್ತು ಅರ್ಗೆ ಮಾಡಿದ್ಮೇಲೆ ಮತ್ತೆ withdrawn. Yes.
Number 9.
ನೀವ್ಯಾಕೆ ಮತ್ತೆ ಬಂದ್ರೆ? ಸೇಮ್ ಮ್ಯಾಟ್ರ್ ಮೇಡಮ್. ಯಾವ್ದು ಸೀಲ್ ನಂಬರ್? ಮುಂಚಿನ ಮ್ಯಾಟ್ರ್ ಯಾವ್ದು ಸರ್? 6 and 9 ಸೇಮ್ ಆರ್ಡರ್. Yes, next.
10. Real Chandrasekhar.
Yes, Francis. ನೀವು SBIಗೂ ಇದ್ದೀರಾ? All right. ಎಷ್ಟಿದೆ? ಈಗೇನ್ ಸೇಲಾ? ಮೆಷಿನರಿ ಅವ್ರದಾ? ಹೈಪೋಥಿಕೇಶನ್ ಇದೆಯಾ? DRTಗೆ ಹೋಗ್ಬಿಡಿ ಸರ್. ಬೆಟರ್. ಕ್ವಶನ್ ದಿ ಸೇಲ್ ನೋಟಿಸ್ ಬಿಫೋರ್ ದ DRT. ಎಲ್ಲ ಏನೋ ಸ್ಮಾಲ್ ಮನೆ ಇರೋರಿಗೆ 10 ಲಕ್ಷ 15 ಲಕ್ಷ ಅಥವಾ 1 ಕೋಟಿವರೆಗೂ ಹೋಗಿ. ಈ 2 ಕೋಟಿ 3 ಕೋಟಿ ಎಲ್ಲ. ಸರಿ, ಒಂದ್ ನಿಮಿಷ ಫ್ರಾನ್ಸಿಸ್. ಪೇಜ್ 50. ಇದು 2022 ಸರ್. That's 2022. You are in 25. Nor you have improved. Go before the DRT. Yes. DRT. Sir, 2022 ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋ ನೋಟಿಸ್ ತೋರಿಸ್ಬಿಟ್ಟು they have given up recovery of movables ಅಂತಿಲ್ಲ. There is a recovery certificate issued also. DRT. I will not interfere in this. Movables 2022 ಅಲ್ಲಿ ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಿದ್ದೀವಿ. There is a decree in their favor. Challenge that, sir. Challenge that. By this method, don't take stay of that. Yes, next. ಏನ್ ಮಾಡ್ತೀರಾ? ಇಲ್ದಾರ ಅಡ್ಜನ್ ಮಾಡ್ತೀರಾ ಅಷ್ಟೇ. No, movables will. Sir, movables recovery certificate is already issued. Don't show a document of 2022. Yes, next. List after 4 weeks.
I will just take instructions, I will sir.
List on Monday in the fresh matters list. No stay, nothing. Yes.
7.
Yes, Sangat.
When I was researching on this matter, I came across
Why did you research?
I came across a certain judgment of your lordships, which began with a very interesting quote. Lord, I have drawn inspiration from that quote. So let me just state what the quote was.
Which judgment is it? Which judgment?
There's a certain judgment that I came across, which began with a very interesting quote. It read, when the state is afraid of its citizens.
Oh, that policeman, 3 crores at
there is liberty.
5 lakhs. Yes.
When the citizens fear the state, there is tyranny. Lord,
Yes.
I've drawn inspiration from that.
Now what has
I've
happened?
drafted my own quote. Of
What
course,
is tyrannical now?
No, of course, my quote would not be as impactful as your lordship's quote.
Yes,
But
yes.
your lordship may permit me to say, to preface my submissions with that quote.
No, what is the problem here?
When persons accused of crime fear the law and the proper enforcement of the law, the victims and citizens would celebrate the
Sir,
rule of law.
Correct. Yes, it is as impactful as my quote. Don't worry. Yes.
When the accused break the law with impunity and the law enforcement agencies
ಈಗ problem ಏನ?
stand by and just watch, then Lord, the
They're
victims
standing
and
by and watching, is it?
will lose faith in the law. I'm one such victim who's losing faith in the
Now
law.
what is the problem?
Yes, my Lord. Now please see.
Hmm.
Lord, 84 days have passed since registration of a crime. There were 4 accused in the crime. 1 was arrested, 2 are absconding, 41A notices were issued. Lord, 84 days now, there is no action taken on that 41A notice, even though there has been complete non-compliance.
Bail is not granted?
Lord, 2 courts between those 84 dates have rejected their anticipatory bail, have specifically observed that custodial interrogation is required. 41A4.
Custodial interrogation is required? Where?
That's the observation, and that's why, my lord, both the anticipatory bail courts have rejected the bail petitions.
Even this court has rejected?
This court also, my lord, just 2 days back has rejected an anticipatory bail application of both the accused. Lord, I'll have to just give your lordship some facts, because only then will your
No, no.
lordship.
Now what is your prayer here?
Lord, I have 3 interim prayers, Lord. My final prayer is for constitution of an SIT.
SIT?
Yes, my lord, high ranking SIT officer. I'll tell your lordships why, but 3 prayers, my lord, which interim prayers, which your lordships will find at page 18.
Copy kotilva?
Lord,
Mirror
35(6),
images of
Lord,
all.
once a 41A notice is issued, immediately he has to come and comply on the terms mentioned in that notice.
No, he has not appeared.
26th is when the notice was issued to accused number 2 and 4, accused number 1 and 4, 3. 31st is when he was required to come. He breaches that notice, does not come. Till today, he has not come. All 3 accused, even those on bail, have not come. No action taken.
No,
Absolutely
those on
nothing.
bail, who is not on bail?
Lord, A1,
A1 is not on bail.
A3, both are absconding. It's a cyber crime of serious magnitude. No action taken. I'll tell your lordships why no action is taken. Lord, please see.
No, let the.
No, I'll seek instructions.
Why you have not arrested them?
No, your lordship, I think they're hold up in some other state.
Some other state?
Of course, not. They're absconding. They're holed up in a different state. They're not Karnataka.
No, I'll find out.
What are the steps taken to bring them?
No, anyway, the
Bring
police
them
have-
to books. What have you taken?
Your lordship.
There is no anticipatory bail granted. There is no regular bail. Arrest agila regular bail bide.
No, I'll
That
find
is
out.
not granted, and the notices issued. Nothing is happening.
Notices have been
Bere
issued.
yaragidre, you would have rushed behind him. What has happened in this?
Notice, you know. I'll seek instructions.
Please see one page, no? Please just go to page 31. On 25th, when the FIR was registered, the investigating officer forms a team of sub-inspectors to go to Delhi and Noida to arrest that team. Just see that, not.
Nothing has happened after that?
Registered for data theft of classified and sensitive nature, you are instructed to secure an arrest. Now that notice, which is issued to the subordinate officials on 25th, suddenly on 26th becomes a 41A notice. Lord, once there is a direction to go and arrest, they go to Delhi, they pick him up. After having picked him up, the general diary entry in the local jurisdictional police say that he has been arrested from his premises. Then suddenly, Lord, on 26/12, which your lordships will find on 30.
After arrest, 35(3) comes?
After arrest, suddenly that order of arrest becomes a 41A notice, requires them to come the very next day. Till today, no one has come. 2 anticipatory bail orders which reject the entire bail petition. It's a cyber crime. Time is of the essence. Karnataka has troubling and alarming statistics when it comes to cybercrime investigations. 18% is the charge sheet filing rate.
I'll seek instructions.
Let's the matter heard the learned counsel Angat Kamath appearing for the petitioner. The petitioner, you are the complainant.
I am the complainant in the crime, but
The
I'm seeking to
petitioner
enforce
is-
a statutory duty
The
on part of the
petitioner
police.
is the complainant. The allegation is that the accused in the crime, who are 4 in number, are roaming free without them being arrested for custodial interrogation, notwithstanding the fact that 2 of the courts, i.e. the concerned court and coordinate bench of this court, both have held that the custodial interrogation of the accused is necessary. He would take this court through a formation of a team on 25/12/2024, directing arrest of the accused. The notice on the next day gets converted to a 35(3) notice with certain conditions. The learned counsel would submit that the accused were in fact arrested at Delhi, but in the light of the notice issued under 35(3), they have not appeared and in fact disappeared today. The learned AGA to secure instructions as to why despite the necessity of custodial interrogation, no steps are taken to take the accused into custody, and also secure instructions as to what has become of the constitution of the committee on 25/12/2024. Place the matter on Tuesday in the fresh matters list.
One small addition. Lord, there is some serious interference from a certain Rajasthan-based IPF officer. Those allegations.
This is what you said while moving the matter in the morning.
Yes, Lord, there is some interference in this. Evidence is being destructed. So kindly, Lord, direct the police to deposit the mirror image of the devices which have been seized, the mirror images that have been there. Let that come before.
Yes,
the
where
court.
are the records of investigation now?
I have to,
No, ಏನು ಗೊತ್ತಿಲ್ಲ ಅವ್ರಿಗೆ. Now you can't, yes, list the matter on Monday in the fresh matters list.
I have it on Tuesday itself.
Monday in the fresh Tuesday in the fresh matters list, the learned counsel for the petitioner submits that the evidence also is being destroyed on certain external influence. The learned AGA to also secure instructions with regard and see to that the mirror images of the phones are kept intact.
Can I request for hand delivery?
Ida.
I'll put away.
No, tomorrow. Yes. And delivery ಎಲ್ಲರೂ ಕೇಳ 5 ಗಂಟೆ ಆಗಿದೆ. Upload will see. Yes.
Yes, grateful.
Your Lordship may have this on Tuesdays.
Tuesday ne fresh matters. Yes. Next.
Hearing on IA, party in person, number 12.
My lords, I'm the petitioner and party in person, your lordship.
Bangalore Golf Club.
Yes, my lord.
ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ?
My lords, after passing of the interim order dated 22/4/24 by this honorable court, by a deftly worded.
30 ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ?
No, ಇಲ್ಲ, my lords, I sought for tomorrow. Your lordship said 2:30. I didn't object.
Interim order ಇದೆಯಲ್ಲ?
Either, my lords, in spite of the interim order, they do not appear before the court, but they pass a resolution and also issue me a notice by which they seek to affect my position in the waiting list, my lords.
Let's see. There is no representation on behalf of the respondent despite service of notice. List the matter on Thursday in the fresh matters list, awaiting the appearance. In the event nobody appears, the court would be constrained to pass orders. Hearing the petitioner in person. Next.
14.
Withdrawal 1, 2.
For the petitioner and.
Both, yes, next.
Adik,
Madam.
Matter sought to be withdrawn, my lord. This was a matter where the impugned, there was
Which
a
one? Serial number?
14, my lord.
Withdrawn, yes, in terms of memo.
They want to simply withdraw, my lord. I have no objection.
Let's,
What are they trying to withdraw? Not simply withdrawal, is
My
it?
lord, there is, if I may just brief your lordship.
there is an
on the factual
order,
background.
if lordships permit, there is a, may I, my lords, I appear for respond number 2. After this writ petition, they approached Honorable Supreme Court and their petition was dismissed before
My
Honorable.
lord, if my lordship has the memo, I have attached a certified copy of the Supreme Court order. All I've said in the memo is what the Supreme Court says, my lord.
Well, what is said in the
A
memo?
portion of the
in the
NCLT
judgment
order
of-
had been impugned, where a quasi-judicial authority had passed observation on possession and title over the petitioner's lands, my lord. Thereafter, the entire order was impugned in the Encroachment, which came
So
to be
this is your
dismissed.
withdrawal affidavit, is it?
No, my lord, it's a memo. I've just attached the Supreme Court order.
In
No, the
reply.
contents.
This was the affidavit filed by the resolution professional, where he states that these assets do not belong to them, and further, whatever rights he had at the time of taking
In
over.
terms of the order of the apex
Please,
court, what is
please,
the problem?
That's
Yes,
all we
my
want.
lord, there is no problem, but the contents of his memo is the
No,
issue.
that's all right. The petitioner is
Lordships
before
may
this
record
court. One
that
minute.
in view of
My lord,
the
if your
order
lordship
of
just sees the
Supreme
prayer
Court,
in
he
the
wants
memo.
to
One
withdraw.
minute, sir. The petitioner is before this court, the petitioner files a memo seeking to withdraw the petition. Paragraph 1 to 4 of the memo are narration as to what has happened in the case at hand. What is germane is only the last paragraph. It reads as follows. The petitioner seeks to withdraw the petition withdraw the petition in terms of the order passed by the apex court on 16/1/2025. Therefore, the petition is withdrawn only in terms of is dismissed as disposed as withdrawn only in terms of the order passed by the apex court on 16/1/2025 and nothing else.
Great.
Lords, can I only request one thing to lordships? Because he has interpreted the order of Supreme Court in paragraph 4. Because according to us, it's
I
not.
have told in terms of 16/1/25, nothing else. What else you want?
Because they will try to say again that lordships have given recognition to what they've said in paragraph 4. And
Sir, I have no. I own paragraph 4 ನೋಡಿದ್ದೀರಾ? ಅದು in terms of memo ಅಂತ ಇದೆಯಾ ಅದರಲ್ಲಿ ಕೊಡಿ.
Please.
Because it's
Para 4, my lord, if I may read it. The Honorable Supreme Court of India, on hearing the matter, dismissed the appeals by recording the statements made by the respondent number 2 herein, while its reply affidavit dated 6/6/2024, filed in IA number so-and-so, before the Honorable NCLT, and came to the finding that the cooperator has the right
No,
to
I'm
review.
not on that. It is humbly pleased to take this memo on record and dismiss the
That's all, ma'am.
petition withdrawn in terms of the order of the apex. That's all, yes.
I am not ignorant.
Please.
ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ಬೇಕು. Yes.
Obliged.
Yes, 14 and 15 both.
My lord, no, 15 is a different matter, my lord.
No.
15 is also for withdrawal.
Please, my lord.
Ah.
15 is,
1 and 2.
my lord, the respondent is Reserve Bank of India. They filed a memo stating that the complaint that I had preferred before the ombudsman will be reconsidered by them.
That is the reason for withdrawal?
Please, my
Have you quote-
timeline may be fixed.
Have you said that in the memo?
My lord, the memo has been filed by them. I
You
have not-
ಹಾಕಿರೋದು. Where is it? Where is the memo?
My lord,
The
it was filed on
respondent has filed a memo.
on 22nd of January.
Memo. The memo reads as follows. The respondent is seeking permission in the hands of this court to grant permission to reconsider the complaint against the petitioner. In the light of the said memo, I deem it appropriate to,
Not by the petitioner, apologies to interrupt.
by the respondents.
By the petitioner. I preferred a complaint to the Reserve Bank of India.
Reconsider the complaint preferred by the petitioner.
Please,
So and so. In the light of the memo so filed by the respondent wherein they have sought to reconsider the complaint of the complainant, the petitioner, I deem it appropriate to dispose the petition with a direction to the respondent bank ಇದು?
Reserve Bank of India.
Reserve Bank of India to dispose the complaint of the petitioner on its reconsideration. 4 weeks? R2 na?
The Reserve Bank of India, my lord.
Ombudsman of the Reserve Bank of India ಅಂತ ಮಾಡಿ ಕಾವ್ಯ. Not the Reserve Bank. Ombudsman of the Reserve Bank of India to dispose the complaint within 4 weeks from the date of receipt of the copy of this order.
Grateful.
Yes, next. With the aforesaid observation, petition stands disposed. ಎಷ್ಟಿದೆ? Sale did not take place. ಅದಕ್ಕೆ ಇವರು ಬಂದೇ ಇಲ್ಲ. The counsel for the petitioner, respondent submits that the sale has not taken place. In that light, the date of the sale has spent itself or the date of auction has spent itself, reserving liberty to the petitioner to approach the court, approach the appropriate fora in the event the sale would again take place. The petition stands disposed. Yes, next. ಯಾರು? ಲೋಕೇಶ್, ವಿಘ್ನೇಶ್ ಎಲ್ಲಿದ್ದಾರೆ?
ಸರ್ವ್ ಮಾಡಿಲ್ಲ.
ಮಾಡಿ.
ನಾಳೆ.
ನಾಳೆ ಆಗಲ್ಲ ಮೇಡಮ್, 5 ಗಂಟೆಲಿ ನಾಳೆ ಆಗಲ್ಲ. ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ, ಸರ್ವ್ ಮಾಡಿ ಇವತ್ತು, ನಾಳೆ ಬೆಳಗ್ಗೆ 10:30 ಮೂವ್ ಮಾಡಿ.
Please.
ಎಸ್, ನೆಕ್ಸ್ಟ್. ಅದು ಪಾರ್ಟೆಡ್ ತಗೊಂಬಿಡಿ. ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್ ಯಾವುದೋ ಇದೆಯಲ್ಲ, ಆಯ್ತಾ? Others need not wait. ನಿಮ್ದು ಎಷ್ಟನೇ?
Disposed of.
Which one?
Review matter.
ಯಾವ್ದು ಡಿಸ್ಪೋಸಲ್ ಆಗಲ್ಲ. ಏನಾಗ್ಬೇಕು ಹೇಳಿ? ರಿವ್ಯೂ ಇದೆಯಾ ಇವತ್ತು?
Review.
ಪ್ರಸನ್ನ ಕುಮಾರ್ ಎಲ್ಲಿದೆ?
Informed him in the morning also, Lordship.
Rahul, he was here. Rahul Reddy was here. Rahul, where is Prasanna Kumar?
He's traveling to Gulbarga, my lords.
Now, these review petitions of Tahir on jurisdictional issue, I will recall my order and post it before the division bench.
May I say, my senior wanted to make some submissions in this. May I request your lordship to have it on?
It was reserved for order. There is no some further submission was required.
Some assistance, brother.
Allah, with regard to this aspect,
Yes.
not on the merit of the matter, only recalling it and posting before the division bench. That's all right. ಅದಕ್ಕಾದ್ರೆ
The Lordship, my learned friend himself has.
ಅಷ್ಟಕ್ಕಾದ್ರೆ ಏನ್ ಮಾಡೋದು? ಕೊಡ್ಬೇಕು. Yes. We'll post it on Monday.
Serial number
Tuesday or
90.
Wednesday, my
Why is Tuesday? All right.
in serial number
Your
80.
lordship,
All adjournments, I will grant dates now. Please don't hold up the.
Serial number with your.
My lord,
ಮಾಡ್ರಿ,
serial
ಎಲ್ಲಿದೆ?
number.
Continue ಆಗುತ್ತೆ.
My lord, serial number.
ಆಯ್ತು, ಪೇಜ್ ವೈಸ್ ಕರ್ದ್ಬಿಡಿ ಮೇಡಮ್.
My lord,
Wait, sir. Pass over, I'm not taking. Wait. Yes.
84, 85,
84.
84 ಏನು?
25th, madam. As the matter is so urgency.
So urgency, big group ಅಲ್ಲಿ ಇದೆ. Yes.
25th, madam.
No, 25th.
There the property will be coming to the earth, madam. Developed condition ಒಳಗಿದೆ, ಬೀಳ್ತಾ ಇದೆ.
Oh, ಅದು ಮೇಡಮ್ ಅವ್ರು ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಅದಕ್ಕೋಸ್ಕರ.
List this 25th in the fresh matters list. Next.
84.
ಅದನ್ನೇ ಹಾಕಿದೆ 84. Yes, next. After 2 weeks, on date, yes. 86, interim order will continue, please don't make a mention. Yes, next. 2 weeks, yes.
Lord, 87, Lord, last minute, and feelings are ready, Lord, last minute fix any date, it's tender matter.
Stay there.
Stay, not to precipitate until any date.
Just 2 weeks, date on code. Yes, next.
Seal number 88, I appear for the petitioner, my lords.
It
It is a blacklisting matter. There is no stay, my lords, and objections have not been filed. It may be
List
had
the
on
matter.
Monday.
Will you please stop, madam?
Yes, my lords.
List the matter on Tuesday in the fresh matters list. Next.
89.
Which matter?
89.
Yes. Correct, sir. Thoroughly forest. List the matter on 8th April. Objections, if any, by then. Yes, next.
Lordship, scene number 76, your lordship.
ನಿಮ್ಮ ಆಫೀಸಲ್ಲಿ ಬೈಕ್ ತುಂಬಾ ಓಡಾಡ್ತಾ ಇದೆ. Wait, sir.
91.
Yes.
Your lordship is in 91, I appear for the respondent, my lords. There's an interim order operating, my lords. Any date may be fixed.
List on 16th April. Yes. Interim order subsisting will continue to the next date of hearing.
For the petitioner. For the petitioner.
That's 92, I appear for.
We served the petition, but not the.
Steel hypermart, Supreme Court in Bandira, they have to dispose it. Yes, the list. Next Friday, Hakim. Yes.
93.
My lord, 93, my lord, I appear for the petitioner. This is a matter where, my lord. Yes, my lord.
Sir, this also Friday. This has to be allowed.
Yes, my lord.
Matte, I won't grant you time at all.
Yes.
Straight away allowed.
Yes.
Yes.
94.
My interim order is 5 pages, I think.
94,
That will
yes.
be the final order.
Yes.
94, I appear for the respondent, my lord. This
90,
is a
94 next Friday.
next. Time may kindly.
No,
be fixed.
Swami, next Friday.
Time may kindly be
Yes,
fixed.
yes,
at,
next.
2:30, my lord. For all the 8 matters, sir.
Gottu, sir. Yes.
Check bounce cases.
96. 96 ಯಾವ್ದು ಮೇಡಮ್? ಅದು KDB. Single window. ಅದು Friday ಹಾಕಿ. 97. All these matters. Government, enforcement officer. Shanti Bhushan ಅಲ್ಲ? Registry to print the name of Shanti Bhushan is appearing for the respondent in all these cases. List next Friday. ಕೆಲವರಲ್ಲಿ ಮಾಡಿಲ್ಲ ಮೇಡಮ್. Being spoken to ಏನಿದೆ? Being spoken to ಆಯ್ತಾ?
Being
My lordship.
spoken to.
For the petitioner, my lordship.
Parole matter. Parole matter, your lordship had granted parole.
ಇದು I granted parole but not released it on. What are the grounds you said with regard? What is the reason?
My lordship.
Petition ಏನು ಇರಲ್ಲ, that's the problem.
No, my lordship. We want to spend time with the family.
Spend time.
Because he has already.
Other than spending time, nothing else?
He has completed 13 years, 6 months close to that.
Spending time parole.
To.
Should come up with some better reasons.
No, my lordship, I'm not an extent.
ಅವಾಗ್ಲೇ ಬಂದು ಹೇಳ್ದಾಗ ಹೇಳ್ದೇನ.
Time pass ಮಾಡಕ್ ಬರೋಲ್ಲ. Yes.
ಇಲ್ಲ, my lordship.
All right, I will grant you. I wanted to know the reason. Yes, next. ಆಯ್ತಲ್ಲ ಮೇಡಮ್? Being spoken to ಅದು ಅಲ್ಲ, no further orders. We'll release it tomorrow. ಇಲ್ಲಿ ಅವ್ರು ಬರೋಲ್ಲ. ನಿಮ್ದೇನು ಪ್ಯಾಸೋವರ್ ಏನು ಏನಾಗ್ಬೇಕು?
ಪಾಸ್ಪೋರ್ಟ್
ಶಾರ್ಟ್ ವ್ಯಾಲಿಡಿಟಿ ಪಾಸ್ಪೋರ್ಟ್ ಗೊತ್ತಾಯ್ತು, ಬರಲಿ, ಏನು ತೊಂದರೆ ಇಲ್ಲ. ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು ಅರ್ಜೆಂಟಾಗಿ?
ಎಕ್ಸ್ಪೈರಿಂಗ್ ಆನ್ April 1st week.
ಏನು ವರಿ ಮಾಡಬೇಡಿ. ವಿಲ್ ಡೈರೆಕ್ಟ್ ದೆಮ್ ಟು ಗ್ರ್ಯಾಂಟ್. ಎಸ್, ವಿಲ್ ಪೋಸ್ಟ್ ದಟ್ ಆನ್ Monday. Where is the senior counsel?
My lords, he's in VC.
Urena?
KG Raghavan sir is appearing.
Now no time. Yes, Monday.
My lord, I appear, my lord, for the
Tuesday, sir. Now time illa, Tuesday. Yes, next. Call the cases.
But an interim order has to continue, madam.
That will continue, sir. Yes.
Great.
Yes. Tuesday, fresh preliminary hearing that. Yes. Stay ಕೊಟ್ನಲ್ಲ. Yeah, ಜಾಸ್ತಿ wait, we'll see. ನಾಳೆ. ಏನು ಮೇಡಮ್? Sanction ಏನಕ್ಕೆ? For what? What sanction? ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಆಯ್ತು ಅದು. ಆಯ್ತು 25th preliminary hearing ಅಲ್ಲಿ ಹಾಕಿ ಮೇಡಮ್. ಎಸ್ ಆಯ್ತು. ಎಸ್ ಟುಮಾರೋ ರೆಡಿ ಇದೆಯಾ? ರೆಡಿ ಇದೆ, 2 ಸೆಂಟೆನ್ಸ್ ಹಾಕ್ಬೇಕು. ಟುಮಾರೋ ಬೇಡ, ಟೈಮ್ ಪಾಸ್ ಮಾಡೋಕ್ಕೆ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಇಂದ ಕೊಡಿ. ಕೊಡಿ. ಇಲ್ಲಿ ಕೊಡ್ತೀವಿ. ತಾನೇ ನೋ ಪ್ರಾಬ್ಲಮ್.
Any day, my lord.
ಎಸ್ ಅವರು ಎಲ್ಲಿ ಪೆನ್ ಡ್ರೈವ್ ನಾಗೇಂದ್ರ ನಾಯಕ್ ಬನ್ನಿ ಸರ್.
ಬೇಡ ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿದೆ.
1 hour ಲೇಟ್ ಆಯ್ತು.
4:15.
4:15 ಅಲ್ವಾ ಹೇಳಿದ್ದು?
ಹೌದು.
Shamsundar sir has not come, madam. He's landed. He has landed. All right. Sir? ಅದಕ್ಕೆ ಕೇಳಿದ್ದು ಲ್ಯಾಂಡ್ ಆಗಿದಾರ ಏರರ್ ಇದ್ದಾರೆ. ಅವ್ರ ಮುಗಿದ್ಮೇಲೆ ಮಾಡ್ತೀರಾ?
I
ಮುಗಿಸ್ಬಿಡಿ.
will give the reply, my lord.
ಬೇಡ ಬೇಡ ಮುಗಿಸ್ಬಿಡಿ.
I'll finish.
ರಾಜು ಸರ್
ಹೌದು.
ರಾಜು ಸರ್'s reply you
Waiting.
give.
I
Yes.
think he's waiting. He's on.
Yes, sir is waiting. You finish your reply to sir's submissions.
I will continue on Monday, my lords, as
Yes, sir. I'll hear them and close
Very
this.
well.
Monday works exclusively your submissions.
First part, first half.
So whenever you want. Yes.
First half, my lord, because then I have to go back to Delhi, my lords.
All
Yes.
right. You're coming physically?
Yes, I'll come physically.
Then yes, sir, we'll have it. Yes.
Very good.
No, start.
My lords had given a note on 11/3/2025. That note may kindly be taken. The 2 queries which my lords had put.
I think you told about that.
My lords may kindly once notice that.
All right.
Because whether it satisfies the court on the 2 queries, my lords, the present challenge, and then, my lords, insofar as deemed acceptance, these were the 2 queries. Please notice, my lords, the point for consideration there.
Point number 2.
The first point is also
First
important,
point is
my
with
lords.
regard to 482.
Challenge at 482, 226 or 227. And then, my lords, the second point, the inherent powers, my lords may notice that portion. 482, what are the powers that the court would have equivalents to 227? And then, my lords, kindly notice page 3, my lords. I've pointed out when it comes to a challenge to either grant or rejection of pardon, it would be either the accused who is aggrieved, whose pardon has not been granted, or in the case where the pardon is granted, the co-accused who would be the aggrieved person, and he's the one who would take it up on challenge, normally, my lords. And for that, my lords, the judgments in page 3, kindly notice in Lieutenant Colonel Commander Pascal, my lords, that was a case.
Page 3, yeah.
Page 3, adralli, my lords, ಆ note ಈಗ ಕೊಟ್ಟಿದ್ರಲ್ಲಿ.
Page number.
Page numbers ಹಾಕಿಲ್ಲ, but 3rd page ಅಲ್ಲಿ, point number 3 ಅಲ್ಲಿ.
Page number ಹಾಕಿಲ್ಲ. Anyway, page 3.
Yes, my lords. Point 3 ಅಲ್ಲಿ.
1 minute, I'll just page it.
I'm sorry, my.
No problem. ಇಲ್ಲರೆ follow ಮಾಡೋದು ಕಷ್ಟ.
ಹೌದು.
There are 5 pages, right?
It's 5 pages, my lords. It's
Yes.
5 pages. My lords may notice those case laws there, my lords.
Page number?
Pascal, page 3.
Pascal Fernandes.
Fernandes was the state of Maharashtra. In that case, my lords, the court would hold by exercising revisional powers. The next case, my lords, in UP is 482 exercised.
ಇಲ್ಲಿದೆ ಮೇಡಮ್. ಏನು ಹುಡುಕ್ತದೆ? ಇಲ್ಲಿದೆ. ಅದಲ್ಲ, ಇದು ನೋಟ್ ಸಾಕು.
The third, Roman number 3, was excised of 482 and 226 by my lord in the very same case.
4th December.
Yes, my lords. And the fourth was a coordinate bench in the very same case, accused number 17, my lords, where pardon was rejected with those.
Justice Natarajan.
So, my lords, to say challenge lies either under a 482 or under 226, these are all the citations on it. Then, my lords, at page 4 on deemed acceptance.
My
lords,
learned may kindly hand over the citations to me or my colleague who is there.
I will hand it over here, sir. I'll hand it.
Your colleague is here, sir? Rahul is here, yes.
Rahul, you have this.
No, this
Same
points of
basket.
consideration which was given on that day.
You want another? Yeah, it's all right, it's all right. Volume was.
It was earlier given, is not, copy is not given to
My
you?
lords, 11.3 itself, my lords.
11.3 it was given.
Anyway, my lords, it's all right.
We'll give it.
I'll take it up.
Is it same thing or edit?
Judgments, those 4 judgments. I think, just give them another one. My lords, on deemed acceptance at page 4, my lords. Please notice, my lords, we have pointed out 306 to 308 does not make any difference where the application is made either by the prosecutor
Prosecution or by the accused.
the procedure which it mandates is the same. And 306, 3 and 5, which my lords had noticed, the usage of the word shall and the need for acceptance before recording evidence. 308 again reiterates, my lords, in case they turn hostile to it, what the position would be. So 306 to 308, my lords, nowhere recognizes what is a deemed acceptance. No, it should be acceptance in clear terms and it should be recorded that he accepts the pardon before recording the evidence. Now, this is in page 4. Now, my lords, along with this now, Asian resurfacing, I made a mention, my lords, irrespective of the title, what powers that the court exercises would be the same when it comes to either 482, 226, or if it's going to be the revisional powers. Now, may I just point out the relevant paragraphs? First of the Asian resurfacing, the 3-judge bench, my lords, in 2018.
Yes. Judgment ಕೊಟ್ಟಿದ್ದೀರಾ?
Asian resurfacing, my lords.
Yes, 2018 judgment.
2018. I will point out what was it that has been now, my lords, modified only insofar as that extent of stay
No,
for
6
6 months
months.
period. Only that is altered, my lords. Otherwise, rest of it remains the same. So in Asian resurfacing, my lords, their concurring judgment is that of His Lordship Justice Roington, but the main judgment is of Adarsh Kumar Goel, my lords.
Yes.
That judgment would commence at page 308 and the portion dealing with the equivalence of power under 482, 226, 397, my lords. My lords should first get that at paragraph 27
Yes.
at page 319. Ultimately, my lords, they go back to Madhulime's case, my lords. They go back to Madhulime's case, my lords, where they coined the word intermediary orders. Now, my lords, under the CRPC,
I've
we
seen,
get
yes.
interlocutory and final orders.
Intermediary.
Intermediary was coined in Madhulime, which they say is right if it affects the rights of a party but does not amount to an acquittal or a conviction. They come under the category of intermediary.
Intermediary order.
So that, my lords, in paragraph 27, while dealing with that, the court, my lords, notices that. My lords, I might have just marked that portion in 27 paragraph. And then, my lords, the
Good.
next portion,
Please mark and give.
paragraph 37.
Everything, whatever you want to rely, please mark it.
Yes, my lords, I think paragraph 37.
You have marked.
Oh.
Don't worry about it. Please mark it. It makes our job
Some,
easier.
my lords, in some courts, they're, so my lords, paragraph
Some
30.
courts you're trying to influence nothing, sir.
My lords,
Nothing
paragraph,
of that will happen. Yes.
paragraph 37 at page 324 may be noticed, my lords. Thus, we declare the law to be that order framing charge is not purely an interlocutory order nor a final order. Jurisdiction of the High Court is not barred irrespective of the label of a petition, be it under 397 or 482 CRPC or 227 of the Constitution. However, the said jurisdiction is to be exercised consistent with the legislative
Even
policy.
without looking into this, sir, ಹೇಳಿದ್ದದೇನೇನೆ. Yesterday what sir said is the same thing. Yes.
My lords, paragraph 52. My lords, this portion of the order is His Lordship Justice
Drawing to Narimas.
yes, my lords. Because it commences from paragraph 40 onwards. Paragraph 52, 53 and 54 reiterates this power of
Inherent
inherent.
power.
And again they say, my lords, this inherent power is not something that is from a statute, but it is because the court possesses it, being a constitutional court or a court of record. That's exactly what they say. If my lords would have paragraph 52 for a minute, that portion I'll read, my lords, because while comparing the power of revision with inherent, my lords, I think inherent powers is something which is very supreme, my lords. It's very supreme because of this court being a court of record. That's how they put it. I'll just read that one portion, my lords. Paragraph 52. The question as to whether the inherent power of a high court would be available to stay a trial under the act, because, my lords, under the PC Act, section 19 is a bar for stay. So the question arose, under inherent powers, can you stay it? So they say under inherent, it can be done. It can never be subject to a statute. Necessarily leads us to an inquiry as to whether such inherent power sounds in constitutional as opposed to statutory law. First and foremost, it must be appreciated that the high courts are established by the Constitution and are courts of record which have all powers of such court. The High Court, being a superior court of record, is entitled to consider question regarding its own jurisdiction which arises before it. Then, my lords, para 53, they say, in so and so, this court had an occasion to deal with the inherent power of the High Court under 561A, Old Code, my lords, which is equivalent to 482 of the Code of Criminal Procedure Code. It was held that the said section did not confer any power, but only declared that nothing in the code shall be deemed to limit or affect the existence of inherent power of the High Court. It is thus clear that the inherent power of the court set up by the Constitution is a power that inherits in such court because it's a superior court of record and not because it is conferred by the Code of Criminal Procedure. This is vastness of my lord's power. So, my lords, when doubt arises whether could it be done only in a revisional court and not that under excising powers.
In the earlier judgment, I've said so. If the revisional court has that power to suo moto consider it, inherent power under 482 cannot, will not stop this court from doing it. That's what I've said.
So probably that would be the answer insofar as exercise of powers of 482. And, my lords, in 2024, this small change in Asian resurfacing, that
With regard to 6 months stay,
automatically
Madam,
vacating, it should not be so. That's all that has happened in that. Now, my lords, with this, I will straight away deal with the contentions of the CBI, 9 contentions that have taken. My lords, I have done that also into a written form itself, so that, my lords, with this vastness of papers before my lords, I thought
no problem. Your compilation is always good.
Yes. Could I just pass on what I have done as a reply to the 9 contentions, my lords? It makes it much faster.
Copy or ಕೊಟ್ಟಿದ್ದೀರಾ?
You can send it to me by WhatsApp or email.
I'll send it, sir. I'll have it sent. My lords, the first and second contentions have put it together, my lords. The contentions being that the present challenge is not maintainable since the evidence of the accomplice has already been recorded. That was one contention.
Don't have to worry about that.
Second contention there, my lords, that the petitioner ought to have approached this honorable court immediately on the passing of the impugned order and ought to have pressed for stay. Now, my lords, in my reply to it, I've covered both these aspects in saying, when we deal with evidence.
What you have, with regard to the facts, on the same day it had to be and things like that. 24th, the order is passed by the concerned court. Then 26th, the petition is preferred. 27th is a holiday because of the death. Then it comes on 30th next. 30th interim order is granted.
Yes, my lords, when on 30th, the same day
evidence is recorded.
We bring it to the notice of the court, they continue with the chief examination. So that is one aspect. Second aspect.
That's correct, right?
Yes, my lords, absolutely.
Then why do you want to?
Lord, evidence is recorded first, my lord. Evidence is recorded first, then the order has come.
On the same.
No, that's on the same date. It's
and
anyway on
after
30th.
the court is made aware that the matter is before the 30th on the same.
30th, I think in the evening, interim
Yes, my
order is
lords, on
granted
the
is
same
what
day.
you said.
And, my lords, when we say evidence is recorded, evidence does not mean merely chief examination. Section 137 of the Evidence Act has in it chief, cross and re. So,
Correct. Evidence
to
was
say
not-
once evidence.
Evidence is not complete, sir. It's only examination
But
in
the
chief.
argument was evidence is complete, therefore this cannot be maintained. That
No,
will
no, no,
not lie,
sir,
my
sir
lords.
did not say that.
So-
Evidence is complete and he never said. He said examination in chief was over on that day.
If that was the
So
submission.
that was this, I don't,
because
evidence
we-
is
as
not
we
said.
Understand, evidence is complete, the present petition not maintainable. If that's the contention, my note there, 137 of the Evidence
Sir.
Act and Section 3 of the Evidence Act.
Evidence Act, yeah, even under 245 CRPC, if you see, what is evidence? Examination in chief, cross-examination, re-examination, this is
This
evidence.
is evidence.
Yes.
And also Section 3 of the Evidence Act itself. says,
Itself,
my
yes,
lords.
what is evidence?
So, my lords, that contention.
Well, I doubt, evidence andre, because cross-examination is not over yet.
So, my lords, I will not labor much on those two contentions.
Yes, sir.
I'll not labor much on those two
Yes,
contentions.
not
my
necessary.
lords. And also senior also has touched upon that. But contention number 3, my lords,
Yes.
contention number 3,
No, why are you disturbed?
I'm not disturbed.
Distracted rather. Shyam Sundar Bandru antana? Allah, because he came and sat, you appear to be distracted. ಅಲ್ಲ ನೀವೇನು ಬಂದು ಕೂತ್ಕೊಳ್ಳೋದ್ರಲ್ಲೂ ನಾವು ಹೇಳ್ತೀನ ಡಿಸ್ಟ್ರಾಕ್ಟ್ ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. Oh.
Sorry,
Yes,
my lords.
That's all right.
But
ಐದುವರೆ
more-
ಆಗಿದೆ.
I understand.
Yes.
My lords, most important would be contention number 3, my lords. In my respectful submission, I will focus more on that contention. The contention was,
This is the most important.
there is no requirement. The contention was, there is no requirement for an acceptance of a pardon
Hmm.
tendered by the court if the application arises out of a request made by the accused himself. This is a contention, my lords. My lords, in my respectful submission, this contention runs contrary to the section itself.
No, 3 and 5 mandates.
306 to
306(3),
308.
306(3 itself mandates.
305, 308. If we see the section 306 to 308, the mandate would
No.
be that of an acceptance.
Raju sir said, even if it is not followed, it is covered under 465.
I will come to
460 and
irregularity
460,
later. I'll come to
irregularities that would not
irregularity
vitiate.
later.
306 is one such irregularity that is enumerated in 460, that it would not vitiate the proceedings. That is the
dealt in a-
submission.
That's dealt in another submission, my
That's
lords.
the
But here
submission of
kindly-
Raju sir.
This one submission is saying whether there is a mandate to have acceptance or not. Now, for this, my lords, first of all, as I submitted 306 to 308, it is a mandate. You need to have acceptance. Now, this submission of ours is supported by 4 rulings, my lords. Kindly notice the rulings there.
Mm.
Bipin Bihari Sarkar versus State of West Bengal,
Mm.
1958 SCC Online SC 162,
Mm.
paragraph 7. My lords, I have extracted it in the judgments and the contentions taken. If that book is just noticed for a minute, my lords, it's at
Yes.
page 42 of the
Look at it.
index book.
Yes,
I have extracted that portion where acceptance is necessary.
that day you read it also.
Yes, my lord. Now,
Yes.
second judgment there, Santosh Kumar Satish Bhushan versus State of Maharashtra 2009 6 SCC 498, which is extracted at page 46 of the compilation. Then, my lords, A. Srinivas Lu versus State of Tamil Nadu 2023 13 SCC 505, paragraph 65.4. My lords, that is not there in my compilation, but which has been given subsequently, my lords. In that 65.
Can you give me the can you give the citation again, please?
It's 2023 13 SCC 705.
705?
Sanction da.
7.
That is
Sir,
A.
may I repeat it?
A. Srinivas Lu.
2020.
Where is Lu?
2023 13 SCC 705, paragraph 65.4.
ಯಾಕೆ ಐ ಡೋಂಟ್ ಲೈಕ್ ದೋಸ್ ವರ್ಡ್ಸ್ ಒಮಿಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ?
My lords, adrili 65.4 may just be noticed, my lords, one, where acceptance is necessary. So right from 1958, my lords, till 2023, the judgment should say acceptance. Last, my lords, I think
ನಾನು
65.
ಇದ್ಯಾವ್ದು ಎ ಶ್ರೀನಿವಾಸ್ ಅಂತ ನೋಡ್ತಾ ಇದ್ದೇನೆ. ಸ್ಯಾಂಕ್ಷನ್ ಜಡ್ಮೆಂಟ್.
Thanks.
ರಾಮಸುಬ್ರಹ್ಮಣ್ಯಂ.
Prakash
This is
Singh,
ರಾಮಸುಬ್ರಹ್ಮಣ್ಯಂ.
Adreli 65.4, my lords, just notices
Yes,
that
sir.
the usage of the word acceptance.
Obliges the magistrate tendering pardon not only to record reasons for doing so, but also to state whether the tender was accepted by
That
the
is most
person to whom it
important,
was made.
most important, my lords. So from 58 till 2023, these judgments of the Honorable Apex Court. Added to that, my lords, we have the judgment of Andhra Pradesh, my lords, which is part of my compilation. Kona Jetti, Rajababu versus State of AP, 2002 SCC Online SC AP, page 3. In which paragraph 13, my lords, I have extracted it in the book at page 21. In the book itself, page 21, it's extracted to say acceptance is necessary. Now, along with all this, my lords, the division bench of the Kerala High Court also has taken the same view. Now, my lords, this is in State of Kerala versus Anil Kumar, 6th August 2024. Kindly.
Paragraph.
Paragraph 14. Paragraph 14. It says, my lords, once the approver has accepted a tender of pardon, he stands on the same footing as any other witness. My lords would get that at just above paragraph 15, the last sentence, my lords. Internal page 30.
Yes, sir.
My lords gets that one sentence. Once the approver has accepted a tender of pardon, he stands on the same footing as any other witness. So, my lords, in my respectful submission, my lords, all these judgments would answer the third contention that there has to be acceptance of a tender of pardon. My lords, as I pointed out in our case, my lords, the court even has not categorically stated their rendering pardon, application allowed, one portion. And the court then doesn't even put it across for the acceptance. So complete go by to the mandatory provisions under 306. Now with this, my lords, settled position of law is what has to be done in a certain manner or not. My lord, what has to be done in a certain manner has to be done in that manner or not at all. Settled position, my lords. My lords has quoted it a number of times. My lords, it starts with Nazir Ahmad versus
That's
King
what
Emperor.
King Emperor.
And
No,
then, my lords, more
It
recently.
does not start with that. It starts with Taylor versus Taylor.
Taylor versus Taylor. Yes, my lords. Taylor versus Taylor. Again, then thereafter Nazir.
That's again
Ahmad
quoted
is AR 19.
Babu Varghese versus State of Kerala, Bar Council of Kerala. Para 38 and 38.1.
My lords, this was in 36, my lords, Nazir Ahmad. And then opto circuit.
Opto circuit. Justice Bopanna, they quote, he quotes that
Absolutely, my lords.
in opto circuit.
They again
Is
fall
that
back
I've
to
seen.
Mahinder Singh Gills, they fall back to that, but that's that portion.
That's all right. Why do you want?
In
Don't.
present case, if the law mandates under 306 that it has to be done in this manner, it has to be done in that manner or not at all. my lords.
Correct.
So I say pardon, acceptance of pardon, recording of evidence.
When the statute,
Yes, my lords,
when
I
the
use the word
statute
when the
mandates a particular thing to be done in a particular manner.
Now, my lords,
King Emperor is later. Nazir Ahmad is later. Taylor versus Taylor first. 1828. Yes.
my lords, learned ASG had relied upon two decisions to say that there may be no need for acceptance prior to recording evidence. Now, these two judgments which were relied on, one was of the Privy Council, my lords, in Baba Fakir Singh versus King Emperor,
1940.
1938
38
SCC
or 49?
Online, PC 46. Now, my lords, in their compilation for a minute, my lords, I may just have to point out this judgment, whether it says that there's no need for acceptance. Kindly
No.
have this.
That judgment was relied on for the purpose that once you examine yourself, or you file an application yourself, it is deemed acceptance. No, that's why, that's what I thought.
ರಾಮನಿ ಕೇಸಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಹಾಗಲ್ಲ ಮೆಲೋಡ್ಸ್, ಇದ್ರಲ್ಲಿ ಹಾಗಲ್ಲ ಮೆಲೋಡ್ಸ್. ಇನ್ kindly notice the judgment ಮೆಲೋಡ್ಸ್ is at page 149 of their compilation.
What do you mean?
Blue spiral was relied upon for the purpose of quoting the 1978 Karnataka Act that it had relied upon. Alla, but isn't it on the aspect of acceptance? Please notice the judgment.
No, it is on the, for the contention of acceptance only.
Yes, if the judgment is noticed now.
I think Odi,
Melods out ಕೊಟ್ಟಿದ್ರಲ್ಲಿ
blue spiral.
blue spiral.
Your lordship had returned it for
Oh, Kodi, yes. Now it has turned orange.
Oh, it's
Yes.
sorry.
pagination is the same, no? Melods 149.
No, if you turn the color, then tampering, yes. Yes.
Melods page 149. The Privy Council. Please have page 155, my lords. From the center portion, the tender of pardon was made.
Yes, I've already marked it.
It is next to be observed, my lords has marked that portion.
Yes.
Page 155.
Yes,
It is next to be observed that
Yes.
the person who accepted the tenders of pardon.
yes, that particular line I've marked.
So, my lords, how would this judgment be relevant to say that there is no necessity for pardon to be
No, no,
accepted?
ಅದು ಅವ್ರು ಹೇಳಿದಾಗ this you will definitely tell ಅಂತ ಹಾಕಿ. Yes. ಇಲ್ಲೇ ಇದೆ marking them.
Okay, my lords, I just wanted to point that portion out.
Hmm.
Then, my lords, the other judgment which they relied on is Raman.
Raman,
Yes, my lords, Raman S versus State of Karnataka, 1978.
Oh, that is,
SEC online,
Kudur,
page 135, my lords. Now,
it
please,
follows that judgment.
my lords, what in this judgment also, my lords, they say two mandatory things that have to be done is pardon to be granted with conditions, acceptance of pardon. The question then arose is, can this acceptance be oral or not? That is what arose. Please now notice that page 140, I'm sorry, my lords, I'll just 141.
No, if you have, if you should come to the mere fact that the so this
Paragraph 21 would be relevant.
paragraph 21, last 4 lines,
My lords,
the learned judge says, this is what troubled me, that's why I marked that,
Yes.
just check. The mere fact that the magistrate who tenders pardon has failed to record in the order of tendering pardon that the accused to whom the tender is made has accepted the tender or not would not, in my opinion, invalidate the tender of pardon if otherwise valid in law as indicated here and above. It would only amount to an irregularity and not an illegality.
now kindly notice paragraph 21 in the beginning portion. my lords. The tender of pardon would become complete if two conditions are satisfied. They are, one, the tender of pardon by the magistrate should be in conformity with the conditions laid down in subsection 1 of section 306 in respect of offense to which section 306 would be applicable. And two, the acceptance of the tender by the person to whom the tender is made. Now, my lords, even in this judgment, the two conditions they say is, one, grant of pardon with conditions, second, acceptance. Then they go into the issue of saying, this acceptance, if it is not in writing but orally, then can it be accepted? So then they go on to hold that it can be still accepted. But it does not say, my lords, there is no necessity of any acceptance at all. That is not what the judgment is. And also, my lords, more importantly, as pointed out by learned senior, it says that no contrary ruling of the Supreme Court or other court, paragraph 22. Contrary ruling is 1958 judgment. 1958
So
judgment,
nobody
my
is,
lords.
no, he says, the learned judge says, nobody has brought to my notice.
How? So, my lords, this Bipin Bihari Sarkar versus State of West Bengal, 1958 SCC online SC 162 was not made known to the learned single judge about the need for acceptance. That is where, my lords, one aspect of it. Second,
Statute? Yes.
Second, what has happened is post this judgment. Now, this judgment, my lords, was in 1978. Post this judgment, all the judgments of the Supreme Court, be it Santosh Kumar versus State of Maharashtra, A. Srinivaslu versus State of Tamil Nadu, Supreme Court says acceptance has to be there. So how much of reliance can be placed on this judgment of 78, my lords, of the learned single judge, where in my respectful submission, even there they say acceptance is necessary. Whether oral or written is something to be seen. And in our case, my lords, without a fear of contradiction, I can say there's no oral also acceptance. Orally adru, naniga pardon kotta idiri, would you accept that? Orally no kelilla, orally answer illa. Oral or writing, no acceptance. My lords, now I come to the contention of irregular proceeding.
460 and 65.
Senior has dealt with it quite extensively, whether it is 460, 464 or 465. Now, my lords,
They operate in certain circumstances.
yes, and seldom circumstances, and 464 all deals with charge. While framing a charge, if there's going to be some irregularity, what would be the consequence? 464 and even 465, my lords.
No,
what
there,
we see
465 ಅಲ್ಲಿ clause 3
Yes, my
says grant of pardon. Under 306 also would not, irregularity in that would not vitiate. But you see the title of 460.
460, irregular proceedings.
Huh.
Irregular proceedings.
ಅದೇ ಬೇರೆದಕ್ಕೆ
My lords, this is on the aspect of jurisdiction. Now here we are not on the aspect of jurisdiction. We are not trying to say the court which has now allowed the application lacks jurisdiction, because, my lords, they use empowered by law. The reading of 460 commences, if any magistrate not empowered by law, then we get this A to I. Now, our case is not one of saying the trial court does not have power or jurisdiction. 461 vitiates.
460
460, which do not vitiate. 461 is which vitiates. But here in 460, my lords, even if there's lack of jurisdiction, if they do this, this is how you look at it. But we are not on jurisdiction. We are not on power. According to us, court has the power. But whether, my lords, that power has been exercised correctly or it is an illegal exercise of power is what we are questioning before this court. So, my lords, 460 doesn't come. 464 also, my lords, irregular proceedings, this doesn't come. It has nothing to do with charge. Similarly, 465 also, my lords, finding or sentence which, when reversible by reason of error, omission or irregularity. The present case doesn't fit into 465 also. And also in all these provisions, my lords, there's also a caveat. If an accused is able to show that by this act, it has resulted in failure of justice, then he is entitled to question it. So, my lords, it is qualified, similar to how my lord's order is qualified by using the word if there's a threat perspective later. Similarly, these provisions are qualified. If I am able to show, my lords, there's failure of justice, then, my lords, all these irregular proceedings, it will not come in the way at all. And by, my lords, there's a very important usage of failure of justice, my lords. Pradeep Vadeyar then interprets failure of justice. Pradeep Vadeyar, what do they say as failure of justice? Failure of justice is 3 aspects of it. Have you come to the court at an earliest point of time? Second, are the offenses very serious? Third is, are you before the court only to protract the proceedings? Now, lords, in my case,
I think the last one is correct.
well, I don't think so, my lords. I have come as soon as an order is passed. And my contention is all these offenses are very, very serious. It deals with 302. And, my lords, our intention is not to protract. Our intention is to point out an illegality that has occurred, which puts the other.
No, your intention is not to protract, but make him retract his statements.
No.
And come back as accused.
Come back as an accused.
That's why retracting his ground, come back.
Escape, my lords, best just by filing an application. I will jump on the other side. You people face the music. It can't be as light as that. And it can't be entertained so easily. My lords, that's the reason. One more aspect I will point out, my lords, when it comes to pardon. My lords, we will have to also see 265A. I will come to that as my last submission, my lords. There's a difference.
ಈಗ ಮುಗಿಸ್ತೇವೆ ಅಂದ್ರೆ I'll have to seek pardon.
My lords, I'll finish it, my lords, because everything is in writing.
Yes.
Kindly notice, my lords, that's the fourth contention of irregularity, which in my respectful submission, it is not a case of irregularity, but an illegality which is brought to the notice of this court. Contention number 5, my lords. My lords, it was contended 307 is independent and distinct from 306. Not at all, my lords.
No, no.
307 can't exist.
On the same conditions.
It
On the
can't
same
exist.
conditions and the 307 ಅಲ್ಲಿ ಇದ್ರೆ it cannot be referable to anything else but 306.
306. So if 308 is also seen, it's referable to both this. So my lords, if the-
307.
I'm sorry.
Priorly, condition number 1 ಮಾತ್ರ ಅಂತ ಹೇಳಿದ್ದಾರೆ. I will point out. because I
ಆಯ್ತು,
don't want to-
ಒಂದ್ ನಿಮಿಷ ಇನ್ನು ನೀವು ಮುಗಿಸ್ಬೇಕಲ್ಲ ಇನ್ನು ಅಷ್ಟೇ.
My lords, 308 ಅಲ್ಲಿ, where in respect of a person who has accepted a pardon, tender of pardon made under 306 or 307. Now 307 ಅಲ್ಲಿ, where is the question of conditions if 306 is not read into it? The entire procedure, my lords, is contained under 306. 307 says a committee court has the same power.
Procedure is the same. Courts are different.
What's the difference?
306 deals with magistrate's pardon, 307 deals with Court of
Once it
Sessions
is
pardon.
Once it is
Committed, yes.
committed. So 307 will not
No,
exist.
a pardon can come about only after committal in a court, in a matter which is to be tried by the Court of Session. Correct.
Absolutely. So the conditions which apply to 306 is what applies to 307. So we can't treat 307 as a separate and distinct to that of 306. It doesn't work that way at all, my lords. Conditions can't be imposed for grant of pardon if that is read. So, my lords, I have dealt with it in the written note. And even
Yesterday,
this-
sir also has dealt.
And also, my lords, in this case, when grant of pardon is granted, it is under 306.
And 7.
7.
He
So it
says
has
3,
to-
6 and 7.
It has to be read together, my lords. This would be my submission.
Application is filed under 306 and 307. Of course, BNSS also. Yes. The Article 226 and 227. ಏನ್ ಹೆಡ್ಡೇಕೆ ಇಲ್ಲ, ಯಾವ್ದ್ರಲ್ಲಾರು ಕೊಡಿ ಆರ್ಡರ್.
My lords, the sixth contention, three more contention.
ಓ ಹಾಗೆ. Yes.
My lords, kindly notice the sixth contention, totally 9 contentions, my sixth contention, so that I can just,
I am there.
please notice there, my lord, sixth contention was that there need not be any change in circumstance for an accused to file successive 306 application, and a 306 application cannot be equated to that of a bail petition. Now, my lords, all the judgments are contrary to this. Please notice the judgment.
This is what I have said.
UP,
It is akin to bail application.
my lord's order which remains unchallenged in the very same proceedings, where my lord said there is a need for change of circumstance.
No, no. Have I not said it is akin to bail application?
Absolutely, absolutely. So the argument now which is
Oh, not, oh, submission.
submission not akin, whereas we are,
Yes, yes, yes.
my lord's order which was passed on 4th December, between paragraphs 15 to 18 deals with this very aspect.
But that observation is correct that it is akin to bail application.
Yes, my lords, that's the observation. Because, my lords, on any change in circumstance, obviously you can file an application seeking pardon. Now, my lords, a case of repentance, at a certain point of time, he says, no, I'm sick and tired. I want to reveal everything about the crime. I want to become an accomplice. It can happen any point of time. He files an application. He can say, this is what happened to me and this is why I want to be treated as an accomplice. That is a change in circumstance. Or like in a threat perspective, my lords, which real apparent threat comes. Not in a case of this imaginary threat, my lords, but an apparent threat. It is a change in circumstance. Not, my lords, order 4th, 5th, certified copy, 6th application, not in such. But I'm just trying to say, my lords, change in circumstance.
Fifth night he has received a threat call.
ಹೇಳಿಲ್ಲ, ಎಲ್ಲೂ ಬಂದಿಲ್ಲ. Application is as bald as ever. Application goes on the footing as the court granted me this leave and that's why I'm filing this application. That is how it is filed, my lords. As though my lords gave a certificate to say you file. Then, my lords, that would answer the aspect of change in circumstance and akin to bail. Then, my lords, contention 7, prejudice. Co-accused will have to show prejudice. Now, my lords, what is prejudice, my lords?
Disadvantage.
Prejudice
Dictionary meaning of prejudice is
is an
disadvantage.
injurious effect on another person. That is how it is defined, my lords. I must have suffered an impairment of some right. Now, what
Not
happens?
necessary. You must have been put into a disadvantageous situation due to some act.
My
That
lords,
is prejudice.
I couldn't have put it even better.
Bias is different. Prejudice is different.
Disadvantage, I being put to a disadvantage is the right word, my lords, in my respectful submission.
Yes.
Now, I will point out, it's pleaded, we have pleaded it. Now, my lords,
Prejudice is one that is to be pleaded.
and we have paragraph 8, we have pleaded on prejudice. And my lords, kindly notice, when a co-accused becomes an accomplice, what would be the prejudice to the remaining accused, my lords? Firstly, my lords,
Acquittal, conviction.
now it's a case of saying,
Other prejudice. He will get
And
acquitted, you will get convicted.
my lords, first of all, my lords would look at it from the point of view of a betrayal.
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 Yes.
My lords, a co-accused, when he files an application for pardon, it's not just self-betrayal, he betrays the co-accused. That's how it is held in judgments.
Correct.
One is that, my
ಎಲ್ಲ
lords,
ಜೊತೆಗೆ
prejudice.
ಕ್ರೈಮ್ ಮಾಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ಬಿಟ್ರೆ ಮಾಡ್ಬಿಟ್ರೆ.
ಅದೇ. That's why, my lords, they say, though 113 of the Evidence Act, though it talks about the evidence of accomplice, they say it needs to be corroborated. That's the line of ruling. It can't be a substantive piece of evidence. You need to corroborate it because it's a person who's betraying the others and jumping onto the side of
Why
prosecution.
when it came to betrayal, you got very agitated?
My lords, first aspect is that. Second aspect is, my lords, probably my lords would agree with me, the right to silence, a fundamental right that I have under Article 20, Sub-Article 3. Now, when he becomes an accomplice, it definitely affects my right to silence in a trial. This is the second aspect to consider, my lords, whether there is anything that would go contrary to me, because we are on the aspect of prejudice. Third aspect, my lords, in all the cases that we are relying on, the challenge is by co-accused.
That the last
Including
order
this,
also I
my
referred.
lords. Previous round of
I have
litigation.
said so. Yes.
So, my lords, the question is not that of
See,
prejudice. The question
no,
that
no.
should be,
I have qualified that also in my earlier order. Co-accused cannot always challenge the order of pardon, but if he is projecting procedural aberration, definitely has the right to challenge, is what I have said.
yes, my lords. And probably, my lords, our whole case, as we have pointed it out,
No procedure hai.
please, my lords. So, my lords, the question may not be one of prejudice, my lords. My respectful submission would be, the question may at best be whether failure of justice, not that of prejudice. I have to show that there is a failure of justice, and for that the parameters, as I pointed out, is Pradeep Odair, which you have put in the note.
In criminal jurisprudence, generally it is not prejudice.
It's failure
Unlike
of
in other
justice.
jurisprudence,
It is failure of justice, my lords. Everywhere we get the word of failure of justice. And for failure of justice, my respectful submission is only 3 categories, my lords, as pointed out in Pradeep Odair. Now, my lords, prejudice, we have pointed out at paragraph 8, my lords, of the statement of objection, so that it's not that it is not pleaded. We have pleaded it. Then, my lords, contention 8, res judicata, my lords, they said that it doesn't apply. I have pointed out right from Bhagat Ram versus State of Rajasthan till State of Rajasthan versus Tara Singh, my lords. It deals with the aspect of saying res judicata even applies to criminal cases. My lords should get that as contention number 8. And the last contention was parity of reasoning. They said 482 was rejected. So there is some parity of reasoning when it comes to 306 also. Our 482 petition for quashment being rejected stands on absolutely a different.
Quashment kelidra.
Quashment we'd asked. We'd asked quashment. At one point of time.
Where is the quashing petition?
Discharge, yeah? No, the parity of reasoning they gave us between the order passed on discharge.
No, that's Justice Dixit the order. That is a upholding rejection of discharge. Yes.
So, my lords, I think the parity of reasoning as put forth by the learned ASG was in relation to that. Here, my lords, when 2 acts are very distinct cause of action, where we're challenging a grant of pardon, it will have nothing to do with either challenging a discharge or not. So this reasoning, my lords, according to me, will not come. There will be no parity of reasoning between that order and the order which has been passed now. Now, my lords, My lords, just yesterday, my lords was pleased to summarize the aspects, my lords, as submitted. My lords said, this is how I have looked at it. Please notice, my lords, the yardstick applied under the impugned order to grant pardon is totally illegal. That would be the first aspect of it, my lords, illegal, procedure adopted. Accused cannot be granted pardon in a mechanical manner without considering the nature of evidence that is available, number one, and, my lords, the culpability of that accused. My lord senior has elaborately pointed out what the culpability of the accused is. So that would be the yardstick to be adopted, my lords. Here we find neither of it. They don't see what is the evidence that is available on record, whether is there a need to grant pardon is not looked into, and, my lords, the culpability of this accused is not looked into. Then, my lords, third, there's absolutely no change in circumstance. I had pointed that out, my lords. Fourth, the order is passed. Sixth, the application is filed. So even as per the liberty granted by this court, the present application is not in accordance with that. My lords, then second, lack of bona fides in seeking the pardon. My lords, a lot has been pointed out. I will not go.
Pen drive. Don't get into that.
Yes, my lords. Then, my lords, the procedure adopted being illegal, 306 to 308. Then, my lords, if this yardstick of grant of pardon, my lords, if it is considered to be right, then, my lords, kindly consider this situation. What about the remaining 20 accused, 21 accused in all, remaining 20 accused seeking pardon? If this yardstick, we will grant. So it would be a case of saying all the 21 have been rendered pardon. In a case of 302, no one is there to face the charge.
Complainant.
Yeah, yardstick.
ಅದಕ್ಕೆ That's the problem. ಅದಕ್ಕೆ ಯಾರು ಇಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲ ಯಾರು ಇಲ್ಲ ಅಂದ್ರೆ somebody should be tried. Complainant come here. Yes, transposition.
My lords, the last aspect, finally, my lords, the last
No
aspect,
idea.
last aspect, my lords.
You're putting me to prejudice.
No, my lords, I wouldn't. Last
Yes.
aspect, my lords, if such grant of pardons are allowed in such manner, my lords, what would happen to chapter 21A of the CRPC? Please notice chapter 21A of the CRPC for a minute, my lords. This chapter was introduced, inserted. Concept of plea bargaining.
Oh, yes.
Please
all
notice,
right.
my lords. What would happen? Now, if 21 chapter, application of this chapter, it happens as soon as a final report is filed.
Where is it? Where is that available in a cognizable offense?
It is. Please notice 21,
Hold on.
600 and 265A. Very first, my lords. In fact, this chapter shall apply in respect of an accused against whom A,
265A,
365A, my lords.
365.
And my apology, my lords, 265 capital A, which is at chapter 21A, my lords.
Yes, I am there.
My lords, this was inserted with effect from 5/7/2006.
Six.
Please notice, my lords, this chapter shall apply in respect of an accused against whom A.
Oh,
a
7 years.
report-
Yes, yes.
So, my lords, if it is going to be a case of plea bargaining under that chapter, understandable, my lords, because it's a case of seeing a reduced sentence to be given. But, my lords, in a 302, an application for pardon by A1 being considered in such a mechanical manner in saying, all right, you go on the other side, let the others suffer. This is not how it is viewed, my lords. It has a direct effect on this
All
entire
the
chapter.
other accused are hurt.
I'm sorry.
Heartburn. All the other accused are
100%,
heartburn.
Heartburn. My right to silence goes. He may come and say something. Now, what do I do thereafter? And can you allow that person to go scot-free? It's in the nature of a discharge.
What is necessary is an antacid. Heartburn. Yes, Nagendra
My
Nayaka.
lords, this would be,
Yes.
I think the written, it's been given.
That
my
I'll
lords. I
see.
put everything
Yes.
down in writing.
ಇವ್ರು ಎದ್ದಿಂದ ನೋಡಿದ್ರೆ ಮತ್ತೆ ಇವ್ರು ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತಾರೆ. ಅಲ್ಲ ನಮ್ದಲ್ಲ ಅದು ಸುನಿಲ್ ಕುಮಾರ್ಗೆ ಸರ್ ಹೇಳಿದ್ ನಿಮ್ಗಲ್ಲ. No, no, no. When you come back next, after going on air, then we'll take it. Not now. ಇವ್ರು ಮುಗಿಸ್ಬಿಡ್ಲಿ ತಾಳಿ.
ಅಲ್ಲ ಅವರು ಮಾಡಿದ್ಮೇಲೆ ಮಾಡ್ತೀನಿ ಮತ್ತೆ
ಅವ್ರದ್ದೇನಿಲ್ಲ. ಡೋಂಟ್ ವರಿ ಅಬೌಟ್ ದಟ್, ಏನಿಲ್ಲ. ನೀವು ಮುಗಿಸಿ. ನೀವು ಏನೀಗ ರಿಪ್ಲೈ ಕೊಡ್ತಾ ಇರೋದು ಯಾರಿಗೆ?
ಅಲ್ಲ ಇಲ್ಲಿ ನನ್ನ ಪ್ರಕಾರ
ನೀವು ಅಲ್ಲ
acceptance, I will stick to the point.
ಅಷ್ಟೇ.
Your Lordship may kindly have a look at.
ಸರ್ ತಾವು ಯಾಕೆ ಅವಾಗಲೇ ಹೊರಡ್ತು, ನೋ ಪ್ರಾಬ್ಲಮ್, ಅಬ್ಸಲ್ಯೂಟ್ಲಿ ನೋ ಪ್ರಾಬ್ಲಮ್. ಅವರು ಲೆಟ್ ಆಲ್ ಆಫ್ ದೆಮ್ ದೇ, ಅಬ್ಸಲ್ಯೂಟ್ಲಿ ನೋ ಪ್ರಾಬ್ಲಮ್ಸ್. ಯು ನೀಡ್ ನಾಟ್ ವೇಟ್ ಎಟ್ ಆಲ್ ಸರ್.
No.
Yes, sir.
But I will answer the points raised by my learned friend
Yes.
in the same order. Your Lordship may kindly have a look at the power of this honorable court. In Ashok Agarwal, it is settled. In
Power of?
Ashok Agarwal. Para 40, your Lordship may kindly have a look.
For grant of pardon.
Allah, power of this honorable court.
482.
480.
All right.
397 ಅಂತ ಹೇಳಿ.
397,
401. ಅದರಲ್ಲಿ ಆರ್ಬಿಟ್ರರಿ ಅಂಡ್ ಪರ್ವರ್ಸ್ ಫೈಂಡಿಂಗ್ಸ್ ಇದ್ರೆ ಇಂಟರ್ಫಿಯರ್ ಆಗಬೇಕು. ಐ ವಿಲ್ ನಾಟ್ ಗೋ ಇನ್ ಡೀಟೇಲ್ ಬಿಕಾಸ್ ಐ ವಿಲ್ ನಾಟ್ ರೀಡ್ ದ ಜಜ್ಮೆಂಟ್. But what is the scope of the power of the learned section judge while dealing with granting pardon? Lordship may kindly, I will not read all judgments what they have read, but I would like to read Pascal Fernandez for once more because that clinches the issues.
Pascal clinches the issue,
Yes.
even according to them.
Yes.
All right, yes.
But acceptance of pardoning is necessary. There is no doubt about that. But at what stage? Your Lordship may kindly have a look at the.
At what stage?
ಅಲ್ಲಿ 2 stage ಬರುತ್ತೆ. Lord, the page number.
Where is Pascal?
Para 10, your Lordship may kindly. They refer to the language of the sections. 337, 338 in the old code.
ಒಂದು ಕಂಪೈಲೇಷನ್ ಇದೆ. ಸುನಿಲ್ ಕುಮಾರ್, ನಿಮ್ ಕಂಪೈಲೇಷನ್ ಯಾವ್ದು ಇದೆನಾ? ಪ್ಯಾಸ್ಕಲ್ ಫರ್ನಾಂಡಿಸ್ ಎಲ್ಲ ಇರೋದು
ಅಲ್ಲಿ ಇವ್ರದ್ರಲ್ಲೇ ಇದೆ. ಚೌಟ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ.
I think in mine it's there, Melody. See, spiral bound.
ಕೊಡಿ.
Spiral bound. Which are you quoting?
Para 10.
Pascal.
Pascal.
Para 10.
Para 10 ನಲ್ಲಿ ಬಾಟಮ್ ಅಲ್ಲಿ third line is. These provision between them establishes 2 periods of time in relation to the tender of pardon. In so far as offences mentioned in subsection 1 on 6171 and 3 of the criminal amendment are concerned before the case reaches the special judge. The provision of section 337(1) of the Code of Criminal Procedure apply at the stage of investigation or inquiry. If the magistrate therein mentioned tenders pardon, the person who is tendered pardon is examined under subsection 2. The magistrate must, without making any further inquiry, send the case to the special judge. If the offence is one of those mentioned in subsection 2 be above set out. In other words, just under subsection 2A, a magistrate has no option but to commit the accused to the court of session or the high court. Under subsection 2, he has no option but to stop further inquiry and send the case to the special judge. When the case is before the special judge, the tender of pardon can only be by the special judge and it is deemed to be one under section 338 for the purpose of section 339 and 339A as explained above. The fiction is necessary because no committal proceedings is necessary before a case is sent to a special judge. The words underlined by us in section 337(1) cannot apply to tender of pardon by special judge, as some of the words of section 338 do not apply to them.
This 337, 338 is 306 and
Similar language.
306 and 307.
Even under the latest code also interpreted, I will point.
Yes.
It follows that the powers of the special judge are not circumscribed by any condition except one, namely, that the action must be with a view to obtaining the evidence of a person supposed to have been directly or indirectly concerned in or privy to the offence. The person so tendered is also on condition of his making a full and true disclosure of the whole circumstances within his knowledge relating to the offence and every other person concerned, whether as principal or abettor. The disclosure must be complete as to himself
and as to any other person concerned as principal or abettor. There is no provision for the recording of reason for doing, nor is the special judge is required to furnish a copy of to the accused. There is no provision for recording a preliminary statement of the person. Therefore, my submission is, I will point out from the other
No,
judgment.
are you suggesting
Yes,
that the matter is placed before a special judge?
yes,
Not by way of committal. It is because of the position.
yes.
It goes before a special
Special
judge.
judge.
There is no order of committal here.
Here, yes.
So when it goes straight away before the special judge, the procedure under 306 or 337,
Yes.
306 need not be followed for a pardon under 307.
Lord,
Is that your submission?
That is my submission. I'll show the other
Submission.
judgment also.
Ah.
Lord, I'll
1898 code.
1898 ಕೋಡ್ ಕೊಡಿ ಬೆಟರ್. ನೀವು ಕೊಟ್ಟಿದ್ದೀರಾ ಮತ್ತೆ ರಿಸರ್ಚ್ ಅಲ್ಲಿಗೆ ಹೋಗಿ.
I will read few lines further.
Yes, sir.
My lords, it's culled out. In this compilation, it says the old news are culled out.
ಅಲ್ಲ ಅದು
ಯಾರು ಇವ್ರು ನೀವು ಅಸಿಸ್ಟ್ ಮಾಡ್ಲಿಲ್ವಾ ಅದಕ್ಕೆ?
Change it, I've seen.
Yes.
It follows that the powers of the special judge are not circumscribed by any condition except one, namely that the action must be with a view to obtaining the evidence of any person supposed to have been directly or indirectly concerned in or privy to an offense. The pardon so tendered is also on condition of his making a full disclosure of the whole circumstances within his knowledge relating to the offense and to every other person concerned, whether as a principal or abettor. The disclosure must be complete as to himself and as to any other person concerned as a principal or abettor. There is no provision for the recording of the reason for so doing, nor is the special judge required to furnish a copy of the accused. There is no provision for recording a preliminary statement of the person. There cannot be no doubt that the section is enabling and its terms are wide enough to enable the special judge to tender a pardon to any person who is supposed to have been directly or indirectly concerned or privy to an offense. This must necessarily include a person arraigned before him, but it may be possible to tender a pardon to a person not so arraigned. The power so concerned can also be exercised at any time after the case is received for trial and before its conclusion. There is nothing in the language of the section to show that special judge must be moved by the prosecution. He may be considered an offer by an accused as in this case. The action therefore was not outside the jurisdiction of the special judge in this case. There is no merit in the contention that Section 540 of the Code of Criminal Procedure governs Section 337 and 338 of the Code, Section 8 subclause 2 of the Criminal Law Amendment Act. That section only confers power on the court to summon material witness at any, that is not required. Next, I'll skip that. Next para 14. The next question is whether the special judge acted with due propriety in his jurisdiction. Here, the interest of the accused are just as important as those of the prosecution. No procedure or action can be in the interest of justice if it is prejudicial to an accused. There are also matters of public policy to consider before the special judge acts to tender pardon. He must, of course, know the nature of the evidence. The person seeking conditional pardon is also likely to give the nature of his complicity and the degree of his culpability in relation to the offense and in relation to the co-accused. What is meant by public policy is illustrated by a case of Dublin Commission Code.
All right.
Referred. Para 15, Your Lordship. In the case, the special judge made no effort to find out what Jagasia had to disclose. The English law and practice is A, to omit the proposed approver from the indictment, B, or to take his plea of guilty or arraignment, or C, to offer no evidence and permit his acquittal, or D, to enter a so-and-so. In our criminal jurisdiction, there is a tender of pardon on condition of full disclosure. Section 8(2) of the Criminal Law Amendment Act is enabling. Without recourse to it, an accused person cannot be examined as a witness in the same case against another accused. To determine whether accused testimony as an approver is likely to advance the interest of justice, the special judge must have material before him to show what is the nature of the testimony will be. Ordinarily, it is for the prosecution to ask that a particular accused out of several may be tendered pardon. But where the accused directly applies to the special judge, he must first report to the request to the prosecuting agency. Well, this is important. It is not for the special judge to enter the ring as a veritable director of prosecution. The power which the special judge exercises is not on his own behalf, but on behalf of the prosecuting agency, and must therefore be exercised only when the prosecuting joins tender for pardon, because it does not need approver's testimony. It may also not like the tender of a pardon to the crime of the worst offender. The proper course for the special judge is to ask for a statement from the prosecution on the request of the prisoner. If the prosecution thinks that the tender of a pardon will be in the interest of a successful prosecution of the other offenders whose conviction is not easily without the approver's testimony, it will indubitably agree to the tendering of pardon. The special judge or the magistrate must not take on himself the task of determining the propriety of tendering pardon in the circumstances of the case. Lord, my submission is, I am stressing on this line. Lord, at that stage, the judge has no duty to see the propriety of the accused being taken as a witness.
So whether he's giving full disclosure or not, that is all that is.
That's all the court is required to consider. Court need not weigh what is his evidence, how it is going
So
to
that
help
is
the-
ultimately for examination, cross-examination.
Yes, my lord. That is exact. Therefore, my submission is, if read with this, while exercising arbitrariness and perversity, my lord, the question, when the judge has no duty to verify what is the necessity of that witness, my lord, there is no question of, the procedure is completely followed by the learned trial judge. And yesterday, while the senior counsel, when he read the order of the trial court, he stressed that it is added by the judge. It is not added by the judge. From the judgment, it is called out. But regarding the condition, another condition which I was speaking, last may kindly have a look at the judgment of, which is referred by my friend. By Barrier State, 34. That is under the new code, Santosh Parikh. They were referred to it.
ಸಂದೇಶ್ ಸರ್, ಇನ್ಮೇಲೆ ಇವರಿಬ್ಬರಿಗೂ ಎಂಟ್ರಿ ಮಾಡ್ರಿಲ್ಲ,
Yeah,
ಅವರಿಬ್ಬರಿಗೆ
too much of material, man.
ಎಷ್ಟು
Sorry, my lords. I think you will be.
ಒಂದು ಇವರು ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ಗೋಸ್ಕರ ಅವ್ರು ಮಿಕ್ಕಿದ್ದಕ್ಕೆಲ್ಲ.
2000
ಸ್ವಲ್ಪ ನಮ್ದು ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ಇತ್ತು, my lords.
ಹೌದಾ?
ರೆಡಿ ಮಾಡಿ.
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ನಿಮ್ಗೆ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಎಸ್. ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಅವ್ರಿಗೂ ಇಲ್ಲ. ಸರಿ.
ಇಲ್ಲ ಇಲ್ಲಿ ಎಲ್ಲ ನಾಲೆಜ್ ಇವರು ಸುನಿಲ್ ಒಬ್ನಿಗೆ, ಬಿಕಾಸ್ ಈಸ್ ದೇರ್ ಫ್ರಮ್ ದಿ ಬಿಗಿನಿಂಗ್.
ಇಲ್ಲ, ಪ್ರತಿಯೊಂದು ಫಸ್ಟ್ ಇಂದ ಗೊತ್ತು. To tell you, admit both these boys are excellent.
We vouch for
Very,
it.
very nice.
We totally vouch for it.
Absolutely. Their research, their
Hardworking,
submission,
my lords. In
everything.
spite of it,
See,
the
this is how the growth of bar happens.
amount of hours put, my lords, that is most important.
That
How
I can know.
industrious
Next
you
day they would have come up with a compilation
are. Totally.
trained by you. ಅದು ಪರವಾಗಿಲ್ಲ. ಓ, ದೇಖ್ ಲೂಂಗಾ. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ಸ್ ಹೇಳಂಗಿಲ್ಲ, ಅದು ಅದಕ್ಕೆ ಹೇಳಿಲ್ಲ. ಯಾಕೆ? TGI, all right, yes. Yes.
This second judgment which I would like to, 2009 6 SCC 498, Lord Santosh Kumar Barrier.
ಕಂಪೈಲೇಷನ್
ಕಂಪೈಲೇಷನ್
ಕಂಪೈಲೇಷನ್ ಕೊಡಿ.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ನಾನು ಹಾಕಿರಲಿಲ್ಲ, ಇವರು ಅವ್ರು ಹಾಕಿದ್ದಾರೆ.
ಅದ್ರಲ್ಲಿ ಪೇಜ್ ಹೇಳಿ ನಂಗೆ, ಅದು ಸಿಗ್ಬೇಕಲ್ಲ. ಎಸ್ ಸುನಿಲ್ ಕುಮಾರ್, ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ? ಯಾವ
ಸಂತೋಷ್
ಜಡ್ಜ್ಮೆಂಟ್?
ಕುಮಾರ್ ಬರಿಯರ್.
ಸಂತೋಷ್ ಕುಮಾರ್
ಬರಿಯರ್
2009
2009
ಬರಿಯ
6
ಪೇಜ್
498.
ಪೇಜ್ 42 ನಾ? Santosh Kumar
Kumar
Bariya.
Bariya.
It be at
Para 34 of the judgment.
page. Page.
Page 175.
175.
Para 34 SP page.
175 to 237.
Paragraph 12.
Santosh.
Para
Bariya.
34, your lordship.
All right. Of this judgment?
Yes.
And also get it at page 198.
Yes, it's here. Yes.
Subsection 4 of section 306 in procedural in nature. It is necessary to be followed only by a magistrate, as he would not have any jurisdiction to try the case himself. The learned session judge before whom the case is committed for trial must be informed as to on what basis pardon had been tendered. Section 307 does not contain any such condition. The power of the learned session judge is independent of the provision of contained in section 306 thereof. The condition mentioned in section 307 refers to the condition laid down in subsection 1 of section 306, namely that the person in whose favor the pardon has been tendered will make a full and true disclosure of the whole of the circumstances within his knowledge. The power of the session court is not hedged with any other condition.
So that's the distinction.
That is the distinction. Well, I'll give an example, my lord, how the situation arises.
Yes.
Well, there are two stages. One before commencement of the trial, another during investigation. Well, all those judgment my learned friend has referred. I will not read the facts of each case because I have seen the case. All judgments are speaking about the power of the magistrate under 300.
So there is nothing about the session court session.
It is not the interpretation of power under section 307. And my lord, in all those judgments, either the person to whom pardon is given has contested saying that I had not accepted it, or co-accused have contended that he has not been examined.
So when according to you, when that condition itself is not applicable to 307,
yes,
the question of informing him the pardon, seeking him his consent, seeking his consent, all that would not arise at all.
That will
according
not
to
arise.
you.
That,
so the fact that he has accepted and deposed
yes,
is itself enough compliance with 307.
Yes. That's a
That is
submission. One limb of the condition. Another limb of the condition liability. Lord, here while considering the pardon, consent of three parties are necessary. Illi, suppose prosecution moves an application, then the acceptance by the accused is
that is imperative because prosecution may move saying we'll grant him pardon.
Yes.
He may say I don't accept it.
Yes.
Yes.
Lord, when I move the application or when the accused moves an application, that is his voluntariness. That is exactly held in the judgment of Pascal Parliament. There, the public prosecutor makes a statement that on the application of the accused, we have given consent.
All right.
Therefore, my submission is a specific acceptance from my part was not necessary in this case.
All right.
And my lord, there is no arbitrariness pointed out from the order. The trial court's order.
Then procedural ಇದೆ ಅಷ್ಟೇ.
ಅದರ ಬಗ್ಗೆ ಹೇಳಿದ್ದಾರೆ. Then second aspect which they have was argued about the constructive restitution. Lord, to say that, they should show that I was a party in the earlier proceedings. When your lordship rendered the judgment.
Oh, you are not a party.
I am not a party.
No, constructive restitudicate ಅದಕ್ಕೆಲ್ಲ ಹೇಳಿದ್ದವರು. There's one fact ಅದು.
Yes.
The third application that you filed is verbatim similar to the earlier one. It has ended in a particular thing. Oh, so you mean to say that they ended here? So you are not a party.
I was not a party here. My lord, when they argue, they should say, I have raised certain contention, I have left out. I had no opportunity to appear before this honorable court. My lord, that issue they cannot raise because having not made me a party.
I will consider.
That one which are right. Amele, your lordship may kindly see the judgment of the trial court, how it is. Just I will read few lines from there. The change of mind, page 91.
Change of
mind. Adral, 3 lines I will read from the Narayan Chetan Ram Chaudhary.
I have also changed my mind. We'll continue it tomorrow. 6:30 ಆಯ್ತು.
ಅಲ್ಲ 6 ಗಂಟೆಗೆ ನಾನೇ ಹೇಳೋಣ ಅನ್ಕೊಂಡೆ ಬೇಡ ಅಂತ, ಬಟ್ ಸಿನ್ಸ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಇನ್ಸಿಸ್ಟೆಡ್ ಐ ದಟ್
We'll get exhausted for the next day.
4 hours it's
Because ಹೋದ್ಮೇಲೆ ಏನು ಸುಮ್ಮನೆ ಇರಲ್ಲ, ಕರೆಕ್ಷನ್ ಸಿಗ್ನೇಚರ್ ಎಲ್ಲ ಮುಗಿಸೇ ಹೋಗ್ಬೇಕು.
My lord, I hope my lords have not changed the mind as far as my coming on 24th, because I have to
Not
make
at all, sir. That is fixed.
So I'll make arrangements accordingly.
No problem, sir. वो एक बार फिक्स हो गया तो हो गया. Yes.
Grateful.
हाँ? Permission. Tomorrow ಆಗಲ್ವಾ? ಲಿಸ್ಟ್ ಹೇಳಿಲ್ವಾ? Oh, there are about 200 matters tomorrow. I can't tomorrow. Yes.
Well, it's, if it's going to be 24th.
No, sir is coming on
Yes, but it's on
24th.
the same day it could be finished, my lords.
Date ಮಾತ್ರ ಹಾಕ್ಬಿಡು, next day ಹಾಕಲ್ವಾ? Date ಎಷ್ಟಿದೆ? Let me say, I have to adjust because Monday ಅಲ್ವಾ? Mondays will be huge rush, so.
Tuesday.
ನೋಡ್ತೀನಿ, I think they should come.
ಅಲ್ಲ ಕೋರ್ಟ್ಗೆ ಆಗಲ್ಲ.
ಅಲ್ಲ, Saturday ತಗೊಂತೀನಿ. ನೀವು Saturday ಮುಗಿಸ್ಬಿಡಿ.
My lords are keeping it on Saturday, my lords?
No, Saturday for everybody else to finish, sir. For you, Monday, sir.
Saturday, any fixed time, my lords?
Saturday, I have a few matters. Saturday morning itself I'll take.
Grateful, my lords.
At 10:30 itself I'll take.
Grateful.
Because Saturday is, it's an extra day, so I have kept only hearing matters on that day. I'll take it on Saturdays.
Grateful.
In criminal petition.
Huh?
Submission, your lordship.
Mike.
A small submission, your lordship. Criminal petition 12992 of 23. Saturday gittidira, your lordship. Adu, we have already moved the memos for tomorrow.
List close ಆಗಿದೆಯಲ್ಲ madam. Saturday is there. You're not there on Saturday?
Senior counsel is unable, sir.
You make a mention on that day. We'll grant you another day. ಇವಾಗ ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗಿದೆ, ಅದು ಸೈನ್ ಆಗಿದೆ, ಇಟ್ ಬಿ ಡಿಫಿಕಲ್ಟ್.
Oblige.
ನಾಳೆ ಯು ಮೇಕ್ ಅ ಮೆನ್ಷನ್ ಆನ್ ಸ್ಯಾಟರ್ಡೇ, ಅನ್ಲೆಸ್ ಯು ಆರ್ ಆಲ್ಸೋ ನಾಟ್ ಕಮಿಂಗ್ ಆನ್ ಸ್ಯಾಟರ್ಡೇ. Yes, then make.